singly or at a joint sitting, is presented to the President for issue assent. There are three alternatives before the President. A. Husha may give issue assent to the bill. Or B. Husha may withhold issue assent to the bill. Or C. Husha may return the bill for reconsideration of the Houses. If President gives issue assent to the bill becomes an act and is placed on the statute book. If the President withholds issue assent to the bill, it ends and does not become an act. If the President returns the bill for reconsideration and if it is passed by both the Houses again with or without amendments and presented to the President for issue assent, the President must give issue assent to the bill. Thus, the President enjoys only a suspensive veto. Money Bills Article No of the Constitution deals with the definition of money bills. It states that a bill, Parliament M 247, is deemed to be a money bill if it contains only provisions dealing with all or any of the following matters. 1. The imposition, abolition, remission, alteration, or regulation of any tax. 2. The regulation of the borrowing of money by the Union government. 3. The custody of the Consolidated Fund of India or the Contingency Fund of India, the payment of monies into or the withdrawal of money from any such fund. 4. The appropriation of money out of the Consolidated Fund of India. 5. Declaration of any expenditure charged on the Consolidated Fund of India or increasing the amount of any such expenditure. 6. The receipt of money on account of the Consolidated Fund of India or the Public Account of India or the custody or issue of such money, or the audit of the accounts of the Union or of a state. Or 7. Any matter incidental to any of the matters specified above. However, a bill is not to be deemed to be a money bill by reason only that it provides for 1. The imposition of fines or other pecuniary penalties, or 2. The demand or payment of fees for licenses or fees for services rendered. Or 3. The imposition, abolition, remission, alteration, or regulation of any tax by any local authority or body for local purposes. If any question arises whether a bill is a money bill or not, the decision of the Speaker of the Lok Sabha is final. His decision in this regard cannot be questioned in any court of law or in the either House of Parliament or even the President. When a money bill is transmitted to the Rajya Sabha for recommendation and presented to the President for assent, the Speaker endorses it as a money bill. The Constitution lays down a special procedure for the passing of money bills in the Parliament. A money bill can only be introduced in the Lok Sabha, and that too on the recommendation of the President. Every such bill is considered to be a government bill and can be introduced only by a minister. 248K** Indian Polity. After a money bill is passed by the Lok Sabha, it is transmitted to the Rajya Sabha for its consideration. The Rajya Sabha has restricted powers with regard to a money bill. It cannot reject or amend a money bill. It can only make the recommendations. It must return the bill to the Lok Sabha within 14 days, whether with or without recommendations. The Lok Sabha can either accept or reject all or any of the recommendations of the Rajya Sabha. If the Lok Sabha accepts any recommendation, the bill is then deemed to have been passed by both the Houses in the modified form. If the Lok Sabha does not accept any recommendation, the bill is then deemed to have passed by both the Houses in the form originally passed by the Lok Sabha without any change. If the Rajya Sabha does not return the bill to the Lok Sabha within 14 days, the bill is deemed to have been passed by both the Houses in the form originally passed by the Lok Sabha. Thus, the Lok Sabha has more powers than Rajya Sabha with regard to a money bill. On the other hand, both the Houses have equal powers with regard to an ordinary bill. Finally, when a money bill is presented to the President, Husha may either give his or her assent to the bill or withhold his or her assent to the bill but cannot return the bill for reconsideration of the Houses. Normally, the President gives his or her assent to a money bill as it is introduced in the Parliament with his or her prior permission. Table 23.4 shows the differences between the procedures for the enactment of ordinary bills and money bills. Ordinary bill, money bill. Table 23.4 Ordinary bill versus money bill. 1. It can be introduced either in the Lok Sabha or the 1. It can be introduced only in the Lok Sabha and Rajya Sabha, not in the Rajya Sabha. 2. It can be introduced either by a minister or by a private member. 2. It can be introduced only by a minister. 3. It is introduced without the recommendation of the President. 3. It can be introduced only on the recommendation of the President. 4. It can be amended or rejected by the Rajya Sabha. 4. It cannot be amended or rejected by the Rajya Sabha. The Rajya Sabha should return the bill with or without recommendations, which may be accepted or rejected by the Lok Sabha. 5. It can be detained by the Rajya Sabha for a maximum period of 6 months. 5. It can be detained by the Rajya Sabha for a maximum period of 14 days only. 6. It does not require the certification of the Speaker when transmitted to the Rajya Sabha if it has originated in the Lok Sabha. 6. It requires the certification of the Speaker when transmitted to the Rajya Sabha. 7. It is sent for the President's assent only after being approved by both the Houses. In case of a deadlock due to disagreement between the two Houses, a joint sitting of both the Houses can be summoned by the President to resolve the deadlock. 7. It is sent for the President's assent even if it is approved by only Lok Sabha. There is no chance of any disagreement between the two houses and hence, there is no provision of joint sitting of both the houses in this regard. 8. Its defeat in the Lok Sabha may lead to the resignation. 8. Its defeat in the Lok Sabha leads to the resignation of the government if it is introduced by a minister. 10 of the government. 9. It can be approved or rejected or returned for recon. 9. It can be approved or rejected but cannot be side rationed by the President. Returned for reconsideration by the President. Financial bills. Financial bills are those bills that deal with fiscal matters, that is, revenue or expenditure. However, the Constitution uses the term financial bill in a technical sense. Financial bills are of three kinds. 1. Money bills Article 110(2). Financial bills, I. Article 117, 1, 3. Financial bills, 2. Article 117, 3. This classification implies that money bills are simply a species of financial bills. Hence, all money bills are financial bills, but all financial bills are not money bills. Only those financial bills are money bills which contain exclusively those matters which are mentioned in Article 110 of the Constitution. These are also certified by the Speaker of Lok Sabha as money bills. The financial bills, I and 2, on the other hand, have been dealt with in Article 117 of the Constitution. Financial bills, I, a financial bill, I, is a bill that contains not only any or all the matters mentioned in Article 110, but also other matters of general legislation. For instance, a bill that contains a borrowing clause, but does not exclusively deal with borrowing. In two respects, a financial bill, I, is similar to a money bill -A. Both of them can be introduced only in the Lok Sabha and not in the Rajya Sabha, and B. Both of them can be introduced only on the recommendation of the President. In all other respects, a financial bill, I, is governed by the same legislative procedure applicable to an ordinary bill. Hence, it can be either rejected or amended by the Rajya Sabha, except that an amendment other than for reduction or abolition of a tax cannot be moved in the Rajya Sabha or in the Lok Sabha without the recommendation of the President, i.e., the recommendation of President is not required for moving an amendment making provision for the reduction or abolition of a tax. In case of a disagreement between the two houses over such a bill, the President can summon a joint sitting of the two houses to resolve the deadlock. When the bill is presented to the President, Husha. Parliament 249. Can either give issue assent to the bill or withhold issue assent to the bill or return the bill for reconsideration of the houses. Financial bills, 11. A financial bill, 2, contains provisions involving expenditure from the Consolidated Fund of India, but does not include any of the matters mentioned in Article 110. It is treated as an ordinary bill and in all respects, it is governed by the same legislative procedure which is applicable to an ordinary bill. The only special feature of this bill is that it cannot be passed by either House of Parliament unless the President has recommended to that House the consideration of the bill. Hence, Financial Bill 2 can be introduced in either House of Parliament and recommendation of the President is not necessary for its introduction. In other words, the recommendation of the President is not required at the introduction stage, but is required at the consideration stage. It can be either rejected or amended by either House of Parliament. In case of a disagreement between the two houses over such a bill, the President can summon a joint sitting of the two houses to resolve the deadlock. When the bill is presented to the President, Husha can either give issue assent to the bill or withhold issue assent to the bill or return the bill for reconsideration of the houses. T. Joint sitting of two houses. Joint sitting is an extraordinary machinery provided by the Constitution to resolve a deadlock between the two houses over the passage of a bill. A deadlock is deemed to have taken place under any one of the following three situations after a bill has been passed by one house and transmitted to the other house. 1. If bill is rejected by the other house. 2. If houses have finally disagreed as to the amendments to be made in the bill. Or 3. If more than 6 months have elapsed from the date of the receipt of the bill by the other house without the bill being passed by it. 250p Indian Polity. In the above three situations, the President can summon both the houses to meet in a joint sitting for the purpose of deliberating and voting on the bill. It must be noted here that the provision of joint sitting is applicable to ordinary bills or financial bills only and not to money bills or constitutional amendment bills. In the case of a money bill, the Lok Sabha has overriding powers, while a constitutional amendment bill must be passed by each house separately. In reckoning the period of 6 months, no account can be taken of any period during which the other house, to which the bill has been sent, is prorogued or adjourned for more than 4 consecutive days. If the bill, under dispute, has already lapsed due to the dissolution of the Lok Sabha, no joint sitting can be summoned. But, the joint sitting can be held if the Lok Sabha is dissolved after the President has notified his intention to summon such a sitting, as the bill does not lapse in this case. After the President notifies his intention to summon a joint sitting of the two houses, none of the houses can proceed further with the bill. The Speaker of Lok Sabha presides over a joint sitting of the two houses and the Deputy Speaker, in his absence. If the Deputy Speaker is also absent from a joint sitting, the Deputy Chairman of Rajya Sabha presides. If Husha is also absent, such other person as may be determined by the members present at the joint sitting, presides over the meeting. It is clear that the Chairman of Rajya Sabha does not preside over a joint sitting as Husha is not a member of either House of Parliament. The quorum to constitute a joint sitting is 1/10 of the total number of members of the two houses. The joint sitting is governed by the rules of procedure of Lok Sabha and not of Rajya Sabha. If bill in dispute is passed by a majority of the total number of members of both the houses present and voting in the joint sitting, the bill is deemed to have been passed by both the houses. Normally, the Lok Sabha with greater number wins the battle in a joint sitting. The Constitution has specified that at a joint sitting, new amendments to the bill cannot be proposed except in two cases. 1. Those amendments that have caused final disagreement between the houses. And 2. Those amendments that might have become necessary due to the delay in the passage of the bill. Since 1950, the provision regarding the joint sitting of the two houses has been invoked only thrice. The bills that have been passed at joint sittings are 1. Dowry Prohibition Bill, I-960. 2. Banking Service Commission, Repeal, Bill, 1977.2012222. 20. The Lok Sabha did not agree to the amendments made by the Rajya Sabha. A joint sitting was held on May 6, 1961. 21. The bill was passed by the Lok Sabha but rejected by the Rajya Sabha. A joint sitting was held on May 16, 1978. 22. The bill was passed by the Lok Sabha but rejected by the Rajya Sabha. A joint sitting was held on March 26, 2002. The bill was passed when 425 members voted for it and 296 against. 3. Prevention of Terrorism Bill, 2002. Budget in Parliament The Constitution refers to the budget as the annual financial statement. In other words, the term budget has nowhere been used in the Constitution. It is the popular name for the annual financial statement that has been dealt with in Article 112 of the Constitution. The budget is a statement of the estimated receipts and expenditure of the Government of India in a financial year, which begins on April 1st and ends on March 31st of the following year. In addition to the estimates of receipts and expenditure, the budget contains certain other elements. Overall, the budget contains the following. 1. Estimates of revenue and capital receipts. 2. Ways and means to raise the revenue. Parliament 251. 3. Estimates of expenditure. 4. Details of the actual receipts and expenditure of the closing financial year and the reasons for any deficit or surplus in that year. And 5. Economic and financial policy of the coming year, that is, taxation proposals, prospects of revenue, spending program and introduction of new schemes projects. Merger of railway budget till 2017. The Government of India had two budgets, namely, the railway budget and the general budget. While the former consisted of the estimates of receipts and expenditures of only the Ministry of Railways, the latter consisted of the estimates of receipts and expenditure of all the ministries of the Government of India, except the railways. The railway budget was separated from the general budget in 1924 on the recommendations of the Ackworth Committee Report, 1921. The reasons or objectives of this separation were as follows. 1. Introduce flexibility in railway finance. 2. Facilitate a business approach to the railway policy. 3. Secure stability of the general revenues by providing an assured annual contribution from railway revenues. 4. Enable the railways to keep their profits for their own development after paying a fixed annual contribution to the general revenues. In 2017, the central government merged the railway budget into the general budget. Hence, there is now only one budget for the Government of India, i.e., Union Budget. Constitutional provisions. The Constitution of India contains the following provisions with regard to the enactment of budget. 1. The President shall in respect of every financial year cause to be laid before both the Houses of Parliament a statement of estimated receipts and expenditure of the Government of India for that year, Article 112. 2. No demand for a grant shall be made except on the recommendation of the President, Article 113. 3. No money shall be withdrawn from the Consolidated Fund of India except under appropriation made by law, Article 114. 4. No money bill imposing tax shall be introduced in the Parliament except on the recommendation of the President, and such a bill shall not be introduced in the Rajya Sabha, Article 117. 5. No tax shall be levied or collected except by authority of law, Article 265. 6. Parliament can reduce or abolish a tax but cannot increase it, Article 117. 7. The Constitution has also defined the relative roles or position of both the Houses of Parliament with regard to the enactment of the budget in the following way. A money bill or finance bill dealing with taxation cannot be introduced in the Rajya Sabha. It must be introduced only in the Lok Sabha, Article 109. B. The Rajya Sabha has no power to vote on the demand for grants. It is the exclusive privilege of the Lok Sabha, Article 113. C. The Rajya Sabha should return the money bill or finance bill to the Lok Sabha within 14 days. The Lok Sabha can either accept or reject the recommendations made by Rajya Sabha in this regard, Article 109. 8. The estimates of expenditure embodied in the budget shall show separately the expenditure charged on the Consolidated Fund of India and the expenditure made from the Consolidated Fund of India, Article 112. 9. The budget shall distinguish expenditure on revenue account from other expenditure, Article 112. 10. The expenditure charged on the Consolidated Fund of India shall not be submitted to the vote of Parliament. 252 M. Indian Polity. However, it can be discussed by the Parliament. Article 113. 11. The Lok Sabha can approve or refuse any demand or reduce the amount specified in the demand, but cannot increase it. Article 113. 12. No such amendment can be proposed to the Appropriation Bill in either House of the Parliament that will have the effect of varying the amount or altering the destination of any grant voted, or of varying the amount of any expenditure changed on the Consolidated Fund of India. Article 114. 13. The Lok Sabha can make any grant in advance, vote on account, in respect to the estimated expenditure for a part of the financial year, pending the completion of the voting of the demands for grants and the enactment of the Appropriation Bill. Article 116. Charged expenditure. The budget consists of two types of expenditure: the expenditure charged upon the Consolidated Fund of India and the expenditure made from the Consolidated Fund of India. The charged expenditure is non-votable by the Parliament. That is, it can only be discussed by the Parliament, while the other type has to be voted by the Parliament. The list of the charged expenditure is as follows. 1. Emoluments and allowances of the President and other expenditure relating to his office. 2. Salaries and allowances of the Chairman and the Deputy Chairman of the Rajya Sabha and the Speaker and the Deputy Speaker of the Lok Sabha. 3. Salaries, allowances and pensions of the judges of the Supreme Court. 4. Pensions of the judges of high courts. 5. Salary, allowances and pension of the Comptroller and Auditor General of India. 6. Salaries, allowances and pension of the Chairman and members of the Union Public Service Commission. 7. Administrative expenses of the Supreme Court, the Office of the Comptroller and Auditor General of India, and the Union Public Service Commission, including the salaries, allowances and pensions of the persons serving in these offices. 8. The debt charges for which the Government of India is liable, including interest, sinking fund charges and redemption charges, and other expenditure relating to the raising of loans and the service and redemption of debt. 9. Any sum required to satisfy any judgment, decree, or award of any court or arbitral tribunal. 10. Any other expenditure declared by the Parliament to be so charged. Stages in enactment. The budget goes through the following 6 stages in the Parliament. 1. Presentation of budget. 2. General discussion. 3. Scrutiny by departmental committees. 4. Voting on demands for grants. 5. Passing of Appropriation Bill. 6. Passing of Finance Bill. 1. Presentation of budget. Conventionally, the budget is presented to the Lok Sabha by the Finance Minister on the last working day of February. Since 2017, the presentation of the budget has been advanced to 1st of February. The budget can also be presented to the House in 2 or more parts, and when such presentation takes place, each part shall be dealt with as if it were the budget. Further, there shall be no discussion of the budget on the day on which it is presented to the House. The Finance Minister presents the budget with a speech known as the budget speech. At the end of the speech in the Lok Sabha, the budget is laid before the Rajya Sabha, which can only discuss it and has no power to vote on the demands for grants. Parliament. The budget documents presented to the Parliament comprise of the following: 223. 22. A Budget Manual, Ministry of Finance, Government of India, November 2022, pp. 2-3. 22b. The Fiscal Responsibility and Budget Management Act, 2003 was enacted to provide for the responsibility of the central government to ensure intergenerational equity in fiscal management and long-term macroeconomic stability. I. Budget Speech. 2. Annual Financial Statement. 3. Demands for grants. 4. Finance Bill. V. Statements mandated under the FRBM Act 22-inch. A. Macroeconomic Framework Statement. H. Fiscal Policy Strategy Statement. C. Medium-Term Fiscal Policy Statement. 6. Expenditure Budget. 7. Receipts Budget. 8. Expenditure Profile. 9. Memorandum explaining the provisions in the Finance Bill. X. Budget at a glance. 11. Outcome Budget. Output. Outcome Monitoring Framework. 12. Key features of the budget. 13. Implementation of previous budget announcements. 14. Key to budget documents. Earlier, the economic survey also used to be presented to the Parliament along with the budget. Now, it is presented one day or a few days before the presentation of the budget. This report is prepared by the Finance Ministry and indicates the status of the national economy. 2. General discussion. The general discussion on budget begins a few days after its presentation. It takes place in both the Houses of Parliament and lasts usually for 3 to 4 days. During this stage, the Lok Sabha can discuss the budget as a whole or on any question of principle involved therein, but no cut motion can be moved nor can the budget be submitted to the vote of the House. The Finance Minister has a general right of reply at the end of the discussion. 3. Scrutiny by departmental committees. After the general discussion on the budget is over, the Houses are adjourned for about 3 to 4 weeks. During this gap period, The 24 departmental standing committees of Parliament examine and discuss in detail the demands for grants of the concerned ministers and prepare reports on them. These reports are submitted to both the Houses of Parliament for consideration. The standing committee system established in 1993 and expanded in 2004 makes parliamentary financial control over ministries much more detailed, close, in-depth, and comprehensive. 4. Voting on demands for grants in the light of the reports of the departmental standing committees, the Lok Sabha takes up voting of demands for grants. The demands are presented ministry-wise. A demand becomes a grant after it has been duly voted. Expo points should be noted in this context. 1. The voting of demands for grants is the exclusive privilege of the Lok Sabha. That is, the Rajya Sabha has no power of voting the demands. 2. The voting is confined to the votable part of the budget. The expenditure charged on the Consolidated Fund of India is not submitted to the vote. It can only be discussed. Each demand is voted separately by the Lok Sabha. During this stage, the members of Parliament can discuss the details of the budget. They can also move motions to reduce any demand for grant. Such motions are called as cut motion, which are of three kinds. A. Policy cut motion. It represents the disapproval of the policy underlying the demand. It states that the amount of the demand be reduced to 1. The members can also advocate an alternative policy. B. Economy cut motion. It represents the economy that can be affected in the proposed expenditure. It states that the amount of the $254 Indian Polity demand be reduced by a specified amount, which may be either a lump sum reduction in the demand or omission or reduction of an item in the demand. C. Token cut motion. It ventilates a specific grievance that is within the sphere of responsibility of the Government of India. It states that the amount of the demand be reduced by 100. A cut motion, to be admissible, must satisfy the following conditions. I. It should relate to one demand only. 2. It should be clearly expressed and should not contain arguments or defamatory statements. 3. It should be confined to one specific matter. 4. It should not make suggestions for the amendment or repeal of existing laws. V. It should not refer to a matter that is not primarily the concern of union government. 6. It should not relate to the expenditure charged on the Consolidated Fund of India. 7. It should not relate to a matter that is under adjudication by a court. 8. It should not raise a question of privilege. The significance of a cut motion lies in A. Facilitating the initiation of concentrated discussion on a specific demand for grant, and B. Upholding the principle of responsible government by probing the activities of the government. However, the cut motion do not have much utility in practice. They are only moved and discussed in the House, but not passed as the government enjoys majority support. Their passage by the Lok Sabha amounts to the expressions of one of parliamentary confidence in the government and may lead to its resignation. On the last day of the days allotted for discussion and voting on the demands for grants, the Speaker puts all the remaining demands to vote and disposes them whether they have been discussed by the members or not. This is known as guillotine. 5. Passing of Appropriation Bill. The Constitution states that no money shall be withdrawn from the Consolidated Fund of India except under appropriation made by law. Accordingly, after the demands for grants are voted on and passed by the Lok Sabha, an appropriation bill is introduced to provide for the appropriation, out of the Consolidated Fund of India, of all money required to meet A. The grants voted by the Lok Sabha. B. The expenditure charged on the Consolidated Fund of India. No such amendment can be proposed to the appropriation bill in either house of the Parliament that will have the effect of varying the amount or altering the destination of any grant voted, or of varying the amount of any expenditure charged on the Consolidated Fund of India. The appropriation bill becomes the Appropriation Act after it is assented to by the President. This act authorizes or legalizes the payments from the Consolidated Fund of India. This means that the government cannot withdraw money from the Consolidated Fund of India till the enactment of the appropriation bill. This takes time and usually goes on till the end of April. But the government needs money to carry on its normal activities after March 31st, the end of the financial year. To overcome this functional difficulty, the Constitution has authorized the Lok Sabha to make any grant in advance in respect to the estimated expenditure for a part of the financial year, pending the completion of the voting of the demands for grants and the enactment of the appropriation bill. This provision is known as the vote on account. It is passed or granted after the general discussion on budget is over. It is generally granted for 2 months for an amount equivalent to 1/6 of the total estimation. In an election year, when the Lok Sabha is to be dissolved or a new Lok Sabha is constituted, the vote on account may be taken for a longer period, for about 3 to 5 months. From 2017 onwards, the budget session is advanced to January 31st, and the union budget is presented on February 1st, almost a month ahead of the usual date in the past. This change is intended to enable the Parliament to avoid a vote on account and pass a single appropriation bill for the year before the close of the financial year. After the advancement of budget cycle from the last day of February to the first day of February, the The vote on account is presented in the election year when interim budget is presented. In the year in which general elections to the Lok Sabha are held, the interim budget is presented to the Parliament. After the general elections are over and assumption of office by the new government, the regular budget is presented to the Parliament on a date as decided by the new government. 6. Passing of Finance Bill. The Finance Bill means the bill ordinarily introduced in each year to give effect to the financial proposals of the Government of India for the next financial year, and includes a bill to give effect to supplementary financial proposals for any period. It is subjected to all the conditions applicable to a money bill. Unlike the Appropriation Bill, the amendments, seeking to reject or reduce a tax, can be moved in the case of Finance Bill. During this stage, a member can discuss matters relating to general administration, local grievances within the sphere of the responsibility of the Government of India, or monetary or financial policy of the government. According to the Provisional Collection of Ixes Act of 1931, the Finance Bill must be enacted, i.e., passed by the Parliament and assented to by the President, within 75 days. The Finance Act legalizes the income side of the budget and completes the process of the enactment of the budget. Other grants. In addition to the budget that contains the ordinary estimates of income and expenditure for one financial year, various other Parliament M. 255. Grants are made by the Parliament under extraordinary or special circumstances. Supplementary grant. It is granted when the amount authorized by the Parliament through the Appropriation Act for a particular service for the current financial year is found to be insufficient for that year. Additional grant. It is granted when a need has arisen during the current financial year for additional expenditure upon some new service not contemplated in the budget for that year. Excess grant. It is granted when money has been spent on any service during a financial year in excess of the amount granted for that service in the budget for that year. It is voted by the Lok Sabha after the financial year. Before the demands for excess grants are submitted to the Lok Sabha for voting, they must be approved by the Public Accounts Committee of Parliament. Vote of credit. It is granted for meeting an unexpected demand upon the resources of India, when on account of the magnitude or the indefinite character of the service, the demand cannot be stated with the details ordinarily given in a budget. Hence, it is like a blank check given to the executive by the Lok Sabha. Exceptional grant. It is granted for a special purpose and forms no part of the current service of any financial year. Token grant. It is granted when funds to meet the proposed expenditure on a new service can be made available by reappropriation. A demand for the grant of a token sum is submitted to the vote of the Lok Sabha, and if assented, funds are made available. Reappropriation involves transfer of funds from one head to another. It does not involve any additional expenditure. Supplementary, additional, excess, and exceptional grants and vote of credit are regulated by the same procedure which is applicable in the case of a regular budget. Funds. The Constitution of India provides for the following three kinds of funds for the central government. Consolidated Fund of India, Article 266(2). Public Account of India, Article 266(3). Contingency Fund of India, Article 267. Consolidated Fund of India. It is a fund to which all receipts are credited and all payments are debited. In other words, A. All revenues received by the Government of India. B. All loans raised by the government by the issue of treasury bills, loans or ways and means of advances. And C. All money received by the government in repayment of loans forms the Consolidated Fund of India. All the legally authorized payments on behalf of the Government of India are made out of this fund. No money out of this fund can be appropriated, issued, or drawn, except in accordance with a parliamentary law. Public Account of India. All other public money, other than those which are credited to the Consolidated Fund of India, received by or on behalf of the Government of India shall be credited to the Public Account of India. This includes Provident Fund deposits, judicial deposits, savings bank deposits, departmental deposits, remittances, and so on. This account is operated by executive action, that is, the payments from this account can be made without parliamentary appropriation. Such payments are mostly in the nature of banking transactions. Contingency Fund of India. The Constitution authorized the Parliament to establish a Contingency Fund of India, into which amounts determined by law are paid from time to time. Accordingly, the Parliament enacted the Contingency Fund of India Act in 1950. This fund is placed at the disposal of the President, and HESA can make advances out of it to meet unforeseen expenditure pending its authorization by the Parliament. The fund is held by the Finance Secretary on behalf of the President. Like the Public Account of India, it is also operated by executive action. T. Multifunctional role of Parliament in the Indian politico-administrative system. The Parliament occupies a central position and has a multifunctional role. It enjoys extensive powers and performs a variety of functions towards the fulfillment of its constitutionally expected role. Its powers and functions can be classified under the following heads. 1. Legislative powers and functions. 2. Executive powers and functions. C. Financial powers and functions. 4. Constituent powers and functions. 5. Judicial powers and functions. 6. Electoral powers and functions. 7. Other powers and functions. EBI legislative powers and functions. The primary function of Parliament is to make laws for the governance of the country. It has exclusive power to make laws on the subjects enumerated in the Union List, which at present has 98 subjects, originally 97 subjects, and on the residuary subjects, that is, subjects not enumerated in any of the three lists. With regard to Concurrent List, which has at present 52 subjects, originally 47 subjects, the Parliament has overriding powers, that is, the law of Parliament prevails over the law of the state legislature in case of a conflict between the two. The Constitution also empowers the Parliament to make laws on the subjects enumerated in the state list, which at present has 59 subjects, originally 66 subjects, under the following 5 abnormal circumstances. A. When Rajya Sabha passes a resolution to that effect. B. When a proclamation of national emergency is in operation. C. When 2 or more states make a joint request to the Parliament. Parliament 257. D. When necessary to give effect to international agreements, treaties, and conventions. E. When President's rule is in operation in the state. All the ordinances issued by the President, during the recess of the Parliament, must be approved by the Parliament within 6 weeks after its reassembly. An ordinance becomes inoperative if it is not approved by the Parliament within that period. The Parliament makes laws in a skeleton form and authorizes the executive to make detailed rules and regulations within the framework of the parent law. This is known as delegated legislation or executive legislation or subordinate legislation. Such rules and regulations are placed before the Parliament for its examination. A. Executive powers and functions. The Constitution of India established a parliamentary form of government in which the executive is responsible to the Parliament for its policies and acts. Hence, the Parliament exercises control over the executive through question hour, 0 hour, half-an-hour discussion, short duration discussion, calling attention motion, adjournment motion, no confidence motion, censure motion, and other discussions. It also supervises the activities of the executive with the help of its committees like Committee on Government Assurances, Committee on Subordinate Legislation, Committee on Petitions, etc. The ministers are collectively responsible to the Parliament in general and to the Lok Sabha in particular. As a part of collective responsibility, there is individual responsibility, that is, each minister is individually responsible for the efficient administration of the ministry under his charge. This means that they continue in office so long as they enjoy the confidence of the majority members in the Lok Sabha. In other words, the Council of Ministers can be removed from office by the Lok Sabha by passing a no confidence motion. The Lok Sabha can also express lack of confidence in the government in the following ways. A. By not passing a motion off tanks on the President's inaugural address. B. By rejecting a money bill. C. By passing a censure motion or an adjournment motion. D. By defeating the government on a vital issue. E. By passing a cut motion. Therefore, the first function of Parliament can be said to be to select the group which is to form the government, support and sustain it in power so long as it enjoys its confidence, and to expel it when it ceases to do so, and leave it to the people to decide at the next general election. 23. 23N.N. Malia, Indian Parliament, p. 39. EJI financial powers and functions. No tax can be levied or collected and no expenditure can be incurred by the executive except under the authority and with the approval of Parliament. Hence, the budget is placed before the Parliament for its approval. The enactment of the budget by the Parliament legalizes the receipts and expenditure of the government for the ensuing financial year. The Parliament also scrutinizes government spending and financial performance with the help of its financial committees. These include Public Accounts Committee, Estimates Committee, and Committee on Public Undertakings. They bring out the cases of illegal, irregular, unauthorized, improper usage and wastage and extravagance in public expenditure. Therefore, the parliamentary control over the executive in financial matters operates in 2 stages. A. Budgetary control, that is, control before the appropriation of grants through the enactment of the budget. And B. Post-budgetary control, that is, control after the appropriation of grants through the 3 financial committees. Indian Polity. The budget is based on the principle of annuity, that is, the Parliament grants money to the government for one financial year. If the granted money is not spent by the end of the financial year, then the balance expires and returns to the Consolidated Fund of India. This practice is known as the rule of lapse. It facilitates effective financial control by the Parliament as no reserve funds can be built without its authorization. However, the observance of this rule leads to heavy rush of expenditure towards the close of the financial year. This is popularly called as March rush. QI constituent powers and functions. The Parliament is vested with the powers to amend the Constitution by way of addition, variation, or repeal of any provision. The major part of the Constitution can be amended by the Parliament with special majority, that is, a majority of the total membership of each House and a majority of not less than 2/3 of the members present and voting in each House. Some other provisions of the Constitution can be amended by the Parliament with simple majority, that is, a majority of the members present and voting in each House of Parliament. Only a few provisions of the Constitution can be amended by the Parliament, by special majority, and with the consent of at least half of the state legislatures, by simple majority. However, the power to initiate the process of the amendment of the Constitution, in all the 3 cases, lies exclusively in the hands of the Parliament and not the state legislature. There is only one exception, that is, the state legislature can pass a resolution requesting the Parliament for the creation or abolition of the Legislative Council in the state. Based on the resolution, the Parliament makes an act for amending the Constitution to that effect. To sum up, the Parliament can amend the Constitution in three ways: A. By simple majority, B. By special majority, and C. By special majority but with the consent of half of all the state legislatures. The constituent power of the Parliament is not unlimited. It is subject to the basic structure of the Constitution. In other words, the Parliament can amend any provision of the Constitution except the basic features of the Constitution. This was ruled by the Supreme Court in the Kesavananda Bharati Case 2*1, 1973. 24 Kesavananda Bharati vs. State of Kerala, 1973. 31 Judicial powers and functions. The judicial powers and functions of the Parliament include the following. A. It can impeach the President for the violation of the Constitution. B. It can remove the Vice President from his office. C. It can recommend the removal of judges, including Chief Justice, of the Supreme Court and the High Courts, Chief Election Commissioner, State Election Commissioner and Comptroller and Auditor General to the President. D. It can punish its members or outsiders for the breach of its privileges or its contempt. 31 Electoral powers and functions. The Parliament participates in the election of the President, along with the state legislative assemblies, and elects the Vice President. The Lok Sabha elects its Speaker and Deputy Speaker, while the Rajya Sabha elects its Deputy Chairman. The Parliament is also authorized to make laws to regulate the elections to the offices of President and Vice President, to both the Houses of Parliament and to both the Houses of State Legislature. Accordingly, Parliament enacted the Presidential and Vice Presidential Elections Act, 1952, the Representation of the People Act, 1950, the Representation of the People Act, 1951, etc. Parliament M. 259. QI Other powers and functions. The various other powers and functions of the Parliament include: A. It serves as the highest deliberative body in the country. It discusses various issues of national and international significance. B. It approves all the three types of emergencies, national, state, and financial, proclaimed by the President. C. It can create or abolish the state legislative councils on the recommendation of the concerned state legislative assemblies. D. It can increase or decrease the area, alter the boundaries, and change the names of states of the Indian Union. E. It can regulate the organization and jurisdiction of the Supreme Court and High Courts and can establish a common High Court for two or more states. Ineffectiveness of parliamentary control incurred by the executive. Thus, they do post-mortem work. G. The increased recourse to guillotine reduced the scope of financial control. H. The growth of delegated legislation has reduced the role of Parliament in making detailed laws and has increased the powers of bureaucracy. I. The frequent promulgation of ordinances by the President dilutes the Parliament's power of legislation. J. The Parliament's control is sporadic, general, and mostly political in nature. K. Lack of strong and steady opposition in the Parliament and a setback in the parliamentary behavior and ethics have also contributed to the ineffectiveness of legislative control over administration in India. T. Position of Rajya Sabha. The constitutional position of the Rajya Sabha as compared with the Lok Sabha can be studied from three angles. 1. Where Rajya Sabha is equal to Lok Sabha. 2. Where Rajya Sabha is unequal to Lok Sabha. 3. Where Rajya Sabha has special powers that are not at all shared with the Lok Sabha. Equal status with Lok Sabha in the following matters. The powers and status of the Rajya Sabha are equal to that of the Lok Sabha. 1. Introduction and passage of ordinary bills. 2. Introduction and passage of constitutional amendment bills. 3. Introduction and passage of financial bills involving expenditure from the Consolidated Fund of India. 4. Election and impeachment of the President. 5. Election and removal of the Vice President. However, Rajya Sabha alone can initiate the removal of the Vice President. PESA is removed by a resolution. The parliamentary control over government and administration in India is more theoretical than practical. In reality, the control is not as effective as it ought to be. The following factors are responsible for this. A. The Parliament has neither time nor expertise to control the administration, which has grown in volume as well as complexity. B. Parliament's financial control is hindered by the technical nature of the demands for grants. The parliamentarians, being laymen, cannot understand them properly and fully. C. The legislative leadership lies with the executive, and it plays a significant role in formulating policies. D. The very size of the Parliament is too large and unmanageable to be effective. E. The majority support enjoyed by the executive in the Parliament reduces the possibility of effective criticism. F. The financial committees like Public Accounts Committee examines the public expenditure after it has been 260 or Indian Polity. Passed by the Rajya Sabha by an effective majority and agreed to by the Lok Sabha by a simple majority. 6. Making recommendation to the President for the removal of Chief Justice and judges of Supreme Court and High Courts, Chief Election Commissioner and Comptroller and Auditor General. 7. Approval of ordinances issued by the President. 8. Approval of proclamation of all three types of emergencies by the President. 9. Selection of ministers including the Prime Minister. Under the Constitution, the ministers including the Prime Minister can be members of either house. However, irrespective of their membership, they are responsible only to the Lok Sabha. 10. Consideration of the reports of the constitutional bodies like Finance Commission, Union Public Service Commission, Comptroller and Auditor General, etc. 11. Enlargement of the jurisdiction of the Supreme Court and the Union Public Service Commission. Unequal status with Lok Sabha in the following matters. The powers and status of the Rajya Sabha are unequal to that of the Lok Sabha. 1. A money bill can be introduced only in the Lok Sabha and not in the Rajya Sabha. 2. Rajya Sabha cannot amend or reject a money bill. It should return the bill to the Lok Sabha within 14 days, either with recommendations or without recommendations. 3. The Lok Sabha can either accept or reject all or any of the recommendations of the Rajya Sabha. In both the cases, the money bill is deemed to have been passed by the two houses. 4. A financial bill, not containing solely the matters of Article 110, also can be introduced only in the Lok Sabha and not in the Rajya Sabha. But with regard to its passage, both the houses have equal powers. 5. The final power to decide whether a particular bill is a money bill or not is vested in the Speaker of the Lok Sabha. 6. The Speaker of Lok Sabha presides over the joint sitting of both the houses. 7. The Lok Sabha with greater number wins the battle in a joint sitting except when the combined strength of the ruling party in both the houses is less than that of the opposition parties. 8. Rajya Sabha can only discuss the budget but cannot vote on the demands for grants, which is the exclusive privilege of the Lok Sabha. 9. A resolution for the discontinuance of the national emergency can be passed only by the Lok Sabha and not by the Rajya Sabha. 10. The Rajya Sabha cannot remove the Council of Ministers by passing a no-confidence motion. This is because the Council of Ministers is collectively responsible only to the Lok Sabha. But the Rajya Sabha can discuss and criticize the policies and activities of the government. Special powers of Rajya Sabha. The Rajya Sabha has been given 4 exclusive or special powers that are not enjoyed by the Lok Sabha. 1. It can authorize the Parliament to make a law on a subject enumerated in the State List, Article 249. 2. It can authorize the Parliament to create new All India services common to both the centre and states, Article 312. 3. It alone can initiate a move for the removal of the Vice President. In other words, a resolution for the removal of the Vice President can be introduced only in the Rajya Sabha and not in the Lok Sabha, Article 67. 4. If a proclamation is issued by the President for imposing national emergency or President's rule or financial emergency at a time when the Lok Sabha has been dissolved or the dissolution of the Lok Sabha takes place within the period allowed for its approval, then the proclamation can remain effective even if it is approved by the Rajya Sabha alone, Articles 352, 356 and 360. An analysis of the above points makes it clear that the position of the Rajya Sabha in our constitutional system is not as weak as that of the House of Lords in the British constitutional system nor as strong as that of the Senate in the American constitutional system. Except in financial matters and control over the Council of Ministers, the powers and status of the Rajya Sabha in all other spheres are broadly equal and coordinate with that of the Lok Sabha. Even though the Rajya Sabha has been given less powers as compared with the Lok Sabha, its utility is supported on the following grounds. 1. It checks hasty, defective, careless, and ill-considered legislation made by the Lok Sabha by making provision of revision and thought. 2. It facilitates giving representation to eminent professionals and experts who cannot face the direct election. The President nominates 12 such persons to the Rajya Sabha. 3. It maintains the federal equilibrium by protecting the interests of the states against the undue interference of the center. Parliamentary privileges. Meaning parliamentary privileges are special rights, immunities, and exemptions enjoyed by the two houses of Parliament, their committees, and their members. They are necessary in order to secure the independence and effectiveness of their actions. Without these privileges, the houses can neither maintain their authority, dignity, and honor nor can protect their members from any obstruction in the discharge of their parliamentary responsibilities. The Constitution has also extended the parliamentary privileges to those persons. Parliament 261. Who are entitled to speak and take part in the proceedings of a House of Parliament or any of its committees. These include the Attorney General of India and Union Ministers. It must be clarified here that the parliamentary privileges do not extend to the President, who is also an integral part of the Parliament. Classification. Parliamentary privileges can be classified into 2 broad categories. 1. Those that are enjoyed by each House of Parliament collectively, and 2. Those that are enjoyed by the members individually. Collective privileges. The privileges belonging to each House of Parliament collectively are: 1. It has the right to publish its reports, debates, and proceedings, and also the right to prohibit others from publishing the same. The 44th Amendment Act of 1978 restored the freedom of the press to publish true reports of parliamentary proceedings without prior permission of the House. But this is not applicable in the case of a secret sitting of the House. 2. It can exclude strangers from its proceedings and hold secret sittings to discuss some important matters. 3. It can make rules to regulate its own procedure and the conduct of its business and to adjudicate upon such matters. 4. It can punish members as well as outsiders for breach of its privileges or its contempt by reprimand, admonition or imprisonment, also suspension or expulsion, in case of members. 25. 25 inches 1977, the 6th Lok Sabha expelled Mrs. Indira Gandhi from its membership and sentenced her to jail for a week for committing a contempt of House while she was Prime Minister. But the 7th Lok Sabha rescinded the resolution expelling her by describing it as politically motivated. In 1990, a former minister, K.K. Tiwari, was reprimanded by the Rajya Sabha. 262p Indian Polity. 5. It has the right to receive immediate information of the arrest, detention, conviction, imprisonment, and release of a member. 6. It can institute inquiries and order the attendance of witnesses and send for relevant papers and records. 7. The courts are prohibited to inquire into the proceedings of a House or its committees. 8. No person, either a member or outsider, can be arrested, and no legal process, civil or criminal, can be served within the precincts of the House without the permission of the presiding officer. Individual privileges. The privileges belonging to the members individually are: 1. They cannot be arrested during the session of Parliament and 40 days before the beginning and 40 days after the end of a session. This privilege is available only in civil cases and not in criminal cases or preventive detention cases. 2. They have freedom of speech in Parliament. No member is liable to any proceedings in any court for anything said or any vote given by him or in Parliament or its committees. This freedom is subject to the provisions of the Constitution and to the rules and standing orders regulating the procedure of Parliament. 26.3. They are exempted from jury service. They can refuse to give evidence and appear as a witness in a case pending in a court when Parliament is in session. 27m.n. Call and S.L. Schachter, Practice and Procedure of Parliament, 1st edition, p. 157. 28 Thomas Erskine May, Parliamentary Practice, 15th edition, p. 109. 29 Subhash C. Kashyap, Our Parliament, National Bookfest, 1999 edition, p. 241. 30 Thomas Erskine May, Parliamentary Practice, 16th edition, p. 43. 2.5 Article 121 of the Constitution says that no discussion shall take place in Parliament with respect to the conduct of any judge of the Supreme Court or of a High Court in the discharge of his duties except upon a motion for presenting an address to the President praying for the removal of the judge. Under Rules 349 to 350 of the Lok Sabha, use of unparliamentary language or unparliamentary conduct of a member is prohibited. Breach of privilege and contempt of the House. When any individual or authority disregards or attacks any of the privileges, rights, and immunities, either of the member individually or of the House in its collective capacity, the offense is termed as breach of privilege and is punishable by the House. 27 Any act or omission which obstructs a House of Parliament, its member or its officer in the performance of their functions or which has a tendency, directly or indirectly, to produce results against the dignity, authority, and honor of the House is treated as a contempt of the House. 28 Though the two phrases, breach of privilege and contempt of the House, are used interchangeably, they have different implications. Normally, a breach of privilege may amount to contempt of the House. Likewise, contempt of the House may include a breach. 3H of privilege also. Contempt of the House, however, has wider implications. There may first a contempt of the House without specific why committing a breach of privilege. 29.8 Larly, actions which are not breaches of J specific privilege but are offenses again. A dignity and authority of the House amount to contempt of the House. 30 For example, disobedience to a legitimate order of the House is not a breach of privilege, but can be punished as contempt of the House. Sources of privileges. Originally, the Constitution, Article 105, expressly mentioned two privileges, that is, freedom of speech in Parliament and right Parliament 263. Of publication of its proceedings. With regard to other privileges, it provided that they were to be the same as those of the British House of Commons, its committees and its members on the date of its commencement, i.e., January 26, 1950, until defined by Parliament. The 44th Amendment Act of 1978 provided that the other privileges of each House of Parliament, its committees and its members are to be those which they had on the date of its commencement, i.e., June 20, 1979, until defined by Parliament. This means that the position with regard to other privileges remains same. In other words, the amendment has made only verbal changes by dropping a direct reference to the British House of Commons, without making any change in the implication of the provision. 31. The then Law Minister gave the following reason for dropping reference to the British House of Commons, that the original provision, there was no escape from it, had referred to the British House of Commons. Now a proud country like India would like to avoid making any reference to a foreign institution in its own solemn constitutional document. Therefore, this verbal change is being introduced so that there may not be any reference to a foreign institution. 32a.v. Dicey, Introduction to the Study of the Law of the Constitution, Macmillan, 1965 edition, pp. 39-40. It should be noted here that the Parliament, till now, has not made any special law to exhaustively codify all the privileges. They are based on 5 sources, namely, 1. Constitutional provisions. 2. Various laws made by Parliament. 3. Rules of both the houses. 4. Parliamentary conventions. And 5. Judicial interpretations. T. Sovereignty of Parliament. The doctrine of sovereignty of Parliament is associated with the British Parliament. Sovereignty means the supreme power within the state. That supreme power in Great Britain lies with the Parliament. There are no legal restrictions on its authority and jurisdiction. Therefore, the sovereignty of Parliament, parliamentary supremacy, is a cardinal feature of the British constitutional system. According to A.V. Dicey, the British jurist, this principle has 3 implications. 32.1. The Parliament can make, amend, substitute, or repeal any law. Dalal, a British political analyst, said, the British Parliament can do everything except make a woman a man and a man a woman. 2. The Parliament can make constitutional laws by the same procedure as ordinary laws. In other words, there is no legal distinction between the constituent authority and the legislative authority of the British Parliament. 3. The parliamentary laws cannot be declared invalid by the judiciary as being unconstitutional. In other words, there is no system of judicial review in Britain. The Indian Parliament, on the other hand, cannot be regarded as a sovereign body in the similar sense as there are legal restrictions on its authority and jurisdiction. The factors that limit the sovereignty of Indian Parliament are a written nature of the Constitution. The Constitution is the fundamental law of the land in our country. It has defined the authority and jurisdiction of all the 3 organs of the Union government and the nature of interrelationship between them. Hence, the Parliament has to operate within the limits prescribed by the Constitution. There is also a legal distinction between the legislative authority and the constituent authority of the Parliament. Moreover, to effect certain amendments to the Constitution, the ratification of half of the states is also required. In Britain, on the other hand, the Constitution is neither written nor there is anything like a fundamental law of the land. 264 Indian Polity FL Federal System of Government. India has a federal system of government with a constitutional division of powers between the Union and the states. Both have to operate within the spheres allotted to them. Hence, the lawmaking authority of the Parliament gets confined to the subjects enumerated in the Union list and concurrent list and does not extend to the subjects enumerated in the state list, except in 5 abnormal circumstances, and that too for a short period. Britain, on the other hand, has a unitary system of government and hence, all the powers are vested in the center. L system of judicial review. The adoption of an independent judiciary with the power of judicial review also restricts the supremacy of our Parliament. Both the Supreme Court and High Courts can declare the laws enacted by the Parliament as void and ultra vires, unconstitutional, if they contravene any provision of the Constitution. On the other hand, there is no system of judicial review in Britain. The British courts have to apply the parliamentary laws to specific cases, without examining their constitutionality, legality, or reasonableness. Of fundamental rights. The authority of the Parliament is also restricted by the incorporation of a code of justiciable fundamental rights under Part 3 of the Constitution. Article 13 prohibits the state from making a law that either takes away totally or abrogates in part a fundamental right. Hence, a parliamentary law that contravenes the fundamental rights shall be void. In Britain, on the other hand, there is no codification of justiciable fundamental rights in the Constitution. The British Parliament has also not made any law that lays down the fundamental rights of the citizens. However, it does not mean that the British citizens do not have rights. Though there is no charter guaranteeing rights, there is maximum liberty in Britain due to the existence of the rule of law. Therefore, even though the nomenclature and organizational pattern of our Parliament is similar to that of the British Parliament, there is a substantial difference between the two. The Indian Parliament is not a sovereign body in the sense in which the British Parliament is a sovereign body. Unlike the British Parliament, the authority and jurisdiction of the Indian Parliament are defined, limited, and restrained. In this regard, the Indian Parliament is similar to the American legislature, known as Congress. In USA also, the sovereignty of Congress is legally restricted by the written character of the Constitution, the federal system of government, the system of judicial review, and the Bill of Rights. Table 23.5 Allocation of seats in Parliament for states and union territories and seats reserved for SCs and STs in the Lok Sabha. S. No. States UTs no. Of seats in Rajya Sabha. No. Of seats in Lok Sabha. Reserved for the scheduled castes. Reserved for the scheduled tribes. 1. States. 1. Andhra Pradesh 1125-412. Arunachal Pradesh 12. 3. Assam 714-124. Bihar 1646-5. Chhattisgarh 511-14 Parliament. S. No. States UTs no. Of seats in Rajya Sabha. No. Of seats in Lok Sabha. Reserved for the scheduled castes. Reserved for the scheduled tribes. 6. Goa 12 or Gujarat 1126-248. Haryana 510-9 Himachal Pradesh 341. 10. Jharkhand 614-15L. Karnataka. 1228 S212. Kerala 922. 16. Meghalaya 1-2, __________ 2. 17. Mizoram 11, 1. 18. Nagaland 1-1. 19. Odisha 1021 3. 20. Punjab 713 4. 21. Rajasthan 1025 4. 22. Sikkim 1-1, J23. Tamil Nadu 1839 7. 24. Telangana 717 32. 25. Tripura 12-1. 26. Uttarakhand 351 dash. 27. Uttar Pradesh 3180 17. 28. West Bengal 1642 10 2. 1. Andaman and Nicobar 1. Islands 2. Chandigarh 1-1. 3. Dadra and Nagar Haveli and Daman and Diu 2-1. 4. Delhi, the national 371 capital territory of Delhi. 5. Lakshadweep 1-1D. Puducherry 1-1. 7. Jammu and Kashmir 4-5. 8. Ladakh 1-3. Nominated members 12. Total 245, 543, 8447 266 Indian Polity. Table 23.6 Durations of the Lok Sabha from first Lok Sabha to present Lok Sabha duration remarks. First 1952 to 1957 dissolved 38 days before expiry of its term. Second 1957 to 1962 dissolved 40 days before expiry of its term. Third 1962 to 1967 dissolved 44 days before expiry of its term. Fourth 1967 to 1970 dissolved 1 year and 79 days before expiry of its term. Fifth 1971 to 1977 term of the Lok Sabha was extended 2 times by 1 year at a time. However, the House was dissolved after having been in existence for a period of 5 years, 10 months and 6 days. Sixth 1977 to 1979 dissolved after having been in existence for a period of 2 years, 4 months, and 28 days. Seventh 1980 to 1984 dissolved 20 days before expiry of its term. Eighth 1985 to 1989 dissolved 48 days before expiry of its term. Ninth 1989 to 1991 dissolved after having been in existence for a period of 1 year, 2 months, and 25 days. 10th 1991 to 1996. 11th 1996 to 1997 dissolved after having been in existence for a period of 1 year, 6 months and 13 days. 12th 1998 to 1999 dissolved after having been in existence for a period of 1 year, 1 month and 4 days. 13th 1999 to 2004 dissolved 253 days before expiry of its term. 14th 2004 to 2009. 15th 2009 to 2014. 16th 2014 to 2019. 17th 2019 continuing. Table 23.7 Speakers of the Lok Sabha from first Lok Sabha to present Lok Sabha. A Lok Sabha name tenure remarks. First 1. Ganesh Vasudev Mavalankar 1952 to 1956 died. 2. Ananthasanam Iyengar 1956 to 1957. Second Ananthasanam Iyengar 1957 to 1962. Third Hukam Singh 1962 to 1967. Fourth 1. Neelam Sanjeev Reddy 1967 to 1969, resigned. 2. Gurdi I Singh Dhillon 1969 to 1971. Fifth 1. Gurdi I Singh Dhillon 1971 to 1975, resigned. 2. Bali Rambhagat 1976 to 1977 Parliament M. 267. Lok Sabha name tenure remarks. Sixth 1. Neelam Sanjeev Reddy 1977 to 1977, resigned. 2. K.S. Hegde 1977 to 1980. 7th Bulram Jukkar 1980 to 1985. 8th Bulram Jukkar 1985 to 1989. 9th Rabi Ray 1989 to 1991. 10th Shivraj Patil 1991 to 1996. 17th Om Birla 2019, tilt date. 11th PA Sangama 1996 to 1998. 12th GMC Balayoji 1998 to 1999. 13th 1. GMC Balayoji 1999 to 2002, died. 2. Manohar Joshi 2002 to 2004. 14th Somnath Chatterjee 2004 to 2009. 15th Ms. Meera Kumar 2009 to 2014. 16th Ms. Sumitra Mahajan 2014 to 2019. Continued. Table 23.8 Articles related to Parliament at a glance. Article No. Subject Matter. General. 79. Constitution of Parliament. 80. Composition of the Council of States. 81. Composition of the House of the People. 82. Readjustment after each census. 83. Duration of Houses of Parliament. 84. Qualification for membership of Parliament. 85. Sessions of Parliament, prorogation and dissolution. 86. Right of President to address and send messages to Houses. 87-foot special address by the President. 88. Rights of Ministers and Attorney General as respects Houses. Officers of Parliament. 89. The Chairman and Deputy Chairman of the Council of States. 90. Vacation and resignation of, and removal from, the office of Deputy Chairman. 268 Indian Polity. I Article No. Subject Matter. 91. Power of the Deputy Chairman or other person to perform the duties of the office of, or to act as, Chairman. 92. The Chairman or the Deputy Chairman not to preside while a resolution for his removal from office is under consideration. 93. The Speaker and Deputy Speaker of the House of the People. 94. Vacation and resignation of, and removal from, the offices of Speaker and Deputy Speaker. 95. Power of the Deputy Speaker or other person to perform the duties of the office of, or to act as, Speaker. 96. The Speaker or the Deputy Speaker not to preside while a resolution for his removal from office is under consideration. 97. Salaries and allowances of the Chairman and Deputy Chairman and the Speaker and Deputy Speaker. 98. Secretariat of Parliament. Conduct of business. 99. Oath or affirmation by members. 100. Voting in Houses, power of Houses to act notwithstanding vacancies and quorum. Disqualifications of members. 101. Vacation of seats. 102. Disqualifications for membership. 103. Decision on questions as to disqualifications of members. 104. Penalty for sitting and voting before making oath or affirmation under Article 99 or when not qualified or when disqualified. Powers, privileges, and immunities of Parliament and its members. 105. Powers, privileges, etc. of the Houses of Parliament and of the members and committees thereof. 106. Salaries and allowances of members. Legislative procedure. 107. Provisions as to introduction and passing of bills. 108. Joint sitting of both houses in certain cases. 109. Special procedure in respect of money bills. 110. Definition of money bills. 111. Assent to bills. Procedures in financial matters. 112. Annual financial statement. 113. Procedure in Parliament with respect to estimates Parliament. 114. Appropriation Bills I 1151. Supplementary, additional or excess grants. 116. Votes on account, votes of credit and exceptional grants. 117. Special provisions as to financial bills. Procedure generally. 118. Rules of procedure. 119. Regulation by law of procedure in Parliament in relation to financial business. 120. Language to be used in Parliament. 121. Restriction on discussion in Parliament. 122. Courts not to inquire into proceedings of Parliament. Legislative powers of the President. 123. Power of President to promulgate ordinances during recess of Parliament. Scan the QR code to access the conceptual video on role of Parliament and its limitations and other important topics on EDGE Chapter 24 Parliamentary Committees. T meaning. The Parliament is too unwieldy a body to deliberate effectively the issues that come up before it. The functions of the Parliament are varied, complex, and voluminous. Moreover, it neither has adequate time nor necessary expertise to make a detailed scrutiny of all legislative measures and other matters. Therefore, it is assisted by a number of committees in the discharge of its duties. The Constitution of India makes a mention of these committees at different places, but without making any specific provisions regarding their composition, tenure, functions, etc. All these matters are dealt by the rules of two houses. Accordingly, a parliamentary committee means a committee that 1. Is appointed or elected by the House or nominated by the Speaker-Chairman. 2. Works under the direction of the Speaker-Chairman. 3. Presents its report to the House or to the Speaker-Chairman. 4. Has a secretariat provided by the Lok Sabha Rajya Sabha. The consultative committees, which also consist of members of Parliament, are not parliamentary committees as they do not fulfill above 4 conditions. T. Classification. Broadly, parliamentary committees are of 2 kinds, standing committees and ad hoc committees. The former are permanent, constituted every year or periodically, and work on a continuous basis, while the latter are temporary and cease to exist on completion of the task assigned to them. Standing committees on the basis of the nature of functions performed by them. Standing committees can be classified into the following 6 categories. 1. Financial committees. A. Public Accounts Committee. B. Estimates Committee. C. Committee on Public Undertakings. 2. Department-related standing committees. 24. 3. Committees to inquire. A. Committee on Petitions. B. Committee of Privileges. C. Ethics Committee. 4. Committees to scrutinize and control. A. Committee on Government Assurances. B. Committee on Subordinate Legislation. C. Committee on Papers laid on the ICBL. D. Committee on Welfare of SCs and S1KE. Committee on Empowerment of Women. F. Joint Committee 1 on Offices of Profit. 1A Joint Committee consists of members of both the Houses of Parliament. 5. Committees relating to the day-to-day business of the House. A. Business Advisory Committee. B. Committee on Private Members' Bills and Resolutions. C. Rules Committee. D. Committee on Absence of Members from the Sittings of the House. 6. Housekeeping Committees or Service Committees, i.e., committees concerned with the provision of facilities and services to members. A. General Purposes Committee. B. House Committee. C. Library Committee. D. Joint Committee on Salaries and Allowances of Members of Parliament. Ad hoc committees. Ad hoc committees can be divided into two categories, that is, inquiry committees and advisory committees. 1. Inquiry committees are constituted from time to time, either by the two houses on a motion adopted in that behalf, or by the Speaker Chairman, to inquire into and report on specific subjects. For example, A. Railway Convention Committee. 2. B. Committee on Members of Parliament Local Area Development Scheme, PLADS. C. Joint Committee on Security and Parliament Complex. D. Committee on Provision of Computers to Members of Parliament, Offices of Political Parties and Officers of the Lok Sabha Secretariat. E. Committee on Food Management and Parliament House Complex. F. Committee on Installation of Portrait Statues of National Leaders and Parliamentarians in Parliament House Complex. The Railway Convention Committee, 1949, was the first committee after independence. This committee and subsequent committees confined themselves to determining the rate of dividend payable by the railways to general revenues. Since 1971, the Railway Convention Committee has been taking up subjects which have a bearing on the working of the railways and railway finances. Parliamentary Committees. M271. G. Joint Committee on Maintenance of Heritage Character and Development of Parliament House Complex. H. Committee on Violation of Protocol Norms and Contemptuous Behavior of Government Officers with Members of Lok Sabha. I. Committee on Welfare of Other Backward Classes. J. Committee to inquire into the improper conduct of a member. 2. Advisory committees include select or joint committees on bills, which are appointed to consider and report on particular bills. These committees are distinguishable from the other ad hoc committees in as much as they are concerned with bills, and the procedure to be followed by them is laid down in the rules of procedure and the directions by the Speaker Chairman. When a bill comes up before a House for general discussion, it is open to that House to refer it to a select committee of the House or a joint committee of the two Houses. A motion to this effect has to be moved and adopted in the House in which the bill comes up for consideration. In case the motion adopted is for reference of the bill to a joint committee, the decision is conveyed to the other House, requesting the members to nominate members of the other House to serve on the committee. The select or joint committee considers the bill clause by clause just as the two Houses do. Amendments to various clauses can be moved by members of the committee. The committee can also take evidence of associations, public bodies, or experts who are interested in the bill. After the bill has thus been considered, the committee submits its report to the House. Members who do not agree with the majority report may append their minutes of dissent to the report. T. Financial Committees. Public Accounts Committee. This committee was set up first in 1921 under the provisions of the Government of India Act 272 Indian Polity of 1919 and has since been in existence. At present, it consists of 22 members, 15 from the Lok Sabha and 7 from the Rajya Sabha. The members are elected by the Parliament every year from amongst its members according to the principle of proportional representation by means of the single transferable vote. Thus, all parties get due representation in it. The term of office of the members is 1 year. A minister cannot be elected as a member of the committee. The chairman of the committee is appointed from amongst its members by the Speaker. Until 1966-67, the chairman of the committee belonged to the ruling party. However, since 1967 a convention has developed whereby the chairman of the committee is selected from the opposition. The function of the committee is to examine the annual audit reports of the Comptroller and Auditor General of India, CAG, which are laid before the Parliament by the President. The CAG submits 3 audit reports to the President, namely, Audit Report on Appropriation Accounts, Audit Report on Finance Accounts, and Audit Report on Public Undertakings. The committee examines public expenditure not only from legal and formal point of view to discover technical irregularities but also from the point of view of economy, prudence, wisdom, and propriety to bring out the cases of waste, loss, corruption, extravagance, inefficiency, and nugatory expenses. In more detail, the functions of the committee are 1. To examine the appropriation accounts and the finance accounts of the Union government and any other accounts laid before the Lok Sabha. The appropriation accounts compare the actual expenditure with the expenditure sanctioned by the Parliament through the Appropriation Act, while the finance account shows the annual receipts and disbursements of the Union government. 2. In scrutinizing the appropriation accounts and the audit report of CAG on it, the committee has to satisfy itself that a. The money that has been disbursed was legally available for the applied service or purpose. b. The expenditure conforms to the authority that governs it. c. Every reappropriation has been made in accordance with the related rules. 3. To examine the accounts of state corporations, trading concerns, and manufacturing projects and the audit report of CAG on them, except those public undertakings which are allotted to the Committee on Public Undertakings. 4. Examine the accounts of autonomous and semi-autonomous bodies, the audit of which is conducted by the CAG. 5. LB. Consider the report of the CAG relating to the audit of any receipt or to examine the accounts of stores and stocks. 6. LB. Examine the money spent on any service during a financial year in excess of the amount granted by the Lok Sabha for that purpose in the fulfillment of the above functions. The committee is assisted by the CAG. In fact, the CAG acts as a guide, friend, and philosopher of the committee. On the role played by the committee, Ashok Chanda, who himself has been a CAG of India, observed, over a period of years, the committee has entirely fulfilled the expectation that it should develop into a powerful force in the control of public expenditure. It may be claimed that the traditions established and conventions developed by the Public Accounts Committee conform to the highest traditions of a parliamentary democracy. 3. Ashok Chanda, Indian Administration, George Allen and Unwin Ltd., London, 1967, p. 180. However, the effectiveness of the role of the committee is limited by the following. A. It is not concerned with the questions of policy in broader sense. B. It conducts a post-mortem examination of accounts, showing the expenditure already incurred. C. It cannot intervene in the matters of day-to-day administration. D. Its recommendations are advisory and not binding on the ministries. E. It is not vested with the power of disallowance of expenditures by the departments. F. It is not an executive body and hence cannot issue an order. Only the Parliament can take a final decision on its findings. Estimates Committee. The origin of this committee can be traced to the Standing Financial Committee set up in 1921. The first Estimates Committee in the post-independence era was constituted in 1950 on the recommendation of John Mackay, the then finance minister. Originally, it had 25 members, but in 1956 its membership was raised to 30. All the 30 members are from Lok Sabha only. The Rajya Sabha has no representation in this committee. These members are elected by the Lok Sabha every year from amongst its own members, according to the principles of proportional representation by means of a single transferable vote. Thus, all parties get due representation in it. The term of office is 1 year. A minister cannot be elected as a member of the committee. The chairman of the committee is appointed by the speaker amongst its members and Husha is generally from the ruling party. The function of the committee is to examine the estimates included in the budget and suggest economies in public expenditure. Hence, it has been described as a continuous economy committee. In more detail, the functions of the committee are 1. LB report what economies, improvements in organization, efficiency, and administrative reform consistent with the policy underlying the estimates can be effected. 2. LB suggest alternative policies in order to bring about efficiency and economy in administration. 3. IB examine whether the money is well laid out within the limits of the policy implied in the estimates. 4. LB suggests the form in which the estimates are to be presented to Parliament. J. The committee shall not exercise its functions in relation to such public undertakings as are allotted to the Committee on Public Undertakings. Parliamentary Committees. LJJ 273. The committee may continue the examination of the estimates from time to time, throughout the financial year, and report to the House as its examination proceeds. It shall not be incumbent on the committee to examine the entire estimates of any 1 year. The demands for grants may be finally voted despite the fact that the committee has made no report. However, the effectiveness of the role of the committee is limited by the following. A. It examines the budget estimates only after they have been voted by the Parliament, and not before that. B. It cannot question the policy laid down by the Parliament. C. Its recommendations are advisory and not binding on the ministries. D. It examines every year only certain selected ministries and departments. Thus, by rotation, it would cover all of them over a number of years. E. It lacks the expert assistance of the CAG which is available to the Public Accounts Committee. F. Its work is in the nature of a postmortem. Committee on Public Undertakings. This committee was created in 1964 on the recommendation of the Krishna Menon Committee. Originally, it had 15 members, 10 from the Lok Sabha and 5 from the Rajya Sabha. However, in 1974, its membership was raised to 22, 15 from the Lok Sabha and 7 from the Rajya Sabha. The members of this committee are elected by the Parliament every year from amongst its own members according to the principle of proportional representation by means of a single transferable vote. Thus, all parties get due representation in it. The term of office of the members is 1 year. A minister cannot be elected as a member of the committee. The chairman of the committee is appointed by the speaker from amongst its members. The functions of the committee are 1. TB examine the reports and accounts of public undertakings. Indian Polity. 2. ID examine the reports of the Comptroller and Auditor General on public undertakings. 3. LB examine, in the context of autonomy and efficiency of public undertakings, whether the affairs of the public undertakings are being managed in accordance with sound business principles and prudent commercial practices. 4. 7b exercise such other functions vested in the Public Accounts Committee and the Estimates Committee in relation to public undertakings which are allotted to it by the Speaker from time to time. The committee is not to examine and investigate any of the following. Matters of major government policy as distinct from business or commercial functions of the public undertakings. 2. Matters of day-to-day administration. 3. Matters for the consideration of which machinery is established by any special statute under which a particular public undertaking is established. Further, the effectiveness of the role of the committee is limited by the following. A. It cannot take up the examination of more than 10 to 12 public undertakings in a year. B. Its work is in the nature of a postmortem. C. It does not look into technical matters as its members are not technical experts. D. Its recommendations are advisory and not binding on the ministries. Department-related standing committees. On the recommendation of the Rules Committee of the Lok Sabha, 17 department-related standing committees, DRSCs, were set up in the Parliament in 1993. In 2004, 7 more such committees were set up, thus increasing their number from 17 to 24. For L in 1989, 3 DRSCs were constituted which dealt with agriculture, science and technology, and environment and forests. In 1993, they were superseded by the department-related standing committees, DRSCs. The main objective of the DRSCs is to secure more accountability of the executive, i.e., the Council of Ministers, to the Parliament, particularly financial accountability. They also assist the Parliament in debating the budget more effectively. The 24 DRSCs cover under their jurisdiction all the ministries' departments of the central government. Each DRSC consists of 31 members, 21 from Lok Sabha and 10 from Rajya Sabha. The members of the Lok Sabha are nominated by the Speaker from amongst its own members, just as the members of the Rajya Sabha are nominated by the Chairman from amongst its members. 6A minister is not eligible to be nominated as a member of any of the DRSCs. In case a member, after his nomination to any of the DRSCs, is appointed a minister, his then ceases to be a member of the committee. The term of office of each DRSC is 1 year from the date of its constitution. While inaugurating the DRSC system in the Central Hall of Parliament on March 31, 1993, the then Vice President of India and the Chairman of Rajya Sabha, K.R. Narayanan, observed that the main purpose of these committees is to ensure the accountability of government to Parliament through more detailed consideration of measures in these committees. The intention is not to weaken or criticize the administration but to strengthen it by investing it with more meaningful parliamentary support. 6 till 13th Lok Sabha, each DRSC consisted of not more than 45 members. 30 to be nominated by the Speaker from amongst the members of Lok Sabha and 15 to be nominated by the Chairman from amongst the members of Rajya Sabha. However, with restructuring of DRSCs in July 2004, each DRSC consists of 31 members, 21 from Lok Sabha and 10 from Rajya Sabha. Out of the 24 DRSCs, 8 work under the Rajya Sabha and 16 under the Lok Sabha. The 24 DRSCs in the ministries' departments placed under their jurisdiction are shown below in BLE 24.1. The functions of each of the DRSCs are 1. To consider the demands for grants of the concerned ministries' departments before they are discussed and voted in the Lok Sabha. Its report should not parliamentary committees 275. Table 24.1 Department-related standing committees and their jurisdiction. SI. No. Name of the committees ministries' departments covered. I. Committees under Rajya Sabha. 1. Committee on Commerce and Industry. 2. Committee on Home Affairs. 1. Home Affairs. 2. Development of Northeastern Region. 3. Committee on Education, Women, Children, Youth and Sports. 1. Education. 2. Youth Affairs and Sports. 3. Women and Child Development. 4. Committee on Industry. 1. Heavy Industries. 2. Micro, Small and Medium Enterprises. 5. Committee on Science and Technology, Environment, Forest and Climate Change. 1. Science and Technology. 2. Space. 3. Earth Sciences. 4. Atomic Energy. 5. Environment, Forest and Climate Change. 6. Committee on Transport, Tourism and Culture. 1. Civil Aviation. 2. Road Transport and Highways. 3. Ports, Shipping and Waterways. 4. Culture. 5. Tourism. 7. Committee on Health and Family Welfare. 1. Health and Family Welfare. 2. Ayurveda, Yoga and Naturopathy, Unani, Siddha and Homeopathy, AYUSH. 8. Committee on Personnel, Public Grievances, Law and Justice. 1. Law and Justice. 2. Personnel, Public Grievances and Pensions. 2. Committees under Lok Sabha. 9. Committee on Agriculture, Animal Husbandry and Food Processing. 1. Agriculture and Farmers' Welfare. 2. Fisheries, Animal Husbandry and Dairying. 3. Food Processing Industries. 4. Cooperation. 10. Committee on Communications and Information Technology. 1. Communications. 2. Electronics and Information Technology. 3. Information and Broadcasting. 11. Committee on Defense. 12. Committee on Energy. 1. New and Renewable Energy. 2. Power. 13. Committee on External Affairs. 14. Committee on Finance. 1. Finance. 2. Corporate Affairs. 3. Planning, Niti Aayog. 4. Statistics and Program Implementation. 15. Committee on Consumer Affairs, Food and Public Distribution. Consumer Affairs, Food and Public Distribution. 276 Indian Polity. 21. Committee on Chemicals and Fertilizers. SI. No. Name of the committee's ministries' departments covered. 16. Committee on Labor, Textiles, and Skill Development. 1. Labor and Employment. 2. Textiles. 3. Skill Development and Entrepreneurship. 17. Committee on Petroleum and Natural Gas. Petroleum and Natural Gas. 18. Committee on Railways. 19. Committee on Housing and Urban Affairs. Housing and Urban Affairs. 20. Committee on Water Resources. Jal Shakti. 22. Committee on Rural Development and Panchayati Raj. Chemicals and Fertilizers. 1. Rural Development. 2. Panchayati Raj. 23. Committee on Coal, Mines and Steel. 1. Coal. 2. Mines. 3. Steel. 24. Committee on Social Justice and Empowerment. 1. Social Justice and Empowerment. 2. Tribal Affairs. 3. Minority Affairs. Suggest anything of the nature of cut motions. 2. TB. Examine bills pertaining to the concerned ministries' departments. 3. LB. Consider annual reports of ministries' departments. 4. LB. Consider national basic long-term policy documents presented to the Houses. The following limitations are imposed on the functioning of these DRSCs. I. They should not consider the matters of day-to-day administration of the concerned ministries' departments. 2. They should not generally consider the matters which are considered by other parliamentary committees. It should be noted here that the recommendations of these committees are advisory in nature and hence not binding on the Parliament. The following procedure shall be followed by each of the DRSCs in their consideration of the demands for grants and making a report thereon to the Houses. A. After general discussion on the budget in the Houses is over, the Houses shall be adjourned for a fixed period. B. The committee shall consider the demands for grants of the concerned ministries during the aforesaid period. C. The committee shall make their report within the period and shall not ask for more time. D. The demands for grants shall be considered by the House in the light of the reports of the committees. E. There shall be a separate report on the demands for grants of each ministry. The following procedure shall be followed by each of the DRSCs in examining the bills and making report thereon. A. The committee shall consider the general principles and clauses of bills referred to it. B. The committee shall consider only such bills as introduced in either of the Houses and referred to it. C. The committee shall make report on bills in a given time. The merits of the DRSC system in the Parliament are: 1. Their proceedings are devoid of any party bias. 2. The procedure adopted by them is more flexible than in the Lok Sabha. 3. The system makes parliamentary control over executive much more detailed, close, continuous, in-depth, and comprehensive. 4. The system ensures economy and efficiency in public expenditure as the ministries' departments would now be more careful in formulating their demands. 5. They facilitate opportunities to all the members of Parliament to participate and understand the functioning of the government and contribute to it. 6. They can avail of expert opinion or public opinion to make the reports. They are authorized to invite experts and eminent persons to testify before them and incorporate their opinions in their reports. 7. The opposition parties and the Rajya Sabha can now play a greater role in exercising financial control over the executive. The DRSC system has influenced the functioning of the executive in a significant manner. The recommendations made by the DRSCs have been of immense importance. It has been found that the ministries' department within the purview of these committees have been quite receptive to their recommendations and have, by and large, accepted them and initiated suitable action for their implementation. There have been very few instances where the ministries' departments have convincingly expressed their inability to implement the recommendations of the Committee's 7 Committee System in Rajya Sabha. An Introduction, Rajya Sabha Secretariat, 2003, pp. 29-30. 8. IBID. The DRSCs have made parliamentary debates better informed by nourishing the information supply system. The effectiveness of these committees can be judged on 4 yardsticks, namely, I. Their success in holding officials to account, 2. Publication of information, 3. Their effect on the House and the wider public, and 4. Their parliamentary committees, 277. Influence on government's decisions. Going by any of the criteria, one can emphatically say that DRSCs have proved their worth. The activities of these committees have created a corpus of knowledge for members of the Parliament and public, which otherwise would not have been possible. The discussion and debates in such committees and the reports they produce further sharpen government policies. 8. T. Committees. To inquire. Committee on Petitions. This committee examines petitions on bills and on matters of general public importance. It also entertains representations from individuals and associations on matters pertaining to union subjects. The Lok Sabha Committee consists of 15 members, while the Rajya Sabha Committee consists of 10 members. Committee of Privileges. The functions of this committee are semi-judicial in nature. It examines the cases of breach of privileges of the House and its members and recommends appropriate action. The Lok Sabha Committee has 15 members, while the Rajya Sabha Committee has 10 members. Ethics Committee. This committee was constituted in Rajya Sabha in 1997 and in Lok Sabha in 2000. It enforces the code of conduct of members of Parliament. It examines the cases of misconduct and recommends appropriate action. Thus, it is engaged in maintaining discipline and decorum in Parliament. The Lok Sabha Committee has 15 members, while the Rajya Sabha Committees has 10 members. 278 Indian Polity. Committees to scrutinize and control. Committee on Government Assurances. This committee examines the assurances, promises, and undertakings given by ministers from time to time on the floor of the House and reports on the extent to which they have been carried through. In the Lok Sabha, it consists of 15 members, and in the Rajya Sabha, it consists of 10 members. It was constituted in 1953. Committee on Subordinate Legislation. This committee examines and reports to the House whether the powers to make regulations, rules, sub-rules, and bylaws delegated by the Parliament or conferred by the Constitution to the Executive are being properly exercised by it. In both the Houses, the committee consists of 15 members. It was constituted in 1953. Committee on Papers Laid on the Table. This committee was constituted in 1975. The Lok Sabha Committee has 15 members, while the Rajya Sabha Committee has 10 members. It examines all papers laid on the table of the House by ministers to see whether they comply with provisions of the Constitution or the related act or rule. It does not examine statutory notifications and orders that fall under the jurisdiction of the Committee on Subordinate Legislation. Committee on Welfare of SCs and STs. This committee consists of 30 members, 20 from Lok Sabha and 10 from Rajya Sabha. Its functions are: I. To consider the reports of the National Commission for the SCs and the National Commission for the STK. 2. To examine all matters relating to the welfare of SCs and STK, like implementation of constitutional and statutory safeguards, working of welfare programs, etc. Committee on Empowerment of Women. This committee was constituted in 1997 and consists of 30 members, 20 from Lok Sabha and 10 from Rajya Sabha. It considers the reports of the National Commission for Women and examines the measures taken by the Union government to secure status, dignity, and equality for women in all fields. Joint Committee on Offices of Profit. This committee examines the composition and character of committees and other bodies appointed by the central, state, and union territory governments and recommends whether persons holding these offices should be disqualified from being elected as members of Parliament or not. It consists of 15 members, 10 from Lok Sabha and 5 from Rajya Sabha. T. Committees relating to the day-to-day business of the House. Business Advisory Committee. This committee regulates the program and timetable of the House. It allocates time for the transaction of legislative and other business brought before the House by the government. The Lok Sabha Committee consists of 15 members, including the Speaker as its chairman. In the Rajya Sabha, it has 11 members, including the chairman as its ex officio chairman. Committee on Private Members' Bills and Resolutions. This committee classifies bills and allocates time for the discussion on bills and resolutions introduced by private members, other than ministers. This is a special committee of the Lok Sabha and consists of 15 members, including the Deputy Speaker as its chairman. The Rajya Sabha does not have any such committee. The same function in the Rajya Sabha is performed by the Business Advisory Committee of that House. Rules Committee. This committee considers the matters of procedure and conduct of business in the House and recommends necessary amendments or additions to the rules of the House. The Lok Sabha Committee consists of 15 members, including the Speaker as its ex officio chairman. In the Rajya Sabha, it consists of 16 members, including the chairman as its ex officio chairman. Committee on Absence of Members from the Sittings of the House. This committee considers all applications from members for leave of absence from the sittings of the House and examines the cases of members who have been absent for a period of 60 days or more without permission. It is a special committee of the Lok Sabha and consists of 15 members. There is no such committee in the Rajya Sabha, and all such matters are dealt by the House itself. T. Housekeeping Committees. General Purposes Committee. This committee considers and advises on matters concerning affairs of the House, which do not fall within the jurisdiction of any other parliamentary committee. In each House, this committee consists of the presiding officer, Speaker Chairman, as its ex officio chairman, Deputy Speaker, Deputy Chairman in the case of Rajya Sabha, members of Panel of Chairpersons. Panel of Vice Chairpersons in the case of Rajya Sabha, chairpersons of all the departmental standing committees of the House, leaders of recognized parties and groups in the House, and such other members as nominated by the presiding officer. House Committee. This committee deals with residential accommodation of members and other amenities. Parliamentary Committees M279. Like food, medical aid, etc. Accorded to them in their houses and hostels in Delhi. Both the houses have their respective House Committees. In the Lok Sabha, it consists of 12 members. In the Rajya Sabha, it consists of 10 members. Library Committee. This committee considers all matters relating to Library of the Parliament and assists the members in utilizing the library services. It consists of 9 members, 6 from Lok Sabha and 3 from Rajya Sabha. Joint Committee on Salaries and Allowances of Members of Parliament. This committee was constituted under the Salary, Allowances and Pension of Members of Parliament Act, 1954. It consists of 15 members, 10 from Lok Sabha and 5 from Rajya Sabha. It frames rules for regulating payment of salary, allowances, and pension to members of Parliament. F. Consultative committees. Consultative committees are attached to various ministries, departments of the central government. They consist of members of both the Houses of Parliament. The Minister of State in charge of the ministry concerned acts as the chairman of the consultative committee of that ministry. These committees provide a forum for informal discussions between the ministers and the members of Parliament on policies and programs of the government and the manner of their implementation. These committees are constituted by the Ministry of Parliamentary Affairs. The guidelines regarding the composition, functions, and procedures of these committees are formulated by this ministry. The ministry also makes arrangements for holding their meetings both during the session and the intersession period of Parliament. 280 Indian Polity. The membership of these committees is voluntary and is left to the choice of the members and the leaders of their parties. The maximum membership of a committee is 30 and the minimum is 10. These committees are constituted after a new Lok Sabha is constituted, after general elections for the Lok Sabha. In other words, these committees shall stand dissolved upon dissolution of every Lok Sabha and shall be reconstituted upon constitution of each Lok Sabha. In addition, separate informal consultative committees of the members of Parliament are also constituted for all the railway zones. The members of Parliament belonging to the area falling under a particular railway zone are nominated on the informal consultative committee of that railway zone. Group. Chapter 25 Indian Parliamentary. T. Rationale of the IPG MN Call and SL Schachter have nicely explained the rationale of the Indian Parliamentary Group, IPG, in the following way. The establishment and development of relations among parliaments constitutes part of the regular activities of national parliaments. Although promotion of interparliamentary relations has for many years been a significant part of the work of parliamentarians, recently it has received a new thrust due to the increased interdependence of nations in a global environment. It is imperative that parliamentarians will join hands to safeguard democracy and work in synergy to confront the challenges before the world and convert them into opportunities to facilitate peace and prosperity in their countries as well as globally. 1. The concerned motion was adopted on August 16, 1948. For a member or ex-member of Parliament can become a life member of the IPG on payment of a fixed life subscription. Interparliamentary relations thus assume great importance today when the whole world is beset with many pressing problems. The problems that are faced by one parliament today may confront another tomorrow. It is, therefore, essential that a link should exist between various payments of the world. This link is EATJJ India through the IR Eng of CTE G Jots, goodwill missions, correspondence, documents, etc. With foreign parliaments through the machinery of the IPG that acts both as the national group of the Interparliamentary Union, IPU, and also as the India branch of the Commonwealth Parliamentary Association, CPA. 2. MN Call and SL Schachter, Practice and Procedure of Parliament, Lok Sabha Secretariat, 6th edition 2009, p. 1160. Ibid. F. Composition of the IPG. The IPG is an autonomous body. It was formed in the year 1949 in pursuance of a motion adopted by the Constituent Assembly, Legislative. 3. The membership of IPG is open to all members of Parliament. The former members of Parliament can also become associate members of the IPG. But the associate members are entitled to limited rights only. They are not entitled to representation at meetings and conferences of the IPU and the CPA. They are also not entitled to the travel concessions provided to members by certain branches of the CPA. The Speaker of the Lok Sabha is the ex officio president of the IPG. The Deputy Speaker of the Lok Sabha and the Deputy Chairman of the Rajya Sabha are the ex officio vice presidents of the IPG. The Secretary General of the Lok Sabha acts as the ex officio Secretary General of the IPG. T. Objectives of the IPG. The aims and objects of the IPG are mentioned below. 1. TB promote personal contact between members of the Parliament of India. 2. TB study questions of public importance that are likely to come up before the Parliament. Arrange seminars, $282 Indian Polity, discussions and orientation courses, and bring out publications for the dissemination of information to the members of the IPG. 3. LB arrange lectures on political, defense, economic, social, and educational problems by the members of the Parliament and distinguished persons. 4. To arrange visits to foreign countries with a view to develop contacts with members of other parliaments. F. Functions of the IPG. The various functions performed and activities undertaken by the IPG are as follows. 1. The IPG acts as a link between the Parliament of India and the various parliaments of the world. This link is maintained through the exchange of delegations, goodwill missions, correspondence, documents, etc. with foreign parliaments. 2. The IPG functions as the A. National group of the IPU and B. Main branch of the CPA in India. 3. Addresses to the members of the Parliament by visiting heads of state and government of foreign countries and talks by eminent persons are arranged under the auspices of the IPG. 4. Seminars and symposia on parliamentary subjects of topical interest are organized periodically at national as well as international level. 5. Members of the IPG, when visiting abroad, are given letters of introduction to the secretaries of the national groups of the IPU and secretaries of the CPA branches. The Indian missions in the countries of visit are also suitably informed so as to enable them to get assistance and usual courtesies. 6. Only those members of the Parliament who were members of the IPG of at least 6 months standing at the time of the composition of the delegation may be included in the Indian parliamentary delegations to foreign countries. 7. An uninterrupted flow of information to members regarding the activities of the IPG is maintained through the IPG newsletter brought out every quarter. It is sent regularly to all members of the IPG, including associate members. 8. As per the decision of the IPG, an award of outstanding parliamentarian was instituted in the year 1995 to be given annually. A committee of 5 persons, constituted by the Speaker of the Lok Sabha, invites and finalizes the nomination for the award. Parliamentary friendship groups underscore 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 to encourage bilateral relations. The IPG constitutes parliamentary friendship groups (PFGs) with other countries in the Indian Parliament. Each PFG consists of sitting members of Parliament, both from the Lok Sabha and the Rajya Sabha. The Speaker of the Lok Sabha appoints the president of each PFG. The management and control of all affairs of the PFGs vest in the IPG. The meetings of the PFGs are arranged on the sidelines of visiting foreign parliamentary friendship groups committees delegations. These meetings are held within the Parliament House complex. The aims and objectives of the PFGs are mentioned below. 1. To maintain political, economic, social, and cultural contact between the two countries. 2. LB create favorable conditions for continuous development of interparliamentary contents, especially in the organization of talks, mutual exchanges, and cooperation between the two parliaments. 3. LB assist in having exchanges of information and experiences on issues related to parliamentary activities. 4. LB promote cooperation between the delegations of the two countries while participating in the deliberations of international organizations and also in carrying out consultations on issues of mutual interest. 5. LB increase ties between the member countries. F. The IPG and IPU 5. 5 Handbook for Members of Lok Sabha, 15th edition, 2009, pp. 207-208. 6 Ibid, pp. 208-209. These are published by the CPA Secretariat, London. The IPU is an international organization of the parliaments of sovereign states. At present, the IPU consists of 179 parliaments of sovereign nations. Its aim is to work for peace and cooperation among peoples and for the firm establishment of representative institutions. It fosters contacts, coordination, and the exchange of experience among parliaments and parliamentarians of all member countries and contributes to better knowledge of the working of representative institutions. It also expresses its views on all burning questions of international importance for necessary effective implementation of parliamentary actions and suggests avenues for improving the working standard and capacity of international institutions. The main advantages of membership of the IPG, insofar as its functions as the national group of the IPU are concerned, are as follows. 1. It helps members of the Indian parliamentary delegations to develop contacts with the parliamentarians of the member countries of the IPU. 2. The events provide an opportunity to study and understand contemporary changes reforms taking place in various countries of the world. 3. It provides facilities to meet parliamentarians in different countries during tours and abroad. 4. The members of the IPG are eligible to visit foreign countries as members of the Indian parliamentary delegations to interparliamentary conferences. Further, members of the IPG have been holding various positions in the IPU bodies. Indian Parliamentary Group M283. Namely, office bearers in different committees of the IPU, rapporteurs, chairmen of drafting committees, etc. And by virtue of the same, the IPG has been successful in putting forward effectively the viewpoint of India on various important issues dealt in the IPU meetings. T. The IPG and CPA 6. The CPA is an association of about 17,000 parliamentarians and parliamentary staff spread over 180 national, state, provincial and territorial parliaments and legislatures in 53 Commonwealth countries. Its aims are to promote knowledge and understanding of the constitutional, legislative, economic, social and cultural systems within a parliamentary democratic framework with particular reference to the countries of the Commonwealth of Nations and to countries having close historical and parliamentary associations with it. Its mission is to promote the advancement of parliamentary democracy by enhancing knowledge and understanding of democratic governance and by building an informed parliamentary community able to deepen the Commonwealth's democratic commitment and to further cooperation among its parliaments and legislatures. The main advantages of membership of the IPG, insofar as its functions as the main branch of the CPA in India are concerned, are as follows. 1. Conferences and seminars. Membership provides an opportunity for participation in the plenary and regional conferences, seminars, visits, and exchanges of delegations. 2. Publications. All members of the IPG are entitled to receive, free of charge, the Parliamentarian Quarterly and the newsletter, First Reading, every second month. 7284 Indian Polity. 3. Information. The Parliamentary Information and Reference Center of the CPA Secretariat provides information to members on parliamentary, constitutional, and Commonwealth matters. 4. Introductions. The CPA branches readily assist in arranging introductions for members visiting other jurisdictions. 5. Parliamentary facilities. Members visiting other Commonwealth countries are normally accorded parliamentary courtesies, especially access to debates and local members. 6. Travel facilities. Some branches provide for a designated number of their members annually to undertake study tours of Commonwealth and other countries to compare political and procedural developments. Other branches arrange ad hoc visits. Chapter 26. Supreme Court. Unlike the American Constitution, the Indian Constitution has established an integrated judicial system with the Supreme Court at the top and the high courts below it. Under a high court, and below the state level, there is a hierarchy of subordinate courts, that is, district courts and other lower courts. This single system of courts, adopted from the Government of India Act of 1935, enforces both central laws as well as the state laws. In USA, on the other hand, the federal laws are enforced by the federal judiciary and the state laws are enforced by the state judiciary. There is thus a double system of courts in USA, one for the center and the other for the states. LB sum up, India, although a federal country like the USA, has a unified judiciary and one system of fundamental law and justice. The Supreme Court of India was inaugurated on January 28, 1950. It succeeded the Federal Court of India, established under the Government of India Act of 1935. However, the jurisdiction of the Supreme Court is greater than that of its predecessor. This is because the Supreme Court has replaced the British Privy Council as the highest court of appeal. 1. Before 1950, the British Privy Council had the jurisdiction to hear appeals from India. Articles 124 to 147 in Part 5 of the Constitution deal with the organization, independence, jurisdiction, powers, procedures, and so on of the Supreme Court. The Parliament is also authorized to regulate them. Composition and appointment. At present, the Supreme Court consists of 34 judges, 1 Chief Justice and 33 other judges. Originally, the strength of the Supreme Court was fixed at 8, 1 Chief Justice and 7 other judges. The Parliament has increased this number of other judges progressively to 10 in 1956, to 13 in 1960, to 17 in 1977, to 25 in 1986, to 30 in 2008, and to 33 in 2019. The various acts relating to the composition of the Supreme Court are summarized in Table 26.2. Appointment of judges. The judges of the Supreme Court are appointed by the President. The Chief Justice is appointed by the President after consultation with such judges of the Supreme Court and High Courts as Husha deems necessary. The other judges are appointed by President after consultation with the Chief Justice and such other judges of the Supreme Court and the High Courts as Husha deems necessary. The consultation with the Chief Justice is obligatory in the case of appointment of a judge other than Chief Justice. Controversy over consultation. The Supreme Court has given different interpretation of the word consultation in the above provision. In the first judge's case 1 inch 1981, the court held that consultation does not mean concurrence. Loss. P. Gupta vs. Union of India, 1981. 286, Indian Polity. And it only implies exchange of views. But, in the second judge's case 11 foot, 1993, the court reversed its earlier ruling and changed the meaning of the word consultation to concurrence. Hence, it ruled that the advice tendered by the Chief Justice of India is binding on the President in the matters of appointment of the judges of the Supreme Court. But, the Chief Justice would tender Husha advice on the matter after consulting 2 of Husha's senior-most colleagues. Similarly, in the third judge's case *2, 1998, the court opined that the consultation process to be adopted by the Chief Justice of India requires consultation of plurality judges. The sole opinion of the Chief Justice of India does not constitute the consultation process. Husha should consult a collegium of 4 senior-most judges of the Supreme Court, and even if 2 judges give an adverse opinion, Husha should not send the recommendation to the government. The court held that the recommendation made by the Chief Justice of India without complying with the norms and requirements of the consultation process are not binding on the government. B. Supreme Court Advocates on Record Association vs. Union of India, 1993. 2 inches Re-Presidential Reference, 1998. The President sought the Supreme Court's opinion, under Article 143, on certain doubts over the consultation process to be adopted by the Chief Justice of India as stipulated in the 1993 case. Supreme Court Advocates on Record Association vs. Union of India, 2015. The 99th Constitutional Amendment Act of 2014 and the National Judicial Appointments Commission Act of 2014 have replaced the collegium system of appointing judges to the Supreme Court and High Courts with a new body called the National Judicial Appointments Commission, NJC. However, in 2015, the Supreme Court has declared both the 99th Constitutional Amendment as well as the NJC Act as unconstitutional and void. Consequently, the earlier collegium system became operative again. This verdict was delivered by the Supreme Court in the 4th Judge's Case 2-1-2015. The court opined that the new system, i.e., NJC, would affect the independence of the judiciary. Appointment of Chief Justice from 1950 to 1973, the practice has been to appoint the senior-most judge of the Supreme Court as the Chief Justice of India. This established convention was violated in 1973 when A.N. Ray was appointed as the Chief Justice of India by superseding 3 senior judges. 3 again in 1977, M.U. Beg was appointed as the Chief Justice of India by superseding the then senior-most judge. This discretion of the government was curtailed by the Supreme Court in the second judge's case, 1993, in which the Supreme Court ruled that the senior-most judge of the Supreme Court should alone be appointed to the office of the Chief Justice of India. Qualifications, oath and salaries. Qualifications of judges. A person to be appointed as a judge of the Supreme Court should have the following qualifications. 1. Pisha should be a citizen of India. 2. A. Pisha should have been a judge of a high court or high courts in succession for 5 years. Or B. Pisha should have been an advocate of a high court or high courts in succession for 10 years. Or C. Pisha should be a distinguished jurist in the opinion of the President. From the above, it is clear that the Constitution has not prescribed a minimum age for appointment as a judge of the Supreme Court. A.N. Ray was 4th in seniority. The 3 superseded judges were J.M. Sheelat, K.S. Legda, and A.N. Grover. All the 3 judges resigned from the Supreme Court. They were superseded due to their judgment in Kesavananda Bharti case, 1973, which was not favorable to the government. For he was H.R. Khanna, and he too resigned. His dissenting judgment upholding the right to life even during emergency in the ADM Jabalpur vs. Shawkant Shtikla case, 1976, was not appreciated by the government. Supreme Court 287. Oath or affirmation. A person appointed as a judge of the Supreme Court, before entering upon his or her office, has to make and subscribe an oath or affirmation before the President, or some person appointed by him or her for this purpose. In his or her oath, a judge of the Supreme Court swears, 1. To bear true faith and allegiance to the Constitution of India. 2. To uphold the sovereignty and integrity of India. 3. To duly and faithfully, and to the best of his or her ability, knowledge and judgment perform the duties of the office without fear or favor, affection or ill will. And 4. To uphold the Constitution and the laws. Salaries and allowances. The salaries, allowances, privileges, leave and pension of the judges of the Supreme Court are determined from time to time by the Parliament. They cannot be varied to their disadvantage after their appointment except during a financial emergency. In 2018, the salary of the Chief Justice was increased from lakh to 2.80 lakh per month, and that of a judge from 90,000 to 2.50 lakh per month. 5. They are also paid sumptuary allowance and provided with free accommodation and other facilities like medical, car, telephone, etc. 5 inches 1950, their salaries were fixed at 5,000 per month and 4,000 per month respectively. In 1986, their salaries were raised to 10,000 per month and 9,000 per month respectively. In 1998, their salaries were raised to 33,000 per month and 30,000 per month respectively. In 2009, their salaries were raised to 1 lakh per month and 90,000 per month respectively. 6. The word impeachment is not used in the Constitution in relation to the removal of judges. However, it is used only in the case of the removal of the President. The retired Chief Justice and judges are entitled to 50% of their last drawn salary as monthly pension. F. Tenure and removal. Tenure of judges. The Constitution has not fixed the tenure of a judge of the Supreme Court. However, it makes the following 3 provisions in this regard. 1. Husha holds office until Husha attains the age of 65 years. Any question regarding his or her age is to be determined by such authority and in such manner as provided by Parliament. 2. Husha can resign from his or her office by writing to the President. 3. Husha can be removed from his or her office by the President on the recommendation of the Parliament. Removal of judges. A judge of the Supreme Court can be removed from his or her office by an order of the President. The President can issue the removal order only after an address by Parliament has been presented to him or her in the same session for such removal. The address must be supported by a special majority of each House of Parliament, i.e., a majority of the total membership of that House and a majority of not less than 2/3 of the members of that House present and voting. The grounds of removal are 2. Proved misbehavior or incapacity. The Judges' Inquiry Act, 1968, regulates the procedure relating to the removal of a judge of the Supreme Court by the process of impeachment. 6. 1. A removal motion signed by 100 members, in the case of Lok Sabha, or 50 members, in the case of Rajya Sabha, is to be given to the Speaker Chairman. 2. The Speaker Chairman may admit the motion or refuse to admit it. 3. If it is admitted, then the Speaker Chairman is to constitute a 3-member committee to investigate into the charges. 4. The committee should consist of A. The Chief Justice or a judge of the Supreme Court, B. A Chief Justice of a High Court, and C. A distinguished jurist. $288 Indian Polity. 5. If the committee finds the judge to be guilty of misbehavior or suffering from an incapacity, the House can take up the consideration of the motion. 6. After the motion is passed by each House of Parliament by special majority, an address is presented to the President for removal of the judge. 7. Finally, the President passes an order removing the judge. It is interesting to know that no judge of the Supreme Court has been impeached so far. The first case of impeachment is that of Justice V. Ramaswamy of the Supreme Court, 1991 to 1993. Though the Inquiry Committee found him or guilty of misbehavior, Husha could not be removed as the impeachment motion was defeated in the Lok Sabha. The Congress Party abstained from voting. Acting, ad hoc, and retired judges. Acting Chief Justice. The President can appoint a judge of the Supreme Court as an acting Chief Justice of India when 1. The office of Chief Justice of India is vacant, or 2. The Chief Justice of India is temporarily absent, or 3. The Chief Justice of India is unable to perform the duties of his office. Ad hoc judge. When there is a lack of quorum of the permanent judges to hold or continue any session of the Supreme Court, the Chief Justice of India can appoint a judge of a high court as an ad hoc judge of the Supreme Court for a temporary period. Husha can do so only after consultation with the Chief Justice of the High Court concerned and with the previous consent of the President. The judge so appointed should be qualified for appointment as a judge of the Supreme Court. It is the duty of the judge so appointed to attend the sittings of the Supreme Court, in priority to other duties of his office. While so attending, Husha enjoys all the jurisdiction, powers and privileges, and discharges the duties of a judge of the Supreme Court. Retired judge. At any time, the Chief Justice of India can request a retired judge of the Supreme Court or a retired judge of a high court, who is duly qualified for appointment as a judge of the Supreme Court, to act as a judge of the Supreme Court for a temporary period. Husha can do so only with the previous consent of the President and also of the person to be so appointed. Such a judge is entitled to such allowances as the President may determine. Husha will also enjoy all the jurisdiction, powers and privileges of a judge of Supreme Court. But Husha will not otherwise be deemed to be a judge of the Supreme Court. Seat and procedure. Seat of Supreme Court. The Constitution declares Delhi as the seat of the Supreme Court. But it also authorizes the Chief Justice of India to appoint other place or places as seat of the Supreme Court. Husha can take decision in this regard only with the approval of the President. This provision is only optional and not compulsory. This means that no court can give any direction either to the President or to the Chief Justice to appoint any other place as a seat of the Supreme Court. Procedure of the court. The Supreme Court can, with the approval of the President, make rules for regulating generally the practice and procedure of the court. The constitutional cases or references made by the President under Article 143 are decided by a bench consisting of at least 5 judges. All other cases are decided by single judges and division benches. The judgments are delivered by the open court. All judgments are by majority vote, but if differing, then judges can give dissenting judgments or opinions. Supreme Court. 289. Independence of Supreme Court. The Supreme Court has been assigned a very significant role in the Indian democratic political system. It is a federal court, the highest court of appeal, the guarantor of the fundamental rights of the citizens and guardian of the Constitution. Therefore, its independence becomes very essential for the effective discharge of the duties assigned to it. It should be free from the encroachments, pressures, and interferences of the Executive Council of Ministers and the Legislature, Parliament. It should be allowed to do justice without fear or favor. The Constitution has made the following provisions to safeguard and ensure the independent and impartial functioning of the Supreme Court. 1. Mode of appointment. The judges of the Supreme Court are appointed by the President, which means the Cabinet, in consultation with the members of the Judiciary itself, i.e., judges of the Supreme Court and the High Courts. This provision curtails the absolute discretion of the executive as well as ensures that the judicial appointments are not based on any political or practical considerations. 2. Security of tenure. The judges of the Supreme Court are provided with the security of tenure. They can be removed from office by the President only in the manner and on the grounds mentioned in the Constitution. This means that they do not hold their office during the pleasure of the President, though they are appointed by him or her. This is obvious from the fact that no judge of the Supreme Court has been removed or impeached so far. 3. Fixed service conditions. The salaries, allowances, privileges, leave and pension of the judges of the Supreme Court are determined from time to time by the Parliament. They cannot be changed to their disadvantage after their appointment except during a financial emergency. Thus, the conditions of service of the judges of the Supreme Court remain same during their term of office. 4. Expenses charged on consolidated fund. The salaries, allowances and pensions of the judges and the staff as well as all the administrative expenses of the Supreme Court are charged on the Consolidated Fund of India. Thus, they are non-votable by the Parliament, though they can be discussed by it. 5. Conduct of judges cannot be discussed. The Constitution prohibits any discussion in Parliament or in a state legislature with respect to the conduct of the judges of the Supreme Court in the discharge of their duties, except when an impeachment motion is under consideration of the Parliament. 6. Ban on practice. After retirement, the retired judges of the Supreme Court are prohibited from pleading or acting in any court or before any authority within the territory of India. This ensures that they do not favor anyone in the hope of future favor. 7. Power to punish. For its contempt, the Supreme Court can punish any person for its contempt. Thus, its actions and decisions cannot be criticized and opposed by anybody. This power is vested in the Supreme Court to maintain its authority, dignity, and honor. 8. Freedom to appoint its staff. The Chief Justice of India can appoint officers and servants of the Supreme Court without any interference from the executive. Husha can also prescribe their conditions of service. 9. Its jurisdiction cannot be curtailed. The Parliament is not authorized to curtail the jurisdiction and powers of the Supreme Court. The Constitution has guaranteed to the Supreme Court jurisdiction of various kinds. However, the Parliament can extend the same. 290 Indian Polity. Jurisdiction and powers of Supreme Court. The Constitution has conferred a very extensive jurisdiction and vast powers on the Supreme Court. It is not only a federal court like the American Supreme Court, but also a final court of appeal like the British House of Lords, the upper house of the British Parliament. It is also the final interpreter and guardian of the Constitution and guarantor of the fundamental rights of the citizens. Further, it has advisory and supervisory powers. Therefore, Aladi Krishnaswamy Iyer, a member of the drafting committee of the Constituent Assembly, rightly remarked, "The Supreme Court of India has more powers than any other Supreme Court in any part of the world." The jurisdiction and powers of the Supreme Court can be classified into the following. 1. Original jurisdiction. 2. Writ jurisdiction. 3. Appellate jurisdiction. 4. Advisory jurisdiction. 5. A court of record. 6. Power of judicial review. 7. Constitutional interpretation. 8. Other powers. IW, original jurisdiction. As a federal court, the Supreme Court decides the disputes between different units of the Indian Federation. More elaborately, any dispute, A, between the center and one or more states, or B, between the center and any state or states on one side and one or more other states on the other side, or C, between two or more states. In the above federal disputes, the Supreme Court has exclusive original jurisdiction. Exclusive means no other court can decide such disputes, and original means the power to hear such disputes in the first instance, not by way of appeal. With regard to the exclusive original jurisdiction of the Supreme Court, 2 points should be noted. 1. The dispute must involve a question, whether of law or fact, on which the existence or extent of a legal right depends. Thus, the questions of political nature are excluded from it. 2. Any suit brought before the Supreme Court by a private citizen against the center or a state cannot be entertained under this. Further, this jurisdiction of the Supreme Court does not extend to the following. A dispute arising out of any treaty, agreement, covenant, engagement, sanad, or other similar instrument which, having been entered into or executed before the commencement of the Constitution, continues in operation after such commencement, or which provides that the said jurisdiction shall not extend to such a dispute. B. Interstate river water disputes. C. Matters referred to the Finance Commission. D. Adjustment of certain expenses and pensions between the center and the states. In 1961, the first suit, under the original jurisdiction of the Supreme Court, was brought by West Bengal against the center. The state government challenged the constitutional validity of the Coal-Bearing Areas, Acquisition and Development Act, 1957, passed by the Parliament. However, the Supreme Court dismissed the suit by upholding the validity of the act. Outright jurisdiction. The Constitution has constituted the Supreme Court as the guarantor and defender of the fundamental rights of the citizens. The Supreme Court is empowered to issue writs. The Interstate River Water Disputes Act of 1956 has excluded the original jurisdiction of the Supreme Court in disputes between states with respect to the use, distribution, or control of the water of interstate river or river valley, including habeas corpus, mandamus, prohibition, quo warranto, and certiorari for the enforcement of the fundamental rights of an aggrieved citizen. In this regard, the Supreme Court has original jurisdiction in the sense that an aggrieved citizen can directly go to the Supreme Court, not necessarily by way of appeal. However, the writ jurisdiction of the Supreme Court is not exclusive. The high courts are also empowered to issue writs for the enforcement of the fundamental rights. It means, when the fundamental rights of a citizen are violated, the aggrieved party has the option of moving either the High Court or the Supreme Court directly. Therefore, the original jurisdiction of the Supreme Court with regard to federal disputes is different from its original jurisdiction with regard to disputes relating to fundamental rights. In the first case, it is exclusive, and in the second case, it is concurrent with High Court's jurisdiction. Moreover, the parties involved in the first case are units of the Federation, center, and states, while the dispute in the second case is between a citizen and the government, central or state. There is also a difference between the writ jurisdiction of the Supreme Court and that of the High Court. The Supreme Court can issue writs only for the enforcement of the fundamental rights and not for other purposes. The High Court, on the other hand, can issue writs not only for the enforcement of the fundamental rights but also for other purposes. It means that the writ jurisdiction of the High Court is wider than that of the Supreme Court. But the Parliament can confer on the Supreme Court the power to issue writs for other purposes also. Q. Appellate jurisdiction. As mentioned earlier, the Supreme Court has not only succeeded the Federal Court of India but also replaced the British Privy Council as the highest court of appeal. The Supreme Court is primarily a court of appeal and hears appeals against the judgments of the High Supreme Court. 291. Courts. It enjoys a wide appellate jurisdiction which can be classified under four heads. A. Appeals in constitutional matters. B. Appeals in civil matters. C. Appeals in criminal matters. D. Appeals by special leave. A. Constitutional matters and the constitutional cases. An appeal can be made to the Supreme Court against the judgment of a High Court if the High Court certifies that the case involves a substantial question of law that requires the interpretation of the Constitution. Based on the certificate, the party in the case can appeal to the Supreme Court on the ground that the question has been wrongly decided. B. Civil matters and civil cases. An appeal lies to the Supreme Court from any judgment of a High Court if the High Court certifies I. That the case involves a substantial question of law of general importance, and 2. That the question needs to be decided by the Supreme Court. Originally, only those civil cases that involved a sum of not less than $20,000 could be appealed before the Supreme Court. But this monetary limit was removed by the 30th Constitutional Amendment Act of 1972. C. Criminal matters. The Supreme Court hears appeals against the judgment in a criminal proceeding of a High Court if the High Court I. has on appeal reversed an order of acquittal of an accused person and sentenced him or her to death. Or 2. Has taken before itself any case from any subordinate court and convicted the accused person and sentenced him or her to death. Or 3. Certifies that the case is a fit one for appeal to the Supreme Court. In the first two cases, an appeal lies to the Supreme Court as a matter of right, i.e., without any certificate of the High Court. But if the High Court has reversed the order of conviction and has ordered the acquittal of the accused, there is no right to appeal to the Supreme Court. $292 Indian Polity. In 1970, the Parliament had enlarged the criminal appellate jurisdiction of the Supreme Court. Accordingly, an appeal lies to the Supreme Court from the judgment of a High Court if the High Court I. has on appeal reversed an order of acquittal of an accused person and sentenced him or her to imprisonment for life or for 10 years. Or 2. Has taken before itself any case from any subordinate court and convicted the accused person and sentenced him or her to imprisonment for life or for 10 years. D. Appeal by special leave. The Supreme Court is authorized to grant in its discretion special leave to appeal from any judgment in any matter passed by any court or tribunal in the country, except military tribunal and court-martial. This provision contains the four aspects as under. I. It is a discretionary power and hence cannot be claimed as a matter of right. 2. It can be granted in any judgment whether final or interlocutory. 3. It may be related to any matter constitutional, civil, criminal, income tax, labor, revenue, advocates, etc. 4. It can be granted against any court or tribunal and not necessarily against a High Court, of course, except a military court. Thus, the scope of this provision is very wide and it vests the Supreme Court with a plenary jurisdiction to hear appeals. On the exercise of this power, the Supreme Court itself held that being an exceptional and overriding power, it has to be exercised sparingly and with caution and only in special extraordinary situations. Beyond that, it is not possible to fetter the exercise of this power by any set formula or rule. ESI Advisory Jurisdiction. The Constitution, Article 143, authorizes the President to seek the opinion of the Supreme Court in the two categories of matters. A. On any question of law or fact of public importance which has arisen or which is likely to arise. B. On any dispute arising out of any pre-Constitution treaty, agreement, covenant, engagement, sanad, or other similar instrument, which is excluded from the original jurisdiction of the Supreme Court. In the first case, the Supreme Court may tender or may refuse to tender its opinion to the President. But in the second case, the Supreme Court must tender its opinion to the President. In both the cases, the opinion expressed by the Supreme Court is only advisory and not a judicial pronouncement. Hence, it is not binding on the President. She may follow or may not follow the opinion. However, it facilitates the government to have an authoritative legal opinion on a matter to be decided by it. So far, the President has made 15 references to the Supreme Court under its advisory jurisdiction, also known as consultative jurisdiction. These are mentioned below in the chronological order. 1. Delhi Laws Act in 1951-2. Kerala Education Bill in 1958-3. Barabari Union in 1964. C. Customs Act in 1963-5. Keshav Singh's case relating to the privileges of the legislature in 1964-6. Presidential election in 1974-7. Special Courts Bill in 1978-8. Jammu and Kashmir Resettlement Act in 1982-9. Kaveri Water Disputes Tribunal in 1992-10. Ramajanina Bhumi case in 1993-11. Consultation process to be adopted by the Chief Justice of India in 1998. 12. Legislative competence of the Centre and States on the subject of natural gas and liquefied natural gas in 2001. 13. The constitutional validity of the Election Commission's decision on deferring the Gujarat Assembly elections in 2002. 14. Punjab Termination of Agreements Act in 2004. 15. 2G Spectrum case verdict in the mandatory auctioning of natural resources across all sectors in 2012. Supreme Court 293. 31A Court of Record. As a court of record, the Supreme Court has two powers. A. The judgments, proceedings, and acts of the Supreme Court are recorded for perpetual memory and testimony. These records are admitted to be of evidentiary value and cannot be questioned when produced before any court. They are recognized as legal precedents and legal references. B. It has power to punish for contempt of itself. In 1991, the Supreme Court has ruled that it has power to punish for contempt not only of itself but also of the courts, subordinate courts, and tribunals functioning in the entire country. Contempt of Courts Act, 1971. In 1961, the government appointed a special committee under the chairmanship of H. N. Sanya, the then Additional Solicitor General of India, to examine the law relating to the contempt of courts. This committee submitted its report in 1963. Based on the recommendations made by the committee, the Contempt of Courts Act, 1971 was enacted by the Parliament. Under the Act, the contempt of court may be civil or criminal. The civil contempt means willful disobedience to any judgment, order, writ, or other process of a court or willful breach of an undertaking given to a court. The criminal contempt, on the other hand, means the publication of any matter or doing an act which I. Scandalizes or lowers the authority of a court, or 2. Prejudices or interferes with the due course of a judicial proceeding, or 3. Interferes or obstructs the administration of justice in any other manner. However, innocent publication and distribution of matter, fair and accurate report of judicial proceedings, and fair criticism of judicial acts do not amount to contempt of court. Under the Act, a contempt of court is punishable with simple imprisonment for a term up to 6 months or with fine up to 2,000 or with both. The Act also provides that no court shall initiate any proceedings of contempt after the expiry of 1 year from the date on which the contempt is alleged to have been committed. Further, this Act is not applicable to contempt of Nyaya Panchayats or other village courts which have been established for the administration of justice. 31. Power of judicial review. Judicial review is the power of the Supreme Court to examine the constitutionality of legislative enactments and executive orders of both the central and state governments. On examination, if they are found to be violative of the Constitution, ultra vires, they can be declared as illegal, unconstitutional, and invalid, null and void, by the Supreme Court. Consequently, they cannot be enforced by the government. 31. Review jurisdiction. The Supreme Court has power to review any judgment pronounced or order made by it. A review petition has to be filed within 30 days from the date of the judgment or order sought to be reviewed. Also, the review petition should be submitted to the same judge or bench that delivered the judgment or order. Further, a review petition is allowed on the following grounds. I. Discovery of new and important matter or evidence. 2. Mistake or error apparent on the face of the record. 3. Any other sufficient reason. The court may either dismiss the review petition or direct notice to the opposite party. However, even after the dismissal of the review petition, the court can still reconsider its final judgment or order by way of a curative petition on limited grounds like I. Violation of the principles of natural justice. 2. Lb. Cure a gross miscarriage of justice. 294 Indian Polity. 3. Lb. Prevent abuse of the process of the court. 4. Bias of the judge. Constitutional interpretation. The Supreme Court is the ultimate interpreter of the Constitution. It can give final version to the spirit and content of the provisions of the Constitution and the verbiage used in the Constitution. While interpreting the Constitution, the Supreme Court is guided by a number of doctrines. In other words, the Supreme Court applies various doctrines in interpreting the Constitution. The important doctrines are mentioned below. 1. Doctrine of severability. 2. Doctrine of waiver. 3. Doctrine of eclipse. 4. Doctrine of territorial nexus. 5. Doctrine of pith and substance. 6. Doctrine of colorable legislation. 7. Doctrine of implied powers. 8. Doctrine of incidental and ancillary powers. 9. Doctrine of precedent. 10. Doctrine of occupied field. 11. Doctrine of prospective overruling. 12. Doctrine of harmonious construction. 13. Doctrine of liberal interpretation. ESI. Other powers. Besides the above, the Supreme Court has numerous other powers. A. It decides the disputes regarding the election of the president and the vice president. In this regard, it has the original, exclusive, and final authority. B. It inquires into the conduct and behavior of the chairman and members of the UPSC or SPSC or JSPSC on a reference made by the president. If it finds them guilty of misbehavior, it can recommend to the president for their removal. The advice tendered by the Supreme Court in this regard is binding on the president. C. It is authorized to withdraw the cases pending before the high courts and dispose them by itself. It can also transfer a case or appeal pending before one high court to another high court. D. Its law is binding on all courts in India. Its decree or order is enforceable throughout the country. All authorities, civil and judicial, in the country should act in aid of the Supreme Court. E. It has power of judicial superintendence and control over all the courts and tribunals functioning in the entire territory of the country. The Supreme Court's jurisdiction and powers with respect to matters in the Union List can be enlarged by the Parliament. Further, its jurisdiction and powers with respect to other matters can be enlarged by a special agreement of the Center and the states. Indian and American Supreme Courts compared. There are differences in the jurisdiction and powers of the Supreme Court of India and that of the Supreme Court of USA. These are summarized in FLE 26.1. Supreme Court 295. Table 26.1 comparing Indian and American Supreme Courts. Indian Supreme Court, American Supreme Court. 1. Its original jurisdiction is confined to federal cases. 1. Its original jurisdiction covers not only federal cases, but also cases relating to naval forces, maritime activities, ambassadors, etc. 2. Its appellate jurisdiction covers constitutional, civil, and criminal cases. 2. Its appellate jurisdiction is confined to constitutional cases only. 3. It has a very wide discretion to grant special leave to appeal in any matter against the judgment of any court or tribunal, except military. 3. It has no such plenary power. 4. It has advisory jurisdiction. 4. It has no advisory jurisdiction. 5. Its scope of judicial review is limited. 5. Its scope of judicial review is very wide. 6. It defends rights of the citizen according to the procedure established by law. 6. It defends rights of the citizen according to the due process of law. 7. Its jurisdiction and powers can be enlarged by Parliament. 7. Its jurisdiction and powers are limited to that conferred by the Constitution. 8. It has power of judicial superintendence and control over state high courts due to integrated judicial system. 8. It has no such power due to double or separated judicial system. Table 26.2 Acts relating to the composition of the Supreme Court. SI. No. Act, year, maximum number of judges fixed, excluding Chief Justice of India. Maximum number of judges fixed, including Chief Justice of India. 1. Article 124 of the Constitution 78I2, Supreme Court, Number of Judges, Act, 1956 1011. 3. Supreme Court, Number of Judges, Amendment Act, 1960. 1314. 4. Supreme Court, Number of Judges, Amendment Act, 1977. 1718. 5. Supreme Court, Number of Judges, Amendment Act, 1986. 2526. 6. Supreme Court, Number of Judges, Amendment Act, 2008. 3031. 7. Supreme Court, Number of Judges, Amendment Act, 2019. 3334. Note: Article 124(1) of the Constitution reads as follows: There shall be a Supreme Court of India consisting of a Chief Justice of India, and, until Parliament by law prescribes a larger number, of not more than 7 other judges. Table 26.3 Articles related to Supreme Court at a glance. 1 Article No. Subject Matter 124. Establishment and Constitution of Supreme Court. 124A. National Judicial Appointments Commission. 1248. Functions of Commission. 124C. Power of Parliament to make law. 125. Salaries, etc. of judges. 126. Appointment of Acting Chief Justice. 127. Appointment of ad hoc judges. 128. Attendance of retired judges at sittings of the Supreme Court. 129. Supreme Court to be a court of record. 130. Seat of Supreme Court. 131. Original jurisdiction of the Supreme Court. 131A. Exclusive jurisdiction of the Supreme Court in regard to questions as to constitutional validity of central laws, repealed. 132. Appellate jurisdiction of Supreme Court in appeals from high courts in certain cases. 133. Appellate jurisdiction of Supreme Court in appeals from high courts in regard to civil matters. 134. Appellate jurisdiction of Supreme Court in regard to criminal matters. 134A. Certificate for appeal to the Supreme Court. 135. Jurisdiction and powers of the federal court under existing law to be exercisable by the Supreme Court. 136. Special leave to appeal by the Supreme Court. 137. Review of judgments or orders by the Supreme Court. 138. Enlargement of the jurisdiction of the Supreme Court. 139. Conferment on the Supreme Court of powers to issue certain writs. 139A. Transfer of certain cases. 140. Ancillary powers of Supreme Court. 141. Law declared by Supreme Court to be binding on all courts. 142. enforcement of decrees and orders of Supreme Court and orders as to discovery, etc. 143. Power of President to consult Supreme Court. 144. Civil and judicial authorities to act in aid of the Supreme Court. 144a. Special provisions as to disposal of questions relating to constitutional validity of laws, repealed. 145. Rules of court, etc. 146. Officers and servants and the expenses of the Supreme Court. 147. Interpretation. Indian 298 JL Indian Polity. In a number of cases, the Supreme Court has pointed out the significance of the power of judicial review in our country. Some of the observations made by it, in this regard, are given below. In India, it is the Constitution that is supreme, and that a statute law to be valid must be in conformity with the constitutional requirements, and it is for the judiciary to decide whether any enactment is constitutional or not. Our Constitution contains express provisions for judicial review of legislation as to its conformity with the Constitution. This is especially true as regards the fundamental rights, to which the court has been assigned the role of sentinel on the qui-vive. As long as some fundamental rights exist and are a part of the Constitution, the power of judicial review has also to be exercised with a view to see that the guarantees afforded by these rights are not contravened. The Constitution is supreme lex, the permanent law of the land, and there is no branch of government above it. Every organ of government, be it the executive or the legislature or the judiciary, derives its authority from the Constitution, and it has to act within the limits of its authority. No one, however highly placed, and no authority howsoever lofty, can claim that it shall be the sole judge of the extent of its power under the Constitution, or whether its action is within the confines of such power laid down by the Constitution. This court is the ultimate interpreter of the Constitution, and to this court is assigned the delicate task of determining what is the power conferred on each branch of government, whether it is limited, and if so, what are the limits, and whether any action of that branch transgresses such limits? 2 Chief Justice Kania, in A.K. Gopalan vs. State of Madras, 1950. 3 Chief Justice Patanjali Shastri, in State of Madras vs. V.G. Rao, 1952. Justice Khanna, in Kesavananda Bharti vs. State of Kerala, 1973. 5 Justice Bhagwati, in State of Rajasthan vs. Union of India, 1977. It is the function of the judges, may their duty, to pronounce upon the validity of laws. If courts are totally deprived of that power, the fundamental rights conferred on the people will become a mere adornment, because rights without remedies are as rid in water. A controlled constitution will then become uncontrolled. The judges of the Supreme Court have been entrusted with the task of upholding the Constitution, and to this end, have been conferred the power to interpret it. It is they who have to ensure that the balance of power envisaged by the Constitution is maintained, and that the legislature and the executive do not, in the discharge of their functions, transgress constitutional limitations. 7. B. Chief Justice Chandrachud in Minerva Mills vs. Union of India, 1980. 7 Chief Justice Amadi in L. Chandra Kumar vs. Union of India, 1997. Justice Ramaswamy in S.S. Bola vs. B.D. Sharma, 1997. The Founding Fathers very wisely, therefore, incorporated in the Constitution itself the provisions of judicial review so as to maintain the balance of federalism, to protect the fundamental rights and fundamental freedoms guaranteed to the citizens, and to afford a useful weapon for availability, availment, and enjoyment of equality, liberty, and fundamental freedoms, and to help to create a healthy nationalism. The function of judicial review is a part of the constitutional interpretation itself. It adjusts the Constitution to meet new conditions and needs of the time. T. Constitutional provisions I for judicial review. Though the phrase judicial review has nowhere been used in the Constitution, the provisions of several articles explicitly confer the power of judicial review on the Supreme Court and the High Courts. These provisions are explained below. 1. Article 13 declares that all laws that are inconsistent with or in derogation of the fundamental rights shall be null and void. 2. Article 32 guarantees the right to move the Supreme Court for the enforcement of the fundamental rights and empowers the Supreme Court to issue directions or orders or writs for that purpose. 3. Article 131 provides for the original jurisdiction of the Supreme Court in interstate and interstate disputes. 4. Article 132 provides for the appellate jurisdiction of the Supreme Court in constitutional cases. 5. Article 133 provides for the appellate jurisdiction of the Supreme Court in civil cases. 6. Article 134 provides for the appellate jurisdiction of the Supreme Court in criminal cases. 7. Article 134 deals with the certificate for appeal to the Supreme Court from the High Courts. 9.8. Article 135 empowers the Supreme Court to exercise the jurisdiction and powers of the federal court under any pre-constitution law. 9. Article 136 authorizes the Supreme Court to grant special leave to appeal from any court or tribunal, except military tribunal and court-martial. 10. Article 143 authorizes the President to seek the opinion of the Supreme Court on any question of law or fact and on any pre-Constitution legal matters. 11. Article 226 empowers the High Courts to issue directions or orders or writs for the enforcement of the fundamental rights and for any other purpose. 12. Article 227 vests in the High Courts the power of superintendence over all courts and tribunals within their respective territorial jurisdictions, except military courts or tribunals. 13. Article 245 deals with the territorial extent of laws made by Parliament and by the legislatures of states. 9. This provision was added by the 44th Constitutional Amendment Act of 1978. 10. Sabha c. Kashyap, Our Constitution, National Book Test, 3rd edition, 2001, p. 232. Judicial Review M. 299. 14. Article 246 deals with the subject matter of laws made by Parliament and by the legislatures of states, i.e., Union List, State List, and Concurrent List. 15. Articles 251 and 254 provide that in case of a conflict between the central law and state law, the central law prevails over the state law, and the state law shall be void. 16. Article 372 deals with the continuance in force of the pre-Constitution laws. Scope of judicial review. The constitutional validity of a legislative enactment or an executive order can be challenged in the Supreme Court or in the High Courts on the following 3 grounds. A. It infringes the fundamental rights, Part 3. B. It is outside the competence of the authority which has framed it. And C. It is repugnant to the constitutional provisions. From the above, it is clear that the scope of judicial review in India is narrower than what exists in the USA, though the American Constitution does not explicitly mention the concept of judicial review in any of its provisions. This is because the American Constitution provides for due process of law against that of procedure established by law, which is contained in the Indian Constitution. The difference between the two is, the due process of law gives wide scope to the Supreme Court to grant protection to the rights of its citizens. It can declare laws violative of these rights void not only on substantive grounds of being unlawful, but also on procedural grounds of being unreasonable. Our Supreme Court, while determining the constitutionality of a law, however, examines only the substantive question, i.e., whether the law is within the powers of the authority concerned or not. It is not expected to go into the question of its reasonableness, suitability, or policy implications. 10.300 YS Indian Polity. The exercise of wide power of judicial review by the American Supreme Court in the name of due process of law clause has made the critics to describe it as a third chamber of the legislature, a superlegislature, the arbiter of social policy, and so on. This American principle of judicial supremacy is also recognized in our constitutional system, but to a limited extent. Nor do we fully follow the British principle of parliamentary supremacy. There are many limitations on the sovereignty of Parliament in our country, like the written character of the Constitution, the federalism with division of powers, the fundamental rights, and the judicial review. In effect, what exists in India is a synthesis of both, that is, the American principle of judicial supremacy and the British principle of parliamentary supremacy. Judicial review of the 9th Schedule Article 31b saves the acts and regulations included in the 9th Schedule from being challenged and invalidated, on the ground of contravention of any of the fundamental rights. Article 31b along with the 9th Schedule was added by the First Constitutional Amendment Act of 1951. Originally, in 1951, the 9th Schedule contained only 13 acts and regulations, but at present their number is 282.11 of these. The acts and regulations of the state legislature deal with land reforms and abolition of the zamindari system, and that of the parliament deal with other matters. Though the last entry is numbered 284, the actual total number is 282. This is because the 3 entries, 87, 92, and 130, have been deleted and 1 entry is numbered as 257A. 12 Kesavananda Bharati vs. State of Kerala, 1973. 13 Woman Rao vs. Union of India, 1980. 14 I.R. Qualo vs. State of Tamil Nadu, 2007. However, in the Kesavananda Bharati Case 12, 1973, the Supreme Court rules that the acts and regulations that are included in the 9th Schedule are open to challenge on the grounds of being violative of the basic structure of the Constitution. This was later clarified by the court in the Woman Rao Case 13, 1980, wherein it held that the various acts and regulations included in the 9th Schedule after April 24, 1973, date of judgment in the Kesavananda Bharati case, are valid only if they do not damage the basic structure of the Constitution. Again, in the I.R. Qualo Case 14, 2007, the Supreme Court reaffirmed the above view. In this case, the court ruled that there could not be any blanket immunity from judicial review of the laws included in the 9th Schedule. It held that judicial review is a basic feature of the Constitution, and it could not be taken away putting a law under the 9th Schedule. It said that the laws placed under the 9th Schedule after April 24, 1973, are open to challenge in court if they violated fundamental rights guaranteed under Articles 14, 15, 19, and 21, or the basic structure of the Constitution. While delivering the above judgment, the Supreme Court made the following conclusions. 1. A law that abrogates or abridges rights guaranteed by Part 3 of the Constitution may violate the basic structure doctrine, or it may not. If former is the consequence of law, whether by an amendment of any article of Part 3 or by an insertion in the Ninth Schedule, such law will have to be invalidated in the exercise of judicial review power of the court. The constitutional validity of the Ninth Schedule laws on the touchstone of basic structure doctrine can be adjudged by applying the direct impact and effect test, i.e., rights test, which means the form of an amendment is not the relevant factor, but the consequence thereof would be the determinative factor. 2. The majority judgment in the Kesavan and Burdi case read with Indira Gandhi case requires the validity of each new constitutional amendment to be judged on its own merits. The actual effect and impact of the law on the rights guaranteed under Part 3 has to be taken into account for determining whether or not it destroys basic structure. The impact test would determine the validity of the challenge. 3. All amendments to the Constitution made on or after April 24, 1973 by which the Ninth Schedule is amended by inclusion of various laws therein shall have to be tested on the touchstone of the basic or essential features of the Constitution as reflected in Article 21 read with Articles 14 and 19 and the principles underlying them. LB put it differently, even though an act is put in the Ninth Schedule by a constitutional amendment, its provisions would be open to attack on the ground that they destroy or damage the basic structure if the fundamental right or rights taken away or abrogated pertains or pertain to the basic structure. 4. Justification for conferring protection, not blanket protection, on the laws included in the Ninth Schedule by constitutional amendments shall be a matter of constitutional adjudication by examining the nature and extent of infraction of a fundamental right by a statute, sought to be constitutionally protected, and on the touchstone of the basic structure doctrine as reflected in Article 21 read with Articles 14 and 19 by application of the rights test and the essence of the right test, taking the synoptic view of the articles in Part 3. Indira Nehru Gandhi vs. Raj Narain, 1975. Judicial Review, 301. As held in the Indira Gandhi Case 16. Applying the above test to the Ninth Schedule laws, if the infraction affects the basic structure, then such a law or laws will not get the protection of the Ninth Schedule. When the triangle of Article 21 read with Article 14 and Article 19 is sought to be eliminated, not only the essence of the right test, but also the rights test has to apply. There is also a difference between the rights test and the essence of the right test. Both form part of application of the basic structure doctrine. When in a controlled constitution conferring limited power of amendment, an entire chapter is made inapplicable, the essence of the right test as applied in Nagaraj Case 17 will have no applicability. In such a situation, to judge the validity of the law, it is the rights test which is more appropriate. 16 Ibid. 17M. Nagaraj vs. Union of India, 2006. 5. If validity of any Ninth Schedule law has already been upheld by this court, it would not be open to challenge such law again on the principles declared by this judgment. However, if a law held to be violative of any rights in Part 3 is subsequently incorporated in the Ninth Schedule after April 24, 1973, such a violation infraction shall be open to challenge on the ground that it destroys or damages the basic structure as indicated in Article 21 read with Articles 14 and 19 and the principles underlying them. 6. Action taken and transactions finalized as a result of the impugned acts shall not be open to challenge. The number of acts and regulations included in the Ninth Schedule before and after April 24, 1973 are mentioned in IBL 27.1. 302 Indian Polity. Table 27.1 Number of acts and regulations included in the Ninth Schedule. Serial number, amendment number, year, number of acts and regulations included in the Ninth Schedule. I. Included before April 24, 1973. 1. First Amendment, 1951, 13, 1-13. 2. Fourth Amendment, 1955, 7, 14-20. 3. Seventh Amendment, 1964, 44, 21-64. 4. 29th Amendment, 1972, 2, 65-66. 2. Included after April 24, 1973. 5. 34th Amendment, 1974, 20, 67-86. 6. 39th Amendment, 1975, 38, 87-124. 7. 40th Amendment, 1976, 64, 125-188. 8. 47th Amendment, 1984, 14, 189-202. 9. 66th Amendment, 1990, 55, 203-257. 10. 76th Amendment, 1994, 1, 257A. 11. 78th Amendment, 1995, 27, 258-284. Note: Entries 87, 92, and 130 have been omitted by the 44th Amendment, 1978. Scan the QR code to access the conceptual video on judicial review and activism and other important topics on EDGE Chapter 28, Judicial Activism. The concept of judicial activism originated and developed in the USA. This term was first coined in 1947 by Arthur Schlesinger, Jr., an American historian and educator. 1. His article entitled, As the Supreme Court, 1947, was published in the Fortune magazine. 2. Black's Law Dictionary. 3. Merriam-Webster's Dictionary of Law. V. G. Polishaker, Judicial Activism, Air 1998, Journal Volume 8, p. 201. 3. H. Black's Law Dictionary. 3. C.P. B. Sawant, Judicial Independence, Myth and Reality, Pune, Board of Extramural Studies, 1987, p. 70. In India, the doctrine of judicial activism was introduced in the mid-1970s. Justice V.R. Krishna Iyer, Justice P. N. Bhagwati, Justice O. Chinnappa Reddy and Justice D. A. Desai laid the foundations of judicial activism in the country. Meaning of judicial activism. Judicial activism denotes the proactive role played by the judiciary in the protection of the rights of citizens and in the promotion of justice in the society. In other words, it implies the assertive role played by the judiciary to force the other two organs of the government, legislature and executive, to discharge their constitutional duties. Judicial activism is also known as judicial dynamism. It is the antithesis of judicial restraint, which means the self-control exercised by the judiciary. Judicial activism is defined in the following way. 1. Judicial activism is a way of exercising judicial power that motivates judges to depart from normally practiced strict adherence to judicial precedent in favor of progressive and new social policies. It is commonly marked by decision calling for social engineering, and occasionally these decisions represent intrusion in the legislative and executive matters. 2. Judicial activism is the practice in the judiciary of protecting or expanding individual rights through decisions that depart from established precedent or are independent of or in opposition to supposed constitutional or legislation intent. 3. Judicial activism can be defined as the process of lawmaking by judges. It means an active interpretation of existing legislation by a judge, made with a view to enhance the utility of that legislation for social betterment. Judicial activism is different from judicial pessimism, which means interpretation of existing provisions of law without an attempt to enhance its beneficial aspects. 38.4. Judicial activism is a philosophy of judicial decision-making whereby judges allow their personal views about public policy, among other factors, to guide their decisions. 3b5. Judicial activism is a procedure to evolve new principles, concepts, maxims, formulae and relief to do justice or to expand the standing of the litigant and open the door of courts for needy or to entertain litigation affecting the entire society or a section of it. 3c. 304 Indian Polity. Aspects of judicial activism. There are two major aspects of judicial activism followed by the Indian judiciary. 3-1. 3-C. Agarwal, Judicial Activism in India, Chapter 12 in Judicial Activism in India, a festschrift in honor of Justice V.R. Krishna Iyer, edited by Lokendra Malik, Universal Law Publishing Company. First edition, 2013, p. 125. 3 EV. N. Shukla and Mahendra Pal Singh, Constitution of India, Eastern Book Company, 13th edition, 2017, p. A51. 3 FDR. G. Rajasekar, Philosophy of Judicial Activism and its Role in the Growth of Environmental Jurisprudence, Chapter 5, Part 2, in Judiciary in India, Constitutional Perspectives, edited by G. Manohar Rao, Dr. G. B. Reddy, and V. Geeta Rao, Asia Law House, Hyderabad, First edition, 2009, p. 180. 3 GDR. Vishal Guleria, Judicial Activism, A Ray of Hope for the Marginalized Masses, Chapter 22 in Judicial Activism in India, a festschrift in honor of Justice V.R. Krishna Iyer, edited by Lokendra Malik, Universal Law Publishing Co. First edition, 2013, pp. 292 to 293. 3 H. Justice A.S. Anand, Judicial Review Judicial Activism Need for Caution, Chapter 1 in Judicial Activism in India, a festschrift in honor of Justice V.R. Krishna Iyer, edited by Lokendra Malik, Universal Law Publishing Company. First edition, 2013, p. 7. 3 I. Rabindra K.R. Puddock, Judicial Process, First edition, 2019, Thomson Reuters, p. 259. I. The first comes in the form of various directions issued by the courts to the government authorities for protecting the rights of citizens and fulfillment of a course of public interest. The cases public interest litigation, PL, fall under this aspect of judicial activism. 2. The second major aspect of judicial activism in India is the field of interpretation of fundamental rights, particularly the right to equality, Article 14, the right to freedom, Article 19, and the right to life and personal liberty, Article 21. The courts have expanded the scope of these rights in their discretion and interpretation of the Constitution. Judicial review and judicial activism underscore the concepts of judicial review and judicial activism are closely related to each other. But there is a difference between them. The following points bring out this difference. 1. Since about the mid-20th century, a version of judicial review has acquired the nickname of judicial activism, especially in the USA. In India, the participants in the debate mix up judicial activism with judicial review. The former is that form of latter in which judges participate in lawmaking policies, i.e., not only they uphold or invalidate laws in terms of constitutional provisions, but also exercise their policy preferences in doing so. 3E2. The concept of judicial review is the interpretation of the law in the light of constitutional parameters, but judicial activism is molding the law to suit the changing social and economic scenario to make the ideals enshrined in the Constitution meaningful and real. 31.3. The term judicial activism came into currency sometime in the 20th century to describe the act of judicial legislation, i.e., judges making positive law. However, there is no standard definition of the term judicial activism. As a whole, it can be said that judicial activism stresses the importance of judicial review and a powerful judiciary in the protection and promotion of certain core rights. 3G4. The expanded concept of locus standi in connection with PL, by judicial interpretation from time to time, has expanded the jurisdictional limits of the courts exercising judicial review. This expanded role has been given the title of judicial activism by those who are critical of this expanded role of the judiciary. 311.5. Judicial activism, as regards constitutional cases, falls under the rubric of what is commonly called judicial review, and at the broadest level, it is any occasion where a court intervenes and strikes down a piece of duly enacted legislation. 31T. Justification of judicial activism. According to Dr. B.L. Wadhera, the reasons for judicial activism are as follows. 4. Upendra Baxi, The Avatars of Indian Judicial Activism, Explorations in the Geographies of Injustice, in S.K. Varma and Kusum ed. 50 Years of the Supreme Court Oflandate's Grasp and Reach, Indian Law Institute and Oxford University Press, 2000, pp. 173 to 175. There is near collapse of the responsible government when the legislature and executive fail to discharge their respective functions. This results in erosion of the confidence in the Constitution and democracy amongst the citizens. 2. The citizens of the country look up to the judiciary for the protection of their rights and freedoms. This leads to tremendous pressure on judiciary to step in aid for the suffering masses. 3. Judicial enthusiasm. That is, the judges like to participate in the social reforms that take place in the changing times. It encourages the public interest litigation and liberalizes the principle of locus standi. 4. Legislative vacuum. That is, there may be certain areas which have not been legislated upon. It is therefore upon the court to indulge in judicial legislation and to meet the changing social needs. V. The Constitution of India has itself adopted certain provisions, which gives judiciary enough scope to legislate or to play an active role. Similarly, Subhash Kashyap observes that certain eventualities may be conceived when the judiciary may have to overstep its normal jurisdiction and intervene in areas otherwise falling within the domain of the legislature and the executive. 5. When the legislature fails to discharge its responsibilities. 2. In case of a hung legislature, when the government it provides is weak, insecure, and busy only in the struggle for survival, and, therefore, unable to take. For Dr. B.L. Wadhera, Public Interest Litigation, a Handbook, 2nd edition, 2009, Universal Law Publishing Company. pp. 161 to 162. 5. Subhash C. Kashyap, Judiciary Legislature Interface, in Politics India, New Delhi, April 1997, p. 22. Judicial Activism 305. Any decision which displeases any caste, community, or other group. 3. Those in power may be afraid of taking honest and hard decisions for fear of losing power and, for that reason, may have public issues referred to courts as issues of law in order to mark time and delay decisions or to pass on the odium of strong decision-making to the courts. 4. Where the legislature and the executive fail to protect the basic rights of citizens, like the right to live a decent life, healthy surroundings, or to provide honest, efficient, and just system of laws and administration. V. Where the court of law is misused by a strong authoritarian parliamentary party government for ulterior motives, as was sought to be done during the emergency aberration. 6. Sometimes, the courts themselves knowingly or unknowingly become victims of human, all too human, weaknesses of craze for populism, publicity, playing to the media, and hogging the headlines. Activators of judicial activism. Upendra Baxi, an eminent jurist, has delineated the following typology of social human rights activists who activated judicial activism. 6. 1. Civil rights activists. These groups primarily focus on civil and political rights issues. 2. People rights activists. These groups focus on social and economic rights within the context of state repression of people's movements. 3. Consumer rights groups. These formations raise issues of consumer rights. 306 Indian Polity. Within the framework of accountability of the polity and the economy. 4. Bonded labor groups. These groups ask for judicial activism is nothing short of annihilation of wage slavery in India. 5. Citizens for environmental action. These groups activate an activist judiciary to combat increasing environmental degradation and pollution. 6. Citizen groups against large irrigation projects. These activist formations ask the Indian judiciary the impossible for any judiciary in the world, namely, cease to and desist from ordering against mega irrigation projects. 7. Rights of child groups. These groups focus on child labor, the right to literacy, juveniles and custodial institutions, and rights of children born to sex workers. 8. Custodial rights groups. These groups include social action by prisoners' rights groups, women under state protective custody, and persons under preventive detention. 9. Poverty rights groups. These groups litigate issues concerning draft and famine relief in urban impoverished. 10. Indigenous peoples' rights groups. These groups agitate for issues of forest dwellers, citizens of the 5th and 6th schedules of the Indian Constitution, and identity rights. 11. Women's rights groups. These groups agitate for issues of gender equality, gender-based violence and harassment, rape and dowry murders. 12. Bar-based groups. These associations agitate for issues concerning autonomy and accountability of the Indian judiciary. 13. Media autonomy groups. These groups focus on the autonomy and accountability of the press and instruments of mass media owned by the state. 14. Assorted lawyer-based groups. This category includes the critically influential lawyers groups which agitate for various causes. 15. Assorted individual petitioners. This category includes freelance activist individuals. Apprehensions of judicial activism ________________________ The eminent jurist, Upendra Baxi, presented a typology of fears which are generated by judicial activism. He observes, the facts entail invocation of a wide range of fears. The invocation is designed to bring into a nervous rationality among India's most conscientious justices. He described the following types of fears. 7. Upendra Baxi, Judicial Activism, Legal Education and Research in Globalizing India, in Mainstream, New Delhi, February 24, 1996, p. 16. 1. Ideological fears. Are they usurping powers of the legislature, the executive, or of other autonomous institutions in a civil society? 2. Epistemic fears. Do they have enough knowledge in economic matters of a Manmohan Singh, in scientific matters of the czars of the atomic energy establishment, the captains of the Council of Scientific and Industrial Research, and so on? 3. Management fears. Are they doing justice by adding this kind of litigation workload to a situation of staggering growth of arrears? 4. Legitimation fears. Are not they causing depletion of their symbolic and instrumental authority by passing orders in public interest litigation which the executive may bypass or ignore? Would not the people's faith in judiciary, a democratic recourse, be thus eroded? 5. Democratic fears. Is a profusion of public interest litigation nurturing democracy or depleting its potential for the future? 6. Biographic fears. What would be my place in national affairs after superannuation if I overdo this kind of litigation? Judicial activism. 307. Judicial activism versus judicial restraint. Meaning of judicial restraint. Judicial activism and judicial restraint are the two alternative judicial philosophies in the United States. Those who subscribe to judicial restraint contend that the role of judges should be scrupulously limited. Their job is merely to say what the law is, leaving the business of lawmaking where it properly belongs, that is, with the legislators and the executives. Under no circumstances, moreover, should judges allow their personal political values and policy agendas to color their judicial opinions. This view holds that the original intent of the authors of the Constitution and its amendments is knowable and must guide the courts. 8. Ian McLean and Alistair Macmillan, Oxford Concise Dictionary of Politics, First Indian Edition, 2004, p. 284. 9. Joel B. Grossman and Richard 8. Wells, ed., Constitutional Law and Judicial Policy Making, 1972, pp. 56-57. Assumptions of judicial restraint in the USA. The doctrine of judicial restraint is based on the following 6 assumptions. 9. 1. The court is basically undemocratic because it is non-elective and presumably non-responsive to the popular will. Because of its alleged oligarchic composition, the court should defer wherever possible to the more democratic branches of government. 2. The questionable origins of the great power of judicial review, a power not specifically granted by the Constitution. 3. The doctrine of separation of powers. 4. The concept of federalism, dividing powers between the nation and the states, requires of the court deference toward the action of state governments and officials. 5. The non-ideological but pragmatic assumption that since the court is dependent on the Congress for its jurisdiction and resources, and dependent on public acceptance for its effectiveness, it ought not to overstep its boundaries without consideration of the risks involved. 6. The aristocratic notion that, being a court of law and inheritor and custodian of the Anglo-American legal tradition, it ought not to go too far to the level of politics. Law being the process of reason and judgment, and politics being concerned only with power and influence. From the above, it is clear that all the assumptions, except the second dealing with the judicial review, hold good in the Indian context too. Supreme Court observations. While delivering a judgment in December 2007, the Supreme Court of India called for judicial restraint and asked courts not to take over the functions of the legislature or the executive, saying there is a broad separation of powers under the Constitution and each organ of the state must have respect for others and should not encroach on others' domain. In this context, the concerned bench of the court made the following observations. 10.1. The bench said, "We are repeatedly coming across cases where judges are unjustifiably trying to perform executive or legislative functions. This is clearly unconstitutional. In the name of judicial activism, judges cannot cross their limits and try to take over functions which belong to another organ of the state." 2. The bench said, judges must know their limits and must not try to run the government. They must have modesty and humility and not behave like emperors. 3. Quoting from the book, The Spirit of Laws by Montesquieu on the consequences of not maintaining separation of powers among the three organs, the bench said the French political degree The Hindu, Don't Cross Limits, Apex Court asked judges, December 11, 2007. 308. Philosophers' warning is particularly apt and timely for the Indian judiciary today, since very often it is rightly criticized for overreach and encroachment on the domain of the other two organs. 4. Judicial activism must not become judicial adventurism. The bench warned the court's adjudication must be done within the system of historically validated restraints and conscious minimization of judges' preferences. 5. The courts must not embarrass administrative authorities and must realize that administrative authorities have expertise in the field of administration while the court does not. 6. The bench said, the justification often given for judicial encroachment on the domain of the executive or the legislature is that the other two organs are not doing their jobs properly. Even assuming this is so, the same allegations can be made against the judiciary too because there are cases pending in courts for half a century. 7. If the legislature or the executive was not functioning properly, it was for the people to correct the defects by exercising their franchise properly in the next elections and voting for candidates who would fulfill their expectations or by other lawful methods, e.g., peaceful demonstrations. 8. The remedy is not in the judiciary taking over the legislative or the executive functions, because that will not only violate the delicate balance of power enshrined in the Constitution but also because the judiciary has neither the expertise nor the resources to perform these functions. 9. The bench said, judicial restraint is consistent with and complementary to the balance of power among the three independent branches of the state. It accomplishes this in two ways. First, judicial restraint not only recognizes the equality of the other two branches with the judiciary, it also fosters that equality by minimizing inter-branch interference by the judiciary. Second, judicial restraint tends to protect the independence of the judiciary. When courts encroach on the legislative or administrative fields, almost inevitably voters, legislators, and other elected officials will conclude that the activities of judges should be closely monitored. Scan the QR code to access the conceptual video on judicial review and activism and other important topics on Edge. Chapter 29, Public Interest. Litigation. The concept of public interest litigation, PL, originated and developed in the USA in the 1960s. In the USA, it was designed to provide legal representation to previously unrepresented groups and interests. It was undertaken in recognition of the fact that the ordinary marketplace for legal services fails to provide such services to significant segments of the population and to significant interests. Such groups and interests include the poor, environmentalists, consumers, racial and ethnic minorities, and others. 1. Balancing the Scales of Justice. Financing Public Interest Law in America, a report by the Council for Public Interest Law, 1976, pp. 6-7. In India, the concept of PL is closely related to the concept of judicial activism. The emergence of PL is mainly attributed to the judicial activism role of the Supreme Court. In other words, the PL is an outcome of judicial activism. In fact, the PL is the most popular form or manifestation of judicial activism. In India, the PL was introduced in the early 1980s. Justice V. R. Krishna Iyer and Justice P. N. Bhagwati were the pioneers of the concept of PL. The PL is also known variously as social action litigation, SAL, social interest litigation, SDL, and class action litigation, CAL. Meaning of PL. The introduction of PL in India was facilitated by the relaxation of the traditional rule of locus standi. According to this rule, only that person whose rights are infringed alone can move the court for the remedies, whereas the PL is an exception to this traditional rule. Under the PL, any public-spirited citizen or a social organization can move the court for the enforcement of the rights of any person or group of persons who, because of their poverty or ignorance or socially or economically disadvantaged position, are themselves unable to approach the court for the remedies. Thus, in a PL, any member of the public having sufficient interest can approach the court for enforcing the rights of other persons and redressal of a common grievance. The Supreme Court has defined a PL as a legal action initiated in a court of law for the enforcement of public interest or general interest in which the public or a class of the community have pecuniary interest or some interest by which their legal rights or liabilities are affected. The PL is absolutely necessary for maintaining the rule of law, furthering the cause of justice, and accelerating the pace of realization of the constitutional objectives. In other words, the real purposes of the PL are I. Vindication of the rule of law. 2. Facilitating effective access to justice to the socially and economically weaker sections of the society. And 3. Meaningful realization of the fundamental rights. 7 features of PL underscore 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 underscore. The various features of the PL are explained below. 1. The PL is a strategic arm of the legal aid movement and is intended to bring justice within the reach of the poor masses, 310t, Indian Polity, who constitute the low visibility area of humanity. 2. The PL is a totally different kind of litigation from the ordinary traditional litigation, which is essentially of an adversary character where there is a dispute between two litigating parties, one making claims seeking relief against the other and that other opposing such claim or resisting such relief. 3. The PL is brought before the court not for the purpose of enforcing the right of one individual against another as happens in the case of ordinary litigation, but it is intended to promote and vindicate public interest. 4. The PL demands that violations of constitutional and legal rights of large numbers of people who are poor, ignorant, or in a socially or economically disadvantaged position should not go unnoticed and unredressed. 5. The PL is essentially a cooperative effort on the part of the petitioner, the state or public authority, and the court to secure observance of the constitutional or legal rights, benefits, and privileges conferred upon the vulnerable sections of the community and to reach social justice to them. 6. In the PL, litigation is undertaken for the purpose of redressing public injury, enforcing public duty, protecting social, collective, diffused rights and interests, or vindicating public interest. 7. In the PL, the role held by the court is more assertive than in traditional actions. It is creative rather than passive, and it assumes a more positive attitude in determining acts. 8. Though in the PL court enjoys a degree of flexibility unknown to the trial of traditional private law litigations, whatever the procedure adopted by the court, it must be procedure known to judicial tenets and characteristics of a judicial proceeding. 9. In a PL, unlike traditional dispute resolution mechanism, there is no determination on adjudication of individual rights. Scope of PL. In 1988, the Supreme Court formulated a set of guidelines to be followed for entertaining letters or petitions received by it as PL. These guidelines were modified in 1993 and 2003. According to them, the letters or petitions falling under the following categories alone will ordinarily be entertained as PL. 1. Bonded labor matters. 2. Neglected children. 3. Non-payment of minimum wages to workers and exploitation of casual workers and complaints of violation of labor laws, except in individual cases. 4. Petitions from jails complaining of harassment, for premature release and seeking release after having completed 14 years in jail, death in jail, transfer, release on personal bond, speedy trial as a fundamental right. 5. Petitions against police for refusing to register a case, harassment by police and death in police custody. 6. Petitions against atrocities on women, in particular harassment of bride burning, rape, murder, kidnapping, etc. 7. Petitions complaining of harassment or torture of villagers by co-villagers or by police from persons belonging to scheduled caste and scheduled tribes and economically backward classes. 8. Petitions pertaining to environmental pollution, disturbance of ecological balance, drugs, food adulteration, maintenance of heritage and culture, antiques, forest and wildlife, and other matters of public importance. 9. Petitions from riot victims. 10. Family pension. The cases falling under the following categories will not be entertained as PL. 1. Landlord-tenant matters. 2. Service matter and those pertaining to pension and gratuity. 3. Complaints against central state government departments and local bodies except those relating to item numbers 1 to 10, above. 4. Admission to medical and other educational institution. 5. Petitions for early hearing of cases pending in high courts and subordinate courts. Principles of PL. The Supreme Court evolved the following principles in regard to PL. 2. Girveyor Devaswamy Managing Committee versus C.K. Rajan, 2003. 1. The court in exercise of powers under Articles 32 and 226 of the Constitution can entertain a petition filed by any interested person in the welfare of the people who are in a disadvantaged position and thus not in a position to knock the doors of the court. The court is constitutionally bound to protect the fundamental rights of such disadvantaged people and direct the state to fulfill its constitutional promises. 2. When the issues of public importance, enforcement of the fundamental rights of large number of people vis-a-vis the constitutional duties and functions of the state are raised, the court treat a letter or a telegram as a PL. In such cases, the court relaxes the procedural laws and also the law relating to pleadings. 3. Whenever injustice is meted out to a large number of people, the court will not hesitate to step in to invoke Articles 14 and 21 of the Constitution of India as well as the international conventions. Public Interest Litigation 311. On human rights which provide for a reasonable and fair trial. 4. The common rule of locus standi is relaxed so as to enable the court to look into the grievances complained on behalf of the poor, deprived, illiterate, and the disabled who cannot vindicate the legal wrong or legal injury caused to them for violation of any constitutional or legal right. 5. When the court is prima facie satisfied about violation of any constitutional right of a group of people belonging to the disadvantaged category, it may not allow the state or the government from raising the question as to the maintainability of the petition. 6. Although procedural laws apply on PL cases, the question as to whether the principles of residential judicata or principles analogous thereto would apply depend on the nature of the petition and also facts and circumstances of the case. 3. 7. The dispute between two warring groups purely in the realm of private law would not be allowed to be agitated as a PL. 8. However, in an appropriate case, although the petitioner might have moved to court in his private interest and for redressal of the personal grievances, the court in furtherance of the public interest may treat it necessary to inquire into the state of affairs of the subject of litigation in the interest of justice. 9. The court in special situations may appoint commission or other bodies for the purpose of investigating into the allegations and finding out facts. It may also direct management of a public institution taken over by such commission. The principle that when a matter has been finally adjudicated upon by a court of competent jurisdiction, it may not be reopened or challenged by the original parties or their successors in interest. Its justification is the need for finality in litigation. Oxford Dictionary of Law, 8th edition, 2015, p. 537. 312 Indian Polity. 10. The court will not ordinarily transgress into a policy. It shall also take utmost care not to transgress its jurisdiction while purporting to protect the rights of the people from being violated. 11. The court would ordinarily not step out of the known areas of judicial review. The High Court, although may pass an order for doing complete justice to the parties, it does not have a power akin to Article 142 of the Constitution of India. 12. Ordinarily, the High Court should not entertain a writ petition by way of PL questioning constitutionality or validity of a statute or a statutory rule. F. Guidelines for admitting PL. The PL has now come to occupy an important field in the administration of law. It should not be allowed to become publicity interest litigation, or politics interest litigation, or private interest litigation, or PESA interest litigation, or middle-class interest litigation MIL. The Supreme Court, in this context, observed, PL is not a pill or a panacea for all wrongs. It was essentially meant to protect basic human rights of the weak and the disadvantaged and was a procedure which was innovated where a public-spirited person files a petition in effect on behalf of such persons who on account of poverty, helplessness, or economic and social disabilities could not approach the court for relief. There have been, in recent times, increasingly instances of abuse of PL. Therefore, there is a need to re-emphasize the parameters within which PL can be resorted to by a petitioner and entertained by the court. 4. For Balco Employees Union vs. Union of India, 2001. 5 State of Uttarankal vs. Balwant Singh Chapal, 2010. Therefore, the Supreme Court laid down the following guidelines for checking the misuse of the PL. 5. 1. The court must encourage genuine and bona fide PL and effectively discourage and curb the PL filed for extraneous considerations. 2. Instead of every individual judge devising his own procedure for dealing with PL, it would be appropriate for each high court to properly formulate rules for encouraging the genuine PL filed and discouraging PL filed with oblique motives. 3. The court should prima facie verify the credentials of the petitioner before entertaining the PL. 4. The court shall be prima facie satisfied regarding the correctness of the contents of petition before entertaining the PL. 5. The court should be fully satisfied that substantial public interest is involved before entertaining the petition. 6. The court should ensure that the petition which involves larger public interest, gravity, and urgency must be given priority over other petitions. 7. The court before entertaining the PL must ensure that the PL is aimed at redressal of genuine public harm and public injury. The court should also ensure that there is no personal gain, private motive, or oblique motive behind filing PL. 8. The court should also ensure that the petition filed by busybodies for extraneous and ulterior motives must be discouraged by imposing exemplary costs or adopting similar novel methods to curb frivolous petitions in the petitions filed for extraneous considerations. Part V. State Government. In this part, 30. Governor 35. Subordinate Courts 31. Chief Minister 36. Tribunals 32. State Council of Ministers 37. Consumer Commissions 33. State Legislature 38. Lockout and other courts 34. High Court. J. Chapter 130 Governor. The Constitution of India envisages the same pattern of government in the states as that for the center, that is, a parliamentary system. Part 6 of the Constitution deals with the government in the states. Articles 153 to 167 in Part 6 of the Constitution deal with the state executive. The state executive consists of the governor, the chief minister, the council of ministers, and the advocate general of the state. Thus, there is no office of vice governor in the state, like that of vice president at the center. The governor is the chief executive head of the state. But, like the president, PESA is a nominal executive head, titular or constitutional head. The governor also acts as an agent of the central government. Therefore, the office of governor has a dual role. Usually, there is a governor for each state, but the 7th Constitutional Amendment Act of 1956 facilitated the appointment of the same person as a governor for 2 or more states. The appointment of governor. The governor is neither directly elected by the people nor indirectly elected by a specially constituted electoral college, as is the case with the president. PESA is appointed by the president by warrant under his hand and seal. In a way, PESA is a nominee of the central government. But, as held by the Supreme Court in Housekeeping Pant Case 1, 1979, the office of governor of a state is not an employment under the central government. It is an independent constitutional office and is not under the control of or subordinate to the central government. 1 Housekeeping Pant vs. Ragakul Taluk, 1979. Constituent Assembly Debates, Volume 4, pp. 588-607. The draft constitution provided for the direct election of the governor on the basis of universal adult suffrage. But the Constituent Assembly opted for the present system of appointment of governor by the president because of the following reasons. 13. 1. The direct election of the governor is incompatible with the parliamentary system established in the states. 2. The mode of direct election is more likely to create conflicts between the governor and the chief minister. 3. The governor being only a constitutional, nominal head, there is no point in making elaborate arrangements for his or her election and spending huge amount of money. 314 Indian Polity. 4. The election of a governor would be entirely on personal issues. Hence, it is not in the national interest to involve a large number of voters in such an election. 5. An elected governor would naturally belong to a party and would not be a neutral person and an impartial head. 6. The election of governor would create separatist tendencies and thus affect the political stability and unity of the country. 7. The system of presidential nomination enables the center to maintain its control over the states. 8. The direct election of the governor creates a serious problem of leadership at the time of a general election in the state. 9. The chief minister would like his or her nominee to contest for governorship. Hence, a second-rate man of the ruling party is elected as governor. Therefore, the American model, where the governor of a state is directly elected, was dropped, and the Canadian model, where the governor of a province state is appointed by the Governor-General Center, was accepted in the Constituent Assembly. Qualifications, oath and conditions. Qualifications. The Constitution lays down only 2 qualifications for the appointment of a person as a governor. These are, 1. PESA should be a citizen of India. 2. PESA should have completed the age of 35 years. The Larkaria Commission on Center-State Relations, 1983-88, made the following recommendations with regard to the selection and appointment of a governor. 1. A person to be appointed as a governor should satisfy the following criteria. PESA should be eminent in some walk of life. 2. PESA should be a person from outside the state. 3. PESA should be a detached figure and not too intimately connected with the local politics of the state. 4. PESA should be a person who has not taken too great a part in politics generally, and particularly in the recent past. 2. It is desirable that a politician from the ruling party at the center is not appointed as governor of a state which is being run by some other party or a combination of other parties. 3. In order to ensure effective consultation with the state chief minister in the selection of a person to be appointed as governor, the procedure of consultation should be prescribed in the Constitution itself by suitably amending Article 155. 4. The Vice President of India and the Speaker of the Lok Sabha may be consulted by the Prime Minister in selecting a governor. This consultation should be confidential and informal and should not be a matter of constitutional obligation. Oath or affirmation. Before entering upon his office, the governor has to make and subscribe to an oath or affirmation. In his oath, the governor swears, A. to faithfully execute the office, B. to preserve, protect, and defend the Constitution and the law, and C. to devote himself or herself to the service and well-being of the people of the state. The oath of office to the governor is administered by the Chief Justice of the concerned state high court and in his absence, the senior-most judge of that court available. Every person discharging the functions of the governor also undertakes the similar oath or affirmation. Conditions of office. The Constitution lays down the following conditions for the governor's office. 1. He should not be a member of either House of Parliament or a House of the Governor 315. State Legislature. If any such person is appointed as governor, he is deemed to have vacated his seat in that house on the date on which he enters upon his office as the governor. 2. He should not hold any other office of profit. Z. He is entitled without payment of rent to the use of his official residence, the Raj Bhavanch. 4. He is entitled to such emoluments, allowances, and privileges as may be determined by Parliament. 5. When the same person is appointed as the governor of 2 or more states, the emoluments and allowances payable to him/her are shared by the states in such proportion as determined by the President. 6. His emoluments and allowances cannot be diminished during his term of office. In 2018, the Parliament has increased the salary of the governor from 1.10 lakh to 3.50 lakh per month. 2. 2V the Finance Act, 2018, with effect from January 1, 2016. This act amended the Governor's Emoluments, Allowances, and Privileges Act, 1982. 3. Surya Narayan vs. Union of India, 1981. Like the President, the Governor is also entitled to a number of privileges and immunities. He enjoys personal immunity from legal liability for his official acts. During his term of office, he is immune from any criminal proceedings, even in respect of his personal acts. He cannot be arrested or imprisoned. However, after giving 2 months' notice, civil proceedings can be instituted against him/her during his term of office in respect of his personal acts. Time by addressing a resignation letter to the President. In the Surya Narayan Case 3, 1981, the Supreme Court held that the pleasure of the President is not justifiable. The Governor has no security of tenure and no fixed term of office. He may be removed by the President at any time. The Constitution does not lay down any grounds upon which a governor may be removed by the President. Hence, the National Front government headed by VP Singh, 1989, asked all the governors to resign as they were appointed by the Congress government. Eventually, some of the governors were replaced and some were allowed to continue. The same thing was repeated in 1991, when the Congress government headed by P.V. Narasimha Rao changed 14 governors appointed by the VP Singh and Chandrasekhar governments. The President may transfer a governor appointed to one state to another state for the rest of the term. Further, a governor whose term has expired may be reappointed in the same state or any other state. A governor can hold office beyond his/her term of 5 years until his successor assumes charge. The underlying idea is that there must be a governor in the state, and there cannot be an interregnum. The President can make such provision as he thinks fit for the discharge of the functions of the governor in any contingency not provided for in the Constitution, for example, the death of a sitting governor. Thus, the Chief Justice of the concerned state high court may be appointed temporarily to discharge the functions of the governor of that state. F. Term of Governor 1's office. A governor holds office for a term of 5 years from the date on which he enters upon his office. However, this term of 5 years is subject to the pleasure of the President. Further, he can resign at any. Powers and functions of governor. A governor possesses executive, legislative, financial, and judicial powers more or less analogous to the President of India. However, he has no diplomatic, military, or emergency powers like the President. 316 and Indian Polity. The powers and functions of the governor can be studied under the following heads. 1. Executive powers. 2. Legislative powers. 3. Financial powers. 4. Judicial powers. Executive powers. The executive powers and functions of the governor are 1. All executive actions of the government of a state are formally taken in his name. 2. He can make rules specifying the manner in which the orders and other instruments made and executed in his/her name shall be authenticated. 3. He can make rules for more convenient transaction of the business of a state government and for the allocation among the ministers of the said business. 4. He appoints the chief minister and other ministers. They also hold office during his pleasure. There should be a tribal welfare minister in the states of Chhattisgarh, Jharkhand, Madhya Pradesh, and Odisha appointed by him. The state of Bihar was excluded from this provision by the 94th Amendment Act of 2006. 5. He appoints the Advocate General of a state and determines his remuneration. The Advocate General holds office during the pleasure of the governor. 6. He appoints the State Election Commissioner and determines his conditions of service and tenure of office. However, the State Election Commissioner can be removed only in like manner and on the like grounds as a judge of a high court. 7. He appoints the chairman and members of the State Public Service Commission. However, they can be removed only by the President and not by a governor. 8. He can seek any information relating to the administration of the affairs of the state and proposals for legislation from the Chief Minister. 9. Husha can require the chief minister to submit for the consideration of the Council of Ministers any matter on which a decision has been taken by a minister but which has not been considered by the Council. 10. Husha can recommend the imposition of constitutional emergency in a state to the president. During the period of president's rule in a state, the governor enjoys extensive executive powers as an agent of the president. 11. Husha acts as the chancellor of universities in the state. Husha also appoints the vice-chancellors of universities in the state. Legislative powers. A governor is an integral part of the state legislature. In that capacity, Husha has the following legislative powers and functions. 1. Husha can summon or prorogue the state legislature and dissolve the state legislative assembly. 2. Husha can address the state legislature at the commencement of the first session after each general election in the first session of each year. 3. Husha can send messages to the House or Houses of the state legislature with respect to a bill pending in the legislature or otherwise. 4. Husha can appoint any member of the state legislative assembly to preside over its proceedings when the offices of both the Speaker and the Deputy Speaker fall vacant. Similarly, Husha can appoint any member of the state legislature council to preside over its proceedings when the offices of both chairman and deputy chairman fall vacant. 5. Husha nominates 1/6 of the members of the state legislative council from amongst persons having special knowledge or practical experience in literature, science, art, cooperative movement, and social service. 6. Husha nominated, before 2020, one member to the State Legislative Assembly from Governor 317. The Anglo-Indian community. However, the 104th Constitutional Amendment Act of 2019 has discontinued this provision. 7. Husha decides on the question of disqualification of members of the state legislature in consultation with the Election Commission. 8. When a bill is sent to the governor after it is passed by state legislature, Husha can A. Give issue assent to the bill, or B. Withhold issue assent to the bill, or C. Return the bill, if it is not a money bill, for reconsideration of the state legislature. However, if bill is passed again by the state legislature with or without amendments, the governor has to give issue assent to the bill, or D. Reserve the bill for the consideration of the president. In one case, such reservation is obligatory, that is, where the bill passed by the state legislature endangers the position of the state high court. In addition, as identified by Soli Sorabji, the former Attorney General of India, the governor can also reserve the bill if it is of the following nature. 4. For Soli Sorabji, the governor, Sager Sabater, Rowley Books, New Delhi, 1985, p. 25. I. Ultra vires, that is, against the provisions of the Constitution. 2. Opposed to the directive principles of state policy. 3. Against the larger interest of the country. 4. Of grave national importance, v. Dealing with compulsory acquisition of property under Article 31A of the Constitution. 9. Husha can promulgate ordinances when the state legislature is not in session. These ordinances must be approved by the state legislature within 6 weeks from its reassembly. Husha can also withdraw an ordinance anytime. This is the most important legislative power of the governor. The Supreme Court's judgment relating to the ordinance-making power of the governor in the D.C. Wadhwa case 4A, 1986, is worth mentioning here. In that case, the court pointed out that between 1967 to 1981, the governor of Bihar promulgated 256 ordinances, and all these were kept in force for periods ranging from 1 to 14 years by repromulgation from time to time. The court ruled that successive repromulgation of ordinances with the same text without any attempt to get the bills passed by the Assembly would amount to violation of the Constitution, and the ordinance so repromulgated is liable to be struck down. It held that the exceptional power of lawmaking through ordinance cannot be used as a substitute for the legislative power of the state legislature. 10. Husha lays the reports of the State Finance Commission, the State Public Service Commission, and the Comptroller and Auditor General relating to the accounts of the state, before the state legislature. Financial powers. The financial powers and functions of the governor are: 1. Husha sees that the annual financial statement, state budget, is laid before the state legislature. 2. Money bills can be introduced in the state legislature only with Husha prior recommendation. 3. No demand for a grant can be made except on Husha recommendation. 4. Husha can make advances out of the contingency fund of the state to meet any unforeseen expenditure. 5. Husha constitutes a finance commission after every 5 years to review the financial position of the panchayats and the municipalities. For at. C. Wadhwa vs. State of Bihar, 1986. 318 Indian Polity. Judicial powers. The judicial powers and functions of the governor are: 1. Husha can grant pardons, reprieves, respites, and remissions of punishment, or suspend, remit, and commute the sentence of any person convicted of any offense against any law relating to a matter to which the executive power of the state extends. 2. Husha is consulted by the president while appointing the judges of the concerned state high court. 3. Husha makes appointments, postings, and promotions of the district judges in consultation with the state high court. 4. Husha also appoints persons to the judicial service of the state, other than district judges, in consultation with the State High Court and the State Public Service Commission. Now, we will study in detail the three important powers of the governor: veto power, ordinance-making power, and pardoning power, by comparing them with that of the President in TIBs 30.1, 30.2, and 30.3 respectively. 2. 3. 4. When the governor reserves a bill for the consideration of the President, Husha will not have any further role in the enactment of the bill. If the bill is returned by the President for the reconsideration of the House or Houses and is passed again, the bill must be presented again for the presidential assent only. If the President gives his or her assent to the bill, it becomes an act. This means that the assent of the governor is no longer required. Then becomes an act. Husha may withhold his or her assent to the bill. The bill then ends and does not become an act. Husha may return the bill for reconsideration of the House or Houses. If the bill is passed by the House or Houses again with or without amendments and presented to the governor for his or her assent, the governor must give his or her assent to the bill. Thus, the governor enjoys only a suspensive veto. Husha may reserve the bill for the consideration of the President. When a state bill is reserved by the governor for the consideration of the President has three alternatives. A. Husha may give his or her assent to the bill then becomes an act. B. Husha may withhold his or her assent to the bill then ends and does not become an act. C. Husha may return the bill for reconsideration of the House or Houses of the state legislature. When a bill is so returned, the House or Houses have to reconsider it within 6 months. If the bill is passed by the House or Houses again with or without amendments and presented to the President for his or her assent, the President is not bound to give his or her assent to the bill. Husha may give his or her assent to such a bill or withhold his or her assent. Husha may withhold his or her assent to the bill. The bill then ends and does not become an act. Husha may return the bill for reconsideration of the Houses. If the bill is passed by both the Houses again with or without amendments and presented to the President for his or her assent, the President must give his or her assent to the bill. Thus, the President enjoys only a suspensive veto. Table 30.1 comparing veto powers of President and Governor. President-Governor with regard to ordinary bills. Every ordinary bill, after it is passed by both the Houses of the Parliament either singly or at a joint sitting, is presented to the President for his or her assent. Husha has three alternatives. 1. Husha may give his or her assent to the bill then becomes an act. Every ordinary bill, after it is passed by the Legislative Assembly in case of a unicameral legislature or by both the Houses in case of a bicameral legislature either in the first instance or in the second instance, is presented to the governor for his or her assent. Husha has four alternatives. 1. Husha may give his or her assent to the bill Governor 319. President. With regard to money bills. Every money bill after it is passed by the Parliament is presented to the President for his or her assent. Husha has two alternatives. 1. Husha may give his or her assent to the bill then becomes an act. 2. Husha may withhold his or her assent to the bill then ends and does not become an act. Thus, the President cannot return a money bill for the reconsideration of the Parliament. Normally, the President gives his or her assent to a money bill as it is introduced in the Parliament with his or her previous permission. When a money bill is reserved by the governor for the consideration of the President has two alternatives. A. Husha may give his or her assent to the bill then becomes an act. B. Husha may withhold his or her assent to the bill then ends and does not become an act. Thus, the President cannot return a money bill for the reconsideration of the state legislature, as in the case of the Parliament. Governor. With regard to money bills. Every money bill, after it is passed by the state legislature, unicameral or bicameral, is presented to the governor for his or her assent. Husha has three alternatives. 1. Husha may give his or her assent to the bill then becomes an act. 2. Husha may withhold his or her assent to the bill then ends and does not become an act. 3. Husha may reserve the bill for the consideration of the President. Thus, the governor cannot return a money bill for the reconsideration of the state legislature. Normally, the governor gives his or her assent to a money bill as it is introduced in the state legislature, with his or her previous permission. 7. When the governor reserves a money bill for the consideration of the President, Husha will not have any further role in the enactment of the bill. If the President gives his or her assent to the bill, it becomes an act. This means that the assent of the governor is no longer required. Table 30.2 comparing ordinance-making powers of President and Governor. President. 1. Husha can promulgate an ordinance only when both the Houses of Parliament are not in session, or when either of the two Houses of Parliament is not in session. The second provision implies that an ordinance can also be promulgated by the President when only one House is in session, because a law can be passed by both the Houses and not by one House alone. 2. Husha can promulgate an ordinance only when Husha is satisfied that circumstances exist which render it necessary for him or her to take immediate action. 3. His ordinance-making power is coextensive with the legislative power of the Parliament. This means that Husha can issue ordinances only on those subjects on which the Parliament can make laws. 4. An ordinance issued by him/her has the same force and effect as an act of the Parliament. Governor. 1. Husha can promulgate an ordinance only when the Legislative Assembly, in case of a unicameral legislature, is not in session, or, in case of a bicameral legislature, when both the houses of the state legislature are not in session, or when either of the two houses of the state legislature is not in session. The last provision implies that an ordinance can be promulgated by the governor when only one house, in case of a bicameral legislature, is in session, because a law can be passed by both the houses and not by one house alone. 2. Husha can promulgate an ordinance only when he/she is satisfied that circumstances exist which render it necessary for him/her to take immediate action. 3. His ordinance-making power is coextensive with the legislative power of the state legislature. This means that Husha can issue ordinances only on those subjects on which the state legislature can make laws. 4. An ordinance issued by him/her has the same force and effect as an act of the state legislature. Continued. 320 Indian Polity. Table 30.3 Comparing pardoning powers of President and Governor. 5. An ordinance issued by him/her is subject to the 5. An ordinance issued by him/her is subject to the same limitations as an act of Parliament. This same limitations as an act of the state legislature means that an ordinance issued by him/her will be this means that an ordinance issued by him/her will invalid to the extent it makes any provision which be invalid to the extent it makes any provision which the Parliament cannot make. The state legislature cannot make. 6. Husha can withdraw an ordinance at any time. 6. Husha can withdraw an ordinance at any time. 7. His ordinance-making power is not a discretionary power. This means that Husha can promulgate or withdraw an ordinance only on the advice of the Council of Ministers headed by the Prime Minister. 7. His ordinance-making power is not a discretionary power. This means that Husha can promulgate or withdraw an ordinance only on the advice of the Council of Ministers headed by the Chief Minister. G. An ordinance issued by him/her should be laid before both the Houses of Parliament when it reassembles. 8. An ordinance issued by him/her should be laid before the Legislative Assembly or both the houses of the state legislature, in case of a bicameral legislature, when it reassembles. 9. An ordinance issued by him/her ceases to operate on the expiry of 6 weeks from the reassembly of Parliament. It may cease to operate even earlier than the prescribed 6 weeks, if both the houses of Parliament passes resolutions disapproving it. 9. An ordinance issued by him/her ceases to operate on the expiry of 6 weeks from the reassembly of the state legislature. It may cease to operate even earlier than the prescribed 6 weeks, if a resolution disapproving it is passed by the Legislative Assembly and is agreed to by the Legislative Council, in case of a bicameral legislature. 10. Husha needs no instruction for making an ordinance. 10. Husha cannot make an ordinance without the instructions from the President in 3 cases. A. If a bill containing the same provisions would have required the previous sanction of the President for its introduction into the state legislature. B. If Husha would have deemed it necessary to reserve a bill containing the same provisions for the consideration of the President. C. If an act of the state legislature containing the same provisions would have been invalid without receiving the President's assent. Governor. President. 1. Husha can pardon, reprieve, respite, remit, suspend, or commute the punishment or sentence of any person convicted of any offense against a central law. 2. Husha cannot pardon a death sentence. Even if a state law prescribes for death sentence, the power to grant pardon lies with the President and not the Governor. But the Governor can suspend, remit, or commute a death sentence. 2. Husha can pardon, reprieve, respite, remit, suspend, or commute a death sentence. Husha is the only authority to pardon a death sentence. 1. Husha can pardon, reprieve, respite, remit, suspend, or commute the punishment or sentence of any person convicted of any offense against a state law. 3. Husha can grant pardon, reprieve, respite, suspend. 3. Husha does not possess any such power, shown, remission, or commutation in respect to punishment or sentence by a court-martial, military court. Constitutional position of governor. The Constitution of India provides for a parliamentary form of government in the states, as in the center. Consequently, the governor has been made only a nominal executive. The real executive constitutes the Council of Ministers headed by the Chief Minister. In other words, the governor has to exercise his/her powers and functions with the aid and advise of the Council of Ministers headed by the Chief Minister, except in matters in which Husha is required to act in his/her discretion, i.e., without the advice of ministers. In estimating the constitutional position of the governor, particular reference has to be made to the provisions of Articles 154, 163, and 164. These are A. The executive power of the state shall be vested in the governor and shall be exercised by him or either directly or through officers subordinate to him or in accordance with this Constitution, Article 154. B. There shall be a council of ministers with the chief minister as the head to aid and advise the governor in the exercise of his functions, except in so far as he/she is required to exercise his functions in his discretion. Article 163. C. The council of ministers shall be collectively responsible to the legislative assembly of the state, Article 164. This provision is the foundation of the parliamentary system of government in the state. From the above, it is clear that constitutional position of the governor differs from that of the president in the following two respects. 5. 5M.P. Jain, Indian Constitutional Law, Wadhwa, 4th ed., p. 186. 1. While the Constitution envisages the possibility of the governor acting at times in his discretion, no such possibility has been envisaged for the president. 2. After the 42nd Constitutional Amendment, 1976, ministerial advice has, Governor M. 321, been made binding on the president, but no such provision has been made with respect to the governor. The Constitution makes it clear that if any question arises whether a matter falls within the governor's discretion or not, the decision of the governor is final and the validity of anything done by him or cannot be called in question on the ground that he ought or ought not to have acted in his discretion. The governor has constitutional discretion in the following cases. 1. Reservation of a bill for the consideration of the president. 2. Recommendation for the imposition of the president's rule in the state. 3. While exercising his functions as the administrator of an adjoining union territory in case of additional charge. 4. Determining the amount payable by the government of Assam, Meghalaya, Tripura, and Mizoram to an autonomous tribal district council as royalty accruing from licenses for mineral exploration. 6. In addition to the above constitutional discretion, i.e., the express discretion mentioned in the Constitution, the governor, like the president, also has situational discretion, i.e., the hidden discretion derived from the exigencies of a prevailing political situation in the following cases. 1. Appointment of chief minister when no party has a clear-cut majority in the state legislative assembly or when the chief minister in office dies suddenly and there is no obvious successor. B. Paragraph 9(2) of the 6th Schedule says, if any dispute arises as to the share of such royalties to be made over to a district council, it shall be referred to the governor for determination, and the amount determined by the governor in his discretion shall be deemed to be the amount payable to the district council, and the decision of the governor shall be final. The 6th Schedule contains the provisions as to the administration of tribal areas in the states of Assam, Meghalaya, Tripura, and Mizoram. 322 are Indian Polity. 2. Dismissal of the Council of Ministers when it cannot prove the confidence of the State Legislative Assembly. 3. Dissolution of the State Legislative Assembly if the Council of Ministers has lost its majority. Moreover, the governor has certain special responsibilities to discharge according to the directions issued by the president. In this regard, the governor, though has to consult the Council of Ministers led by the chief minister, acts finally in his discretion. They are as follows. 1. Maharashtra, establishment of separate development boards for Vidarbha and Marathwada. 2. Gujarat, establishment of separate development boards for Saurashtra and Kutch. 3. Nagaland, with respect to law and order in the state for so long as the internal disturbance in the Naga Hills Linsang area continues. 4. Assam, with respect to the administration of tribal areas. 5. Manipur, regarding the administration of the hill areas in the state. 6. Sikkim, for peace and for ensuring social and economic advancement of the different sections of the population. 7. Arunachal Pradesh, with respect to law and order in the state. 8. Karnataka, establishment of a separate development board for Hyderabad Karnataka Region 7. 7. This provision was added by the 98th Constitutional Amendment Act of 2012. Thus, the Constitution has assigned a dual role to the office of a governor in the Indian federal system. Pusha is the constitutional head of the state as well as the representative of the center, i.e., president. Issues in the governor's functioning. The Sarkaria Commission on Center-State Relations, 1983-88, identified various issues in the functioning of the governor. These issues are continuing and relevant even today. The Commission has explained them in the following way. 1. In choosing chief minister, soon after an election when a single party or a coalition emerges as the largest single party or group, there is no difficulty in the selection and appointment of a chief minister. However, where no single party or group command absolute majority, the governor has to exercise his discretion in the selection of chief minister. In such a situation, the leader of the party or group which, insofar as the governor is able to ascertain, has the largest support in the legislative assembly, may be called upon to form the government, leaving it to the assembly to determine the question of confidence. This procedure leaves little scope for any allegation of unfairness or partisanship on the part of the governor in the use of his discretion. Such a situation may also arise when a ministry resigns after being defeated in the assembly or because it finds itself in a minority. 2. In testing majority, the governors have employed various ways to determine which party or group is likely to command a majority in the legislative assembly. Some have relied only on lists of supporters of rival claimants produced before them. In other cases, physical verification by counting heads was carried out. 3. In dismissal of chief minister, there has been no uniformity in regard to the criteria adopted for dismissal of a chief minister. Obviously, a chief minister cannot continue in office after he ceases to command a majority in the Legislative Assembly. It is normal for a chief minister to resign immediately or face the Legislative Assembly to prove that he continues to enjoy majority support. 4. In dissolving the Legislative Assembly, various governors have adopted different approaches in similar situations in regard. Governor 323. To dissolution of the Legislative Assembly. The advice of a chief minister, enjoying majority support in the Assembly, is normally binding on the governor. However, where the chief minister had lost such support, some governors refused to dissolve the Legislative Assembly on his advice, while others in similar situations accepted his advice and dissolved the Assembly. 5. In recommending President's rule, in a number of situations of political instability in the states, the governors recommended President's rule under Article 356 without exhausting all possible steps under the Constitution to induct or maintain a stable government. The governors concerned neither gave a fair chance to contending parties to form a ministry, nor allowed a fresh appeal to the electorate after dissolving the Legislative Assembly. Almost all these cases have been criticized on the ground that the governors, while making their recommendations to the President, behaved in a partisan manner. Further, there has been no uniformity of approach in such situations. 6. In reserving bills for President's consideration, the governor's reservation of state bills passed by the legislature for the consideration of the President have created a controversy in some cases. 7. Regarding nominations to Legislative Council, the use of discretion by governors in the nomination of members to the Legislative Council has been criticized. These actions have been criticized on the ground that the governors have no discretion in such matters. 8. Regarding exercise of discretion as Chancellor of University, the use of discretion by governor in nominating members of a university council or university functionary in his capacity as Chancellor of a university in the state has also come in for criticism. In several state universities, the concerned legislation specifically provide that the governor by virtue of his office shall be chancellor or head of the university, and by these legislations certain powers have been conferred on the chancellor. The governors have exercised their powers as chancellor under the statute and not as governor. These actions of the governors have again been questioned on the premise that they have to abide by the advice of the Council of Ministers even in such cases. Table 30.4 Articles related to governor at a glance. Strict no. Subject matter. 153. Governors of states 154. Executive power of state 155. Appointment of governor 156. Term of office of governor 157. Qualifications for appointment as governor 158. Conditions of governor's office 159. Oath or affirmation by the governor 160. Discharge of the functions of the governor in certain contingencies 161. Power of the governor to grant pardons and others 162. Extent of executive power of state. Continued. 324 Ex Indian Polity. Article No. Subject matter. 163. Council of Ministers to aid and advise the governor. 164. Other provisions as to ministers like appointments, term, salaries, and others. 165. Advocate General for the state. 166. Conduct of business of the government of a state. 167. Duties of the chief minister regarding furnishing of information to the governor, and so on. 174. Sessions of the state legislature, prorogation and dissolution. 175. Right of the governor to address and send messages to the House or Houses of state legislature. 176. Special address by the governor RR. X. 200. Assent to bills, i.e. assent of the governor to the bills passed by the state legislature. 201. Bills reserved by the governor for consideration of the president. 213. Power of governor to promulgate ordinances. 217. Governor being consulted by the president in the matter of the appointments of the judges of the high courts. 233. Appointment of district judges by the governor. 234. Appointments of persons, other than district judges, to the judicial service of the state by the governor. Chapter Chief Minister. In the scheme of parliamentary system of government provided by the Constitution, the governor is the nominal executive authority, de jure executive, and the chief minister is the real executive authority, de facto executive. In other words, the governor is the head of the state while the chief minister is the head of the government. Thus the position of the chief minister at the state level is analogous to the position of prime minister at the center. Appointment of chief MINISTERE underscore 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 underscore. The Constitution does not contain any specific procedure for the selection and appointment of the Chief Minister. Article 164 only says that the Chief Minister shall be appointed by the Governor. However, this does not imply that the Governor is free to appoint anyone as the Chief Minister. In accordance with the conventions of the parliamentary system of government, the Governor has to appoint the leader of the majority party in the state legislative assembly as the Chief Minister. But when no party has a clear majority in the assembly, then the Governor may exercise her personal discretion in the selection and appointment of the Chief Minister. In such a situation, the Governor usually appoints the leader of the largest party or coalition in the assembly as the Chief Minister and asks him to seek a vote of confidence in the House within a month. The Governor may have to exercise his individual judgment in the selection and appointed of the Chief Minister when the Chief Minister in office dies suddenly and there is no obvious successor. However, on the death of a Chief Minister, the ruling party usually elects a new leader and the Governor has no choice but to appoint him as Chief Minister. The Constitution does not require that a person must prove his majority in the Legislative Assembly before he is appointed as the Chief Minister. The Governor may first appoint him as the Chief Minister and then ask him to prove his majority in the Legislative Assembly within a reasonable period. A person who is not a member of the state legislature can be appointed as Chief Minister for 6 months, within which time he should be elected to the state legislature, failing which he ceases to be the Chief Minister. Further, the Chief Minister may be a member of any of the 2 houses of a state legislature. Usually Chief Ministers have been selected from the lower house, Legislative Assembly, but, on a number of occasions, a member of the upper house, Legislative Council, has also been appointed as Chief Minister. The Sarkaria Commission on Center-State Relations, 1983-88, made the following recommendations with regard to the selection and appointment of a Chief Minister. 1. In choosing a Chief Minister, the Governor should be guided by the following principles. I. The party or combination of parties which commands the widest support in the Legislative Assembly should be called upon to form the government. 326F Indian Polity. 2. The Governor's task is to see that a government is formed and not to try to form a government which will pursue policies which he approves. 2. If there is a single party having an absolute majority in the Legislative Assembly, the leader of that party should automatically be asked to become the Chief Minister. However, if there is no such party, the Governor should select a Chief Minister from among the following parties or groups of parties by sounding them, in turn, in the order of preference indicated below. I. An alliance of parties that was formed prior to the elections. 2. The largest single party staking a claim to form the government with the support of others, including independents. 3. A post-electoral coalition of parties, with all the partners in the coalition joining the government. 4. A post-electoral alliance of parties, with some of the parties in the alliance forming a government and the remaining parties, including independents, supporting the government from outside. The Governor, while going through the process described above, should select a leader who in his governor's judgment is most likely to command a majority in the Legislative Assembly. 3. A Chief Minister, unless his is the leader of a party, which has absolute majority in the Legislative Assembly, should seek a vote of confidence in the Legislative Assembly within 30 days of taking over. 4. When a number of members of the Legislative Assembly approach the Governor and contest the claim of the incumbent Chief Minister to continued majority support in the Legislative Assembly, the Governor should not risk a determination of this issue of majority support on his own, outside the Legislative Assembly. The prudent course for him would be to cause the rival claims to be tested on the floor of the House. Oath, term and salary. Before the Chief Minister enters his office, the Governor administers to him the oaths of office and secrecy. When in his oath of office, the Chief Minister swears. The form of oath of office and secrecy for the Chief Minister is similar to that for any state minister. 2. This was ruled by the Supreme Court in S.R. Bommai v. Union of India, 1994. However, there have been many violations of this rule, whereby the governors have dismissed the Chief Ministers without giving them an opportunity to prove their majority in the Legislative Assembly. 1. To bear true faith and allegiance to the Constitution of India. 2. To uphold the sovereignty and integrity of India. 3. To faithfully and conscientiously discharge the duties of his office. And 4. To do right to all manner of people in accordance with the Constitution and the law, without fear or favor, affection or ill will. In his oath of secrecy, the Chief Minister swears that his will not directly or indirectly communicate or reveal to any persons any matter that is brought under his consideration or becomes known to him or as a state minister except as may be required for the due discharge of his duties as such minister. The term of the Chief Minister is not fixed and his holds office during the pleasure of the Governor. However, this does not mean that the Governor can dismiss him at any time. His cannot be dismissed by the Governor as long as his enjoys the majority support in the Legislative Assembly. 2. But, if his loses the confidence of the Assembly, his must resign or the Governor can dismiss him. Chief Minister 327. The salary and allowances of the chief minister are determined by the state legislature. In addition to the salary and allowances, which are payable to a member of the state legislature, Husha gets a sumptuary allowance, free accommodation, traveling allowance, medical facilities, etc. Powers and functions of chief minister. The powers and functions of the chief minister can be studied under the following heads. In relation to Council of Ministers, the chief minister enjoys the following powers as head of the State Council of Ministers. A. The governor appoints only those persons as ministers who are recommended by the chief minister. B. Husha allocates and reshuffles the portfolios among ministers. C. Husha can ask a minister to resign or advise the governor to dismiss him or her in case of difference of opinion. D. Husha presides over the meetings of the Council of Ministers and influences its decisions. E. Husha guides, directs, controls, and coordinates the activities of all the ministers. F. Husha can bring about the collapse of the Council of Ministers by resigning from office. Since the chief minister is the head of the Council of Ministers, Husha resignation or death automatically dissolves the Council of Ministers. The resignation or death of any other minister, on the other hand, merely creates a vacancy, which a chief minister may or may not like to fill. In relation to the governor, the chief minister enjoys the following powers in relation to the governor. A. Husha is the principal channel of communication between the governor and the Council of Ministers. 3. It is the duty of the chief minister. Article 167 specifically deals with this function of the chief minister. I. To communicate to the governor of the state all decisions of the Council of Ministers relating to the administration of the affairs of the state and proposals for legislation. 2. To furnish such information relating to the administration of the affairs of the state and proposals for legislation as the governor may call for. And 3. If the governor so requires, to submit for the consideration of the Council of Ministers any matter on which a decision has been taken by a minister but which has not been considered by the Council. B. Husha advises the governor with regard to the appointment of important officials like Advocate General, Chairman and members of the State Public Service Commission, State Election Commissioner, and so on. In relation to state legislature, the chief minister enjoys the following powers as the leader of the House. A. Husha advises the governor with regard to the summoning and proroguing of the sessions of the state legislature. B. Husha can recommend the dissolution of the Legislative Assembly to the governor at any time. C. Husha announces the government policies on the floor of the House. Other powers and functions. In addition, the chief minister also performs the following functions. A. Husha is the chairman of the State Planning Board. $328 Indian Polity. B. Husha acts as a vice chairman of the concerned zonal council by rotation, holding office for a period of 1 year at a time. 4c. Husha is a member of the Intershite Council and the Governing Council of Niti Aayog, both headed by the Prime Minister. D. Husha is the chief spokesman of the state government. E. Husha is the crisis manager-in-chief at the political level during emergencies. F. As a leader of the state, Husha meets various sections of the people and receives memoranda from them regarding their problems, and so on. G. Husha is the leader of the party in power. H. Husha is the political head of the services. For Union Home Minister is the chairman of all the zonal councils. Thus, Husha plays a very significant and highly crucial role in the state administration. However, the discretionary powers enjoyed by the governor reduces to some extent the power, authority, influence, prestige, and role of the chief minister in the state administration. Relationship with the governor. The following provisions of the Constitution deal with the relationship between the governor and the chief minister. 1. Article 163. There shall be a council of ministers with the chief minister as the head to aid and advise the governor on the exercise of Husha functions, except in so far as Husha is required to exercise Husha functions or any of them in his or her discretion. 2. Article 164. A. The chief minister shall be appointed by the governor and other ministers shall be appointed by the governor on the advice of the chief minister. B. The ministers shall hold office during the pleasure of the governor. And C. The Council of Ministers shall be collectively responsible to the Legislative Assembly of the state. 3. Article 167. It shall be the duty of the chief minister. A. To communicate to the governor of the state all decisions of the Council of Ministers relating to the administration of the affairs of the state and proposals for legislation. B. To furnish such information relating to the administration of the affairs of the state and proposals for legislation as the governor may call for. And C. If governor so requires, to submit for the consideration of the Council of Ministers any matter on which a decision has been taken by a minister, but which has not been considered by the Council. Table 31.1 Articles related to Chief Minister at a glance. Article No. Subject Matter. 163. Council of Ministers to aid and advise governor. 164. Other provisions as to ministers. 166. Conduct of business of the government of a state. 167. Duties of chief minister as respects the furnishing of information to governor, etc. 177. Rights of ministers as respects the Houses Chapter State Council of Ministers. A. As the Constitution of India provides for a parliamentary system of government in the states on the union pattern. The Council of Ministers headed by the Chief Minister is the real executive authority in the politico-administrative system of a state. The Council of Ministers in the states is constituted and function in the same way as the Council of Ministers at the center. The principles of parliamentary system of government are not detailed in the Constitution, but two articles, 163 and 164, deal with them in a broad, sketchy, and general manner. Article 163 deals with the status of the Council of Ministers, while Article 164 deals with the appointment, tenure, responsibility, qualifications, oath and salaries and allowances of the ministers. T. Constitutional Provisions. Article 163, Council of Ministers to aid and advise Governor. There shall be a Council of Ministers with the Chief Minister as the head to aid and advise the Governor in the exercise of his functions, except in so far as his is required to exercise his functions in his discretion. 2. If any question arises whether a matter falls within the Governor's discretion or not, decision of the Governor shall be final, and the validity of anything done by the Governor shall not be called in question on the ground that his ought or ought not to have acted in his or her discretion. 3. The advice tendered by ministers to the Governor shall not be inquired into in any court. Article 164, Other provisions as to ministers. 1. The Chief Minister shall be appointed by the Governor, and the other ministers shall be appointed by the Governor on the advice of the Chief Minister. However, in the states of Chhattisgarh, Jharkhand, Madhya Pradesh and Odisha, there shall be a minister in charge of tribal welfare who may in addition be in charge of the welfare of the scheduled castes and backward classes or any other work. The state of Bihar was excluded from this provision by the 94th Amendment Act of 2006. 2. The total number of ministers, including the Chief Minister, in the Council of Ministers in a state shall not exceed 15% of the total strength of the Legislative Assembly of that state. But the number of ministers, including the Chief Minister, in a state shall not be less than 12. This provision was added by the 91st Amendment Act of 2003. 3. A member of either House of State Legislature belonging to any political party who is disqualified on the ground of defection shall also be disqualified to be appointed as a minister. This provision was also added by the 91st Amendment Act of 2003. 4. The ministers shall hold office during the pleasure of the Governor. 330 Indian Polity. 5. The Council of Ministers shall be collective. Be responsible to the State Legislative Assembly. 6. The Governor shall administer the oaths of office and secrecy to a minister. 7. A minister who is not a member of the state legislature for any period of 6 consecutive months shall cease to be a minister. 8. The salaries and allowances of ministers shall be determined by the state legislature. Article 166, Conduct of Business of the Government of a State. 1. All executive action of the government of a state shall be expressed to be taken in the name of the Governor. 2. Orders and other instruments made and executed in the name of the Governor shall be authenticated in such manner as may be specified in rules to be made by the Governor. Further, the validity of an order or instrument which is so authenticated shall not be called in question on the ground that it is not an order or instrument made or executed by the Governor. 3. The Governor shall make rules for the more convenient transaction of the business of the government of the state, and for the allocation among ministers of the said business in so far as it is not business with respect to which the Governor is required to act at his discretion. Article 167, Duties of Chief Minister. It shall be the duty of the Chief Minister of each state 1. To communicate to the Governor of the state all decisions of the Council of Ministers relating to the administration of the affairs of the state and proposals for legislation 2. To furnish such information relating to the administration of the affairs of the state and proposals for legislation as the Governor may call for. 3. If the Governor so requires, to submit for the consideration of the Council of Ministers any matter on which a decision has been taken by a minister but which has not been considered by the Council. Article 177, Rights of Ministers. As respects the Houses, every minister shall have the right to speak and take part in the proceedings of the Assembly, and also the Council where it exists, and any committee of the state legislature of which his may be named a member. But his shall not be entitled to vote. T. Nature of advice by ministers. Article 163 provides for a Council of Ministers with the Chief Minister at the head to aid and advise the Governor in the exercise of his functions except for the discretionary ones. If any question arises whether a matter falls within the Governor's discretion or not, the decision of the Governor is final, and the validity of anything done by him or cannot be called in question on the ground that his ought or ought not to have acted at his discretion. Further, the nature of advice tendered by ministers to the Governor cannot be inquired by any court. This provision emphasizes the intimate and the confidential relationship between the Governor and the ministers. In Shamher Singh Case 1, 1974, the Supreme Court held that except in spheres where the Governor is to act at his discretion, the Governor has to act on the aid and advice of the Council of Ministers in the exercise of his powers and functions. Pasha is not required to act personally without the aid and advice of the Council of Ministers or against the aid and advice of the Council of Ministers. Wherever the Constitution requires the satisfaction of the Governor, the satisfaction is not the personal satisfaction of the Governor, but it is the satisfaction of the Council of Ministers. 1 Shamser Singh versus State of Punjab, 1974. State Council of Ministers, 331. 7. Appointment of ministers. The Chief Minister is appointed by the Governor. The other ministers are appointed by the Governor on the advice of the Chief Minister. This means that the Governor can appoint only those persons as ministers who are recommended by the Chief Minister. But there should be a tribal welfare minister in Chhattisgarh, Jharkhand, Madhya Pradesh, and Odisha. 1. Originally, this provision was applicable to Bihar, Madhya Pradesh, and Odisha. The 94th Amendment Act of 2006 freed Bihar from the obligation of having a tribal welfare minister, as there are no scheduled areas in Bihar now and the fraction of population of the scheduled tribes is very small. The same amendment also extended the above provision to the newly formed states of Chhattisgarh and Jharkhand. Usually, the members of the state legislature, either the Legislative Assembly or the Legislative Council, are appointed as ministers. A person who is not a member of either house of the state legislature can also be appointed as a minister. But within 6 months, Husha must become a member either by election or by nomination of either house of the state legislature, otherwise, Husha ceases to be a minister. A minister who is a member of one house of the state legislature has the right to speak and to take part in the proceedings of the other house. But Husha can vote only in the house of which Husha is a member. Oath and salary of ministers. Before a minister enters upon his office, the Governor administers to him/her the oaths of office and secrecy. In his oath of office, the minister swears, 1. To bear true faith and allegiance to the Constitution of India. Lady may, in addition, be in charge of the welfare of the SCs and BCs or any other work. 2. To uphold the sovereignty and integrity of India. 3. To faithfully and conscientiously discharge the duties of his office. And 4. To do right to all manner of people in accordance with the Constitution and the law, without fear or favor, affection or ill will. In his oath of secrecy, the minister swears that Hisha will not directly or indirectly communicate or reveal to any persons any matter that is brought under Hisha consideration or becomes known to her as a state minister except as may be required for the due discharge of Hisha duties as such minister. The salaries and allowances of ministers are determined by the state legislature from time to time. A minister gets salary and allowances, which are payable to a member of the state legislature. Additionally, Hisha gets a sumptuary allowance, according to Hisha rank, free accommodation, traveling allowance, medical facilities, etc. 7. Responsibility of ministers. Collective responsibility. The fundamental principle underlying the working of parliamentary system of government is the principle of collective responsibility. Article 164 clearly states that the Council of Ministers is collectively responsible to the Legislative Assembly of the state. This means that all the ministers own joint responsibility to the Legislative Assembly for all their acts of omission and commission. They work as a team and swim or sink together. When the Legislative Assembly passes a no-confidence motion against the Council of Ministers, all the ministers have to resign, including those ministers who are from the Legislative Council too. Alternatively, 2. Each minister need not resign separately. The resignation of the Chief Minister amounts to the resignation of the entire Council of Ministers. $332 Indian Polity. The Council of Ministers can advise the Governor to dissolve the Legislative Assembly on the ground that the House does not represent the views of the electorate faithfully and call for fresh elections. The Governor may not oblige the Council of Ministers which has lost the confidence of the Legislative Assembly. The principle of collective responsibility also means that the cabinet decisions bind all cabinet ministers and other ministers, even if they deferred in the cabinet meeting. It is the duty of every minister to stand by the cabinet decisions and support them both within and outside the state legislature. If any minister disagrees with the cabinet decision and is not prepared to defend it, Husha must resign. Several ministers have resigned in the past owing to their differences with the cabinet. Individual responsibility. Article 164 also contains the principle of individual responsibility. It states that the ministers hold office during the pleasure of the Governor. This means that the Governor can remove a minister at a time when the Council of Ministers enjoys the confidence of the Legislative Assembly. But the Governor can remove a minister only on the advice of the Chief Minister. In case of difference of opinion or dissatisfaction with the performance of a minister, the Chief Minister can ask him/her to resign or advise the Governor to dismiss him/her. By exercising this power, the Chief Minister can ensure the realization of the rule of collective responsibility. No legal responsibility as at the center, there is no provision in the Constitution for the system of legal responsibility of the minister in the states. It is not required that an order of the Governor for a public act should be countersigned by a minister. Moreover, the courts are barred from inquiring into the nature of advice rendered by the ministers to the Governor. Degree composition of the Council of Ministers. The Constitution does not specify the size of the State Council of Ministers or the ranking of ministers. They are determined by the Chief Minister according to the exigencies of the time and requirements of the situation. Like at the center, in the states too, the Council of Ministers consists of 3 categories of ministers, namely, cabinet ministers, ministers of state, and deputy ministers. The difference between them lies in their respective ranks, emoluments, and political importance. At the top of all these ministers stands the Chief Minister, supreme governing authority in the state. At times, the Council of Ministers may also include a deputy Chief Minister. The deputy chief ministers are appointed mostly for local political reasons. The cabinet ministers head the important departments of the state government like home, education, finance, agriculture, and so forth. 3. They are members of the cabinet, attend its meetings, and play an important role in deciding policies. Thus, their responsibilities extend over the entire gamut of state government. 3. The term ministry or ministries is used only in the center and not in the states. In other words, the state government is divided into departments and not ministries. The ministers of state can either be given independent charge of departments or can be attached to cabinet ministers. However, they are not members of the cabinet and do not attend the cabinet meetings unless specially invited when something related to their departments are considered by the cabinet. Next in rank are the deputy ministers. They are not given independent charge of departments. They are attached to the cabinet ministers and assist them in their administrative, political, and parliamentary duties. They are not members of the cabinet and do not attend cabinet meetings. Cabinet. A smaller body called cabinet is the nucleus of the Council of Ministers. It consists of only the cabinet ministers. It is the real center of authority in the state government. It performs the following role. 1. It is the highest decision-making authority in the politico-administrative system of a state. 2. It is the chief policy-formulating body of the state government. 3. It is the supreme executive authority of the state government. 4. It is the chief coordinator of the state administration. 5. It is an advisory body to the governor. 6. It is the chief crisis manager and thus deals with all emergency situations. 7. It deals with all major legislative and financial matters. State Council of Ministers 333. 8. It exercises control over higher appointments like constitutional authorities and senior secretariat administrators. Cabinet committees. The cabinet works through various committees called cabinet committees. They are of two types, standing and ad hoc. The former are of a permanent nature, while the latter are of a temporary nature. They are set up by the chief minister according to the exigencies of the time and requirements of the situation. Hence, their number, nomenclature, and composition varies from time to time. They not only sort out issues and formulate proposals for the consideration of the cabinet but also take decisions. However, the cabinet can review their decisions. Table 32.1 Articles related to the State Council of Ministers at a glance. Rights of ministers as respects the houses. Article No. Subject matter. I-63, _ Council of Ministers to aid and advise Governor F-164. Other provisions as to ministers. Conduct of business of the government of a state 67. Duties of chief minister as respects the furnishing of information to governor, etc. 177. Chapter State Legislature. State legislature occupies a preeminent and central position in the political system of a state. Articles 168 to 212 and Part 6 of the Constitution deal with the organization, composition, duration, officers, procedures, privileges, powers, and so on of the state legislature. Though these are similar to that of Parliament, there are some differences as well. Organization of state legislature. There is no uniformity in the organization of state legislatures. Most of the states have a unicameral system, while others have a bicameral system. At present, only 6 states have 2 houses bicameral. These are Andhra Pradesh, Telangana, Uttar Pradesh, Bihar, Maharashtra, and Karnataka. The Jammu and Kashmir Legislative Council was abolished by the Jammu and Kashmir Reorganization Act, 2019.1. The Tamil Nadu Legislative Council Act, 2010 has not come into force. The Legislative Council in Andhra Pradesh was revived by the Andhra Pradesh Legislative Council Act, 2005. The 7th Amendment Act of 1956 provided for a legislative council in Madhya Pradesh. However, a notification to this effect has to be made by the President. So far, no such notification has been made. Hence, Madhya Pradesh continues to have one house only. 2M.P. Jain, Indian Constitutional Law, Wadhwa 4th edition, p. 159. The erstwhile state of Jammu and Kashmir had adopted a bicameral legislature by its own state constitution, which was separate from the Indian Constitution. The 22 states have a unicameral system. Here, the state legislature consists of the governor and the legislative assembly. In the states having bicameral system, the state legislature consists of the governor, the legislative council, and the legislative assembly. The legislative council, Vidhan Parishad, is the upper house second chamber or house of elders, while the legislative assembly, Vidhan Sabha, is the lower house first chamber or popular house. The Constitution, Article 169, provides for the abolition or creation of legislative councils in states. Accordingly, the Parliament can abolish a legislative council, where it already exists, or create it, where it does not exist, if the legislative assembly of the concerned state passes a resolution to that effect. Such a specific resolution must be passed by the state assembly by a special majority, that is, a majority of the total membership of the assembly and a majority of not less than 2/3 of the members of the assembly present and voting. This act of Parliament is not to be deemed as an amendment of the Constitution for the purposes of Article 368 and is passed like an ordinary piece of legislation, i.e., by simple majority. The idea of having a second chamber in the states was criticized in the Constituent Assembly on the ground that it was not representative of the people, that it delayed legislative process, and that it was an expensive institution too. Consequently, the provision was made for the abolition or creation of a legislative council to enable a state to have a second chamber, or not according to its own willingness and financial strength. For example, Andhra Pradesh got the Legislative Council created in 1957 and got the same abolished in 1985. The Legislative Council in Andhra Pradesh was again revived in 2007 after the enactment of the Andhra Pradesh Legislative Council Act, 2005. The Legislative Council of Tamil Nadu had been abolished in 1986 and that of Punjab and West Bengal in 1969. In 2010, the Legislative Assembly of Tamil Nadu passed a resolution for the revival of the Legislative Council in the state. Accordingly, the Parliament enacted the Tamil Nadu Legislative Council Act, 2010, which provided for the creation of Legislative Council in the state. However, before this act was enforced, the Legislative Assembly of Tamil Nadu passed another resolution in 2011 seeking the abolition of the proposed Legislative Council. The various laws made by the Parliament, under Article 169 of the Constitution, for the abolition or creation of state legislative councils are mentioned in Table 33.4. T. Composition of two houses. Composition of assembly strength. The Legislative Assembly consists of representatives directly elected by the people on the basis of universal adult franchise. Its maximum strength is fixed at 500 and minimum strength at 60. It means that its strength varies from 60 to 500 depending on the population size of the state. However, in case of Arunachal Pradesh, Sikkim and Goa, the minimum number is fixed at 30, and in case of Mizoram and Nagaland, it is 40 and 46 respectively. Further, some members of the legislative assemblies in Sikkim and Nagaland are also elected indirectly. The strength of legislative assemblies is indicated in TBLI 33.2. Nominated member. Before 2020, the governor nominated one member from the state legislature, 335. Anglo-Indian community 3 to the assembly, if the community was not adequately represented. Originally, this provision was to operate for 10 years, i.e., up to 1960, only. Later, this duration has been extended continuously since then by 10 years each time. The last extension up to 2020 was made by the 95th Amendment Act, 2009. But the 104th Amendment Act, 2019, has not extended further the operation of this provision. In other words, the amendment discontinued this provision of special representation of the Anglo-Indian community in the Assembly by nomination. Consequently, this provision ceased to have effect on the January 25, 2020. 3. An Anglo-Indian means a person whose father or any other male progenitor in the male line is or was of European descent, but who is domiciled within the territory of India and is or was born within such territory of parents habitually resident therein and not established there for temporary purposes only. Territorial constituencies. For the purpose of holding direct elections to the Assembly, each state is divided into territorial constituencies. The demarcation of these constituencies is done in such a manner that the ratio between the population of each constituency and the number of seats allotted to it is the same throughout the state. In other words, the Constitution ensures that there is uniformity of representation between different constituencies in the state. The expression population means the population is ascertained at the last preceding census of which the relevant figures have been published. Readjustment after each census. After each census, a readjustment is to be made in the A. Total number of seats in the assembly of each state and B. The division of each state into territorial constituencies. The Parliament is empowered to determine the authority and the manner in which it is to be made. Accordingly, Parliament has enacted the Delimitation Commission Acts in 1952, 1962, 1972, and 2002 for this purpose. The 42nd Amendment Act of 1976 had frozen total number of seats in the assembly of each state and the division of such state into territorial constituencies till the year 2000 at the 1971 level. This ban on readjustment has been extended for another years, i.e., up to year 2026, by the 84th Amendment Act of 2001 with the same objective of encouraging population limiting measures. The 84th Amendment Act of 2001 also empowered the government to undertake readjustment and rationalization of territorial constituencies in a state on the basis of the population figures of 1991 census. Later, the 87th Amendment Act of 2003 provided for the delimitation of constituencies on the basis of 2001 census and not 1991 census. However, this can be done without altering the total number of seats in the assembly of each state. Reservation of seats for SCs and STs. The Constitution provided for the reservation of seats for scheduled castes and scheduled tribes in the assembly of each state on the basis of population ratios. Originally, this reservation was to operate for 10 years, i.e., up to 1960. But this duration has been extended continuously since then by 10 years each time. Now, under the 104th Amendment Act of 2019, this reservation is to last until 2030. The seats reserved for SCs and STS in the legislative assemblies is indicated in Table 33.2. Composition of council strength. Unlike the members of the Legislative Assembly, the members of the Legislative Council are indirectly elected. The maximum strength of the council is fixed at 1/3 of the total strength of the assembly, and the minimum strength is fixed at 40. It means that the size of the council depends on the size of the assembly of the concerned state. This is done to ensure the predominance of the directly elected House Assembly in the legislative affairs of the state. Though the Constitution has fixed the maximum and the minimum limits, the actual strength of a council is fixed by Parliament. The strength of legislature councils is indicated in FBLE 33.2. Manner of election of the total number of members of a legislative council. 1. 13 are elected by the members of local bodies in the state like municipalities, district boards, etc. 2. 112 are elected by graduates of 3 years standing and residing within the state. 3. 112 are elected by teachers of 3 years standing in the state, not lower in standard than secondary school. 4. 13 are elected by the members of the Legislative Assembly of the state from amongst persons who are not members of the Assembly. And 5. The remainder are nominated by the governor from amongst persons who have a special knowledge or practical experience of literature, science, art, cooperative movement, and social service. Thus, 56 of the total number of members of a legislative council are indirectly elected and 16 are nominated by the governor. The members are elected in accordance with the system of proportional representation by means of a single transferable vote. This scheme of composition of a legislative council as laid down in the Constitution is tentative and not final. The Parliament is authorized to modify or replace the same. However, it has not enacted any such law so far. Duration of 2 houses. Duration of assembly. Like the Lok Sabha, the Legislative Assembly is not a continuing chamber. Its normal term is 5 years from the date of its first meeting. This means that the number of assembly seats reserved in a state for such castes and tribes is to bear the same proportion to the total number of seats in the assembly as the population of such castes and tribes in the concerned state bears to the total population of the state. After the general elections. 8. The expiration of the period of 5 years operates as automatic dissolution of the assembly. However, the governor is authorized to dissolve the assembly at any time, i.e., even before the completion of 5 years, to pave the way for fresh elections. A minister in the union or state government is not considered as holding an office of profit. Also, the state legislature can declare that a particular office of profit will not disqualify its holder from its membership. Further, the term of the assembly can be extended during the period of national emergency by a law of Parliament for 1 year at a time, for any length of time. However, this extension cannot continue beyond a period of 6 months after the emergency has ceased to operate. This means that the assembly should be re-elected within 6 months after the revocation of emergency. Duration of council. Like the Rajya Sabha, the Legislative Council is a continuing chamber, that is, it is a permanent body and is not subject to dissolution. But 1/3 of its members retire on the expiration of every 2nd year. So, a member continues as such for 6 years. The vacant seats are filled up by fresh elections and nominations by governor at the beginning of every 3rd year. The retiring members are also eligible for re-election and renomination any number of times. Membership of state legislature. The Constitution lays down the following qualifications for a person to be chosen a member of the state legislature. A. Hisha must be a citizen of India. B. Hisha must make and subscribe to an oath or affirmation before the person authorized by the Election Commission for this purpose. In Hisha oath or affirmation, Hisha swears, £0 bear true faith and allegiance to the Constitution of India. 2. LB uphold the sovereignty and integrity of India. C. Hisha must be not less than 30 years of age in the case of the Legislative Council. State Legislature 337. And not less than 25 years of age in the case of the Legislative Assembly. D. Hisha must possess other qualifications prescribed by Parliament. Accordingly, the Parliament has laid down the following additional qualifications in the Representation of People Act, 1951. A. A person to be elected to the Legislative Council must be an elector for an assembly constituency in the concerned state, and to be qualified for the governor's nomination, Hisha must be a resident in the concerned state. B. A person to be elected to the Legislative Assembly must be an elector for an assembly constituency in the concerned state. C. Hisha must be a member of a scheduled caste or scheduled tribe if Hisha wants to contest a seat reserved for them. However, a member of scheduled castes or scheduled tribes can also contest a seat not reserved for them. AI disqualifications under the Constitution. A person shall be disqualified for being chosen as and for being a member of the Legislative Assembly or Legislative Council of a state. A. If Hisha holds any office of profit under the union or state government, except that of a minister or any other office exempted by state legislature. 5. B. If Hisha is of unsound mind and stands so declared by a court. C. If Hisha is an undischarged insolvent. D. If Hisha is not a citizen of India or has voluntarily acquired the citizenship of a foreign state or is under any acknowledgement of allegiance to a foreign state, and Ft. Hisha is so disqualified under any law made by Parliament. 338 Indian Polity. Accordingly, the Parliament has prescribed a number of additional disqualifications in the Representation of People Act, 1951. These are similar to those for Parliament. These are mentioned here. 1. Hisha must not have been found guilty of certain electoral offenses or corrupt practices in the elections. 2. Hisha must not have been convicted for any offense resulting in imprisonment for 2 or more years. But the detention of a person under a preventive detention law is not a disqualification. 3. Hisha must not have failed to lodge an account of Hisha election expenses within the time. 4. Hisha must not have any interest in government contracts, works, or services. 5. Hisha must not be a director or managing agent nor hold an office of profit in a corporation in which the government has at least 25% share. 6. Hisha must not have been dismissed from government service for corruption or disloyalty to the state. 7. Hisha must not have been convicted for promoting enmity between different groups or for the offense of bribery. 8. Hisha must not have been punished for preaching and practicing social crimes such as untouchability, dowry, and suttee. On the question whether a member has become subject to any of the above disqualifications, the governor's decision is final. However, Hisha should obtain the opinion of the Election Commission and act accordingly. Disqualification on ground of defection. The Constitution also lays down that a person shall be disqualified for being a member of either House of State Legislature if Hisha is so disqualified on the ground of defection under the provisions of the 10th Schedule. The question of disqualification under the T-H Schedule is decided by the Chairman, in the case of Legislative Council, and Speaker, in the case of Legislative Assembly, and not by the Governor. In Kahoto-Halahan case. 1992. 6 Kahoto-Halahan vs. Zakilhu, 1992. The Supreme Court ruled that the decision of Chairman Speaker in this regard is subject to judicial review. QI oath or affirmation. Every member of either House of State Legislature, before taking Hisha's seat in the House, has to make and subscribe an oath or affirmation before the Governor or some person appointed by him or for this purpose. In this oath, a member of the state legislature swears a. To bear true faith and allegiance to the Constitution of India, b. To uphold the sovereignty and integrity of India, and c. To faithfully discharge the duty of Hisha office. Unless a member takes the oath, Hisha cannot vote and participate in the proceedings of the House and does not become eligible to the privileges and immunities of the state legislature. A person is liable to a penalty of 500 for each day Hisha sits or votes as a member in a House, a. Before taking and subscribing the prescribed oath or affirmation, or b. When Hisha knows that Hisha is not qualified or that Hisha is disqualified for its membership, or c. When Hisha knows that Hisha is prohibited from sitting or voting in the House by virtue of any law made by the Parliament or the state legislature. The members of a state legislature are entitled to receive such salaries and allowances as may from time to time be determined by the state legislature. ESI vacation of seats. In the following cases, a member of the state legislature vacates Hisha's seat. A. Double membership. A person cannot be a member of both houses of state legislature at one and the same time. If a person is elected to both the houses, Hisha's seat in one of the houses falls State Legislature 339. Vacant as per the provisions of a law made by the state legislature. B. Disqualification. If a member of the state legislature becomes subject to any of the disqualifications, Hisha's seat becomes vacant. C. Resignation. A member may resign from Hisha's seat by writing to the Chairman of Legislative Council or Speaker of Legislative Assembly, as the case may be. The seat falls vacant when the resignation is accepted. 7. D. Absence. A House of the state legislature can declare the seat of a member vacant if Hisha absents himself or herself from all its meeting for a period of 60 days without its permission. E. Other cases. A member has to vacate his or her seat in either House of state legislature. I. If Hisha election is declared void by the court. 2. If Hisha is expelled by the House. 3. If Hisha is elected to the office of President or office of Vice President. And 4. If Hisha is appointed to the office of Governor of a state. T. Presiding officers of Vice State Legislature. Each House of State Legislature has its own presiding officer. There is a Speaker and a Deputy Speaker for the Legislative Assembly and a Chairman and a Deputy Chairman for the Legislative Council. A panel of Chairmen for the Assembly and a panel of Vice Chairmen for the Council is also appointed. The salaries and allowances of the Speaker and the Deputy Speaker of the Assembly and the Chairman and the Deputy Chairman of the Council are fixed by the state legislature. They are charged on the consolidated fund of the state and thus are not subject to the annual vote of the state legislature. However, the Chairman Speaker need not accept the resignation if Hisha is satisfied that it is not voluntary or genuine. Speaker of Assembly. The Speaker is elected by the Assembly itself from amongst its members. Usually, the Speaker remains in office during the life of the Assembly. However, Hisha vacates Hisha office earlier in any of the following 3 cases. 1. If Hisha ceases to be a member of the Assembly. 2. If Hisha resigns by writing to the Deputy Speaker. And 3. If Hisha is removed by a resolution passed by a majority of all the then members of the Assembly, i.e., an effective majority. Such a resolution can be moved only after giving 14 days advance notice. The Speaker has the following powers and duties. 1. Hisha maintains order and decorum in the Assembly for conducting its business and regulating its proceedings. This is Hisha's primary responsibility and she has final power in this regard. 2. Hisha is the final interpreter of the provisions of a. The Constitution of India, b. The rules of procedure and conduct of business of Assembly, and c. The legislative precedents within the Assembly. 3. PESA adjourns the assembly or suspends the meeting in the absence of a quorum. 4. PESA does not vote in the first instance, but PESA can exercise a casting vote in the case of a tie. 5. PESA can allow a secret sitting of the House at the request of the Leader of the House. 6. PESA decides whether a bill is a money bill or not, and his decision on this question is final. 7. PESA decides the questions of disqualification of a member of the Assembly, arising on the ground of defection under the provisions of the 10th Schedule. 8. PESA appoints the chairman of all the committees of the Assembly and supervises their functioning. PESA is the chairman of the Business Advisory Committee, the Rules Committee, and the General Purpose Committee. 340 Indian Polity. Deputy Speaker of Assembly. Like the Speaker, the Deputy Speaker is also elected by the Assembly itself from amongst its members. PESA is elected after the election of the Speaker has taken place. Like the Speaker, the Deputy Speaker remains in office usually during the life of the Assembly. However, PESA also vacates his office earlier in any of the following 3 cases. 1. If PESA ceases to be a member of the Assembly. 2. If PESA resigns by writing to the Speaker. And 3. If PESA is removed by a resolution passed by a majority of all the then members of the Assembly, i.e., an effective majority. Such a resolution can be moved only after giving 14 days advance notice. The Deputy Speaker performs the duties of the Speaker's office when it is vacant. She also acts as the Speaker when the latter is absent from the sitting of Assembly. In both the cases, PESA has all the powers of the Speaker. The Speaker nominates from amongst the members a panel of chairmen. Any one of them can preside over the Assembly in the absence of the Speaker or the Deputy Speaker. PESA has the same power as the Speaker when so presiding. PESA holds office until a new panel of chairmen is nominated. Chairman of Council. The chairman is elected by the Council itself from amongst its members. The chairman vacates his office in any of the following 3 cases. 1. If PESA ceases to be a member of the Council. 2. If PESA resigns by writing to the Deputy Chairman. And 3. If PESA is removed by a resolution passed by a majority of all the then members of the Council, i.e., an effective majority. Such a resolution can be moved only after giving 14 days advance notice. As a presiding officer, the power and functions of the chairman in the Council are similar to those of the Speaker in the Assembly. However, the Speaker has one special power which is not enjoyed by the chairman. The Speaker decides whether a bill is a money bill or not, and her decision on this question is final. Deputy Chairman of Council. Like the Chairman, the Deputy Chairman is also elected by the Council itself from amongst its members. The Deputy Chairman vacates his office in any of the following 3 cases. 1. If PESA ceases to be a member of the Council. 2. If PESA resigns by writing to the Chairman. And 3. If PESA is removed by a resolution passed by a majority of all the then members of the Council, i.e., an effective majority. Such a resolution can be moved only after giving 14 days advance notice. The Deputy Chairman performs the duties of the Chairman's office when it is vacant. PESA also acts as the Chairman when the latter is absent from the sitting of the Council. In both the cases, PESA has all the powers of the Chairman. The Chairman nominates from amongst the members a panel of Vice Chairmen. Any one of them can preside over the Council in the absence of the Chairman or the Deputy Chairman. She has the same powers as the Chairman when so presiding. PESA holds office until a new panel of Vice Chairmen is nominated. Sessions of State Legislature. Summoning. The Governor from time to time summons each House of State Legislature to meet. The maximum gap between the 2 sessions of State Legislature cannot be more than 6 months, i.e., the State Legislature should meet at least twice a year. A session of the State Legislature consists of many sittings. Adjournment. An adjournment suspends the work in a sitting for a specified time, which may be hours, days, or weeks. Adjournment sine die means terminating a sitting of the State Legislature for an indefinite period. The power of the adjournment as well as adjournment sine die lies with the presiding officer of the House. Prorogation. The presiding officer, Speaker, or Chairman, declares the House adjourned sine die when the business of the session is completed. Within the next few days, the Governor issues a notification for prorogation of the session. However, the Governor can also prorogue the House which is in session. Unlike an adjournment, a prorogation terminates a session of the House. Dissolution. The Legislative Council, being a permanent House, is not subject to dissolution. Only the Legislative Assembly is subject to dissolution. Unlike a prorogation, a dissolution ends the very life of the existing House, and a new House is constituted after the general elections are held. The position with respect to lapsing of bills on the dissolution of the Assembly is mentioned below. 1. A bill pending in the Assembly lapses, whether originating in the Assembly or transmitted to it by the Council. 2. A bill passed by the Assembly but pending in the Council lapses. 3. A bill pending in the Council but not passed by the Assembly does not lapse. 4. A bill passed by the Assembly in a unicameral state, or passed by both the Houses in a bicameral state, but pending assent of the Governor or the President does not lapse. State Legislature 341. 5. A bill passed by the Assembly in a unicameral state, or passed by both the Houses in a bicameral state, but returned by the President for reconsideration of House S, does not lapse. Quorum. Quorum is the minimum number of members required to be present in the House before it can transact any business. It is 10 members or 1/10 of the total number of members of the House, including the presiding officer, whichever is greater. If there is no quorum during a meeting of the House, it is the duty of the presiding officer either to adjourn the House or to suspend the meeting until there is a quorum. Voting in House. All matters at any sitting of either House are decided by a majority of votes of the members present and voting excluding the presiding officer. Only a few matters which are specifically mentioned in the Constitution require either effective majority or special majority, not simple majority. The presiding officer, i.e., Speaker in the case of Assembly or Chairman in the case of Council or the person acting as such, does not vote in the first instance, but exercises a casting vote in the case of an equality of votes. Language in state legislature. The Constitution has declared the official languages of the state or Hindi or English to be the languages for transacting business in the state legislature. However, the presiding officer can permit a member to address the House in his or mother tongue. The state legislature is authorized to decide whether to continue or discontinue English as a floor language after the completion of 15 years from the commencement of the Constitution, i.e., from 1965. In case of Himachal Pradesh, Manipur, Meghalaya, and Tripura, this time limit is 25 years, and that of Arunachal Pradesh, Goa, and Mizoram, it is 40 years. 342 Indian Polity. Rights of ministers and advocate general. In addition to the members of a House, every minister and the advocate general of the state have the right to speak and take part in the proceedings of either House or any of its committees of which HSA is named a member, without being entitled to vote. There are two reasons underlying this constitutional provision. 1. A minister can participate in the proceedings of a House of which HSA is not a member. 2. A minister, who is not a member of either House, can participate in the proceedings of both the Houses. 8. A person can remain a minister for 6 months without being a member of either House of the state legislature. Legislative procedure in state legislature. Ordinary bills. Bill in the originating House. An ordinary bill can originate in either House of the state legislature in case of a bicameral legislature. Such a bill can be introduced either by a minister or by any other member. The bill passes through 3 stages in the originating House, viz. 1. First reading, 2. Second reading, and 3. Third reading. After the bill is passed by the originating House, it is transmitted to the second House for consideration and passage. A bill is deemed to have been passed by the state legislature only when both the Houses have agreed to it, either with or without amendments. In case of a unicameral legislature, a bill passed by the Legislative Assembly is sent directly to the governor for his assent. Bill in the second House. In the second House also, the bill passes through all the 3 stages, that is, first reading, second reading, and third reading. When a bill is passed by the Legislative Assembly and transmitted to the Legislative Council, the latter has 4 alternatives before it. 1. It may pass the bill as sent by the Assembly, i.e., without amendments. 2. It may pass the bill with amendments and return it to the Assembly for reconsideration. 3. It may reject the bill altogether. And 4. It may not take any action and thus keep the bill pending. If the Council passes the bill without amendments or the Assembly accepts the amendments suggested by the Council, the bill is deemed to have been passed by both the Houses and the same is sent to the governor for his assent. On the other hand, if the Assembly rejects the amendments suggested by the Council or the Council rejects the bill altogether or the Council does not take any action for 3 months, then the Assembly may pass the bill again and transmit the same to the Council. If the Council rejects the bill again or passes the bill with amendments not acceptable to the Assembly or does not pass the bill within 1 month, then the bill is deemed to have been passed by both the Houses in the form in which it was passed by the Assembly for the second time. Therefore, the ultimate power of passing an ordinary bill is vested in the Assembly. At the most, the Council can detain or delay the bill for a period of 4 months, 3 months in the first instance and 1 month in the second instance. The Constitution does not provide for the mechanism of joint sitting of both the Houses to resolve the disagreement between the 2 Houses over a bill. On the other hand, there is a provision for joint sitting of the Lok Sabha and the Rajya Sabha to resolve a disagreement between the 2 over an ordinary bill. Moreover, when a bill, which has originated in the Council and was sent to the Assembly, is rejected by the Assembly, the bill ends and becomes dead. Thus, the Council has been given much lesser significance, position, and authority than that of the Rajya Sabha at the center. Assent of the governor. Every bill, after it is passed by the Assembly or by both the Houses in case of a bicameral legislature, is presented to the governor for his assent. There are 4 alternatives before the governor. 1. HSA may give his assent to the bill. 2. HSA may withhold his assent to the bill. 3. HSA may return the bill for reconsideration of the House or Houses. And 4. HSA may reserve the bill for the consideration of the President. If the governor gives his assent to the bill becomes an act and is placed on the statute book. If governor withholds his or her assent to the bill ends and does not become an act. If the governor returns the bill for reconsideration and if bill is passed by the House or both the Houses again, with or without amendments, and presented to the governor for his assent, the governor must give his assent to the bill. Thus, the governor enjoys only a suspensive veto. The position is same at the central level also. Assent of the President when a bill is reserved by the Governor for the consideration with the President. The President may either give issue assent to the bill or withhold issue assent to the bill or return the bill for reconsideration of the House or Houses of the state legislature. When a bill is so returned, the House or Houses have to reconsider it within a period of 6 months. The bill is presented again to the presidential assent after it is passed by the House or Houses with or without amendments. It is not mentioned in the Constitution whether it is obligatory on the part of the President to give issue assent to such a bill or not. Money bills. The Constitution lays down a special procedure for the passing of money bills in the state legislature. This is as follows. A money bill cannot be introduced in the Legislative Council. It can be introduced in the Legislative Assembly only and that too on State Legislature for 343. The recommendation of the Governor. Every such bill is considered to be a government bill and can be introduced only by a minister. After a money bill is passed by the Legislative Assembly, it is transmitted to the Legislative Council for its consideration. The Legislative Council has restricted powers with regard to a money bill. It cannot reject or amend a money bill. It can only make recommendations and must return the bill to the Legislative Assembly within 14 days. The Legislative Assembly can either accept or reject all or any of the recommendations of the Legislative Council. If the Legislative Assembly accepts any recommendation, the bill is then deemed to have been passed by both the Houses in the modified form. If the Legislative Assembly does not accept any recommendation, the bill is then deemed to have been passed by both the Houses in the form originally passed by the Legislative Assembly without any change. If the Legislative Council does not return the bill to the Legislative Assembly within 14 days, the bill is deemed to have been passed by both Houses at the expiry of the said period in the form originally passed by the Legislative Assembly. Thus, the Legislative Assembly has more powers than Legislative Council with regard to a money bill. At the most, the Legislative Council can detain or delay a money bill for a period of 14 days. Finally, when a money bill is presented to the Governor, PESA may either give issue assent, withhold issue assent, or reserve the bill for presidential assent, but cannot return the bill for reconsideration of the state legislature. Normally, the Governor gives his or her assent to a money bill as it is introduced in the state legislature with issue prior permission. When a money bill is reserved for consideration of the President may either give issue assent to the bill or withhold issue assent to the bill, but cannot return the bill for reconsideration of the state legislature. 344 Indian Polity. Bills reserved for President's consideration underscore in the Sarkaria Commission on Interstate Relations, 1963-88, classified the state bills reserved for President's consideration under the Constitution in the following three categories. 1. Bills which must be reserved for President's consideration. In this category come bills, which so derogate from the powers of the High Court as to endanger the position which that court is under the Constitution designed to fill, Article 200. 2. Which relate to imposition of taxes on water or electricity in certain cases and detract the provisions of Article 288. And 3. Which fall within Article 360 during a financial emergency. 2. Bills which may be reserved for President's consideration and assent for specific purposes. In this category, the following bills come. TB secure immunity from operation of Articles 14 and 19. These are bills for A. Acquisition of estates, etc. Article 31A. B. Giving effect to certain directive principles of state policy, Article 31. 1. 2. A bill relating to a subject enumerated in the concurrent list to ensure operation of its provisions despite their repugnancy to a union law or an existing law by securing President's assent in terms of Article 254. 3. A bill imposing restrictions on trade and commerce requiring prior presidential sanction which was not obtained under Article 304. 3. Bills which may not specifically fall under any of the above categories, yet may be reserved by the Governor for President's consideration under Article 200. Legislative procedure compared underscore a comparison of the legislature procedure in the Parliament and state legislature is given in Table 33.1. Table 33.1 comparing legislative procedure in the Parliament and state legislature. Parliament state legislature. A. With regard to ordinary bills. 1. It can be introduced in either house of the Parliament. 1. It can be introduced in either house of the state legislature. 2. It can be introduced either by a minister or by a private member. 2. It can be introduced either by a minister or by private member. 3. It passes through first reading, second reading, and third reading in the originating house. 3. It passes through first reading, second reading, and third reading in the originating house. 4. It is deemed to have been passed by the Parliament only when both the houses have agreed to it, either with or without amendments. 4. It is deemed to have been passed by the state legislature only when both the houses have agreed to it, either with or without amendments. 5. A deadlock between the two houses takes place when the second house, after receiving a bill passed by the first house, rejects the bill or proposes amendments that are not acceptable to the first house or does not pass the bill within 6 months. 5. A deadlock between the two houses takes place when the Legislative Council, after receiving a bill passed by the Legislative Assembly, rejects the bill or proposes amendments that are not acceptable to the Legislative Assembly or does not pass the bill within 3 months. State Legislature 345. Parliament State Legislature. 6. The Constitution provides for the mechanism of joint sitting of two houses of the Parliament to resolve a deadlock between them over the passage of a bill. 6. The Constitution does not provide for the mechanism of joint sitting of two houses of the state legislature to resolve a deadlock between them over the passage of a bill. 7. The Legislative Assembly can override the Legislative Council by passing the bill for the second time and not vice versa. When a bill is passed by the Assembly for the second time and transmitted to the Legislative Council, if the Legislative Council rejects the bill again, or proposes amendments that are not acceptable to the Legislative Assembly, or does not pass the bill within 1 month, then the bill is deemed to have been passed by both the houses in the form in which it was passed by the Legislative Assembly for the second time. 7. The Lok Sabha cannot override the Rajya Sabha by passing the bill for the second time and vice versa. A joint sitting is the only way to resolve a deadlock between the two houses. 8. The mechanism of joint sitting for resolving a deadlock applies to a bill whether originating in the Lok Sabha or the Rajya Sabha. If a joint sitting is not summoned by the President, the bill ends and becomes dead. B. With regard. 1. It can be introduced only in the Lok Sabha and not in the Rajya Sabha. 2. It can be introduced only on the recommendation of the President. 3. It can be introduced only by a minister and not by a private member. 4. It cannot be rejected or amended by the Rajya Sabha. It should be returned to the Lok Sabha within 14 days, either with or without recommendations. 5. The Lok Sabha can either accept or reject all or any of the recommendations of the Rajya Sabha. 6. If the Lok Sabha accepts any recommendation, the bill is then deemed to have been passed by both the houses in the modified form. 8. The mechanism of passing the bill for the second time to resolve a deadlock applies to a bill originating in the Legislative Assembly only. When a bill, which has originated in the Legislative Council and sent to the Legislative Assembly, is rejected by the latter, the bill ends and becomes dead. Archfic. RF. Are to money bills. 1. It can be introduced only in the Legislative Assembly and not in the Legislative Council. 2. It can be introduced only on the recommendation of the governor. 3. It can be introduced only by a minister and not by a private member. 4. It cannot be rejected or amended by the Legislative Council. It should be returned to the Legislative Assembly within 14 days, either with or without amendments. 5. The Legislative Assembly can either accept or reject all, or any of the recommendations of the Legislative Council. 6. If the Legislative Assembly accepts any recommendation, the bill is then deemed to have been passed by both the houses in the modified form. 7. If the Lok Sabha does not accept any recommendation, the bill is then deemed to have been passed by both the houses in the form originally passed by the Lok Sabha without any change. 8. If the Rajya Sabha does not return the bill to the Lok Sabha within 14 days, the bill is deemed to have been passed by both the houses at the expiration of the said period in the form originally passed by the Lok Sabha. 7. If the Legislative Assembly does not accept any recommendation, the bill is then deemed to have been passed by both the houses in the form originally passed by the Legislative Assembly without any change. 8. If the Legislative Council does not return the bill to the Legislative Assembly within 14 days, the bill is deemed to have been passed by both the houses at the expiration of the said period in the form originally passed by the Legislative Assembly. 9. The Constitution does not provide for the resolution of any deadlock between the two houses. This is because the will of the Lok Sabha is made to prevail over that of the Rajya Sabha if the latter does not agree to the bill passed by the former. 9. The Constitution does not provide for the resolution of any deadlock between the two houses. This is because the will of the Legislative Assembly is made to prevail over that of Legislative Council if the latter does not agree to the bill passed by the former. 346 Indian Polity. Position of Legislative Council underscore the constitutional position of the Council, as compared with the Assembly, can be studied from two angles. A. Spheres where Council is equal to Assembly. B. Spheres where Council is unequal to Assembly. Equal with Assembly in the following matters. The powers and status of the Council are broadly equal to that of the Assembly. 1. Introduction and passage of ordinary bills. However, in case of disagreement between the two houses, the will of the Assembly prevails over that of the Council. 2. Approval of ordinances issued by the governor. 3. Selection of ministers including the chief minister. Under the Constitution, the ministers including the chief minister can be members of either house of the state legislature. However, irrespective of their membership, they are responsible only to the Assembly. 4. Consideration of the reports of the constitutional bodies like State Finance Commission, State Public Service Commission, and Comptroller and Auditor General of India. 5. Enlargement of the jurisdiction of the State Public Service Commission. Unequal with Assembly in the following matters. The powers and status of the Council are unequal to that of the Assembly. 1. A money bill can be introduced only in the Assembly and not in the Council. 2. The Council cannot amend or reject a money bill. It should return the bill to the Assembly within 14 days, either with recommendations or without recommendations. Z. The Assembly can either accept or reject all or any of the recommendation of the Council. In both the cases, the money bill is deemed to have been passed by the two houses. 4. The final power to decide whether a particular bill is a money bill or not is vested in the Speaker of the Assembly. 5. The final power of passing an ordinary bill also lies with the Assembly. At the most, the Council can detain or delay the bill for the period of 4 months, 3 months in the first instance and 1 month in the second instance. In other words, the Council is not even a revising body like the Rajya Sabha. It is only a dilatory chamber or an advisory body. 6. The Council can only discuss the budget but cannot vote on the demands for grants, which is the exclusive privilege of the Assembly. 7. The Council cannot remove the Council of Ministers by passing a no-confidence motion. This is because the Council of Ministers is collectively responsible only to the Assembly. But the Council can discuss and criticize the policies and activities of the government. 8. When an ordinary bill, which has originated in the Council and was sent to the Assembly, is rejected by the Assembly, the bill ends and becomes dead. 9. The Council does not participate in the election of the President of India and representatives of the state in the Rajya Sabha. 10. The Council has no effective say in the ratification of a constitutional amendment bill. In this respect also, the will of the Assembly prevails over that of the Council. 9. The position in this regard is very well analyzed by J.C. Johari in the following way. The Constitution is not clear on this point whether a bill of constitutional amendment referred to the states for ratification by their legislatures shall include the Vidhan Parishad or not. In practice, it may be understood that the will of the Vidhan Sabha has to prevail. In case the Vidhan Parishad concurs with the view of State Legislature 347. 11. Finally, the very existence of the Council depends on the will of the Assembly. The Council can be abolished by the Parliament on the recommendation of the Assembly. From the above, it is clear that the position of the Council vis-a-vis the Assembly is much weaker than the position of the Rajya Sabha vis-a-vis the Lok Sabha. The Rajya Sabha has equal powers with the Lok Sabha in all spheres except financial matters and with regard to the control over the government. On the other hand, the Council is subordinate to the Assembly in all respects. Thus, the predominance of the Assembly over the Council is fully established. Even though both the Council and the Rajya Sabha are second chambers, the Constitution has given the Council much lesser importance than the Rajya Sabha due to the following reasons. 1. The Rajya Sabha consists of the representatives of the states and thus reflect the federal element of the polity. It maintains the federal equilibrium by protecting the interests of the states against the undue interference of the center. Therefore, it has to be an effective revising body and not just an advisory body or dilatory body like that of the Council. On the other hand, the issue of federal significance does not arise in the case of a Council. 2. The Council is heterogeneously constituted. It represents different interests and consists of differently elected members and also includes some nominated members. Its very composition makes its position weak and reduces its utility as an effective revising body. On the other hand, the Rajya Sabha is homogeneously constituted. It represents the states and union territories and consists of mainly elected members. Only 12 out of 250 are nominated. 3. The position accorded to the Council is in accordance with the principles of democracy. The Council should yield to the Assembly, which is a popular house. This pattern of relationship between the two houses of the state legislature is adopted from the British model. In Britain, the House of Lords, upper house, cannot oppose and obstruct the House of Commons, lower house. The House of Lords is only a dilatory chamber. It can delay an ordinary bill for a maximum period of 1 year and a money bill for 1 month. Keeping in view its weak, powerless, and insignificant position and role, the critics have described the Council as a secondary chamber, costly ornamental luxury, white elephant, etc. The critics have opined that the Council has served as a refuge for those who are defeated in the Assembly elections. It enabled the unpopular, rejected, and ambitious politicians to occupy the post of a chief minister or a member of the state legislature. Even though the Council has been given less powers as compared with the Assembly, its utility is supported on the following grounds. 1. It checks the hasty, defective, careless, and ill-considered legislation made by the Assembly by making provision for revision and thought. 2. It facilitates representation of eminent professionals and experts who cannot face direct elections. The governor nominates 1/6 members of the Council to provide representation to such people. Privileges of state legislature. Privileges of a state legislature are a sum of special rights, immunities, and exemptions enjoyed by the houses of state legislature, their committees, and their members. They are necessary in order to secure the independence and effectiveness of their actions. The Vidhan Sabha, it is all right. In case it differs, The Vidhan Sabha may pass it again and thereby ignore the will of the Vidhan Paris had as it can do in case of a non-money bill. Indian Government and Politics, Vishal, 13th edition, 2001, p. 441. 348 W. Indian Polity. Without these privileges, the houses can neither maintain their authority, dignity, and honor, nor can protect their members from any obstruction in the discharge of their legislative responsibilities. The Constitution has also extended the privileges of the state legislature to those persons who are entitled to speak and take part in the proceedings of a house of the state legislature or any of its committees. These include Advocate General of the state and state ministers. It must be clarified here that the privileges of the state legislature do not extend to the governor, who is also an integral part of the state legislature. The privileges of a state legislature can be classified into two broad categories: those that are enjoyed by each house of the state legislature collectively, and those that are enjoyed by the members individually. Collective privileges: the privileges belonging to each house of the state legislature collectively are: 1. It has the right to publish its reports, debates, and proceedings, and also the right to prohibit others from publishing the same. 111. 2. It can exclude strangers from its proceedings and hold secret sittings to discuss some important matters. 3. It can make rules to regulate its own procedure and the conduct of its business, and to adjudicate upon such matters. 4. It can punish members as well as outsiders for breach of its privileges or its contempt by reprimand, admonition, or imprisonment, also suspension or expulsion in case of members. 5. It has the right to receive immediate information of the arrest, detention. 10. The 44th Amendment Act of 1978 restored the freedom of the press to publish true reports of state legislature without its prior permission. But this is not applicable in the case of a secret sitting of the House. Conviction, imprisonment, and release of a member. 6. It can institute inquiries and order the attendance of witnesses and send for relevant papers and records. 7. The courts are prohibited to inquire into the proceedings of a House or its committees. 8. No person, either a member or outsider, can be arrested, and no legal process, civil or criminal, can be served within the precincts of the House without the permission of the presiding officer. Individual privileges: the privileges belonging to the members individually are: 1. They cannot be arrested during the session of the state legislature and 40 days before the beginning and 40 days after the end of such session. This privilege is available only in civil cases and not in criminal cases or preventive detention cases. 2. They have freedom of speech in the state legislature. No member is liable to any proceedings in any court for anything said or any vote given by him/her in the state legislature or its committees. This freedom is subject to the provisions of the Constitution and to the rules and standing orders regulating the procedure of the state legislature. 101. 3. They are exempted from jury service. They can refuse to give evidence and appear as a witness in a case pending in a court when the state legislature is in session. Article 211 of the Constitution says that no discussion shall take place in the legislature of a state with respect to the conduct of any judge of the Supreme Court or of a high court in the discharge of his/her duties. Under the rules of a houses of the state legislature, use of unparliamentary language or unparliamentary conduct of a member is prohibited. State Legislature 349. Table 33.2 Strength of legislative assemblies and legislative councils and seats reserved for SCs and STs in the legislative assemblies. S. No. Name of the number of seats in reserve for the number of seats in state union territory legislative assembly scheduled castes scheduled tribes legislative council. I. States. 1. Andhra Pradesh 175 29 758. 2. Arunachal Pradesh 60 59. 3. Assam 126 816. 4. Bihar 243 38 275. 5. Chhattisgarh 90 10 29. 6. Go 340 to 1. L. Gujarat 182 13 27. 8. Haryana 90 17 19. Himachal Pradesh 68 17 3. 17. 15. Manipur 61 19. V. 10. Jharkhandi 81 928. 11. Karnataka 224 36 1575. 12. Kerala 140 14 213. Madhya Pradesh 230 35 47 14. Maharashtra 288 29 2578. 18. Nagaland 60 to 59. 19. Odisha. Mumwu 71 147. 24. IT 33. 16. Meghalaya 60 55. Continued. 12. The Andhra Pradesh Reorganization Amendment Act 2015 increased the number of seats in the Legislative Council of Andhra Pradesh from 50 to 58. 350 p. Indian Polity. S. No. Name of the number of seats in State Union Territory Legislative Assembly. Reserved for the scheduled castes. Reserved for the scheduled tribes. Number of seats in Legislative Council. Mu. Uttar Pradesh 40385, 100. 28. West Bengal 294, 68, 16. 2. Union Territories. 1. NCT of Delhi 7012. 2. Puducherry 35. 3. Jammu and Kashmir 83-13-6. 1. Under the Jammu and Kashmir Reorganization Act, 2019, the total number of seats fixed for the Legislative Assembly of the Union Territory of Jammu and Kashmir is 107. But 24 seats fall in the Pakistan-occupied Kashmir, POK. These seats are vacant and are not to be taken into account for reckoning the total membership of the Assembly. Table 33.3 Articles related to State Legislature at a glance. 1. Article No. Subject Matter. General. 168. Constitution of Legislatures and States. 169. Abolition or creation of legislative councils and states. 170. Composition of the legislative assemblies. 171. Composition of the legislative councils. 172. Duration of state legislatures. 173. Qualification for membership of the state legislature. 174. Sessions of the state legislature, prorogation and dissolution. 175. Right of governor to address and send messages to the House or Houses. 176. Special address by the governor. 177. Rights of ministers and advocate general as respects the Houses. Officers of the state legislature. 178. The Speaker and Deputy Speaker of the Legislative Assembly. 179. Vacation and resignation of, and removal from, the offices of Speaker and Deputy Speaker. 180. Power of the Deputy Speaker or other person to perform the duties of the office of, or to act as, Speaker. 181. The Speaker or the Deputy Speaker not to preside while a resolution for his or removal from office is under consideration. 182. The Chairman and Deputy Chairman of the Legislative Council. 183. Vacation and resignation of, and removal from, the offices of Chairman and Deputy Chairman. 184. Power of the Deputy Chairman or other person to perform the duties of the office of, or to act as, Chairman. State Legislature. 351. Disqualifications of members. V. MJ. I. AZ. Article No. Subject Matter. 185. The Chairman or the Deputy Chairman not to preside while a resolution for his or removal from office is under consideration. 186. Salaries and allowances of the Speaker and Deputy Speaker and the Chairman and Deputy Chairman. 187. Secretariat of State Legislature. Conduct of business. 188. Oath or affirmation by members. 189. Voting in houses. Power of houses to act notwithstanding vacancies and quorum. 190. Vacation of seats. 191. Disqualifications for membership. 192. Decision on questions as to disqualifications of members. 193. Penalty for sitting and voting before making oath or affirmation under Article 188 or when not qualified or when disqualified. Powers, privileges, and immunities of state legislatures and their members. 194. Powers, privileges, etc. of the House of Legislatures and of the members and committees thereof. R-**= H.R. 195. Salaries and allowances of members. Legislative procedure. 196. Provisions as to introduction and passing of bills. 19.7. Restriction on powers of Legislative Council as to bills other than money bills. 198. Special procedure in respect of money bills. 199. Definition of money bills. 200. Assent to bills. 201. Bills reserved for consideration. Procedure in financial matters. 202. Annual financial statement. 203. Procedure in legislature with respect to estimates. 204. Appropriation bills. 205. Supplementary, additional, or excess grants. 206. Votes on account, votes of credit and exceptional grants. 207. Special provisions as to financial bills. Procedure generally. 208. Rules of procedure. 209. Regulation by law of procedure in the legislature of the state in relation to financial business. Continued. 352 Indian Polity. Article No. Subject Matter. 210. Language to be used in the legislature. 211. Restriction on discussion in the legislature. 212. Courts not to inquire into proceedings of the legislature. Legislative powers of the governor. 213. Power of governor to promulgate ordinances during recess of legislature. Table 33.4 Laws made by the Parliament, under Article 169 of the Constitution, for the abolition or creation of state legislative councils. SI. No. Acts provisions. 1. West Bengal Legislative Council Abolition Act, 1969 provided for the abolition of the Legislative Council of the State of West Bengal. 2. Punjab Legislative Council Abolition Act, 1969 provided for the abolition of the Legislative Council of the State of Punjab. 3. Andhra Pradesh Legislative Council Abolition Act, 1985 provided for the abolition of the Legislative Council of the State of Andhra Pradesh. 4. Tamil Nadu Legislative Council Abolition Act, 1986 provided for the abolition of the Legislative Council of the State of Tamil Nadu. 5. Andhra Pradesh Legislative Council Act, 2005 provided for the creation of Legislative Council for the State of Andhra Pradesh. 6. Tamil Nadu Legislative Council Act, 2010 provided for the creation of Legislative Council for the State of Tamil Nadu. Chapter 34 High Court. In the Indian single integrated judicial system, the High Court operates below the Supreme Court, but above the subordinate courts. The judiciary in a state consists of a High Court and a hierarchy of subordinate courts. The High Court occupies the top position in the judicial administration of a state. The institution of High Court originated in India in 1862 when the High Courts were set up at Calcutta, Bombay, and Madras. In 1866, a fourth High Court was established at Allahabad. In the course of time, each province in British India came to have its own High Court. After 1950, a High Court existing in a province became the High Court for the corresponding state. These three High Courts were set up under the provisions of the Indian High Courts Act, 1861. With the creation of three more new states in 2000, the number of High Courts increased from 18 to 21. Again, with the creation of separate High Courts for the three northeastern states of Manipur. The Constitution of India provides for a High Court for each state, but the 7th Amendment Act of 1956 authorized the Parliament to establish a common High Court for two or more states or for two or more states and a union territory. The territorial jurisdiction of a High Court is coterminous with the territory of a state. Similarly, the territorial jurisdiction of a common High Court is coterminous with the territories of the concerned states and union territory. At present, there are 25 High Courts in the country too. Out of them, only 3 High Courts have jurisdiction over more than one state. Among the 8 union territories, Delhi alone has a separate High Court since 1966. The union territories of Jammu and Kashmir and Ladakh have a common High Court. The other union territories fall under the jurisdiction of different state High Courts. The Parliament can extend the jurisdiction of a High Court to any union territory or exclude the jurisdiction of a High Court from any union territory. The name, year of establishment, territorial jurisdiction, and seat, with bench or benches, of all the 25 High Courts are mentioned in THB 34.1. Articles 214 to 231, in Part 6 of the Constitution, deal with the organization, independence, jurisdiction, powers, procedures, and so on of the High Courts. Composition and appointment. Every High Court, whether exclusive or common, consists of a Chief Justice and such other judges as the President may from time to time deem necessary to appoint. Thus, the Constitution does not specify the strength of a High Court and leaves it to the discretion of the President. Accordingly, the President determines the strength of a High Court from time to time depending upon its workload. Meghalaya and Tripura in 2013, the number of High Courts increased from 21 to 24. Further, with the establishment of a separate High Court for the state of Andhra Pradesh in 2019, the number of High Courts increased from 24 to 25. 354 Indian Polity. Appointment of judges. The judges of a High Court are appointed by the President. The Chief Justice is appointed by the President after consultation with the Chief Justice of India and the Governor of the state concerned. For appointment of other judges, the Chief Justice of the concerned High Court is also consulted. In case of a common High Court for 2 or more states, the governors of all the states concerned are consulted by the President. In the second Judges Case 1, 1993, the Supreme Court ruled that no appointment of a judge of the High Court can be made, unless it is in conformity with the opinion of the Chief Justice of India. In the third Judges Case 34, 1998, the Supreme Court opined that in case of the appointment of High Court judges, the Chief Justice of India should consult a collegium of 2 senior-most judges of the Supreme Court. Thus, the sole opinion of the Chief Justice of India alone does not constitute the consultation process. 3 Supreme Court Advocates on Record Association vs. Union of India, 1993. For Inchesry Presidential Reference, 1998. The President sought the Supreme Court's opinion, under Article 143, on certain doubts over the consultation process to be adopted by the Chief Justice of India as stipulated in the 1993 case. AA Supreme Court Advocates on Record Association vs. Union of India 2015. The 99th Constitutional Amendment Act of 2014 and the National Judicial Appointments Commission Act of 2014 have replaced the collegium system of appointing judges to the Supreme Court and High Courts with a new body called the National Judicial Appointments Commission, NJC. However, in 2015, the Supreme Court has declared both the 99th Constitutional Amendment as well as the NJC Act as unconstitutional and void. Consequently, the earlier collegium system became operative again. This verdict was delivered by the Supreme Court in the Fourth Judge's Case 4-2015. The court opined that the new system, i.e., NJC, would affect the independence of the judiciary. Degree qualifications, oath and salaries. Qualifications of judges. A person to be appointed as a judge of a high court should have the following qualifications. 1. Pisha should be a citizen of India. 2. A. Pisha should have held a judicial office in the territory of India for 10 years. Or B. Pisha should have been an advocate of a high court or high courts in succession for 10 years. From the above, it is clear that the Constitution has not prescribed a minimum age for appointment as a judge of a high court. Moreover, unlike in the case of the Supreme Court, the Constitution makes no provision for the appointment of a distinguished jurist as a judge of a high court. Oath or affirmation. A person appointed as a judge of a high court, before entering upon his office, has to make and subscribe to an oath or affirmation before the governor of the state or some person appointed by him or her for this purpose. In his oath, the judge of a high court swears, 1. To bear true faith and allegiance to the Constitution of India. 2. To uphold the sovereignty and integrity of India. 3. To duly and faithfully and to the best of his ability, knowledge and judgment perform the duties of the office without fear or favor, affection or ill will. And 4. To uphold the Constitution and the laws. Salaries and allowances. The salaries, allowances, privileges, leave and pension of the judges of a high court are determined from time to time by the Parliament. They cannot be varied to their disadvantage after their appointment except during a financial emergency. In 2018, the salary of the Chief Justice was increased from $90,000 to 2.50 lakh per month, and that of a judge from $80,000 to 2.25 lakh per month. 5. They are also paid sumptuary allowance and provided with free accommodation and other facilities like medical, car, telephone, etc. 5 inches 1950, their salaries were fixed at T4,000 per month and T3,500 per month respectively. In 1986, their salaries were raised to T9,000 per month and 8,000 per month respectively. In 1998, their salaries were raised to T30,000 per month and T26,000 per month respectively. In 2009, their salaries were raised to T90,000 per month and T80,000 per month respectively. The retirement age has been raised from 60 to 62 years by the 15th Amendment Act of 1963. The retired Chief Justice and judges are entitled to 50% of their last drawn salary as monthly pension. Tenure, removal, and transfer. Tenure of judges. The Constitution has not fixed the tenure of a judge of a high court. However, it makes the following 4 provisions in this regard. 1. Pisha holds office until Pisha attains the age of 62 years. Any questions regarding his age is to be decided by the President after consultation with the Chief Justice of India, and the decision of the President is final. 6. 2. Pisha can resign his office by writing to the President. 3. Pisha can be removed from his office by the President on the recommendation of the Parliament. 4. Pisha vacates his office when Pisha is appointed as a judge of the Supreme Court or when Pisha is transferred to another high court. Removal of judges. A judge of a high court can be removed from his office by an order of the President. The President can issue the removal order only after an address by the Parliament has been presented to him or her in the same session for such removal. The address. High Court 355. Must be supported by a special majority of each House of Parliament, i.e., a majority of the total membership of that House and majority of not less than 2/3 of the members of that House present and voting. The grounds for removal are 2. Proved misbehavior or incapacity. Thus, a judge of a high court can be removed in the same manner and on the same grounds as a judge of the Supreme Court. The Judges Inquiry Act, 1968, regulates the procedure relating to the removal of a judge of a high court by the process of impeachment. 1. A removal motion signed by 100 members, in the case of Lok Sabha, or 50 members, in the case of Rajya Sabha, is to be given to the Speaker Chairman. 2. The Speaker Chairman may admit the motion or refuse to admit it. 3. If it is admitted, then the Speaker Chairman is to constitute a 3-member committee to investigate into the charges. 4. The committee should consist of A. The Chief Justice or a judge of the Supreme Court, B. Chief Justice of a High Court, and C. A distinguished jurist. 5. If the committee finds the judge to be guilty of misbehavior or suffering from an incapacity, the House can take up the consideration of the motion. 6. After the motion is passed by each House of Parliament by a special majority, an address is presented to the President for removal of the judge. 7. Finally, the President passes an order removing the judge. From the above, it is clear that the procedure for the impeachment of a judge of a high court is the same as that for a judge of the Supreme Court. It is interesting to know that no judge of a high court has been impeached so far. Transfer of judges. The President can transfer a judge from one high court to another after consulting the Chief Justice of India. On transfer, Husha is entitled to receive in addition to his salary such compensatory allowance as may be determined by Parliament. $356 Indian Polity. In 1977, the Supreme Court ruled that the transfer of high court judges could be resorted to only as an exceptional measure and only in public interest and not by way of punishment. Again in 1994, the Supreme Court held that judicial review is necessary to check arbitrariness and transfer of judges. But only the judge who is transferred can challenge it. In the third judge's case, 1998, the Supreme Court opined that in case of the transfer of high court judges, the Chief Justice of India should consult, in addition to the collegium of 4 senior-most judges of the Supreme Court, the Chief Justice of the 2 high courts, one from which the judge is being transferred and the other receiving him or her. Thus, the sole opinion of the Chief Justice of India does not constitute the consultation process. Acting, additional and retired judges _ Acting Chief Justice. The President can appoint a judge of a high court as an acting Chief Justice of the High Court when 1. The office of Chief Justice of the High Court is vacant, or 2. The Chief Justice of the High Court is temporarily absent, or 3. The Chief Justice of the High Court is unable to perform the duties of his office. Additional and acting judges. The President can appoint duly qualified persons as additional judges of a high court for a temporary period not exceeding 2 years when 1. There is a temporary increase in the business of the High Court, or 2. There are arrears of work in the High Court. The President can also appoint a duly qualified person as an acting judge of a high court when a judge of that high court, other than the Chief Justice, is 1. Unable to perform the duties of his office due to absence or any other reason, or 2. Appointed to act temporarily as Chief Justice of that high court. An acting judge holds office until the permanent judge resumes his office. However, both the additional or acting judge cannot hold office after attaining the age of 62 years. Retired judges. At any time, the Chief Justice of a high court of a state can request a retired judge of that high court or any other high court to act as a judge of the high court of that state for a temporary period. Husha can do so only with the previous consent of the President and also of the person to be so appointed. Such a judge is entitled to such allowances as the President may determine. Husha will also enjoy all the jurisdiction, powers and privileges of a judge of that high court. But Husha will not otherwise be deemed to be a judge of that high court. Independence of high court. The independence of a high court is very essential for the effective discharge of the duties assigned to it. It should be free from the encroachments, pressures, and interferences of the executive, council of ministers, and the legislature. It should be allowed to do justice without fear or favor. The Constitution has made the following provisions to safeguard and ensure the independent and impartial functioning of a high court. Mode of appointment. The judges of a high court are appointed by the President, which means the Cabinet, in consultation with the members of the Judiciary itself, i.e., Chief Justice of India and the Chief Justice of the High Court. This provision curtails the absolute discretion of the executive as well as ensures that the judicial appointments are not based on any political or practical considerations. 2. Security of tenure. The judges of a high court are provided with the security of tenure. They can be removed from office by the President only in the manner and on the grounds mentioned in the Constitution. This means that they do not hold their office during the High Court 357. Pleasure of the President, though they are appointed by him or her. This is obvious from the fact that no judge of a high court has been removed or impeached so far. 3. Fixed service conditions. The salaries, allowances, privileges, leave and pension of the judges of a high court are determined from time to time by the Parliament. But they cannot be changed to their disadvantage after their appointment except during a financial emergency. Thus, the conditions of service of the judges of a high court remain same during their term of office. 4. Expenses charged on consolidated fund. The salaries and allowances of the judges, the salaries, allowances and pensions of the staff as well as the administrative expenses of a high court are charged on the consolidated fund of the state. Thus, they are non-votable by the state legislature, though they can be discussed by it. It should be noted here that the pension of a high court judge is charged on the consolidated fund of India and not the state. 5. Conduct of judges cannot be discussed. The Constitution prohibits any discussion in Parliament or in a state legislature with respect to the conduct of the judges of a high court in the discharge of their duties, except when an impeachment motion is under consideration of the Parliament. 6. Ban on practice. After retirement, the retired permanent judges of a high court are prohibited from pleading or acting in any court or before any authority in India except the Supreme Court and the other high courts. This ensures that they do not favor anyone in the hope of future favor. 7. Power to punish for its contempt. A high court can punish any person for its contempt. Thus, its actions and decisions cannot be criticized and opposed by anybody. This power is vested in a high court to maintain its authority, dignity, and honor. 8. Freedom to appoint its staff. The Chief Justice of a High Court can appoint officers and servants of the High Court without any interference from the executive. HUSHA can also prescribe their conditions of service. 9. Its jurisdiction cannot be curtailed. The jurisdiction and powers of a High Court insofar as they are specified in the Constitution cannot be curtailed both by the Parliament and the state legislature. Jurisdiction and powers of High Court. Like the Supreme Court, the High Court has been vested with quite extensive and effective powers. It is the highest court of appeal in the state. It is the protector of the fundamental rights of the citizens. It is vested with the power to interpret the Constitution. Besides, it has supervisory and consultative roles. However, the Constitution does not contain detailed provisions with regard to the jurisdiction and powers of a High Court. It only lays down that the jurisdiction and powers of a High Court are to be the same as immediately before the commencement of the Constitution. But there is one addition, that is, the Constitution gives a High Court jurisdiction over revenue matters, which it did not enjoy in the pre-Constitution era. The Constitution also confers, by other provisions, some more additional powers on a High Court like writ jurisdiction, power of superintendence, consultative power, etc. At present, a High Court enjoys the following jurisdiction and powers. 1. Original jurisdiction. 2. Writ jurisdiction. 3. Appellate jurisdiction. 4. Supervisory jurisdiction. 5. Control over subordinate courts. 6. A court of record. 7. Power of judicial review. The present jurisdiction and powers of a High Court are governed by a. The constitutional provisions, b. The letters patent, c. The acts of Parliament, d. The acts of state legislature, e. Indian Penal Code, 1860, f. Criminal Procedure Code, 1973, and g. Civil Procedure Code, 1908. 358 are Indian Polity. BL Original jurisdiction. It means the power of a High Court to hear disputes in the first instance, not by way of appeal. It extends to the following. A. Disputes relating to the election of members of Parliament and state legislatures. B. Regarding revenue matter or an act ordered or done in revenue collection. C. Enforcement of fundamental rights of citizens. D. Cases ordered to be transferred from a subordinate court involving the interpretation of the Constitution to its own file. E. The 4 High Courts, IC, Calcutta, Bombay, Madras, and Delhi High Courts, have original civil jurisdiction in cases of higher value. Before 1973, the Calcutta, Bombay, and Madras High Courts also had original criminal jurisdiction. But this was fully abolished by the Criminal Procedure Code, 1973. BL Writ jurisdiction. Article 226 of the Constitution empowers a High Court to issue writs including habeas corpus, mandamus, certiorari, prohibition and quo warranto for the enforcement of the fundamental rights of the citizens and for any other purpose. The phrase "for any other purpose" refers to the enforcement of an ordinary legal right. The High Court can issue writs to any person, authority, and government not only within its territorial jurisdiction but also outside its territorial jurisdiction if the cause of action arises within its territorial jurisdiction. 7. The second provision was added by the 15th Constitutional Amendment Act of 1963. S.L. Chandrakumar vs. Union of India, 1997. The writ jurisdiction of the High Court, under Article 226, is not exclusive but concurrent with the writ jurisdiction of the Supreme Court, under Article 32. It means, when the fundamental rights of a citizen are violated, the aggrieved party has the option of moving either the High Court or the Supreme Court directly. However, the writ jurisdiction of the High Court is wider than that of the Supreme Court. This is because the Supreme Court can issue writs only for the enforcement of fundamental rights and not for any other purpose. That is, it does not extend to a case where the breach of an ordinary legal right is alleged. In the Chandrakumar case, 1997, the Supreme Court ruled that the writ jurisdiction of both the High Court and the Supreme Court constitute a part of the basic structure of the Constitution. Hence, it cannot be ousted or excluded even by way of an amendment to the Constitution. Appellate jurisdiction. A High Court is primarily a court of appeal. It hears appeals against the judgments of subordinate courts functioning in its territorial jurisdiction. It has appellate jurisdiction in both civil and criminal matters. Hence, the appellate jurisdiction of a High Court is wider than its original jurisdiction. A. Civil matters. The civil appellate jurisdiction of a High Court is as follows. I. First, appeals from the orders and judgments of the district courts, additional district courts, and other subordinate courts lie directly to the High Court on both questions of law and fact if the amount exceeds the stipulated limit. 2. Second, appeals from the orders and judgments of the district court or other subordinate courts to the High Court in the cases involving questions of law only and not questions of fact. 3. Some High Courts have provision for intra-court appeals. When a single judge of the High Court has decided a case, either under the original or appellate jurisdiction of the High Court, an appeal from such a decision lies to the division bench of the same High Court. 4. Appeals from the decisions of the administrative and other tribunals lie to the division bench of the state High Court. In 1997, the Supreme Court ruled. 3. High Court 359. That the tribunals are subject to the writ jurisdiction of the High Courts. Consequently, it is not possible for an aggrieved person to approach the Supreme Court directly against the decisions of the tribunals without first going to the high courts. B. Criminal matters. The criminal appellate jurisdiction of a high court is as follows. I. Appeals from the judgments of Sessions Court and Additional Sessions Court lie to the High Court if the sentence is one of imprisonment for more than 7 years. It should also be noted here that a death sentence, popularly known as capital punishment, awarded by a Sessions Court or an Additional Sessions Court should be confirmed by the High Court before it can be executed, whether there is an appeal by the convicted person or not. 2. In some cases specified in various provisions of the Criminal Procedure Code, 1973, the appeals from the judgments of the Assistant Sessions Judge, Metropolitan Magistrate, or other magistrates judicial lie to the High Court. L. Supervisory jurisdiction. A High Court has the power of superintendence over all courts and tribunals functioning in its territorial jurisdiction, except military courts or tribunals. Thus, it may A. Call for returns from them, B. Make and issue general rules and prescribe forms for regulating the practice and proceedings of them, C. Prescribe forms in which books, entries, and accounts are to be kept by them, and D. Settle the fees payable to the sheriff, clerks, officers, and legal practitioners of them. This power of superintendence of a high court is very broad because I. It extends to all courts and tribunals whether they are subject to the appellate jurisdiction of the high court or not. 2. It covers not only administrative superintendents but also judicial superintendents. 3. It is a revisional jurisdiction. And 4. It can be suo motu on its own and not necessarily on the application of a party. However, this power does not vest the High Court with any unlimited authority over the subordinate courts and tribunals. It is an extraordinary power and hence has to be used most sparingly and only in appropriate cases. Usually, it is limited to I. Excess of jurisdiction, 2. Gross violation of natural justice, 3. Error of law, 4. Disregard to the law of superior courts, v. Perverse findings, and 6. Manifest injustice. 31. Control over subordinate courts. In addition to its appellate jurisdiction and supervisory jurisdiction over the subordinate courts as mentioned above, a high court has an administrative control and other powers over them. These include the following. A. It is consulted by the governor in the matters of appointment, posting, and promotion of district judges and in the appointments of persons to the judicial service of the state, other than district judges. B. It deals with the matters of posting, promotion, grant of leave, transfers, and discipline of the members of the judicial service of the state, other than district judges. C. It can withdraw a case pending in a subordinate court if it involves a substantial question of law that require the interpretation of the Constitution. It can then either dispose of the case itself or determine the question of law and return the case to the subordinate court with its judgment. D. Its law is binding on all subordinate courts functioning within its territorial jurisdiction in the same sense as the law declared by the Supreme Court is binding on all courts in India. $360 Indian Polity BL. A court of record. As a court of record, a high court has two powers. A. The judgments, proceedings, and acts of the high courts are recorded for perpetual memory and testimony. These records are admitted to be of evidentiary value and cannot be questioned when produced before any subordinate court. They are recognized as legal precedents and legal references. B. It has power to punish for contempt of itself. The expression contempt of court has not been defined by the Constitution. However, the expression has been defined by the Contempt of Courts Act of 1971. Under this, contempt of court may be civil or criminal. According to this act, a high court has power to punish for contempt of not only itself but also contempt of subordinate courts. However, no high court shall take cognizance of a contempt alleged to have been committed in respect of a subordinate court, where such contempt is an offense punishable under the Indian Penal Code, 1860. As a court of record, a high court also has the power to review and correct its own judgment or order or decision, even though no specific power of review is conferred on it by the Constitution. The Supreme Court, on the other hand, has been specifically conferred with the power of review by the Constitution. BL. Power of judicial review. Judicial review is the power of a high court to examine the constitutionality of legislative enactments and executive orders of both the central and state governments. On examination, if they are found to be violative of the Constitution, ultra vires, they can be declared as illegal, unconstitutional, and invalid, null and void, by the High Court. Consequently, they cannot be enforced by the government. Though the phrase judicial review has nowhere been used in the Constitution, the provisions of Articles 13 and 226 explicitly confer the power of judicial review on a high court. The constitutional validity of a legislative enactment or an executive order can be challenged in a high court on the following three grounds. A. It infringes the fundamental rights, Part 3. B. It is outside the competence of the authority which has framed it. And C. It is repugnant to the constitutional provisions. The 42nd Amendment Act of 1976 curtailed the judicial review power of high court. It debarred the high courts from considering the constitutional validity of any central law. However, the 43rd Amendment Act of 1977 restored the original position. Table 34.1 Name and jurisdiction of high courts. Name year of establishment. Territorial jurisdiction seat. 1. Allahabad 1866 Uttar Pradesh Prayagraj, Allahabad, Benchat. Lucknow. 2. Andhra Pradesh 2019 Andhra Pradesh Amaravati. 3. Bombay 9 1862 Maharashtra, Goa and Dadra and Nagar Haveli and Daman and Diu. Mumbai, benches at Nagpur, Panaji and Aurangabad. 4. Calcutta 9 1862 West Bengal and Andaman and Nicobar Islands. Kolkata, circuit benches at Port Blair and Jalpaiguri. Though the names of Bombay, Calcutta and Madras are changed to Mumbai, Kolkata and Chennai respectively, the names of respective high courts are not changed. High Court 361. Odisha Cuttack. 1916 Bihar Patna. Chandigarh. Jodhpur Bench at Jaipur. Gangtok. Agartala. Nainital. 18. Orissa 13. Hyderabad. 1948. Name year of establishment. Territorial jurisdiction seat. 5. Chhattisgarh 2000 Chhattisgarh Bilaspur 6. Delhi. 1966 NCT of Delhi New Delhi. 7. Guwahati 194819 Assam, Nagaland, Mizoram and Arunachal Pradesh. Guwahati, benches at Kohima, Asval and Atangar. 8. Gujarat 1960 Gujarat Ahmedabad. 9. Himachal Pradesh 1971 Himachal Pradesh Shimla. 10. Jammu and Kashmir and Ladakh 11. 1928 Jammu and Kashmir and Ladakh Srinagar and Jammu. 11. Jharkhand 2000 Jharkhand Ranchi 12. Karnataka 188412 Karnataka Bengaluru, benches at Dharwad. 77. And Gulbarga, 13. Kerala 1956 Kerala and Lakshadweep Ernakulam 14. Madhya Pradesh 1956 Madhya Pradesh Jabalpur, benches at Gwalior and Indore. 15. Madras 9 1862 Tamil Nadu and Puducherry Chennai, bench at Madurai. 16. Manipur 2013 Manipur Impulse 17. Meghalaya 2013 Meghalaya Shillong. Originally known as Assam High Court and renamed Guwahati High Court in 1971. Originally known as the High Court of Jammu and Kashmir and renamed as the High Court of Jammu and Kashmir and Ladakh in 2021. Originally known as Mysore High Court and renamed Karnataka High Court in 1973. Though the name of Orissa is changed to Odisha, the name of Orissa High Court is not changed. Originally known as Punjab High Court and renamed Punjab and Haryana High Court in 1966. Originally known as Andhra Pradesh High Court, established in 1954. In 2014, it was renamed as the High Court of Judicature at Hyderabad and was made a common high court for the states of Andhra Pradesh and Telangana. Again, with the establishment of a separate high court for the state of Andhra Pradesh in 2019, it became the High Court for the state of Telangana. 19. Patna. 20. Punjab and Haryana 14. 1947 Punjab, Haryana and Chandigarh. 21. Rajasthan 1949 Rajasthan 22 Sikkim 1975 Sikkim 23. Telangana 15 1954 Telangana I-24. Tripura 2013 Tripura 25. Uttarakhand 2000 Uttarakhand 362 P. Indian Polity. Table 34.2 Articles related to High Courts at a glance. Article No. Subject Matter. 214. High Courts for States. 215. High Courts to be Courts of Record. 216. Constitution of High Courts. 217. Appointment and conditions of the office of a judge of a High Court. 218. Application of certain provisions relating to Supreme Court to High Courts. 219. Oath or affirmation by judges of High Courts. 220. Restriction on practice after being a permanent judge. 221. Salaries, etc. of judges. 222. Transfer of a judge from one High Court to another. 223. Appointment of acting Chief Justice. 224. Appointment of additional and acting judges. 224A. Appointment of retired judges at sittings of High Courts. 225. Jurisdiction of existing High Courts. 226. Power of High Courts to issue certain writs. 226A. Constitutional validity of central laws not to be considered in proceedings under Article 226 repealed. 227. Power of superintendence over all courts by the High Court. 228. Transfer of certain cases to High Court. 228A. Special provisions as to disposal of questions relating to constitutional validity of state laws, repealed. 229. Officers and servants and the expenses of High Courts. 230. Extension of jurisdiction of High Courts to Union territories. 231. Establishment of a common High Court for two or more states. 232. Interpretation, repealed, Chapter 35 Subordinate Courts. The state judiciary consists of a High Court and a hierarchy of subordinate courts, also known as lower courts. The subordinate courts are so called because of their subordination to the state High Court. They function below and under the High Court at district and lower levels. Constitutional provisions. Articles 233 to 237 in Part 6 of the Constitution make the following provisions to regulate the organization of subordinate courts and to ensure their independence from the executive one. The 20th Constitutional Amendment Act of 1966 added a new Article 233, which retrospectively validated the appointment of certain district judges as well as the judgments delivered by them. 1. Appointment of district judges. The appointment, posting, and promotion of district judges in a state are made by the governor of the state in consultation with the High Court. A person to be appointed as a district judge should have the following qualifications. A. He should not already be in the service of the central or the state government. B. He should have been an advocate or a pleader for 7 years. C. He should be recommended by the High Court for appointment. 2. Appointment of other judges. Appointment of persons, other than district judges, to the judicial service of a state are made by the governor of the state after consultation with the State Public Service Commission and the High Court. 2. 3. Control over subordinate courts. The control over district courts and other subordinate courts, including the posting, promotion, and leave of persons belonging to the judicial service of a state and holding any post inferior to the post of district judge, is vested in the High Court. 4. Interpretation. The expression district judge includes the judges of a city civil court, additional district judge, joint district judge, assistant district judge, chief judge of a small cause court, chief presidency magistrate, additional chief presidency magistrate, sessions judge, additional sessions judge, and assistant sessions judge. The expression judicial service means a service consisting exclusively of persons intended to fill the post of district judge and other civil judicial posts inferior to the post of a district judge. 5. Application of the above provisions to certain magistrates. The governor may direct that the above-mentioned provisions relating to persons in the state judicial service would apply to any class or classes of magistrates in the state. Structure and jurisdiction. The organizational structure, jurisdiction, and nomenclature of the subordinate judiciary are laid down by the states. Hence, they differ. In practice, the State Public Service Commission conducts a competitive examination for recruitment to the judicial service of the state. 36040 Indian Polity. Slightly from state to state. Broadly speaking, there are 3 tiers of civil and criminal courts below the High Court. This is shown as follows. High Court 1. District and Sessions Judges Court. IA-1. Civil side, criminal side, II. Subordinate Chief Judicial Judges Court. Magistrates Court. Munsif's Court. Judicial. Magistrates Court. The district judge is the highest judicial authority in the district. He possesses original and appellate jurisdiction in both civil as well as criminal matters. In other words, the district judge is also the sessions judge. When he deals with civil cases, he is known as the district judge, and when he hears the criminal cases, he is called as the sessions judge. The district judge exercises both judicial and administrative powers. He also has supervisory powers over all the subordinate courts in the district. Appeals against he orders and judgments lie to the High Court. The sessions judge has the power to impose any sentence, including life imprisonment and capital punishment, death sentence. However, a capital punishment passed by him/her is subject to confirmation by the High Court, whether there is an appeal or not. Below the district and sessions court stands the Court of Subordinate Judges on the civil side and the Court of Chief Judicial Magistrates on the criminal side. The subordinate judge exercises unlimited pecuniary jurisdiction over civil suits. 3. The Chief Judicial Magistrate decides criminal cases which are punishable with imprisonment for a term of up to 7 years. At the lowest level on the civil side is the Court of Munds IFF, and on the criminal side is the Court of Judicial Magistrate. The Munsif possesses limited jurisdiction and decides civil cases of small pecuniary stake. 1. The Judicial Magistrate tries criminal cases which are punishable with imprisonment for a term of up to 3 years. In some metropolitan cities, there are city civil courts, chief judges, on the civil side and the courts of metropolitan magistrates on the criminal side. Some of the states and presidency towns have established small causes courts. 1. These courts decide the civil cases of small value in a summary manner. Their decisions are final, but the High Court possesses the power of revision. In some states, Panchayat courts try petty civil and criminal cases. They are variously known as Naya Panchayat, Gram Kachari, Adalati Panchayat, Panchayat Adalat, and so on. A subordinate judge is also known as civil judge, senior division, civil judge, class I, and so on. He may also be given the powers of an assistant sessions judge. In such a case, he combines in himself/herself both civil as well as criminal powers like that of a district judge. For a Munsif is also known as civil judge, junior division, civil judge, class 2, and so on. Delhi, Bombay, Calcutta, and Madras were formerly called presidency towns. Table 35.1 Articles related to subordinate courts at a glance. Article No. Subject Matter. 233. Appointment of district judges. 233a. Validation of appointments of, and judgments, etc. Delivered by certain district judges. 234. Recruitment of persons other than district judges to the judicial service. 235. Control over subordinate courts. 236. Interpretation. 237. Application of the provisions of this chapter to certain class or classes of magistrates. Chapter 36. Tribunals. The original Constitution did not contain provisions with respect to tribunals. The 42nd Amendment Act of 1976 added a new Part XIVA to the Constitution. This part is entitled as Tribunals and consists of only two articles: Article 323A dealing with administrative tribunals and Article 323B dealing with tribunals for other matters. Administrative tribunals. Article 323A empowers the Parliament to provide for the establishment of administrative tribunals for the adjudication of disputes relating to recruitment and conditions of service of persons appointed to public services of the center, the states, local bodies, public corporations, and other public authorities. In other words, Article 323A enables the Parliament to take out the adjudication of disputes relating to service matters from the civil courts and the high courts and place it before the administrative tribunals. In pursuance of Article 323A, the Parliament has passed the Administrative Tribunals Act in 1985. The Act authorizes the central government to establish one central administrative tribunal and the state administrative tribunals. This Act opened a new chapter in the sphere of providing speedy and inexpensive justice to the aggrieved public servants. Central Administrative Tribunal, CAT. The Central Administrative Tribunal, CAT, was set up in 1985 with the principal bench at New Delhi and additional benches in different states. At present, it has 19 regular benches, 17 of which operate at the principal seats of high courts and the remaining 2 at Jaipur and Lucknow. These benches also hold circuit sittings at other seats of high courts. The name and jurisdiction of benches of CAT are given in FLE 36.1. Similarly, the details of circuit sittings of benches of CAT are given in FLE 36.2. The CAT exercises original jurisdiction in relation to recruitment and all service matters of public servants covered by it. Its jurisdiction extends to the All India Services, the Central Civil Services, civil posts under the Centre, and civilian employees of defense services. However, the members of the defense forces, officers and servants of the Supreme Court, and the secretarial staff of the Parliament are not covered by it. The CAT is a multi-member body consisting of a chairman and members. Originally, the CAT consisted of a chairman, vice-chairman, and members. Later, in 2006, the provision for the vice-chairman was removed by the Administrative Tribunals Amendment Act 2006. Hence, there is now no vice-chairman in the CAT. At present, the sanctioned strength of the chairman is 1 and sanctioned strength of the members is 69. They are drawn from both judicial and administrative streams. But, a person who has not completed the age of 50 years is not eligible for appointment as a chairman or member. They hold office for a term of 4 years or until they attain the age of 70 years in case of chairman and 67 years in case of members, whichever is earlier. 1. As per the Tribunals Reforms Act, 2021. 366 F. Indian Polity. The appointment of chairman and members in the CAT is made by the central government on the basis of recommendations of a search-cum-selection committee chaired by the Chief Justice of India or a judge of Supreme Court, who is nominated by the Chief Justice of India. The CAT is not bound by the procedure laid down in the Civil Procedure Code of 1908. It is guided by the principles of natural justice. These principles keep the CAT flexible in approach. Only a nominal fee of 50 is to be paid by the applicant. The applicant may appear either in person or through a lawyer. Originally, appeals against the orders of the CAT could be made only in the Supreme Court and not in the high courts. However, in the Chandra Kumar case, 23, 1997, the Supreme Court declared this restriction on the jurisdiction of the high courts as unconstitutional, holding that judicial review is a part of the basic structure of the Constitution. It laid down that appeals against the orders of the CAT shall lie before the division bench of the concerned high court. Consequently, now it is not possible for an aggrieved public servant to approach the Supreme Court directly against an order of the CAT, without first going to the concerned high court. 2L. Chandrakumar's Union of India, 1997. Clause 2D of Article 323A was declared as unconstitutional. 3 added by the 75th Amendment Act of 1993. 4L. Chandrakumar's Union of India, 1997. Clause 2D of Article 323A and Clause 3D of Article 3238 were declared as unconstitutional. State Administrative Tribunals. The Administrative Tribunals Act of 1985 empowers the central government to establish the State Administrative Tribunals, SAT, on specific request of the concerned state governments. Like the CAT, the SAC exercise original jurisdiction in relation to recruitment and all service matters of state government employees. The chairman and members of the SATs are appointed by the central government on the recommendations of a search-cum-selection committee chaired by the Chief Justice of the High Court of the concerned state. The Act also makes a provision for setting up off-joint administrative tribunal, JAT, for 2 or more states. A JAT exercises all the jurisdiction. and powers exercisable by the administrative tribunals for such states. Tribunals for other matters. Under Article 323b, the Parliament and the state legislatures are authorized to provide for the establishment of tribunals for the adjudication of disputes relating to the following matters: A. Taxation, B. Foreign exchange, import and export, C. Industrial and labor, D. Land reforms, E. Sealing on urban property, F. Elections to Parliament and state legislatures, G. Foodstuffs, H. Rent and tenancy rights. 5. Articles 323a and 323b differ in the following three aspects. 1. While Article 323a contemplates establishment of tribunals for public service matters only, Article 323b contemplates establishment of tribunals for certain other matters, mentioned above. 2. While tribunals under Article 323a can be established only by Parliament, tribunals under Article 323b can be established both by Parliament and state legislatures with respect to matters falling within their legislative competence. 3. Under Article 323a, only one tribunal for the center and one for each state or two or more states may be established. There is no question of hierarchy of tribunals, whereas under Article 323b a hierarchy of tribunals may be created. In the Chandrakumar case 4, 1997, the Supreme Court declared those provisions of these two articles which excluded the jurisdiction of the High Courts and the Supreme Court as unconstitutional. Hence, the judicial remedies are now available against the orders of these tribunals. Tribunals 367. Table 36.1 Name and jurisdiction of benches of the CAT. NCT of Delhi, Uttar Pradesh except the districts covered by the Lucknow bench, and Uttarakhand. 3. Lucknow bench Uttar Pradesh except the districts covered by the Allahabad bench. 5. Hyderabad bench Andhra Pradesh and Telangana. Bangalore bench Karnataka Tamil Nadu and Puducherry Image Kerala and Lakshadweep. 9. Bombay bench Maharashtra, Goa and Dadra and Nagar Haveli. And Daman and Diu. Ahmedabad bench Gujarat. Rajasthan except the districts covered by the Jaipur bench. Rajasthan except the districts covered by the Jodhpur bench. Haryana, Himachal Pradesh, Punjab and Chandigarh. Madhya Pradesh and Chhattisgarh. Bihar and Jharkhand. Assam, Meghalaya, Manipur, Tripura, Nagaland, Mizoram and Arunachal Pradesh. Table 36.2 Circuit sittings of benches of CAT. Territorial jurisdiction of the bench. Jammu and Kashmir, except the districts covered by the Jammu bench, and Kargil district of Ladakh. Jammu and Kashmir, except the districts covered by the Srinagar bench, and Leh district of Ladakh. West Bengal, Sikkim and Andaman and Nicobar Islands. 2. Allahabad bench. 4. Cuttack bench. 7. Madras bench. 1. Principal bench, New Delhi. SI. No. Bench. Ernakulam bench. 7. 11. Jodhpur bench. 12. Jaipur bench. 13. Chandigarh bench. 14. Jabalpur bench. 15. Patna bench. I6. Calcutta bench. 17. Guwahati bench. 18. Jammu bench. 19. Srinagar bench. Continued. 368-0 Indian Polity. SI. No. Bench circuit sittings held at 5. Guwahati bench Shillong, Atangar, Kohima, Agratla, Impal, Aizwal. 6. Jabalpur bench Indore, Gwalior, Bilaspur. 7. Bombay bench Nagpur, Aurangabad, Panaji. 8. Patna bench Ranchi. 9. Ernakulam bench Lakshadweep. 323b. Table 36.3 Articles related to tribunals at a glance. Article No. Subject Matter. 323a. Administrative Tribunals. Tribunals for Other Matters Chapter 5S Consumer Commissions. The Consumer Protection Act, 2019 has repealed and replaced the earlier Consumer Protection Act, 1986. Like the new Act also provides for the establishment of a three-tier consumer dispute redressal machinery at the district, state, and national levels. These are called as the District Consumer Disputes Redressal Commission, the State Consumer Disputes Addressal Commission, and the National Consumer Disputes Redressal Commission. In brief, they are known as the District Commission, the State Commission, and the National Commission respectively. The three-level hierarchy of the Consumer Commissions provides an alternative DISPT resolution mechanism exclusively for consumers. These are quasi-judicial bodies. They are also popularly known as consumer forums or consumer courts. The District Commission is established in MEM Ho 0 degree FHN, he state, over MIT. However, the state government may A to the power of O establish more than one district commission in a district. The Tam-T, C degree mission is established in Ord and 1 BFI the SU government. It shall ordinarily function at the state capital and perform its functions at such other places as the state government may notify. This is done 76 government in consultation with the State Commission. Further, the State Gov. 7 ALS degree Estab HSH Inal branches OT the State Commission. TIN's information is adopted from the official web. SIE of the National Consumer Disputes Redressal Commission. 2. As per the Consumer Protection Consumer Disputes Redressal Commission's Rules, 2020. The National Commission is established the central government. It shall ordinarily function at the national capital region and perform its functions at such other places as the central government may notify. This is done by the central government in consultation with the National Commission. Further, the central government may also establish regional branches of the National Commission. At present, there are 678 district commissions and 35 state commissions with the National Commission at the apex. The National Commission was constituted in 19881. National Consumer Disputes Redressal Commission. HI composition. The National Commission shall consist of a president and not less than 4 or not more than such number of members as may be prescribed. Accordingly, in 2020, the central government has prescribed that the National Commission shall consist of a president and not less than 4 or not more than 11 members. Further, out of these 11 members, at least 1 member shall be a woman too. The central government may make rules to provide for qualifications, appointment, salaries and allowances, resignation, removal and other conditions of service of the president and members of the National Commission. 370 Indian Polity. The president and members of the National Commission are appointed by the central government on the recommendations of a search cum selection committee chaired by the Chief Justice of India or a judge of Supreme Court, who is nominated by the Chief Justice of India. But a person who has not completed the age of 50 years is not eligible for appointment as a president or member. They hold office for a term of 4 years or until they attain the age of 70 years in case of president and 67 years in case of members, whichever is earlier. 211. 2. 1. As per the Tribunals Reforms Act, 2021. As per the Consumer Protection, Jurisdiction of the District Commission, the State Commission, and the National Commission, Rules, 2021. Neither the salary and allowances nor the other terms and conditions of service of the President or any other member of the National Commission shall be varied to his disadvantage after his appointment. Al jurisdiction. The National Commission has the pecuniary jurisdiction, the appellate jurisdiction, and the revisional jurisdiction. These are explained below. 1. Pecuniary jurisdiction. The National Commission shall have jurisdiction to entertain complaints where the value of the goods or services paid as consideration exceeds Rs 10 crores. But the central government may prescribe such other values as it deems fit. Accordingly, in 2021, this limit was reduced to above Rs 2 crores 3. 2. Appellate jurisdiction. The National Commission shall have jurisdiction to entertain appeals against the orders of any state commission. The appeal may be made within 30 days from the date of the order of the state commission. But the National Commission may entertain an appeal filed after the expiry of 30 days if it is satisfied that there was sufficient cause for not filing the appeal within the given time. Further, the National Commission shall also have jurisdiction to entertain appeals against the orders of the Central Consumer Protection Authority, CCPA. The appeal may be made within 30 days from the date of receipt of the order of the CCPA. 3. Revisional jurisdiction. The National Commission shall have jurisdiction to call for the records and pass appropriate orders in any consumer dispute which is pending before or has been decided by any state commission in the following circumstances. I. If the state commission has exercised a jurisdiction not vested in it by law, or 2. If state commission has failed to exercise a jurisdiction so vested, or 3. If state commission has acted in the exercise of its jurisdiction illegally, or with material irregularity. L. Other powers. In addition to the above jurisdiction, the National Commission has the following other powers. 1. The National Commission may declare any terms of contract, which is unfair to any consumer, to be null and void. 2. The National Commission shall have the power to review any of the orders passed by it if there is an error apparent on the face of the record. This can be done by the Commission either of its motion or on an application made by any of the parties within 30 days of such order. 3. Where an order is passed by the National Commission ex parte, the aggrieved party may make an application to the Commission for setting aside such order. 4. The National Commission may transfer any complaint pending before the Consumer Commission's 31. District Commission of one state to a District Commission of another state, or before one state commission to another state commission. This can be done by the Commission either on the application of the complainant or of its own motion. An appeal against the order of the National Commission lies with the Supreme Court. The appeal can be made within 30 days from the date of the order of the National Commission. However, the Supreme Court may entertain an appeal filed after the expiry of 30 days if it is satisfied that there was sufficient cause for not filing the appeal within the given time. Administrative control. The National Commission shall have administrative control over all the state commissions in the following matters. 1. Monitoring the performance of the state commissions in terms of their disposal of cases. This includes calling for periodical returns regarding the institution, disposal, and pendency of cases. 2. Investigating any allegations against the President and members of a state commission and submitting inquiry reports to the concerned state government. 3. Issuance of instructions regarding the following matters. Adoption of uniform procedures in the hearing of matters. Prohibit. 2. Prior service of copies of documents produced by one party to the opposite parties. In furnishing of English translation of judgments written in any language. 4. Speedy grant of copies of documents. 4. overseeing the functioning of the State Commission or the District Commission either by way of inspection or by any other methods to ensure that the objectives of this Act are best served without interfering with their quasi-judicial freedom. State Consumer Disputes. Redressal Commission B. Composition. Each State Commission shall consist of a president and not less than 4 or not more than such number of members as may be prescribed, in consultation with the central government. The central government may make rules to provide for the qualifications for appointment, method of recruitment, procedure of appointment, term of office, resignation, and removal of the president and members of the State Commission. The state government may make rules to provide for salaries and allowances and other terms and conditions of service of the president and members of the State Commission. EB jurisdiction. The State Commission has the pecuniary jurisdiction, the appellate jurisdiction, and the revisional jurisdiction. These are explained below. 1. Pecuniary jurisdiction. The State Commission shall have jurisdiction to entertain complaints where the value of the goods or services paid as consideration exceeds rupees 1 crore but does not exceed rupees 10 crores. But the central government may prescribe such other values as it deems fit. Accordingly, in 2021, this limit was reduced to above rupees 50 lakhs but up to rupees 2 crores for. 2. Appellate jurisdiction. The State Commission shall have jurisdiction to entertain appeals against the orders of any district commission within the state. The appeal may be made within 45 days from the date of the order of the district commission. But the State 372 Indian Polity. Commission may entertain an appeal filed after the expiry of 45 days if it is satisfied that there was sufficient cause for not filing the appeal within the given time. 3. Revisional jurisdiction. The State Commission shall have jurisdiction to call for the records and pass appropriate orders in any consumer dispute which is pending before or has been decided by any district commission within the state in the following circumstances. I. If district commission has exercised a jurisdiction not vested in it by law, or 2. If district commission has failed to exercise a jurisdiction so vested, or 3. If the district commission has acted in exercise of its jurisdiction illegally or with material irregularity. L. Other powers. In addition to the above jurisdiction, the State Commission has the following other powers. 1. The State Commission may declare any terms of contract, which is unfair to any consumer, to be null and void. 2. The State Commission shall have the power to review any of the order passed by it if there is an error apparent on the face of the record. This can be done by the Commission either off its own motion or on an application made by any of the parties within 30 days of such order. 3. The State Commission may transfer any complaint pending before a district commission to another district commission within the state. This can be done by the Commission either on the application of the complainant or of its own motion. 4. The State Commission shall have administrative control over all the district commissions within its jurisdiction. F. District Consumer Disputes Redressal Commission BL Composition. Each district commission shall consist of a president and not less than 2 or not more than such number of members as may be prescribed, in consultation with the central government. The central government may make rules to provide for the qualifications for appointment, method of recruitment, procedure for appointment, term of office, resignation, and removal of the president and members of the district commission. The state government may make rules to provide for salaries and allowances and other terms and conditions of service of the president and members of the district commission. If there is a vacancy in the office of the president or member of a district commission, then the state government may direct a. Any other specified district commission to exercise the jurisdiction in respect of that district also. Or b. The president or a member of any other specified district commission to exercise the power and discharge the functions of the president or member of that district commission also. AI jurisdiction. The district commission shall have jurisdiction to entertain complaints where the value of the goods or services paid as consideration does not exceed rupees 1 crore. But the central government may prescribe such other value as it deems fit. Accordingly, in 2021, this limit was reduced to up to rupees 50 lakhs. The district commission shall ordinarily function in the district headquarters. It may also perform its functions at such other place. 5. IBID. Consumer Commissions 373. Either of its own motion or on an application made by any of the parties within 30 days of such order. The pecuniary jurisdiction of the District Commission, the State Commission, and the National Commission is mentioned in FLE 37.1. In the district, as the state government may notify. This is done by the state government in consultation with the State Commission. The District Commission shall have the power to review any of the order passed by it if there is an error apparent on the face of the record. This can be done by the Commission. Table 37.1 Pecuniary jurisdiction of the Consumer Commissions. SI. No. Name under 2021 rules under 2019 Act under 1986 Act District Commission up to Rs. 50 lakhs up to Rs. 1 crore up to Rs. 20 lakhs 2. State Commission above Rs. 50 lakhs but up to Rs. 2 crores. Above Rs. 1 crore but up to Rs. 10 crores. Above Rs. 20 lakhs but up to Rs. 1 crore. 3. National Commission above Rs. 2 crores above Rs. 10 crores above Rs. 1 crore. Chapter 38 Lakh Adalats and Other Courts. National Legal Services Authority 1. This information is adopted from the website of the Department of Justice, Ministry of Law and Justice, Government of India. Article 39A of the Constitution of India provides for free legal aid to the poor and weaker sections of the society and ensures justice for all. Further, Articles 14 and 22(1) of the Constitution also make it obligatory for the state to ensure equality before law and a legal system which promotes justice on the basis of equal opportunity to all. In the year 1987, the Legal Services Authorities Act was enacted by the Parliament, which came into force on November 9, 1995, to establish a nationwide uniform network for providing free and competent legal services to the weaker sections of the society on the basis of equal opportunity. The National Legal Services Authority, NALSA, has been constituted under the Legal Services Authorities Act, 1987 to monitor and evaluate implementation of legal aid programs and to lay down policies and principles for making legal services available under the Act. In every state, a state legal services authority, and in every high court, a high court legal services committee have been constituted. The district legal services authorities, think legal services committees, have been constituted in the districts and most of the flux to give effect to the policies and directions of the NALSA and to provide free legal services to the people and conduct lock adalats in the state. The Supreme Court Legal Services Committee has been constituted to administer and implement the legal services program insofar as it relates to the Supreme Court of India. The NALSA lays down policies, principles, guidelines, and frames effective and economical schemes for the state legal services authorities to implement the legal services programs throughout the country. Primarily, the state legal services authorities, district legal services authorities, FLUC legal services committees, etc., have been asked to discharge the following main functions on regular basis. 1. To provide free and competent legal services to the eligible persons. 2. To organize lock adalats for amicable settlement of disputes. 3. Organize legal awareness camps in the rural areas. The free legal services include a. Payment of court fee, process fees, and all other charges payable or incurred in connection with any legal proceedings. b. Providing service of lawyers in legal proceedings. c. Obtaining and supply of certified copies of orders and other documents in legal proceedings. d. Preparation of appeal, paper book including printing and translation of documents in legal proceedings. The persons eligible for getting free legal services include I. Women and children. The second, members of SSC. 3. Industrial workmen. 4. Victims of mass disaster, violence, flood, drought, earthquake, industrial disaster. v. Disabled persons. 6. Persons in custody. 7. Persons whose annual income does not exceed $1 lakh. In the Supreme Court Legal Services Committee, the limit is 5,000,000. 8. Victims of trafficking in human beings or beggar. F. Locadalats. The lockadalat is a forum where the cases or disputes, which are pending in a court or which are at pre-litigation stage, not yet brought before a court, are compromised or settled in an amicable manner. Meaning. The Supreme Court has explained the meaning of the institution of lockadalat in the following way too. 2 points. Thomas versus Thomas Job, 2005. The lockadalat is an old form of adjudicating system prevailed in ancient India, and its validity has not been taken away even in the modern days. The word lockadalat means people's court. This system is based on Gandhian principles. It is one of the components of the ADR, Alternative Dispute Resolution System. As the Indian courts are overburdened with the backlog of cases, and the regular courts are to decide the cases involving a lengthy, expensive, and tedious procedure. The court takes years together to settle even petty cases. The lockadalat, therefore, provides alternative resolution or devise for expeditious and inexpensive justice. In lockadalat proceedings, there are no victors and vanquished, and, thus, no rancor. The experiment of lockadalat as an alternate mode of dispute settlement has come to be accepted in India as a viable, economic, efficient, and informal one. Lockadalats and other courts. 375. The lockadalat is another alternative in judicial justice. This is a recent strategy for delivering informal, cheap, and expeditious justice to the common man by way of settling disputes, which are pending in courts, and also those which have not yet reached courts, by negotiation, conciliation, and by adopting persuasive, common sense, and human approach to the problems of the disputants, with the assistance of specially trained and experienced members of a team of conciliators. Features. The first lockadalat camp in the post-independence era was organized in Gujarat in 1982. This initiative proved very successful in the settlement of disputes. Consequently, the institution of lockadalat started spreading to other parts of the country. At that time, this institution was functioning as a voluntary and conciliatory agency without any statutory backing for its decisions. In view of its growing popularity, there arose a demand for providing a statutory backing to this institution in the awards given by lockadalats. Hence, the institution of lockadalat has been given statutory status under the Legal Services Authorities Act, 1987. The Act makes the following provisions relating to the organization and functioning of the lockadalats. 1. the State Legal Services Authority, or the District Legal Services Authority, or the Supreme Court Legal Services Committee, or the High Court Legal Services Committee, or the THLUC Legal Services Committee may organize lock adalats at such intervals and places and for exercising such jurisdiction and for such areas as it thinks fit. 2. Every lock adalat organized for an area shall consist of such number of serving or retired judicial officers and other persons of the area as may be specified by the agency organizing such lock adalat. Generally, a lock adalat consists of a judicial officer as the chairman and a 376 Indian Polity, lawyer, advocate, and a social worker as members. 3. A lock adalat shall have jurisdiction to determine and to arrive at a compromise or settlement between the parties to a dispute in respect of I. Any case pending before any court, or 2. Any matter which is falling within the jurisdiction of any court and is not brought before such court. Thus, the lock adalat can deal with not only the cases pending before a court but also with the disputes at pre-litigation stage. But the lock adalat shall have no jurisdiction in respect of any case or matter relating to an offense not compoundable under any law. In other words, the offenses which are non-compoundable under any law fall outside the purview of the lock adalat. 4. Any case pending before the court can be referred to the lock adalat for settlement if I. The parties thereof agree to settle the dispute in the lock adalat, or 2. One of the parties thereof makes an application to the court for referring the case to the lock adalat, or 3. The court is satisfied that the matter is an appropriate one to be taken cognizance of by the lock adalat. In the case of a pre-litigation dispute, the matter can be referred to the lock adalat for settlement by the agency organizing the lock adalat, on receipt of an application from any one of the parties to the dispute. 5. The lock adalat shall have the same powers as are vested in a civil court under the Code of Civil Procedure, 1908, while trying a suit in respect of the following matters. A. The summoning and enforcing the attendance of any witness examining him her on oath. B. The discovery and production of any document. C. The reception of evidence on affidavits. D. The requisitioning of any public record or document from any court or office. And E. Such other matters as may be prescribed. Further, a lock adalat shall have the requisite powers to specify its own procedure for the determination of any dispute coming before it. Also, all proceedings before a lock adalat shall be deemed to be judicial proceedings within the meaning of the Indian Penal Code, I-860, and every lock adalat shall be deemed to be a civil court for the purpose of the Code of Criminal Procedure, 1973. 6. An award of a lock adalat shall be deemed to be a decree of a civil court or an order of any other court. Every award made by a lock adalat shall be final and binding on all the parties to the dispute. No appeal shall lie to any court against the award of the lock adalat. Types. There are 3 types of lock adalats, viz. National lock adalats, state lock adalats, and permanent lock adalats, public utility services. The various cases settled in national lock adalats and state lock adalats include pre-litigation and pending matters related to Negotiable Instruments Act, bank recovery cases, labor dispute cases, service matters, criminal compoundable matters, MACD, etc. 2. 1. These 3 types of lock adalats are explained below. 2b. 1. National lock adalats. The national level lock adalats are held at regular intervals where on a single day lock adalats are held throughout the country, in all the Annual Report 2020 to 2021, National Legal Services Authority, p. 37. 2b. This information is obtained from the official website of the National Legal Services Authority. Courts right from the Supreme Court till the alloc levels wherein cases are disposed of in huge numbers. From 2015, national lock adalats are being held on a specific subject matter every month. 2. State lock adalats. These are also known as regular lock adalats. These can be further classified into the following types. A. Continuous lock adalat. A lock adalat bench sits continuously for a set number of days to facilitate settlements by deferring unsettled matters to the next date and encouraging parties to reflect on the terms of the mutually accepted settlement before actual settlement. B. Daily lock adalat. This type of lock adalat is organized on daily basis. C. Mobile lock adalat. These are organized by taking the lock adalat set up in a multi-utility van to different areas for resolving petty cases and also spreading legal awareness in the area. D. Mega lock adalat. This is organized in the state on a single day in all courts of the state. 3. Permanent lock adalats. These are explained below in detail. Benefits. According to the Supreme Court, the benefits under lock adalat are as follows. 3. For Law Commission of India, Report No. 222 entitled As Need for Justice Dispensation through ADR etc. April 2009, pp. 22-23. 1. There is no court fee, and if court fee is already paid, the amount will be refunded if the dispute is settled at lock adalat. 2. The basic features of lock adalat are the procedural flexibility and speedy trial of the disputes. There is no strict application of procedural laws like the Civil Procedure Code and the Evidence Act while assessing the claim by lock adalat. 3. The parties to the dispute can directly interact with the judge through their counsel, which is not possible in regular courts of law. 3p. T. Thomas vs. Thomas Job, 2005. Lock Adalats and other courts M. 377. 4. The award by the Lock Adalat is binding on the parties and it has the status of a decree of a civil court and it is non-appealable, which does not cause the delay in the settlement of disputes finally. In view of above facilities provided by the Act, Lock Adalats are boon to the litigating public as they can get their disputes settled fast and free of cost amicably. The Law Commission of India summarized the advantages of the ADR, alternative dispute resolution, in the following way: 4. 1. It is less expensive. 2. It is less time-consuming. 3. It is free from technicalities vis-a-vis conducting of cases in law courts. 4. Parties are free to discuss their differences of opinion without any fear of disclosure before any law courts. 5. Parties have the feeling that there is no losing or winning side between them, but at the same time their grievance is redressed and their relationship is restored. Permanent Lock Adalats. The Legal Services Authorities Act, 1987 was amended in 2002 to provide for the establishment of the Permanent Lock Adalats to deal with cases pertaining to the public utility services. The salient features of the new institution of Permanent Lock Adalats are as follows. 1. The Permanent Lock Adalat shall consist of a chairman who is or has been a district judge or additional district judge or has held judicial office higher in rank than that of the district judge and 2 other persons having adequate experience in public utility services. 2. The Permanent Lock Adalat shall exercise jurisdiction in respect of 1 or more public utility services such as transport services of passengers or goods by air, road and water, postal, telegraph, or 378F Indian Polity, telephone services, supply of power, light or water to the public by any establishment, public conservancy or sanitation, services in hospitals or dispensaries, and insurance services. 3. The pecuniary jurisdiction of the Permanent Lock Adalat shall be up to Rs 10 lakhs. However, the central government may increase the said pecuniary jurisdiction from time to time. Accordingly, in 2015, the central government has increased the said pecuniary jurisdiction up to Rs 1 crore. 4. The Permanent Lock Adalat shall have not jurisdiction in respect of any matter relating to an offense not compoundable under any law. 5. Before the dispute is brought before any court, any party to the dispute may make an application to the Permanent Lock Adalat for settlement of the dispute. After an application is made to the Permanent Lock Adalat, no party to that application shall invoke jurisdiction of any court in the same dispute. 6. Where it appears to the Permanent Lock Adalat that there exist elements of a settlement, which may be acceptable to the parties, it shall formulate the terms of a possible settlement and submit them to the parties for their observations, and in case the parties reach an agreement, the Permanent Lock Adalat shall pass an award in terms thereof. In case parties to the dispute fail to reach an agreement, the Permanent Lock Adalat shall decide the dispute on merits. 7. Every award made by the Permanent Lock Adalat shall be final and binding on all the parties thereto, and shall be by a majority of the persons constituting the Permanent Lock Adalat. Family Courts. The Family Courts Act, 1984 was enacted to provide for the establishment of family courts with a view to promote conciliation and secure speedy settlement of disputes relating to marriage and family affairs. Reasons. While introducing the Family Courts Bill in the Parliament, the Government of India gave the following reasons for the establishment of separate family courts. 1. Several associations of women, other organizations and individuals have urged, from time to time, that family courts be set up for the settlement of family disputes, where emphasis should be laid on conciliation and achieving socially desirable results, and adherence to rigid rules of procedure and evidence should be eliminated. 2. The Law Commission in its 59th report, 1974, had also stressed that in dealing with disputes concerning the family, the court ought to adopt an approach radically different from the adopted in ordinary civil proceedings, and that it should make reasonable efforts at settlement before the commencement of the trial. The Code of Civil Procedure was amended in 1976 to provide for a special procedure to be adopted in suits or proceedings relating to matters concerning the family. 3. However, not much use has been made by the courts in adopting this conciliatory procedure, and the courts continue to deal with family disputes in the same manner as other civil matters, and the same adversary approach prevails. The need was, therefore, felt, in the public interest, to establish family courts for speedy settlement of family disputes. Therefore, the main objectives and reasons for setting up of family courts are: 5. This information is adopted from the website of the Department of Justice, Ministry of Law and Justice, Government of India. ILB create a specialized court which will exclusively deal with family matters so that such a court may have the necessary expertise to deal with these cases expeditiously. Thus, expertise and expeditious disposal are 2 main factors for establishing such a court. 2. LB institute a mechanism for conciliation of the disputes relating to family. 3. LB provide an inexpensive remedy. And 4. LB have flexibility and an informal atmosphere in the conduct of proceedings. Features. The salient features of the Family Courts Act, 1984 are as follows. 1. It provides for the establishment of family courts by the state governments in consultation with the high courts. 2. It makes it obligatory on the state governments to set up a family court in every oidy or town with a population exceeding 1 million. 3. It enables the state governments to set up family courts in other areas also, if they deem it necessary. 4. It exclusively provides within the jurisdiction of the family courts the matters relating to matrimonial relief, including nullity of marriage, judicial separation, divorce, restitution of conjugal rights, or declaration as to the validity of marriage or as to the matrimonial status of any person. 2. The property of the spouses or of either of them. 3. Declaration as to the legitimacy of any person. 4. Guardianship of a person or the custody of any minor. And v. Maintenance of wife, children, and parents. 5. It makes it obligatory on the part of the family court to endeavor, in the first instance, to effect a reconciliation or a settlement between the parties to a family dispute. During this stage, the proceedings will be informal and rigid rules of procedure shall not apply. Lockout and other courts. 6. It provides for the association of social welfare agencies, counselors, etc. during conciliation stage, and also to secure the service of medical and welfare experts. 7. It provides that the parties to a dispute before a family court shall not be entitled, as of right, to be represented by legal practitioner. However, the court may, in the interest of justice, seek assistance of a legal expert as amicus curiae. 8. It simplifies the rules of evidence and procedure so as to enable a family court to deal effectively with a dispute. 9. It provides for only one right of appeal which shall lie to the High Court. F. Graham Nylays. The Graham-Nylays Act, 2008 has been enacted to provide for the establishment of the Graham-Nylays at the grassroots level for the purposes of providing access to justice to the citizens at their doorsteps and to ensure that opportunities for securing justice are not denied to any citizen due to social, economic, or other disabilities. Reasons. While introducing the Graham-Nylays bill in the Parliament, the Government of India gave the following reasons for the establishment of Graham-Nylays. 1. Access to justice by the poor and disadvantaged remains a worldwide problem despite diverse approaches and strategies that have been formulated and implemented to address it. In our country, Article 39A of the Constitution directs the state to secure that the operation of the legal system promotes justice on a basis of equal opportunity and shall provide free legal aid to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities. 2. In the recent past, the government has taken various measures to strengthen judicial system, inter alia, by simplifying 380 Indian Polity, the procedural laws, incorporating various alternative dispute resolution mechanisms such as arbitration, conciliation, and mediation, conducting of lock-adelats, etc. These measures are required to be strengthened further. 3. The Law Commission of India in its 114th report on Graham-Nylays suggested establishment of Graham-Nylays so that speedy, inexpensive, and substantial justice could be provided to the common man. The Graham-Nylays Act, 2008 is broadly based on the recommendations of the Law Commission. 4. Justice to the poor at their doorstep is a dream of the poor. Setting up of Graham-Nylays in the rural areas would bring to the people of rural areas speedy, affordable, and substantial justice. Features. The salient features of the Graham-Nylays Act are as follows. 1. 6 Press Information Bureau, Government of India, September 29, 2009. 1. The Graham-Nylays shall be Court of Judicial Magistrate of the first class, and its presiding officer, Nyadhikari, shall be appointed by the state government in consultation with the High Court. 2. The Graham-Nylays shall be established for every panchayat at intermediate level or a group of contiguous panchayats at intermediate level in a district, or where there is no panchayat at intermediate level in any state, for a group of contiguous panchayats. 3. The Nyadhikaris who will preside over these Graham-Nylays are strictly judicial officers and will be drawing the same salary, deriving the same powers as first-class magistrates working under high courts. 4. The Graham-Nylays shall be a mobile court and shall exercise the powers of both criminal and civil courts. 5. The seat of the Graham-Nylays will be located at the headquarters of the intermediate panchayat. They will go to villages, work there, and dispose of the cases. 6. The Graham-Nylays shall try criminal cases, civil suits, claims, or disputes which are specified in the first schedule and the second schedule to the Act. 7. The central as well as the state governments have been given power to amend the first schedule and the second schedule of the Act, as per their respective legislative competence. 8. The Graham-Nylays shall follow summary procedure in criminal trial. 9. The Graham-Nylays shall exercise the powers of a civil court with certain modifications and shall follow the special procedure as provided in the Act. 10. The Graham-Nylays shall try to settle the disputes as far as possible by bringing about conciliation between the parties, and for this purpose, it shall make use of the conciliators to be appointed for this purpose. 11. The judgment and order passed by the Graham-Nylays shall be deemed to be a decree, and to avoid delay in its execution, the Graham-Nylays shall follow summary procedure for its execution. 12. The Graham-Nylays shall not be bound by the rules of evidence provided in the Indian Evidence Act, 1872, but shall be guided by the principles of natural justice and subject to any rule made by the High Court. 13. Appeal in criminal cases shall lie to the Court of Session, which shall be heard and disposed of within a period of 6 months from the date of filing of such appeal. 14. Appeal in civil cases shall lie to the District Court, which shall be heard and disposed of within a period of 6 months from the date of filing of the appeal. 15. A person accused of an offense may file an application for plea bargaining. Establishment. Under the Gram Nihilayas Act, 2008, it is for the state governments to establish Gram Nihilayas in consultation with the respective high courts. However, the Act does not make the setting up of the Gram Nihilayas mandatory. Majority of states have now set up regular courts at a local level. Further, reluctance of police officials and other state functionaries to invoke jurisdiction of Gram Nihilayas, lukewarm response of the bar, non-availability of notaries and stamp vendors. Problem of concurrent jurisdiction of regular courts are other issues indicated by the states which are coming in the way of operationalization of the Gram Nihilayas. The issues affecting operationalization of the Gram Nihilayas were discussed in the Conference of Chief Justices of High Courts and Chief Ministers of the States in April 2013. It was decided in the conference that the state government and High Court should decide the question of establishment of Gram Nihilayas wherever feasible, taking into account their local problems. The focus is on setting up Gram Nihilayas in the thlukas where regular courts have not been set up. Commercial courts. The Commercial Courts Act, 2015 was enacted for the constitution of commercial courts, commercial appellate courts, commercial division, and commercial appellate division in the high courts for adjudicating commercial disputes of specified value. Under the Act, the commercial dispute is defined broadly to mean dispute arising out of ordinary transactions of merchants, bankers, financiers, and traders, such as those relating to mercantile documents, joint venture and partnership agreements, intellectual property rights, insurance, and other areas. Reasons. While introducing the Commercial Courts Bill, 2015, in the Parliament, the Central Lock Adalats and other courts, 381. Government gave the following reasons for establishing the commercial courts. 1. The proposal to provide for speedy disposal of high-value commercial disputes has been under consideration of the government for quite some time. The high-value commercial disputes involve complex facts and question of law. Therefore, there is a need to provide for an independent mechanism for their early resolution. The early resolution of commercial disputes shall create a positive image to the investor world about the independent and responsive Indian legal system. 2. The Law Commission of India, in its 253rd report, has recommended for the establishment of the commercial courts, the commercial division, and the commercial appellate divisions in the high courts for disposal of commercial disputes of specified value. 3. Based on the above recommendations of the Law Commission, the said bill was introduced in the Parliament. As provided in the said bill, all the suits, appeals, or applications related to commercial disputes of specified value are to be dealt with by the commercial courts or the commercial division of the high courts. 4. The proposed bill shall accelerate economic growth, improve the international image of the Indian justice delivery system, and the faith of the investor world in the legal culture of the nation. Features. The salient features of the Act are as follows. 1. The state government may constitute commercial courts at district level for the purpose of exercising the jurisdiction over the commercial disputes of a specified value. But, the state government may, with respect to high courts having ordinary original civil jurisdiction, constitute commercial courts at the district judge level. $382 Indian Polity. 2. The state government may, except the territories over which the high courts have ordinary original civil jurisdiction, designate commercial appellate courts at district judge level to exercise the appellate jurisdiction over the commercial courts below the district judge level. 3. In all high courts having ordinary original civil jurisdiction, the Chief Justice of the High Court may constitute commercial division for the purpose of exercising the jurisdiction over the commercial disputes of a specified value filed in the High Court. 4. The Chief Justice of the concerned High Court shall constitute commercial appellate division to hear the appeals against the orders of the commercial courts at the district judge level and the orders of the commercial division of that High Court. 5. The specified value of commercial disputes shall not be less than 3 lakh rupees or such higher value, which may be notified by the central government. In 2018, the specified value of commercial disputes was reduced from the earlier 1 crore rupees to 3 lakh rupees. 6. A provision is made for compulsory mediation before institution of a suit, which does not contemplate any urgent interim relief. In this regard, the pre-institution mediation and settlement mechanism is introduced. Further, the central government may empower the authorities constituted under the Legal Services Authorities Act, 1987, for the purposes of pre-institution mediation. Part Local Government _VS. Panchayati Raj. The term Panchayati Raj in India signifies the system of rural local self-government. It has been established in all the states of India by the acts of the state legislatures to build democracy at the grassroots level. It is entrusted with rural development. It was constitutionalized through the 73rd Constitutional Amendment Act of 1992. In the scheme of division of powers between the center and the states in the Indian federal system, the item of local government is given to the states. Thus, the fifth entry of the state list of the seventh schedule to the Constitution of India deals with local government. F. Evolution of Panchayati Raj. Balwantrai Mehta Committee. In January 1957, the Government of India appointed a committee to examine the working of the Community Development Program, 1952, and the National Extension Service, 1953, and to suggest measures for their better working. The chairman of this committee was Balwantrai G. Mehta. The committee submitted its report in November 1957 and recommended the establishment of the scheme of democratic decentralization, which ultimately came to be known as Panchayati Raj. The specific recommendations made by it are: 1. Establishment of a three-tier Panchayati Raj system, Gram Panchayat at the village level, Panchayat Samiti at the block level, and Zila Parishad at the district level. These tiers should be organically linked through a device of indirect elections. 2. The village Panchayat should be constituted with directly elected representatives, whereas the Panchayat Samiti and Zila Parishad should be constituted with indirectly elected members. 3. All planning and development activities should be entrusted to these bodies. 4. The Panchayat Samiti should be the executive body, while the Zila Parishad should be the advisory, coordinating, and supervisory body. 5. The district collector should be the chairman of the Zila Parishad. 6. There should be a genuine transfer of power and responsibility to these democratic bodies. 7. Adequate resources should be transferred to these bodies to enable them to discharge their functions and fulfill their responsibilities. 8. A system should be evolved to effect further devolution of authority in future. These recommendations of the committee were accepted by the National Development $384 Indian Polity Council in January 1958. The council did not insist on a single rigid pattern and left it to the states to evolve their own patterns suitable to local conditions. But the basic principles and broad fundamentals should be identical throughout the country. Rajasthan was the first state to establish Panchayati Raj. The scheme was inaugurated by the Prime Minister on October 2, 1959, in Nagaur district. Rajasthan was followed by Andhra Pradesh, which also adopted the system in 1959. Thereafter, most of the states adopted the system. Though most of the states created Panchayati Raj institutions by the mid-1960s, there were differences from one state to another with regard to the number of tiers, relative position of Samiti and Parishad, their tenure, composition, functions, finances, and so on. For example, Rajasthan adopted the three-tier system, while Tamil Nadu adopted the two-tier system. West Bengal, on the other hand, adopted the four-tier system. Further, in the Rajasthan-Andhra Pradesh pattern, Panchayat Samiti was powerful as the block was the unit of planning and development, while in Maharashtra-Gujarat pattern, Zila Parishad was powerful as the district was the unit of planning and development. Some states also established Nyaya Panchayats, that is, judicial panchayats to try petty civil and criminal cases. Study teams and committees. Since 1960, many study teams, committees, and working groups have been appointed to examine the various aspects of functioning of Panchayati Raj system. They are mentioned in FLE 39.1. Table 39.1 Study teams and committees on Panchayati Raj SI. No. Year name of the study team, Committee Chairman 1. 1960 Committee on Rationalization of Panchayat Statistics VR Rao. 2. 1961 Working Group on Panchayats and Cooperatives, SD Mishra. 3. 1961 Study Team on Panchayati Raj Administration V. Iswaran. 4. 1962 Study Team on Nyaya Panchayats, GR Rajgopal. 5. 1963 Study Team on the Position of Gram Sabha in Panchayati Raj Movement, RR Devakar. 6. 1963 Study Group on Budgeting and Accounting Procedure of Panchayati Raj. Institutions. M. Ramakrishnaya. 7. 1963 Study Team on Panchayati Raj Finances K. Santhanam. 8. 1965 Committee on Panchayati Raj Elections K. Santhanam. 9. 1965 Study Team on the Audit and Accounts of Panchayati Raj Bodies RK Khanna 10. 1966 Committee on Panchayati Raj Training Centers G. Ramachandran. 11. 1969 Study Team on Involvement of Community Development Agency and Panchayati Raj institutions in the implementation of basic land reform measures. V. Ramanathan. 12. 1972 Working Group for Formulation of Fifth Five-Year Plan on Community Development and Panchayati Raj. N. Ramakrishnaya. 13. 1976 Committee on Community Development and Panchayati Raj S&T. Diachubi Panchayati Raj 385. Ashok Mehta Committee. In December 1977, the Janata government appointed a committee on Panchayati Raj institutions under the chairmanship of Ashok Mehta. It submitted its report in August 1978 and made 132 recommendations to revive and strengthen the declining Panchayati Raj system in the country. Its main recommendations were: 1. The three-tier system of Panchayati Raj should be replaced by the two-tier system, that is, Zila Paris had at the district level and below it. The Mandal Panchayat consisting of a group of villages with a total population of 15,000 to 20,000. 2. A district should be the first point for decentralization under popular supervision below the state level. 3. Zila Paris should be the executive body and made responsible for planning at the district level. 4. There should be an official participation of political parties at all levels of Panchayat elections. 5. The Panchayati Raj institutions should have compulsory powers of taxation to mobilize their own financial resources. 6. There should be a regular social audit by a district-level agency and by a committee of legislators to check whether the funds allotted for the vulnerable social and economic groups are actually spent on them. 7. The state government should not supersede the Panchayati Raj institutions. In case of an imperative supersession, elections should be held within 6 months from the date of supersession. 8. The Nyaya Panchayats should be kept as separate bodies from that of development Panchayats. They should be presided over by a qualified judge. 9. The chief electoral officer of a state in consultation with the chief election commissioner should organize and conduct the Panchayati Raj elections. 10. Development functions should be transferred to the Zila Paris and all development staff should work under its control and supervision. 11. The voluntary agencies should play an important role in mobilizing the support of the people for Panchayati Raj. 12. A minister for Panchayati Raj should be appointed in the State Council of Ministers to look after the affairs of the Panchayati Raj institutions. 13. Seats for SCs and STK should be reserved on the basis of their population. 14. A constitutional recognition should be accorded to the Panchayati Raj institutions. This would give them the requisite status, sanctity and stature, and an assurance of continuous functioning. Due to the collapse of the Janata government before the completion of its term, no action could be taken on the recommendations of the Ashok Mehta Committee at the central level. However, the three states of Karnataka, West Bengal and Andhra Pradesh took steps to revitalize the Panchayati Raj, keeping in view some of the recommendations of the Ashok Mehta Committee. GVK Rao Committee. The committee to review the existing administrative arrangements for rural development and poverty alleviation programs under the chairmanship of GVK Rao was appointed by the erstwhile Planning Commission in 1985. The committee came to the conclusion that the developmental process was gradually bureaucratized and divorced from the Panchayati Raj. This phenomena of bureaucratization of development administration as against the democratization weakened the Panchayati Raj institutions, resulting in what is aptly called as grass without roots. Hence, the committee made the following recommendations to strengthen and revitalize the Panchayati Raj system. The district-level body, that is, the Zila Paris should be of pivotal importance 386 Indian Polity. In the scheme of democratic decentralization, it stated that the district is the proper unit for planning and development, and the Zila Paris should become the principal body for management of all development programs which can be handled at that level. 2. The Panchayati Raj institutions at the district and lower levels should be assigned an important role with respect to planning, implementation, and monitoring of rural development programs. 3. Some of the planning functions at the state level should be transferred to the district-level planning units for effective decentralized district planning. 4. A post of District Development Commissioner should be created. PESA should act as the chief executive officer of the Zila Paris and should be in charge of all the development departments at the district level. Elections to the Panchayati Raj institutions should be held regularly. It found that elections became overdue for one or more tiers in 11 states. Thus the committee, in its scheme of decentralized system of field administration, assigned a leading role to the Panchayati Raj in local planning and development. It is in this respect that the recommendations of the GVK Rao Committee Report, 1986, differed from those of the Dantwala Committee Report on Block-Level Planning, 1978, and the Hanumantha Rao Committee Report on District Planning, 1984. Both the committees have suggested that the basic decentralized planning function should be done at the district level. The Hanumantha Rao Committee advocated separate district planning bodies under either the district collector or a minister. In both the models, the collector should play a significant role in the decentralized planning, though the committee stated that Panchayati Raj institutions would also be associated with this process of decentralized planning. The committee recommended that the collector should be the coordinator at the district level of all developmental and planning activities. Thus, the Hanumantha Rao Committee differed in this respect from those of the Balwan Tri Mehta Committee, the First Administrative Reforms Commission of India, the Ashok Mehta Committee, and finally the GVK Rao Committee, which recommended reduction in the developmental role of the district collector and which assigned a major role to the Panchayati Raj and Development Administration. L.M. Singhvi Committee in 1986, Rajiv Gandhi government appointed a committee to prepare a concept paper on revitalization of Panchayati Raj institutions for democracy and development under the chairmanship of L.M. Singhvi. It made the following recommendations. The Panchayati Raj institutions should be constitutionally recognized, protected, and preserved. For this purpose, a new chapter should be added in the Constitution of India. This will make their identity and integrity reasonably and substantially inviolate. It also suggested constitutional provisions to ensure regular, free, and fair elections to the Panchayati Raj bodies. 2. Nyaya Panchayats should be established for a cluster of villages. 3. The villages should be reorganized to make Gram Panchayats more viable. It also emphasized the importance of the Gram Sabha and called it as the embodiment of direct democracy. 4. The village panchayats should have more financial resources. The judicial tribunals should be established in each state to adjudicate controversies about election to the Panchayati Raj institutions, their dissolution, and other matters related to their functioning. Thungan Committee in 1988. A subcommittee of the Consultative Committee of Parliament was constituted under the chairmanship of P.K. Thungan to examine the political and administrative structure in the district for the purpose of District Panchayati Raj 387. Planning. This committee suggested for the strengthening of the Panchayati Raj system. It made the following recommendations. 1. The Panchayati Raj bodies should be constitutionally recognized. 2. A three-tier system of Panchayati Raj with panchayats at the village, block, and district levels. 3. Zilla Parishad should be the pivot of the Panchayati Raj system. It should act as the planning and development agency in the district. 4. The Panchayati Raj bodies should have a fixed tenure of 5 years. 5. The maximum period of supersession of a body should be 6 months. 6. A planning and coordination committee should be set up at the state level under the chairmanship of the Minister for Planning. The presidents of Zilla Parishad should be its members. 7. A detailed list of subjects for Panchayati Raj should be prepared and incorporated in the Constitution. 8. Reservation of seats in all the 3 tiers should be on the basis of population. There should also be reservation for women. 9. A state finance commission should be set up in each state. It would lay down the criteria and guidelines for the devolution of finances to the Panchayati Raj institutions. 10. The district collector should be the chief executive officer of the Zilla Parishad. Godgil Committee. The Committee on Policy and Programs was constituted in 1988 by the Congress Party under the chairmanship of V. N. Godgil. This committee was asked to consider the question of how best Panchayati Raj institutions could be made effective. In this context, the committee made the following recommendations. 1. A constitutional status should be bestowed on the Panchayati Raj institutions. 2. A three-tier system of Panchayati Raj with panchayats at the village, block, and district levels. 3. The term of Panchayati Raj institutions should be fixed at 5 years. 4. The members of the panchayats at all the 3 levels should be directly elected. 5. Reservation for SCs, STS, and women. 6. The Panchayati Raj bodies should have the responsibility of preparation and implementation of plans for socio-economic development. For this purpose, a list of subjects should be specified. 3. The Constitution. 7. The Panchayat Raj bodies should be empowered to levy, collect, and appropriate taxes and duties. 8. Establishment of a state finance commission for the allocation of finances to the panchayats. 9. Establishment of a state election commission for the conduction of elections to the panchayats. The above recommendations of the Godgil Committee became the basis for drafting an amendment bill aimed at conferring the constitutional status and protection to the Panchayati Raj institutions. Constitutionalization. Rajiv Gandhi government. The Rajiv Gandhi government introduced the 64th Constitutional Amendment Bill in the Lok Sabha in July 1989 to constitutionalize Panchayati Raj institutions and make them more powerful and broad-based. Although the Lok Sabha passed the bill in August 1989, it was not approved by the Rajya Sabha. The bill was vehemently opposed by the opposition on the ground that it sought to strengthen centralization in the federal system. VP Singh government. The National Front government, soon after assuming office in November 1989 under the prime ministership of VP Singh, announced that it would take steps to strengthen the Panchayati Raj institutions. In June 1990, a 2-day conference of the state chief ministers under the chairmanship of VP Singh was held to discuss the issues relating to the strengthening of the Panchayati Raj bodies. The conference 388 Indian Polity approved the proposals for the introduction of a fresh constitutional amendment bill. Consequently, a constitutional amendment bill was introduced in the Lok Sabha in September 1990. However, the fall of the government resulted in the lapse of the bill. Narasimha Rao government. The Congress government under the prime ministership of P.V. Narasimha Rao once again considered the matter of the constitutionalization of Panchayati Raj bodies. It drastically modified the proposals in this regard to delete the controversial aspects and introduced a constitutional amendment bill in the Lok Sabha in September 1991. This bill finally emerged as the 73rd Constitutional Amendment Act, 1992, and came into force on April 24, 1993. Foot. T. 73rd Amendment Act of 1992. Significance of the Act. This Act has added a new Part 9 to the Constitution of India. This part is entitled as the Panchayats and consists of provisions from Articles 243 to 243 to 0. In addition, The Act has also added a new 11th schedule to the Constitution. This schedule contains 29 functional items of the Panchayats. It deals with Article 243G. The Act has given a practical shape to Article 40 of the Constitution, which says that the state shall take steps to organize village panchayats and endow them with such powers and authority as may be necessary to enable them to function as units of self-government. This article forms a part of the directive principles of state policy. The Act gives a constitutional status to the Panchayati Raj institutions. It has brought them under the purview of the justiciable part of the Constitution. In other words, the state governments are under constitutional obligation to adopt the new Panchayati Raj system in accordance with the provisions of the Act. Consequently, neither the formation of panchayats nor the holding of elections at regular intervals depend on the will of the state government anymore. The provisions of the Act can be grouped into two categories: compulsory and voluntary. The compulsory, mandatory, or obligatory provisions of the Act have to be included in the state laws creating the new Panchayati Raj system. The voluntary provisions, on the other hand, may be included at the discretion of the states. Thus, the voluntary provisions of the Act ensures the right of the states to take local factors like geographical, politico-administrative, and others into consideration while adopting the new Panchayati Raj system. The Act is a significant landmark in the evolution of grassroots democratic institutions in the country. It transfers the representative democracy into participatory democracy. It is a revolutionary concept to build democracy at the grassroots level in the country. Salient features. The salient features of the Act are: Gram Sabha. The Act provides for a Gram Sabha as the foundation of the Panchayati Raj system. It is a body consisting of persons registered in the electoral rolls of a village comprised within the area of panchayat at the village level. Thus, it is a village assembly consisting of all the registered voters in the area of a panchayat. It may exercise such powers and perform such functions at the village level as the legislature of a state determines. Three-tier system. The Act provides for a three-tier system of Panchayati Raj in every state, that is, panchayats at the village, intermediate, and district levels too. Thus, the Act brings. This bill was passed by the Lok Sabha on December 22, 1992, and by the Rajya Sabha on December 23, 1992. Later, it was approved by the 17 state assemblies and received the assent of the President on April 20, 1993. The Act defines all these terms in the following manner. A. Panchayat means an institution, by whatever name called, of self-government for rural areas. About uniformity in the structure of Panchayati Raj throughout the country. However, a state having a population not exceeding 20 lakh may not constitute panchayats at the intermediate level. Election of members and chairpersons. All the members of panchayats at the village, intermediate, and district levels shall be elected directly by the people. Further, the chairperson of panchayats at the intermediate and district levels shall be elected indirectly, by and from amongst the elected members thereof. However, the chairperson of a panchayat at the village level shall be elected in such manner as the state legislature determines. The chairperson of a panchayat and other members of a panchayat elected directly or indirectly shall have the right to vote in the meetings of the panchayats. Reservation of seats. The Act provides for the reservation of seats for scheduled castes and scheduled tribes in every panchayat, i.e., at all the three levels, in proportion of their population to the total population in the panchayat area. Further, the state legislature shall provide for the reservation of offices of chairperson in the panchayat at the village or any other level for the SCs and STs. The Act provides for the reservation of not less than 1/3 of the total number of seats for women, including the number of seats reserved for women belonging to the SCs and STs. Further, not less than 1/3 of the total number of offices of chairpersons in the panchayats at each level shall be reserved for women. The Act also authorizes the legislature of a state to make any provision for reservation of seats in any panchayat or offices of chairperson. B. Village means a village specified by the governor by public notification to be a village for this purpose, and includes a group of villages so specified. C. Intermediate level means a level between the village and district levels specified by the governor by public notification for this purpose. D. District means a district in a state. Panchayati Raj 389. In the panchayat at any level in favor of backward classes. The reservation of seats as well as the reservation of offices of chairpersons in the panchayats for the scheduled castes and scheduled tribes shall cease to have effect after the expiration of the period specified in Article 334, which is presently 80 years, that is, till 2030. It must be noted here that the above provision relating to the reservation of seats in panchayats, both members and chairpersons, for the scheduled castes is not applicable to the state of Arunachal Pradesh. This is because the state is inhabited fully by indigenous tribal people and there are no scheduled castes. This provision was added later by the 83rd Constitutional Amendment Act of 2000. Duration of panchayats. The Act provides for a 5-year term of office to the panchayat at every level from the date of its first meeting. However, it can be dissolved before the completion of its term. Further, fresh elections to constitute a panchayat shall be completed a. Before the expiry of its duration of 5 years, or b. In case of dissolution, before the expiry of a period of 6 months from the date of its dissolution. But, where the remainder of the period, for which the dissolved panchayat would have continued, is less than 6 months, it shall not be necessary to hold any election for constituting the new panchayat for such period. Moreover, a panchayat constituted upon the dissolution of a panchayat before the expiration of its duration shall continue only for the remainder of the period for which the dissolved panchayat would have continued had it not been so dissolved. In other words, a panchayat reconstituted after premature dissolution does not enjoy the full period of 5 years, but remains in office only for the remainder of the period. Disqualifications: a person shall be disqualified for being chosen as or for being a member of panchayat if Husha is so disqualified. A. Under any law for the time being in force for 390 YJ Indian Polity. The purpose of elections to the legislature of the state concerned, or b. Under any law made by the state legislature. However, no person shall be disqualified on the ground that Husha is less than 25 years of age if Husha has attained the age of 21 years. Further, all questions of disqualification shall be referred to such authority as the state legislature determines. State Election Commission: the superintendence, direction, and control of the preparation of electoral rolls and the conduct of all elections to the panchayats shall be vested in the State Election Commission. It consists of a state election commissioner to be appointed by the governor. His conditions of service and tenure of office shall also be determined by the governor. Husha shall not be removed from the office except in the manner and on the grounds prescribed for the removal of a judge of the State High Court. 3. His conditions of service shall not be varied to his disadvantage after his appointment. 3. A judge of a high court can be removed from his office by the President on the recommendation of the Parliament. This means that a state election commissioner cannot be removed by the governor, though appointed by him or her. The state legislature may make provision with respect to all matters relating to elections to the panchayats. Powers and functions: the state legislature may endow the panchayats with such powers and authority as may be necessary to enable them to function as institutions of self-government. Such a scheme may contain provisions for the devolution of powers and responsibilities upon panchayats at the appropriate level with respect to a. The preparation of plans for economic development and social justice, and sb. The implementation of schemes for economic development and social justice as may be entrusted to them, including those in relation to the 29 matters listed in the 11th schedule. Finances: the state legislature may a. Authorize a panchayat to levy, collect, and appropriate taxes, duties, tolls, and fees. b. Assign to a panchayat taxes, duties, tolls, and fees levied and collected by the state government. c. Provide for making grants and aid to the panchayats from the consolidated fund of the state. And sd. Provide for constitution of funds for crediting all monies of the panchayats. Finance Commission: the governor of a state shall, after every 5 years, constitute a finance commission to review the financial position of the panchayats. It shall make the following recommendations to the governor. 1. The principles that should govern a. The distribution between the state and the panchayats of the net proceeds of the taxes, duties, tolls, and fees levied by the state and allocation of shares amongst the panchayats at all levels. b. The determination of taxes, duties, tolls, and fees that may be assigned to the panchayats. c. The grants and aid to the panchayats from the consolidated fund of the state. 2. The measures needed to improve the financial position of the panchayats. 3. Any other matter referred to it by the governor in the interest of sound finance of the panchayats. The state legislature may provide for the composition of the commission, the required qualifications of its members, and the manner of their selection. The governor shall place the recommendations of the commission along with the action taken report before the state legislature. The Central Finance Commission shall also suggest the measures needed to augment the consolidated fund of a state to supplement the resources of the panchayats and the states on the basis of the recommendations made by the Finance Commission of the state. Audit of accounts: the state legislature may make provisions with respect to the maintenance of accounts by the panchayats and the auditing of such accounts. Panchayati Raj 391. Application to Union Territories: the provisions of this part are applicable to the Union Territories. But the President may direct that they would apply to a Union Territory subject to such exceptions and modifications as he/she may specify. Exempted states and areas: the Act does not apply to the states of Nagaland, Meghalaya, and Mizoram and certain other areas. These areas include a. The scheduled areas and the tribal areas in the states. 4. b. The hill areas of Manipur for which district councils exist. And c. Darjeeling District of West Bengal for which Darjeeling Gorkha Hill Council exists. For at present, 10 states of India have scheduled areas. These are Andhra Pradesh, Telangana, Jharkhand, Chhattisgarh, Gujarat, Himachal Pradesh, Madhya Pradesh, Maharashtra, Odisha, and Rajasthan. Presently, there are a total of 10 tribal areas, autonomous districts, in the 4 states of Assam, 3, Meghalaya, 3, Tripura, 1, and Mizoram, 3. However, the Parliament may extend the provisions of this part to the scheduled areas and tribal areas subject to such exceptions and modifications as it may specify. Under this provision, the Parliament has enacted the provisions of the Panchayats Extension to the Scheduled Areas Act, 1996, popularly known as the PESA Act or the Extension Act. Continuance of existing laws and panchayats. All the state laws relating to panchayats shall continue to be in force until the expiry of 1 year from the commencement of this act. In other words, the states have to adopt the new Panchayati Raj system based on this act within the maximum period of 1 year from April 24, 1993, which was the date of the commencement of this act. However, all the panchayats existing immediately before the commencement of act shall continue till the expiry of their term, unless dissolved by the state legislature sooner. Consequently, majority of states passed the Panchayati Raj Acts in 1993 and 1994 to adopt the new system in accordance with the 73rd Constitutional Amendment Act of 1992. Bar to interference by courts in electoral matters. The Act bars the interference by courts in the electoral matters of panchayats. It declares that the validity of any law relating to the delimitation of constituencies or the allotment of seats to such constituencies cannot be questioned in any court. It further lays down that no election to any panchayat is to be questioned except by an election petition presented to such authority and in such manner as provided by the state legislature. 11th Schedule. It contains the following 29 functional items placed within the purview of panchayats. 1. Agriculture, including agricultural extension. 2. Land improvement, implementation of land reforms, land consolidation, and soil conservation. 3. Minor irrigation, water management, and watershed development. 4. Animal husbandry, dairying, and poultry. 5. Fisheries. 6. Social forestry and farm forestry. 7. Minor forest produce. 8. Small-scale industries, including food processing industries. 9. Khadi, village and cottage industries. 10. Rural housing. 11. Drinking water. 12. Fuel and fodder. 13. Roads, culverts, bridges, ferries, waterways, and other means of communication. 14. Rural electrification, including distribution of electricity. 15. Non-conventional energy sources. 16. Poverty alleviation programs. 17. Education, including primary and secondary schools. 18. Technical training and vocational education. 19. Adult and non-formal education. 20. Libraries. 21. Cultural activities. 22. Markets and fairs. 23. Health and sanitation, including hospitals, primary health centers, and dispensaries. 392 YS Indian Polity. 24. Family welfare. 25. Women and child development. 26. Social welfare, including welfare of the handicapped and mentally retarded. 27. Welfare of the weaker sections, and in particular, of the scheduled castes and the scheduled tribes. 28. Public distribution system. 29. Maintenance of community assets. Compulsory and voluntary provisions. Now, we will identify separately the compulsory, obligatory or mandatory, and voluntary, discretionary or optional provisions features of the 73rd Constitutional Amendment Act, 1992, or the Part 9 of the Constitution, Q. Compulsory Provisions. 1. Organization of Gram Sabha in a village or group of villages. 2. Establishment of panchayats at the village, intermediate, and district levels. 3. Direct elections to all seats in panchayats at the village, intermediate, and district levels. 4. Indirect elections to the post of chairperson of panchayats at the intermediate and district levels. 5. Voting rights of the chairperson and other members of a panchayat elected directly or indirectly. 6. 21 years to be the minimum age for contesting elections to panchayats. 7. Reservation of seats, both members and chairpersons, for SCs and SLK in panchayats at all the 3 levels. 8. Reservation of 1/3 seats, both members and chairpersons, for women in panchayats at all the 3 levels. 9. Fixing tenure of 5 years for panchayats at all levels and holding fresh elections within 6 months in the event of supersession of any panchayat. 10. Establishment of a state election commission for conducting elections to the panchayats. 11. Constitution of a state finance commission after every 5 years to review the financial position of the panchayats. B. Voluntary provisions. 1. Endowing the Gram Sabha with powers and functions at the village level. 2. Determining the manner of election of the chairperson of the village panchayat. 3. Giving representation to the chairpersons of the village panchayats in the intermediate panchayats or in the case of a state not having intermediate panchayats, in the district panchayats. 4. Giving representation to the chairpersons of the intermediate panchayats in the district panchayats. 5. Giving representation to members of the parliament, both the houses, in the state legislature, both the houses, in the panchayats at different levels falling within their constituencies. 6. Providing reservation of seats, both members and chairpersons, for backward classes in panchayats at any level. 7. Granting powers and authority to the panchayats to enable them to function as institutions of self-government, in brief, making them autonomous bodies. 8. Devolution of powers and responsibilities upon panchayats to prepare plans for economic development and social justice. and to perform some or all of the 29 functions listed in the 11th schedule of the Constitution. 9. Granting financial powers to the Panchayats, that is, authorizing them to levy, collect, and appropriate taxes, duties, tolls, and fees. 10. Assigning to a Panchayat the taxes, duties, tolls, and fees levied and collected by the state government. 11. Making the grants in aid to the Panchayats from the consolidated fund of the state. 12. Providing for constitution of funds for crediting all monies of the Panchayats. Panchayati Raj 393. PESA Act of 1996 Extension Act. The provisions of Part 9 of the Constitution relating to the Panchayats are not applicable to the 5th Schedule areas. However, the Parliament may extend these provisions to such areas, subject to such exceptions and modifications as it may specify. Under this provision, the Parliament has enacted the provisions of the Panchayats Extension to the Scheduled Areas Act, 1996, popularly known as the PESA Act or the Extension Act. At present, 10 states have 5th Schedule areas. These are Andhra Pradesh, Telangana, Chhattisgarh, Gujarat, Himachal Pradesh, Jharkhand, Madhya Pradesh, Maharashtra, Odisha, and Rajasthan. All the 10 states have enacted requisite compliance legislations by amending the respective Panchayati Raj Acts. Objectives of the Act. The objectives of the PESA Act are as follows. 5. S.K. Singh, Panchayats and Scheduled Areas, Kurukshetra, May 2001, p. 26. 1. LB extend the provisions of Part 9 of the Constitution relating to the Panchayats to the Scheduled Areas with certain modifications. 2. LB provides self-rule for the bulk of the tribal population. 3. LB have village governance with participatory democracy and to make the Gram Sabha a nucleus of all activities. 4. To evolve a suitable administrative framework consistent with traditional practices. 5. LB safeguard and to preserve the traditions and customs of tribal communities. 6. LB empower Panchayats at the appropriate levels with specific powers conducive to tribal requirements. 7. LB prevent Panchayats at the higher level from assuming the powers and authority of Panchayats at the lower level of the Gram Sabha. Features of the Act. The features, or the provisions, of the PESA Act are as follows. 1. A state legislation on the Panchayats in the scheduled areas shall be in consonance with the customary law, social and religious practices and traditional management practices of community resources. 2. A village shall ordinarily consist of a habitation or a group of habitations or a hamlet or a group of hamlets comprising a community and managing its affairs in accordance with traditions and customs. 3. Every village shall have a Gram Sabha consisting of persons whose names are included in the electoral rolls for the Panchayat at the village level. 4. Every Gram Sabha shall be competent to safeguard and preserve the traditions and customs of the people, their cultural identity, community resources, and the customary mode of dispute resolution. 5. Every Gram Sabha shall approve of the plans, programs, and projects for social and economic development before they are taken up for implementation by the Panchayat at the village level. And 2. Be responsible for the identification of beneficiaries under the poverty alleviation and other programs. 6. Every Panchayat at the village level shall be required to obtain from the Gram Sabha a certification of utilization of funds for the above plans, programs, and projects. 7. The reservation of seats in the scheduled areas in every Panchayat shall be in proportion to the population of the communities for whom reservation is sought to be given under Part 9 of the Constitution. However, the reservation for the scheduled tribes shall not be less than 1/2 of the total number of seats. Further, all seats of chairpersons of Panchayats at all levels shall be reserved for the scheduled tribes. 3940 Indian Polity. 8. The state government may nominate such scheduled TBs which have no representation in the Panchayat at the intermediate level or the Panchayat at the district level. But such nomination shall not exceed 1/10 of the total members to be elected in that Panchayat. 9. The Gram Sabha or the Panchayats at the appropriate level shall be consulted before making the acquisition of land in the scheduled areas for development projects and before resettling or rehabilitating persons affected by such projects in the scheduled areas. However, the actual planning and implementation of the projects in the scheduled areas shall be coordinated at the state level. 10. Planning and management of minor water bodies in the scheduled areas shall be entrusted to Panchayats at the appropriate level. 11. The recommendations of the Gram Sabha or the Panchayats at the appropriate level shall be mandatory for grant of prospecting license or mining lease for minor minerals in the scheduled areas. 12. The prior recommendation of the Gram Sabha or the Panchayats at the appropriate level shall be mandatory for grant of concession for the exploitation of minor minerals by auction. 13. While endowing Panchayats in the scheduled areas with such powers and authority as may be necessary to enable them to function as institutions of self-government, a state legislature shall ensure that the Panchayats at the appropriate level and the Gram Sabha are endowed specifically with the power to enforce prohibition or to regulate or restrict the sale and consumption of any intoxicant. 2. The ownership of minor forest produce. 3. The power to prevent alienation of land in the scheduled areas and to take appropriate action to restore any unlawfully alienated land of a scheduled tribe. 4. The power to manage village markets. The power to exercise control over money lending to the scheduled TBs. 6. The power to exercise control over institutions and functionaries in all social sectors. 7. The power to control local plans and resources for such plans, including tribal subplans. 14. The state legislation shall contain safeguards to ensure that panchayats at the higher level do not assume the powers and authority of any panchayat at the lower level or of the Gram Sabha. 15. The state legislature shall endeavor to follow the pattern of the 6th schedule to the Constitution while designing the administrative arrangements in the panchayats at district levels in the scheduled areas. 16. Any provision of any law relating to panchayats in the scheduled areas, which is inconsistent with the provisions of this act, shall cease to be in force at the expiry of 1 year from the date on which this act receives the assent of the President. However, all the panchayats existing immediately before such date shall continue till the expiry of their term, unless dissolved by the state legislature sooner. 6. This act received the assent of the President on December 24, 1996. 7. Second Administrative Reforms Commission, Government of India, Report on Local Governance, 2007, pp. 151 to 154. Finances of Panchayati Raj. The Second Administrative Reforms Commission of India, 2005 to 2009, has summarized the sources of revenue of the Panchayati Raj institutions (PRIs) and their financial problems in the following way. 7. 1. A major portion of Part 9 of the Constitution deals with structural empowerment of the PRIs, but the real Panchayati Raj (4 395). Strength in terms of both autonomy and efficiency of these institutions is dependent on their financial position, including their capacity to generate own resources. In general, panchayats in our country receive funds in the following ways. I. Grants from the Union government based on the recommendations of the Central Finance Commission as per Article 280 of the Constitution. 2. Devolution from the state government based on the recommendations of the State Finance Commission as per Article 243 to 1. 3. Loans grants from the state government. 4. Program-specific allocation under centrally sponsored schemes and additional central assistance. V. Internal resource generation, tax and non-tax. 2. Across the country, states have not given adequate attention to fiscal empowerment of the panchayats. The panchayats' own resources are meager. Kerala, Karnataka, and Tamil Nadu are the states which are considered to be progressive in PRIs empowerment, but even there, the panchayats are heavily dependent on government grants. One can draw the following broad conclusions. I. Internal resource generation at the panchayat level is weak. This is partly due to a thin tax domain and partly due to panchayats' own reluctance in collecting revenue. 2. Panchayats are heavily dependent on grants from union and state governments. 3. A major portion of the grants both from union as well as the state governments is scheme-specific. Panchayats have limited discretion and flexibility in incurring expenditure. 4. In view of their own tight fiscal position, state governments are not keen to devolve funds to panchayats. V. In most of the critical 11th schedule matters like primary education, healthcare, water supply, sanitation, and minor irrigation even now, it is the state government which is directly responsible for implementation of these programs and hence expenditure. 6. Overall, a situation has been created where panchayats have responsibility but grossly inadequate resources. 3. Though, in absolute terms, the quantum of funds the union state government transfers to a panchayat forms the major component of its receipt, the PRI's own resource generation is the soul behind its financial standing. It is not only a question of resources. It is the existence of a local taxation system which ensures people's involvement in the affairs of an elected body. It also makes the institution accountable to its citizens. 4. In terms of own resource collection, the Gram Panchayats are comparatively in a better position because they have a tax domain of their own, while the other two tiers are dependent only on tolls, fees, and non-tax revenue for generating internal resources. 5. State Panchayati Raj Acts have given most of the taxation powers to village panchayats. The revenue domain of the intermediate and district panchayats, both tax as well as non-tax, has been kept much smaller and remains confined to secondary areas like ferry services, markets, water and conservancy services, registration of vehicles, cess on stamp duty, and a few others. 6. A study of various state legislations indicates that a number of taxes, duties, tolls, and fees come under the jurisdiction of the village panchayats. These inter alia include property house tax, profession tax, land taxes, taxes tolls on vehicles, entertainment tax fees, license fees, tax on non-agriculture land, fee on registration of cattle, sanitation Indian polity, drainage conservancy tax, water rate tax, lighting rate acts, education cess, and tax on fairs and festivals. Reasons for ineffective performance. Even after conferring the constitutional status and protection through the 73rd Amendment Act, 1992, the performance of the Panchayati Raj institutions (PRIs) has not been satisfactory and not up to the expected level. The various reasons for this suboptimal performance are as follows. 1. Lack of adequate devolution. Many states have not taken adequate steps to devolve 3FS, i.e., functions, funds, and functionaries, to the PRIs to enable them to discharge their constitutionally stipulated function. Further, it is imperative that the PRIs have resources to match the responsibilities entrusted to them. While SFCs, state finance commissions, have submitted their recommendations, not many few states have implemented these or taken steps to ensure the fiscal viability of the PRIs. 2. Excessive control by bureaucracy. In some states, the Gram Panchayats have been placed in a position of subordination. Hence, the Gram Panchayat Sarpanchs have to spend extraordinary amount of time visiting block offices for funds and/or technical approval. These interactions with the block staff office distort the role of Sarpanchs as elected representatives. 3. Tied nature of funds. This has two implications. The activities stated under a certain scheme are not always appropriate for all parts of the district. This results in unsuitable activities being promoted or an underspend of the funds. 8. Ministry of Panchayati Raj, Government of India, Roadmap for the Panchayati Raj, 20U, 16, pp. 11-12, 23, and 7-8. 4. Overwhelming dependency on government funding. A review of money received in own source funds shows the overwhelming dependence of panchayats on government funding. When panchayats do not raise resources and instead receive funds from outside, people are less likely to request a social audit. 5. Reluctance to use fiscal powers. An important power devolved to GP Gram Panchayat is the right to levy tax on property, business, markets, fairs, and also for services provided, like street lighting or public toilets, etc. Very few panchayats use their fiscal power to levy and collect taxes. The argument pushed by panchayat heads is that it is difficult to levy tax on your own constituency, especially when you live in the community. 6. Status of the Gram Sabha. Empowering the Gram Sabhas could have been a powerful weapon for transparency, accountability, and for involvement of the marginalized sections. However, a number of the state acts have not spelt the powers of Gram Sabhas, nor have any procedures been laid down for the functioning of these bodies or penalties for the officials. 7. Creation of parallel bodies. Often, parallel bodies, PBs, are created for supposedly speedy implementation and greater accountability. However, there is little evidence to show that such PBs have avoided the evils, including that of partisan politics, sharing of spoils, corruption, and elite capture. Missions, in particular, often bypassing mainstream programs, create disconnect, duality, and alienation between the existing and the new structures and functions. PBs usurp the legitimate space of PRIs and demoralize the PRIs by virtue of their superior resource endowments. 8. Poor infrastructure. A number of Gram Panchayats in the country do not have even full-time secretary and also basic office buildings. The database for planning, monitoring, etc. are lacking in most of the cases. A large number of elected representatives of PRIs are semi-literate or illiterate. Panchayati Raj 397. And know little about their roles and responsibilities, programs, procedures, systems. Often for want of good, relevant, and periodic training, they are not able to perform their functions properly. Table 39.2 articles related to panchayats at a glance. 243. Definitions. 243a. 243h. 243-1. 2433. 243l. 243m. 243n. Article No. Subject Matter. 243d. 243k. 2438. 243l. 243k. 2436. Powers to impose taxes by and funds of the panchayats. Constitution of Finance Commission to review financial position. Gram Sabha. Audit of accounts of panchayats. Elections to the panchayats. Application to union territories. Part not to apply to certain areas. Continuance of existing laws and panchayats. Bar to interference by courts in electoral matters. Constitution of panchayats. Composition of panchayats. Reservation of seats. Duration of panchayats, and so on. Disqualifications for membership. Powers, authority, and responsibilities of panchayats. 1. Expert Committee on Leveraging Panchayats for Mani Shankar Ayer 2012 Efficient Delivery of Public Goods and Services. Table 39.3 Committees related to Panchayati Raj, after constitutionalization, SI. No. Name of the committee appointed in 1. Task Force on Devolution of Powers and Functions to Panchayati Raj Institutions. Law Lit Mather 2001-2001. 2. Expert Group on Planning at the Grassroots Level v. Ramachandran 2005-2006. 3. I Task Force for Preparation of a Manual for District Planning. SMT. Rajwant Sandhu. 2008-2008. 4. Committee on Restructuring of DRDA, District Rural Development Agency, v. Ramachandran. J. XSS, *J. 2010-2012 Chapter 40 Municipalities. Tihi term urban local government in India signifies the governance of an urban area by the people through their elected representatives. The jurisdiction of an urban local government is limited to a specific urban area which is demarcated for this purpose by the state government. 1. Local government is a subject mentioned in the state list under the 7th schedule of the Constitution. There are 8 types of urban local governments in India: municipal corporation, municipality, notified area committee, town area committee, cantonment board, township, port trust, and special purpose agency. The system of urban government was constitutionalized through the 74th Constitutional Amendment Act of 1992. At the central level, the subject of urban local government is dealt with by the following three ministries. I. Ministry of Housing and Urban Affairs. 2. Ministry of Defense in the case of cantonment boards. 3. Ministry of Home Affairs in the case of union territories. Evolution of urban bodies. Historical perspective. The institutions of urban local government originated and developed in modern India during the period of British rule. The major events in this context are as follows. In 1688, the first municipal corporation in India was set up at Madras. It must be noted here that a charter for the establishment of the Municipal Corporation of Madras was issued on December 30, 1687. However, the corporation came into existence on September 29, 1688. 2. In 1726, the municipal corporations were set up in Bombay and Calcutta. 3. Lord Mayo's resolution of 1870 on financial decentralization visualized the development of local self-government institutions. 4. Lord Ripon's resolution of 1882 has been hailed as the Magna Carta of local self-government. He is called the father of local self-government in India. The Royal Commission on Decentralization was appointed in 1907, and it submitted its report in 1909. Its chairman was C. H. Hobhouse. 6. Under the diarchical scheme introduced in provinces by the Government of India Act of 1919, local self-government became a transferred subject under the charge of a responsible Indian minister. 7. In 1924, the Cantonments Act was passed by the Central Legislature. 8. Under the Provincial Autonomy Scheme introduced by the Government of India Act of 1935, local self-government was declared a provincial subject. Committees and Commissions. The committees and commissions appointed by the central government to improve the municipalities. 399. Table 40.1 Committees and Commissions on Urban Local Governments. SI. No. Your name of the committee commission chairman 1. 1949 to 51 Local Finance Inquiry Committee PK Vatal 2. 1953 to 54 Taxation Inquiry Commission John Matai 3. 1963 to 65 Committee on the Training of Municipal Employees Nurudin Ahmed 4. 1963 to 66 Rural Urban Relationship Committee AP Jain 5. 1963 Committee of Ministers on Augmentation of Financial Resources of Urban Local Bodies. Rafiq Zakaria. 1B 1965 to 68 Committee on Service Conditions of Municipal Employees BS Morthy 7. 1974 Committee on Budgetary Reform and Municipal Administration Gurjapti Mukherjee 00. 1982 RWLW. Study Group on Constitution, Powers and Laws of Urban Local Bodies and Municipal Corporations Kan Sahat 9. 1985 to 88 National Commission on Urbanization CM Korea. Functioning of urban local governments are mentioned in THBLI 40.1. Constitutionalization. Rajiv Gandhi government. In August 1989, the Rajiv Gandhi government introduced the 65th Constitutional Amendment Bill, i.e., Nagar Palika Bill, in the Lok Sabha. The bill aimed at strengthening and revamping the municipal bodies by conferring a constitutional status on them. Although the bill was passed in the Lok Sabha, it was defeated in the Rajya Sabha in October 1989 and hence lapsed. V.P. Singh government. The National Front government under V.P. Singh introduced the revised Nagar Palika Bill in the Lok Sabha again in September 1990. However, the bill was not passed and finally lapsed due to the dissolution of the Lok Sabha. Narasimha Rao government. P.V. Narasimha Rao government also introduced the Modified Municipalities Bill in the Lok Sabha in September 1991. It finally emerged as the 74th Constitutional Amendment Act of 1992 and came into force on June 1, 19932. 2. The bill was passed in both the Lok Sabha and the Rajya Sabha in December 1992. After that, the bill was approved by the required number of state legislatures. It was assented by the President in April 1993. 74th Amendment Act of 1992. This act has added a new Part 9A to the Constitution of India. This part is entitled as the Municipalities and consists of provisions from Articles 243 P to 243 ZG. In addition, the Act has also added a new 12th schedule to the Constitution. This schedule contains 18 functional items of municipalities. It deals with Article 243 W. The Act gave constitutional status to the municipalities. It has brought them under the purview of justiciable part of the Constitution. In other words, state governments are under constitutional obligation to adopt the new system of municipalities in accordance with the provisions of the Act. 400 Indian Polity. The Act aims at revitalizing and strengthening the urban governments so that they function effectively as units of local government. Salient features. The salient features of the Act are: 3 types of municipalities. The Act provides for the constitution of the following 3 types of municipalities in every state. 1. A Nagar Panchayat, by whatever name called, for a transitional area. 3. 2. A municipal council for a smaller urban area. 3. A municipal corporation for a larger urban area. 3A transitional area means an area which is in transition from a rural area to an urban area. But there is one exception. If there is an urban area where municipal services are being provided by an industrial establishment, then the governor may specify that area to be an industrial township. In such a case, a municipality may not be constituted. The governor has to specify a transitional area, a smaller urban area, or a larger urban area, keeping in view the following factors: A. Population of the area. B. Density of the population therein. C. Revenue generated for local administration. D. Percentage of employment in non-agricultural activities. E. Economic importance. F. Such other factors as Husha may deem fit. Composition: all the members of a municipality shall be elected directly by the people of the municipal area. For this purpose, each municipal area shall be divided into territorial constituencies to be known as wards. The state legislature may provide the manner of election of the chairperson of a municipality. It may also provide for the representation of the following persons in a municipality. 1. Persons having special knowledge or experience in municipal administration without the right to vote in the meetings of municipality. 2. The members of the Lok Sabha and the State Legislative Assembly representing constituencies that comprise wholly or partly the municipal area. 3. The members of the Rajya Sabha and the State Legislative Council registered as electors within the municipal area. 4. The chairpersons of committees, other than wards committees. Wards committees: there shall be constituted a wards committee, consisting of one or more wards, within the territorial area of a municipality having population of 3 lakh or more. The state legislature may make provision with respect to the composition and the territorial area of a wards committee and the manner in which the seats in a wards committee shall be filled. Other committees: in addition to the wards committees, the state legislature is also allowed to make any provision for the constitution of other committees. The chairpersons of such committees may be made members of the municipality. Reservation of seats: the Act provides for the reservation of seats for the scheduled castes and the scheduled tribes in every municipality in proportion of their population to the total population in the municipal area. Further, it provides for the reservation of not less than 1/3 of the total number of seats for women, including the number of seats reserved for women belonging to the SCs and the STV. The state legislature may provide for the manner of reservation of offices of chairpersons in the municipalities for SCs, SITs, and women. It may also make any provision for the reservation of seats in any municipality or offices of chairpersons in municipalities in favor of backward classes. The reservation of seats as well as the reservation of offices of chairpersons in the municipalities for the scheduled castes and scheduled tribes shall cease to have effect after the expiration of the period specified in Article 334, which is presently 80 years, that is, till 2030. Duration of municipalities: the Act provides for a 5-year MRM of office for every municipality from the date of its first meeting. However, it can be dissolved before the completion of its term. Further, the fresh elections to constitute a municipality shall be completed: A. Before the expiry of its duration of 5 years. Or B. In case of dissolution, before the expiry of a period of 6 months from the date of its dissolution. But, where the remainder of the period, for which the dissolved municipality would have continued, is less than 6 months, it shall not be necessary to hold any election for constituting the new municipality for such period. Moreover, a municipality constituted upon the dissolution of a municipality before the expiration of its duration shall continue only for the remainder of the period for which the dissolved municipality would have continued had it not been so dissolved. In other words, a municipality reconstituted after premature dissolution does not enjoy the full period of 5 years, but remains in office only for the remainder of the period. The Act also makes 2 more provisions with respect to dissolution. A. A municipality must be given a reasonable opportunity of being heard before its dissolution. And B. No amendment of any law for the time being in force shall cause dissolution of a municipality before the expiry of the 5 years term. Disqualifications: a person shall be disqualified for being chosen as or for being a member of a municipality if Husha is so disqualified. A. Under any law for the time being in force for the purposes of elections to the legislature of the state concerned. Or B. Under any law made by the state legislature. However, no person shall be disqualified on the ground that Husha is less than 25 years of age if Husha has attained the age of 21 years. Further, all questions of disqualification shall be referred to such authority as the state legislature determines. State Election Commission: the superintendence, direction, and control of the preparation. Municipalities: 401. Of electoral rolls and the conduct of all elections to the municipalities shall be vested in the State Election Commission. The state legislature may make provision with respect to all matters relating to elections to the municipalities. Powers and functions: the state legislature may endow the municipalities with such powers and authority as may be necessary to enable them to function as institutions of self-government. Such a scheme may contain provisions for the devolution of powers and responsibilities upon municipalities at the appropriate level with respect to a. the preparation of plans for economic development and social justice, and b. the implementation of schemes for economic development and social justice as may be entrusted to them, including those in relation to the 18 matters listed in the 12th Schedule. Finances the state legislature may a. authorize a municipality to levy, collect, and appropriate taxes, duties, tolls, and fees. b. assign to a municipality taxes, duties, tolls, and fees levied and collected by state government. c. provide for making grants and aid to the municipalities from the consolidated fund of the state. And d. provide for constitution of funds for crediting all monies of the municipalities. Finance Commission. The Finance Commission, which is constituted for the Panchayats, shall also, for every 5 years, review the financial position of municipalities and make recommendations to the governor as to 1. the principles that should govern a. the distribution between the state and the municipalities of the net proceeds of the taxes, duties, tolls, and fees levied by the state and allocation of shares amongst the municipalities at all levels. b. the determination of the taxes, duties, tolls, and fees that may be assigned to the municipalities. c. the grants and aid to the municipalities from the consolidated fund of the state. For O2F Indian Polity. 2. the measures needed to improve the financial position of the municipalities. 3. any other matter referred to it by the governor in the interests of sound finance of municipalities. The governor shall place the recommendations of the commission along with the action taken report before the state legislature. The Central Finance Commission shall also suggest the measures needed to augment the consolidated fund of a state to supplement the resources of the municipalities in the state, on the basis of the recommendations made by the Finance Commission of the state. Audit of accounts. The state legislature may make provisions with respect to the maintenance of accounts by municipalities and the auditing of such accounts. Application to Union Territories. The provisions of this part are applicable to the Union Territories. However, the President may direct that they would apply to a Union Territory subject to such exceptions and modifications as Husha may specify. In exercise of the above power, the President, in 2001, directed that the provisions of Article 243ZD Committee for District Planning and 243ZE Committee for Metropolitan Planning shall not apply to the National Capital Territory of Delhi. Exempted areas. The Act does not apply to the scheduled areas and tribal areas in the states 4. It shall also not affect the functions and powers of the Darjeeling Gorkha Hill Council of the West Bengal. For at present, 10 states of India have scheduled areas. These are Andhra Pradesh, Telangana, Jharkhand, Chhattisgarh, Gujarat, Himachal Pradesh, Madhya Pradesh, Maharashtra, Orissa, and Rajasthan. Presently, there are a total often tribal areas, autonomous districts, in the 4 states of Assam, 3, Meghalaya, 3, Tripura, 1, and Mizoram, 3. However, the Parliament may extend the provisions of this part to the scheduled areas and tribal areas subject to such exceptions and modifications as it may specify. District Planning Committee. Every state shall constitute at the district level a district planning committee to consolidate the plans prepared by panchayats and municipalities in the district, and to prepare a draft development plan for the district as a whole. The state legislature may make provisions with respect to the following. 1. The composition of such committees. 2. The manner of election of members of such committees. 3. The functions of such committees in relation to district planning. And 4. The manner of the election of the chairpersons of such committees. The Act lays down that 4/5 of the members of a district planning committee should be elected by the elected members of the district panchayat and municipalities in the district from amongst themselves. The representation of these members in the committee should be in proportion to the ratio between the rural and urban populations in the district. In preparing the draft development plan, a district planning committee shall have regard to matters of common interest between the panchayats and the municipalities, including spatial planning, sharing of water and other physical and natural resources, the integrated development of infrastructure and environmental conservation, and 2. the extent and type of available resources, whether financial or otherwise. Further, the committee shall also consult such institutions and organizations as the governor may specify. The chairperson of a district planning committee shall forward the development plan to the state government. Metropolitan Planning Committee. Every metropolitan area shall have a Metropolitan Planning Committee to prepare a draft development plan. 5. The state legislature may make provisions with respect to the following. Area. An area having a population O or more, in one or more districts and consisting of 2 or more municipalities or panchayats or other contiguous areas. 1. The composition of such committees. 2. The manner of election of members of such committees. 3. The representation in such committees of the central government, state government, and other organizations. 4. The functions of such committees in relation to planning and coordination for the metropolitan area. And 5. The manner of election of chairpersons of such committees. The Act lays down that 2/3 of the members of a Metropolitan Planning Committee should be elected by the elected members of the municipalities and chairpersons of the panchayats in the metropolitan area from amongst themselves. The representation of these members in the committee should be in proportion to the ratio between the population of the municipalities and the panchayats in that metropolitan area. In preparing the draft development plan, a metropolitan planning committee shall have regard to I. The plans prepared by the municipalities and the panchayats in the metropolitan area. U. Matters of common interest between the municipalities and the panchayats, including coordinated spatial planning of the area, sharing of water and other physical and natural resources, the integrated development of infrastructure and environmental conservation. 3. The overall objectives and priorities set by the Government of India and the Government of the State. And 4. The extent and nature of investments likely to be made in the metropolitan area by agencies of the Government of India and of the Government of the State and other available resources, whether financial or otherwise. Municipalities. M. 403. Further, the committee shall also consult such institutions and organizations as the governor may specify. The chairperson of a metropolitan planning committee shall forward the development plan to the state government. Continuance of existing laws and municipalities. All the state laws relating to municipalities shall continue to be in force until the expiry of 1 year from the commencement of this act. In other words, the states have to adopt the new system of municipalities based on this act within the maximum period of 1 year from June 1, 1993, which is the date of commencement of this act. However, all municipalities existing immediately before the commencement of this act shall continue till the expiry off-year term, unless dissolved by the state legislature sooner. Bar to interference by courts in electoral matters. The Act bars the interference by courts in the electoral matters of municipalities. It declares that the validity of any law relating to the delimitation of constituencies or the allotment of seats to such constituencies cannot be questioned in any court. It further lays down that no election to any municipality is to be questioned except by an election petition presented to such authority and in such manner as provided by the state legislature. 12th Schedule. It contains the following 18 functional items placed within the purview of municipalities. 1. Urban planning including town planning. 2. Regulation of land use and construction of buildings. 3. Planning for economic and social development. 4. Roads and bridges. 5. Water supply for domestic, industrial, and commercial purposes. 6. Public health, sanitation, conservancy, and solid waste management. 7. Fire services. 8. Urban forestry, protection of the environment, and promotion of ecological aspects. Indian Polity. 9. Safeguarding the interests of weaker sections of society, including the handicapped and mentally retarded. 10. Slum improvement and upgradation. 11. Urban poverty alleviation. 12. Provision of urban amenities and facilities such as parks, gardens, playgrounds. 13. Promotion of cultural, educational, and aesthetic aspects. 14. Burials and burial grounds, cremations and cremation grounds, and electric crematoriums. 15. Cattle ponds, prevention of cruelty to animals. 16. Vital statistics including registration of births and deaths. 17. Public amenities including street lighting, parking lots, bus stops, and public conveniences. And 18. Regulation of slaughterhouses and tanneries. Types of urban governments. The following 8 types of urban local bodies are created in India for the administration of urban areas: municipal corporation, municipality, notified area committee, town area committee, cantonment board, township, port trust, special purpose agency. Municipal corporations are created for the administration of big cities like Delhi, Mumbai, Kolkata, Hyderabad, Bangalore, and others. They are established in the states by the acts of the concerned state legislatures, and in the union territories by the acts of the Parliament of India. There may be one common act for all the municipal corporations in a state or a separate act for each municipal corporation. A municipal corporation has 3 authorities, namely, the council, the standing committees, and the commissioner. The council is the deliberative and legislative wing of the corporation. It consists of the councillors directly elected by the people, as well as a few nominated persons having knowledge or experience of municipal administration. In brief, the composition of the council, including the reservation of seats for SCs, 81K, and women, is governed by the 74th Constitutional Amendment Act. The council is headed by a mayor. PESA is assisted by a deputy mayor. The mayor is elected in a majority of the states for a 1-year renewable term. PESA is basically an ornamental figure and a formal head of the corporation. PESA's main function is to preside over the meetings of the council. The standing committees are created to facilitate the working of the council, which is too large in size. They deal with public works, education, health, taxation, finance, and so on. They take decisions in their fields. The municipal commissioner is responsible for the implementation of the decisions taken by the council and its standing committees. Thus, PESA is the chief executive authority of the corporation. PESA is appointed by the state government and is generally a member of the S. A municipality. The municipalities are established for the administration of towns and smaller cities. Like the corporations, they are also set up in the states by the acts of the concerned state legislatures and in the union territories by the acts of the Parliament of India. They are also known by various other names like municipal council, municipal committee, municipal board, borough municipality, city municipality, and others. Like a municipal corporation, a municipality also has three authorities, namely, the council, the standing committees, and the chief executive officer. The council is the deliberative and legislative wing of the municipality. It consists of the councillors directly elected by the people. The council is headed by a president-chairman. PESA is assisted by a vice-president vice-chairman. PESA presides over the meetings of the council. Unlike the mayor of a municipal corporation, PESA plays a significant role and is the pivot of the municipal administration. Apart from presiding over the meetings of the council, PESA enjoys executive powers. The standing committees are created to facilitate the working of the council. They deal with public works, taxation, health, finance, and so on. The chief executive officer, chief municipal officer, is responsible for day-to-day general administration of the municipality. PESA is appointed by the state government. ESI Notified Area Committee. A notified area committee is created for the administration of two types of areas: a fast-developing town due to industrialization, and a town which does not yet fulfill all the conditions necessary for the constitution of a municipality, but which otherwise is considered important by the state government. Since it is established by a notification in the Government Gazette, it is called as Notified Area Committee. Though it functions within the framework of the State Municipal Act, only those provisions of the Act apply to it which are notified in the Government Gazette by which it is created. It may also be entrusted to exercise powers under any other act. Its powers are almost equivalent to those of a municipality. But unlike the municipality, it is an entirely nominated body, that is, all the members of a notified area committee, including the chairman, are nominated by the state government. Thus, it is neither an elected body nor a statutory body. A Town Area Committee. A town area committee is set up for the administration of a small town. It is a semi-municipal authority and is entrusted with a limited number of civic functions like drainage, roads, street lighting, and conservancy. It is created by a municipality's 405 separate act of a state legislature. Its composition, functions, and other matters are governed by the act. It may be wholly elected or wholly nominated by the state government, or partly elected and partly nominated. 6. The Rural-Urban Relationship Committee, 1963-66, headed by A. R. Jain, recommended that small-town area committees should be merged with the Panchayati Raj institutions to avoid multiplicity in the pattern of local bodies. A cantonment area is a delimited area where the military forces and troops are permanently stationed. 31. Cantonment Board. A cantonment board is established for municipal administration for civilian population in the cantonment area. 7. It is set up under the provisions of the Cantonments Act of 2006, a legislation enacted by the central government. It works under the administrative control of the Defense Ministry of the central government. Thus, unlike the above four types of urban local bodies, which are created and administered by the state government, a cantonment board is created as well as administered by the central government. The Cantonments Act of 2006 was enacted to consolidate and amend the law relating to the administration of cantonments with a view to impart greater democratization, improvement of their financial base, to make provisions for developmental activities and for matters connected with them. This act has repealed the Cantonments Act of 1924. At present, there are 62 cantonment boards in the country. They are grouped into four categories on the basis of the civil population. This is shown in Table 40.2. Table 40.2 Classification of Cantonment Boards 4060 Indian Polity. A cantonment board consists of partly elected and partly nominated members. The elected members hold office for a term of 5 years, while the nominated members, i.e., ex officio members, continue so long as they hold the office in that station. The military officer commanding the station is the ex officio president of the board and presides over its meetings. The vice president of the board is elected by the elected members from amongst themselves for a term of 5 years. The Category L cantonment board consists of the following members: I. A military officer commanding the station. 2. An executive engineer in the cantonment. 3. A health officer in the cantonment. 4. A first-class magistrate nominated by the district magistrate. 3 military officers nominated by the officer commanding the station. 6. 8 members elected by the people of the cantonment area. 7. Chief executive officer of the cantonment board. The functions performed by a cantonment board are similar to those of a municipality. These are statutorily categorized into obligatory functions and discretionary functions. The sources of income includes both tax revenue and non-tax revenue. The executive officer of the cantonment board is appointed by the President of India. PESA implements all the resolutions and decisions of the board and its committees. PESA belongs to the central cadre established for the purpose. Oil Township. This type of urban government is established by the large public enterprises to provide civic amenities to its staff and workers who live in the housing colonies built near the plant. The enterprise appoints a town administrator to look after the administration of the township. PESA is assisted by some engineers and other technical and non-technical staff. Thus, the township form of urban government has no elected members. In fact, it is an extension of the bureaucratic structure of the enterprise. A port trust. The port trusts are established in the port areas like Mumbai, Kolkata, Chennai, and so on for two purposes: A, to manage and protect the ports, and B, to provide civic amenities. A port trust is created by an act of parliament. It consists of both elected and nominated members. Its chairman is an official. Its civic functions are more or less similar to those of a municipality. Special purpose agency. In addition to these 7 area-based urban bodies or multi-purpose agencies, the states have set up certain agencies to undertake designated activities or specific functions that legitimately belong to the domain of municipal corporations or municipalities or other local urban governments. In other words, these are function-based and not area-based. They're known as single-purpose, unipurpose, or special-purpose agencies or functional local bodies. Some such bodies are 1. TBW and improvement trusts. 2. Urban development authorities. 3. Water supply and sewerage boards. 4. Housing boards. 5. Pollution control boards. 6. Electricity supply boards. 7. City transport boards. These functional local bodies are established as statutory bodies by an act of state legislature or as departments by an executive resolution. They function as autonomous bodies and deal with the functions allotted to them independently of the local urban governments, that is, municipal corporations or municipalities and so forth. Thus, they are not subordinate agencies of the local municipal bodies. 8. Ex-municipal personnel. There are 3 types of municipal personnel systems in India. The personnel working in the urban governments may belong to any one or all the 3 types. These are: separate personnel system. Under this system, each local body appoints, administers, and controls its own personnel. They are not transferable to other local bodies. It is the most widely prevalent system. This system upholds the principle of local autonomy and promotes undivided loyalty. 2. Unified personnel system. In this system, the state government appoints, administers, and controls the municipal personnel. In other words, statewide services cadres are created for all the urban bodies in the state. They are transferable between the local bodies in the state. This system is prevalent in Andhra Pradesh, Tamil Nadu, Uttar Pradesh, Rajasthan, Madhya Pradesh, and so on. 3. Integrated personnel system. Under this system, the personnel of the state government and those of the local bodies form part of the same service. In other words, the municipal personnel are the members of the state services. They are transferable not only between the local bodies in the state but also between local bodies and departments of state government. Thus, there is no distinction between local civil service and state civil service. This system is prevalent in Odisha, Bihar, Karnataka, Punjab, Haryana, and others. The various national-level institutions providing training to the municipal personnel are 1. All India Institute of Local Self-Government, Mumbai, constituted in 1927. It is a private registered society. 2. Center for Urban and Environmental Studies, New Delhi, set up in 1967 on the recommendation of Nuruddin Ahmed Committee on Training of Municipal Employees, 1963 to 1965. 3. Regional Centers for Urban and Environmental Studies, Kolkata, Lucknow. Municipalities 407. Hyderabad and Mumbai, set up in 1968 on the recommendation of Nuruddin Ahmed Committee on Training of Municipal Employees, 1963 to 1965. 4. National Institute of Urban Affairs, New Delhi, established in 1976. 5. Human Settlement Management Institute, New Delhi, established in 1985. Ex-municipal revenue. There are 5 sources of income of the urban local bodies. These are as follows. 1. T-checks revenue. The revenue from the local taxes include property tax, entertainment tax, taxes on advertisements, professional tax, water tax, tax on animals, lighting tax, pilgrim tax, market tax, toll on new bridges, and so on. In addition, the municipal bodies imposes various cesses like library cess, education cess, beggary cess, and so on. Property tax is the most important tax revenue. 2. Non-IAX revenue. This source include rent on municipal properties, fees and fines, royalty, profits and dividends, interest, user charges, and miscellaneous receipts. The user charges, i.e., payment for public utilities, include water charges, sanitation charges, sewerage charges, and so on. 3. Grants. These include the various grants given to municipal bodies by the central and state governments for several development programs, infrastructure schemes, urban reform initiatives, and so on. 4. Devolution. This consists of the transfer of funds to the urban local bodies from the state government. This devolution is made on the basis of the recommendations of the State Finance Commission. 5. Loans. The urban local bodies raise loans from the state government as well as financial institutions to meet their capital expenditure. They can borrow from the financial institutions or other bodies only with the approval of the state government. Central Council of Local Government. The Central Council of Local Government was set up in 1954. It was constituted under Article 263 of the Constitution of India by an order of the President of India. Originally, it was known as the Central Council of Local Self-Government. However, the term self-government was found to be superfluous and hence was replaced by the term government in the 1980s. Till 1958, It dealt with both urban as well as rural local governments, but after 1958 it has been dealing with matters of urban local government only. The Council is an advisory body. It consists of the Minister for Housing and Urban Affairs in the Government of India and the Ministers for Local Self-Government in States. The Union Minister acts as the chairman of the Council. The Council performs the following functions with regard to local government. I. Considering and recommending the policy matters. 2. Making proposals for legislation. In. Examining the possibility of cooperation between the center and the states. 4. Drawing up a common program of action. V. Recommending central financial assistance. 6. Reviewing the work done by the local bodies with the central financial assistance. Table 40.3 Articles related to municipalities at a glance. Article No. Subject Matter. 243p Definitions. 243q Constitution of Municipalities. 243 or Composition of Municipalities. 2435 Constitution and Composition of Wards Committees, and so on. 2437 Reservation of Seats. 243u Duration of Municipalities, and so on. 243v Disqualifications for Membership. 243w Powers, Authority, and Responsibilities of Municipalities, and so on. 243x Powers to impose taxes by, and funds of, the municipalities. 243y Finance Commission. 2432 Audit of Accounts of Municipalities. 243za Elections to the Municipalities. 24328 Application to Union Territories. 24320 Part Not to Apply to Certain Areas. 2432v Committee for District Planning. 24328 Committee for Metropolitan Planning. 24328 Continuance of Existing Laws and Municipalities. 24326 Bar to Interference by Courts in Electoral Matters. Part Y Union Territories and Special Areas. See CHAPTIA. M41 Union Territories. Under Article 1 of the Constitution, the territory of India comprises 3 categories of territories. A. Territories of the states. B. Union territories. And C. Territories that may be acquired by the Government of India at any time. At present, there are 28 states, 8 union territories, and no acquired territories. The states are the members of the federal system in India and share a distribution of power with the center. The union territories, on the other hand, are those areas which are under the direct control and administration of the central government. Hence, they are also known as centrally administered territories. In this way, existence of these territories constitutes a conspicuous departure from federalism in India. The Government of India is plainly unitary insofar as the relationship between New Delhi and these central enclaves is concerned. 1. 2 inches 1950, the Constitution contained a fourfold classification of the states and territories of the Indian Union, Part A, Part B, and Part C states and Part D territories. T. Creation of Union territories. During the British rule, certain areas were constituted as scheduled districts in 1874. Later, they came to be known as Chief Commissioners' provinces. After independence, they were placed in the category of Part C. S. R. Maheshwari, State Governments in India, Macmillan, 2000 edition, p. 131. States and Part D territories too. In 1956, they were constituted as the Union Territories by the 7th Constitutional Amendment Act, 1956, and the States Reorganization Act, 1956. Gradually, some of these union territories have been elevated to statehood. Thus, Himachal Pradesh, Manipur, Tripura, Mizoram, Arunachal Pradesh, and Goa, which are states today, were formerly union territories. On the other hand, the territories that were acquired from the Portuguese, Goa, Daman and Diu, and Dadra and Nagar Haveli, and the French Puducherry, were constituted as the union territories. At present, there are 8 union territories. They are, along with the year of creation, 1. Andaman and Nicobar Islands, 1956, 2. Delhi, 1956, 3. Lakshadweep, 1956, 4. Puducherry, 1962, 5. Chandigarh, 1966. 6. Jammu and Kashmir, 2019, 7. Ladakh, 2019, and 8. Dadra and Nagar Haveli and Daman and Diu, 2020. Till 1973, Lakshadweep was known by the name of Lakadive, Minicoy, and Amandivi Islands. In 1992, Delhi was redesignated as the National Capital Territory of Delhi. Till 2006, Puducherry was known as Pondicherry. 410 Indian Polity. The Union Territories have been created for a variety of reasons. These are mentioned below. 3. 3J.C. Johari, Indian Government and Politics, Vishal, Volume 2, 13th edition, 2001, p. 499. 1. Political and Administrative Consideration, Delhi and Chandigarh. 2. Cultural Distinctiveness, Puducherry and Dadra and Nagar Haveli and Daman and Diu. 3. Strategic Importance, Andaman and Nicobar Islands and Lakshadweep. 4. Special Treatment and Care of the Backward and Tribal People, Mizoram, Manipur, Tripura and Arunachal Pradesh, which later became states. In 2019, the erstwhile state of Jammu and Kashmir was bifurcated into 2 separate union territories, namely, the Union Territory of Jammu and Kashmir, and the Union Territory of Ladakh. While introducing the Jammu and Kashmir Reorganization Bill 2019 in the Parliament, the central government gave the following reasons for the creation of these two new Union territories. 1. The Ladakh division of the state of Jammu and Kashmir has a large area but is sparsely populated with a very difficult terrain. There has been a long-pending demand of people of Ladakh to give it the status of a Union territory to enable them to realize their aspirations. The Union Territory of Ladakh will be without a legislature. 2. Further, keeping in view the prevailing internal security situation, fueled by cross-border terrorism in the existing state of Jammu and Kashmir, a separate Union Territory for Jammu and Kashmir is being created. The Union Territory of Jammu and Kashmir will be with a legislature. In 2020, the erstwhile two separate Union Territory of Dadra and Nagar Haveli, originally created in 1961, and Union Territory of Daman and Diu, originally created in 1962, were merged into a new Union Territory of Dadra and Nagar Haveli and Daman and Diu. While introducing the Dadra and Nagar Haveli and Daman and Diu Merger of Union Territories Bill 2019 in the Parliament, the central government gave the following reasons for the merger of these two separate Union Territories into a single Union Territory. 1. The Union Territories of Dadra and Nagar Haveli and Daman and Diu share a lot in terms of administrative setup, history, language, and culture. The secretaries to various departments, chief of police and chief conservator of forest of the both Union Territories are common, and the officers of all India services posted by the Ministries of Home Affairs, Environment and Forest serve both these territories as per their work allocation. Further, the policies and development schemes in various sectors including tourism, industries, education, information technology are similar. 2. Besides these, there are two secretariats and parallel departments which consume infrastructure and manpower in each Union Territory. The administrator, secretaries, and heads of certain departments functions in both the Union Territories on alternate days affecting their availability to people and monitoring functioning of subordinate staff. The subordinate employees of both the Union Territories are separate. Further, various departments of the Government of India have to coordinate with both the Union Territories separately, causing duplication of works. Z. Having two separate constitutional and administrative entities in both the Union Territories leads to a lot of duplicacy, inefficiency, and wasteful expenditure. Further, this also causes unnecessary financial burden on the government. Besides, 3. The Dadra and Nagar Haveli and Daman and Diu Merger of Union Territories Act 2019 with effect from January 26, 2020. Union Territories 411. There are various challenges for cadre management and career progression of employees. 4. In view of the policy of the government to have minimum government, maximum governance, considering small population and limited geographical area of both the Union Territories and to use the services of officers efficiently, it has been decided to merge the Union Territories of Dadra and Nagar Haveli and Daman and Diu into a single Union Territory. Administration of Union Territories. For the Assembly of Puducherry consists of 30 members while that of Delhi 70 members and that of Jammu and Kashmir 83 members. Articles 239 to 241 in Part 8 of the Constitution deal with the Union Territories. Even though all the Union Territories belong to one category, there is no uniformity in their administrative system. Every Union Territory is administered by the President acting through an administrator appointed by him or her. An administrator of a Union Territory is an agent of the President and not head of state like a governor. The President can specify the designation of an administrator. It may be Lieutenant Governor or Chief Commissioner or Administrator. At present, it is Lieutenant Governor in the case of Delhi, Puducherry, Andaman and Nicobar Islands, Jammu and Kashmir and Ladakh, and Administrator in the case of Chandigarh, Dadra and Nagar Haveli and Daman and Diu and Lakshadweep. The President can also appoint the Governor of a state as the administrator of an adjoining Union Territory. In that capacity, the Governor is to act independently Officer Council of Ministers. The Union Territories of Puducherry in 1963, Delhi in 1992, and Jammu and Kashmir in 2019 are provided with a Legislative Assembly for and a Council of Ministers headed by a Chief Minister. The remaining 6 Union Territories do not have such popular political institutions. But the establishment of such institutions in the Union Territories does not diminish the supreme control of the President and Parliament over them. The Parliament can make laws on any subject of the 3 lists, including the state list, for the Union Territories. This power of Parliament also extends to Puducherry, Delhi, and Jammu and Kashmir, which have their own local legislatures. This means that the legislative power of Parliament for the Union Territories on subjects of the state list remain unaffected even after establishing a local legislature for them. But the Legislative Assembly of Puducherry can also make laws on any subject of the state list and the concurrent list. Similarly, the Legislative Assembly of Delhi can make laws on any subject of the state list, except public order, police and land, and the concurrent list. Likewise, the Legislative Assembly of Jammu and Kashmir can make laws on any subject of the state list, except public order and police, and the concurrent list. The President can make regulations for the peace, Progress and good government of the Andaman and Nicobar Islands, Lakshadweep, Dadra and Nagar Haveli and Daman and Diu, and Ladakh. In the case of Puducherry also, the president can legislate by making regulations but only when the assembly is suspended or dissolved. A regulation made by the president has the same force and effect as an act of parliament and can also repeal or amend any act of parliament in relation to these union territories. The parliament can establish a high court for a union territory or put it under the jurisdiction of the high court of adjacent state. Delhi is the only union territory that has a high court of its own since 1966. The Bombay High Court has got jurisdiction over the union territory of Dadra and Nagar Haveli and Daman and Diu. Andaman and Nicobar Islands, Chandigarh, Lakshadweep and Puducherry are placed under the Calcutta, Punjab and Haryana, Kerala, and Madras High Courts respectively. The Jammu and Kashmir and Ladakh High Court is the common high court for the two union territories of Jammu and Kashmir and Ladakh. The administrative system, executive, legislature, and judiciary of union territories is summarized in Table 41.1. Similarly, a comparison of states and union territories is also given in Table 41.2. The Constitution does not contain any separate provisions for the administration of acquired territories. But the constitutional provisions for the administration of union territories also apply to the acquired territories. T. Special provisions for Delhi. The 69th Constitutional Amendment Act of 1915 provided a special status to the Union Territory of Delhi and redesignated it the national capital territory of Delhi and designated the administrator of Delhi as the lieutenant governor. It created a legislative assembly and a council of ministers for Delhi. 5 with effect from February 1, 1992. The strength of the assembly is fixed at 70 members, directly elected by the people. The elections are conducted by the Election Commission of India. The assembly can make laws on all the matters of the state list and the concurrent list except the 3 matters of the state list, that is, public order, police, and land. But the laws of parliament prevail over those made by the assembly. The strength of the council of ministers is fixed at 10% of the total strength of the assembly, that is, 7 chief minister and 6 other ministers. The chief minister is appointed by the president, not by the governor. The other ministers are appointed by the president on the advice of the chief minister. The ministers hold office during the pleasure of the president. The council of ministers is collectively responsible to the assembly. The council of ministers headed by the chief minister aid and advise the governor in the exercise of Hisho functions except in so far as Hisho is required to act in Hisho discretion. In the case of difference of opinion between the governor and Hisho ministers, the governor is to refer the matter to the president for decision and act accordingly. When a situation arises in which the administration of the territory cannot be carried on in accordance with the above provisions, the president can suspend their above provisions operation and make the necessary incidental or consequential provisions for administering the territory. In brief, in case of failure of constitutional machinery, the president can impose Hisho rule in the territory. This can be done on the report of the governor or otherwise. This provision resembles Article 356, which deals with the imposition of president's rule in the states. The governor is empowered to promulgate ordinances during recess of the assembly. An ordinance has the same force as an act of the assembly. Every such ordinance must be approved by the assembly within 6 weeks from its reassembly. He can also withdraw an ordinance at any time. But he cannot promulgate an ordinance when the assembly is dissolved or suspended. Further, no such ordinance can be promulgated or withdrawn without the prior permission of the president. Advisory Committees of Union Territories under the Government of India, Allocation of Business, Rules 1961, Ministry of Home Affairs is the nodal ministry for all matters of Union Territories relating to legislation, finance and budget, services and appointment of governors and administrators. All the 5 without legislature, Andaman and Nicobar Islands, Chandigarh, Dadra and Nagar Haveli and Daman and Diu, Lakshadweep and Ladakh, have the Forum Union Territories 413. Of Home Ministers Advisory Committee, HMAC, Administrators Advisory Committee, AAC. While HMAC is chaired by the Union Home Minister, AAC is chaired by the administrator of the concerned UTK, the members of parliament and elected members. From the local bodies, district panchayats and municipal councils of the respective UTs are members of these committees among others. These committees discusses the general issues relating to social and economic development of the UTK 67. 6 Annual Report 2021-22, Ministry of Home Affairs, Government of India, p. 60. 7 India 2022, a Reference Annual, Publications Division, Government of India, p. 71. Note, the Governor of Punjab is concurrently the Administrator of Chandigarh 7. Table 41.1 Administrative System of Union Territories at a glance. Union Territories Executive Legislature Judiciary. 1 Andaman and Nicobar Islands LT. Governor, under Calcutta High Court. 2. Chandigarh Administrator, under Punjab and Haryana High Court. 3. Dadra and Nagar Haveli and Daman and Diu. Administrator, under Bombay High Court. 4. Delhi A. LT. Governor. B. Chief Minister. C. Council of Ministers. Legislative Assembly separate High Court. 5. Lakshadweep Administrator, under Kerala High Court. 6. Puducherry. A. LT. Governor. B. Chief Minister. C. Council of Ministers. Legislative Assembly under Madras High Court. 7. Jammu and Kashmir. A. LT. Governor. B. Chief Minister. C. Council of Ministers. Legislative Assembly under Jammu and Kashmir. Ladakh High Court. 8. Ladakh LT. Governor, under Jammu and Kashmir. Ladakh High Court. Table 41.2 Comparing States and Union Territories. States Union Territories. 1. Their relationship with center is federal. 1. Their relationship with center is unitary. 2. They share a distribution of power with the center. 2. They are under the direct control and administration of the center. 3. They have autonomy. 3. They do not have any autonomy. For foot, there is uniformity in their administrative setup. 4. There is no uniformity in their administrative setup. 5. Their executive head is known as governor. 5. Their executive head is known by various designations. Administrator or lieutenant governor or chief commissioner. Continued. 414 Indian Polity. States Union Territories. 6. A governor is the constitutional head of the state. 6. An administrator is an agent of the president. 7. Parliament cannot make laws on the subjects of the state list in relation to the states except under extraordinary circumstances. 7. Parliament can make laws on any subject of the three lists in relation to the Union Territories. Table 41.3 Articles related to Union Territories at a glance. 239. Administration of Union Territories. 239A. Creation of local legislatures or council of ministers or both for certain Union Territories. 239AA. Special provisions with respect to Delhi. 239AB. Provision in case of failure of constitutional machinery. 2398. Power of administrator to promulgate ordinances during recess of legislature. 240. Power of president to make regulations for certain Union Territories. 241. High Courts for Union Territories. 242. Corg, repealed. Chap 42 Scheduled and Tribal Areas. Article 244, in Part 10 of the Constitution, envisages a special system of administration for certain areas designated as scheduled areas and tribal areas. The fifth schedule of the Constitution deals with the administration and control of scheduled areas and scheduled tribes in any state except the four states of Assam, Meghalaya, Tripura, and Mizoram. The sixth schedule of the Constitution, on the other hand, deals with the administration of the tribal areas in the four northeastern states of Assam, Meghalaya, Tripura, and Mizoram. Administration of scheduled areas. The scheduled areas are treated differently from the other areas in the country because they are inhabited by aboriginals who are socially and economically rather backward, and special efforts need to be made to improve their condition. Therefore, the whole of the normal administrative machinery operating in a state is not extended to the scheduled areas, and the central government has somewhat greater responsibility for these areas too. When at present, 10 states of India have scheduled areas. These are Andhra Pradesh, Telangana, Jharkhand, Chhattisgarh, Gujarat, Himachal Pradesh, Madhya Pradesh, Maharashtra, Odisha, and Rajasthan. MP Jain, Indian Constitutional Law, Wadhwa, 4th edition, 1987, p. 236. Annual Report 2021-22, Ministry of Tribal Affairs, Government of India, p. 51. The various features of administration contained in the fifth schedule are as follows. 1. Declaration of scheduled areas. The President is empowered to declare an area to be a scheduled area. PESA can also increase or decrease its area, alter its boundary lines, rescind such designation, or make fresh orders for such redesignation on an area in consultation with the governor of the state concerned. The criteria for declaring any area as a scheduled area is as follows. 23. I. Preponderance of tribal population. 2. Compactness and reasonable size of the area. 3. A viable administrative entity such as a district, block, or think. And 4. Economic backwardness of the area as compared to the neighboring areas. The above criteria for declaration of scheduled areas is as such not spelt out in the Constitution, but has become well established. 2. Executive power of state and center. The executive power of a state extends to the scheduled areas therein. But the governor has a special responsibility regarding such areas. PESA has to submit a report to the president regarding the administration of such areas, annually or whenever so required by the president. The executive power of the center extends to giving directions to the states regarding the administration of such areas. 3. Tribes Advisory Council. Each state having scheduled areas has to establish a Tribes Advisory Council to advise on welfare and advancement of the scheduled tribes. It is to consist of 20 members, 3/4 of whom are to be the representatives of the scheduled tribes in the state legislative assembly. A similar council can also be established in a state having scheduled tribes but not scheduled areas therein, if the president so directs. 4. Law applicable to scheduled areas. The governor is empowered to direct that any particular act of Parliament or the state legislature does not apply to a scheduled area or apply with specified modifications and exceptions. She can also make regulations for the peace and good government of a scheduled area after consulting the tribe's advisory council. Such regulations may prohibit or restrict the transfer of land by or among members of the scheduled tribes, regulate the allotment of land to members of the scheduled tribes, and regulate the business of moneylending in relation to the scheduled tribes. Also, a regulation may repeal or amend any act of Parliament or the state legislature, which is applicable to a scheduled area. But all such regulations require the assent of the President. The Constitution requires the President to appoint a commission to report on the administration of the scheduled areas and the welfare of the scheduled tribes in the states. PESA can appoint such a commission at any time, but compulsorily after 10 years of the commencement of the Constitution. Hence, a commission was appointed in 1960. It was headed by UN Debar and submitted its report in 1961. After 4 decades, the second commission was appointed in 2002, under the chairmanship of Dalip Singh Bhuria. It submitted its report in 2004. Administration of Tribal Areas the Constitution, under 6th Schedule, contains special provisions for the administration of tribal areas in the 4 northeastern states of Assam, Meghalaya, Tripura, and Mizoram. The rationality behind the special arrangements in respect of only these 4 states lies in the following. The tribes in Assam, Meghalaya, Tripura, and Mizoram have not assimilated much the life and ways of the other people in these states. These areas have hitherto been anthropological specimens. The tribal people in other parts of India have more or less adopted the culture of the majority of the people in whose midst they live. The tribes in Assam, Meghalaya, Tripura, and Mizoram, on the other hand, still have their roots in their own culture, customs, and civilization. These areas are, therefore, treated differently bv the Constitution, and sizable amount of autonomy has been given to these people for self-government. 3. Same as footnote 2 above. p. 237. At present, there are 10 tribal areas in the 4 northeastern states of Assam, Meghalaya, Tripura, and Mizoram. These are mentioned in THBLI 42.1. The various features of administration contained in the 6th Schedule are as follows. 1. The tribal areas in the 4 states of Assam, Meghalaya, Tripura, and Mizoram have been constituted as autonomous districts. But they do not fall outside the executive authority of the state concerned. 2. The governor is empowered to organize and reorganize the autonomous districts. Thus, PESA can increase or decrease their areas or change their names or define their boundaries and so on. 3. If there are different tribes in an autonomous district, the governor can divide the district into several autonomous regions. 4. Each autonomous district has a district council consisting of 30 members, of whom 4 are nominated by the governor and the remaining 26 are elected on the basis of adult franchise. The elected members hold office for a term of 5 years, unless the council is dissolved earlier, and nominated members hold office during the pleasure of the governor. Each autonomous region also has a separate regional council. 5. The district and regional councils administer the areas under their jurisdiction. They can make laws on certain specified matters like land, forests, canal water, shifting cultivation, village administration, inheritance of property, marriage and divorce, social customs, and so on. But all such laws require the assent of the governor. 6. The district and regional councils within their territorial jurisdictions can constitute village councils or courts for trial of suits and cases between the tribes. They hear appeals from them. The jurisdiction of High Court over these suits and cases is specified by the governor. Scheduled and tribal areas for 17. 7. The district council can establish, construct, or manage primary schools, dispensaries, markets, ferries, fisheries, roads, and so on in the district. It can also make regulations for the control of money lending and trading by non-tribals. But such regulations require the assent of the governor. 8. The district and regional councils are empowered to assess and collect land revenue and to impose certain specified taxes. 9. The acts of Parliament or the state legislature do not apply to autonomous districts and autonomous regions or apply with specified modifications and exceptions for the power of direction, in this regard, lies either with the President or the governor. Thus, in the case of Assam, it lies with the governor, both in respect of acts of Parliament or state legislature. In the case of Meghalaya, Tripura, and Mizoram, it lies with the President in respect of acts of Parliament and governor in respect of acts of state legislature. 10. The governor can appoint a commission to examine and report on any matter relating to the administration of the autonomous districts or regions. She may dissolve a district or regional council on the recommendation of the commission. Table 42.1 Tribal areas at a glance. States tribal areas. 1. Assam 1. North Kutcher Hills District. 2. Karbi Along District. 3. Bodoland Territorial Areas District. 2. Meghalaya 1. Khasi Hills District. 2. Jaintia Hills District. 3. Garo Hills District. 3. Tripura Tribal Areas District. 4. Mizoram 1. Chakma District. 2. Mara District. 3. Lai District. For 18.0 Indian Polity. Table 42.2 Articles related to scheduled and tribal areas at a glance. Article No. Subject Matter. 244. Administration of scheduled areas and tribal areas. 244A. Formation of an autonomous state comprising certain tribal areas in Assam and creation of local legislature or council of ministers or both therefore. 339. Control of the Union over the administration of scheduled areas and the welfare of scheduled tribes. Scan the QR code to access the conceptual video on scheduled and tribal areas, demonstration and discussion through Indian map, and other important topics on Edge Part Y constitutional bodies. In this part. 43. Election Commission 44. Union Public Service Commission 45. State Public Service Commission I-46. Finance Commission 47. Goods and Services Tax Council 48. National Commission for SCs 49. National Commission for STs 50. National Commission for BCs 51. Special Officer for Linguistic Minorities 52. Comptroller and Auditor General of India 53. Attorney General of India 54. Advocate General of the State 55. Constitutional Prescriptions. Chapter 43 Election Commission. The Election Commission is a permanent and an independent body established by the Constitution of India directly to ensure free and fair elections in the country. Article 324 of the Constitution provides that the power of superintendence, direction, and control of elections to Parliament, state legislatures, the office of President of India and the office of Vice President of India shall be vested in the Election Commission. Thus, the Election Commission is an all-India body in the sense that it is common to both the central government and the state governments. It must be noted here that the Election Commission is not concerned with the elections to panchayats and municipalities in the states. For this, the Constitution of India provides for a separate State Election Commission 1. The 73rd and 74th Constitutional Amendment Acts of 1992. 7. Composition. Article 324 of the Constitution has made the following provisions with regard to the composition of Election Commission. 1. The Election Commission shall consist of the Chief Election Commissioner and such number of other election commissioners, if any, as the President may from time to time fix. 2. The appointment of the Chief Election Commissioner and other election commissioners shall be made by the President. 3. When any other election commissioner is so appointed, the Chief Election Commissioner shall act as the Chairman of the Election Commission. 4. The President may also appoint after consultation with the Election Commission such regional commissioners as he/she may consider necessary to assist the Election Commission. 5. Subject to the provisions of any law made by the Parliament, the conditions of service and tenure of office of the Election Commissioners and the regional commissioners shall be determined by the President. Since its inception in 1950 until October 15, 1989, the Election Commission functioned as a single-member body consisting of the Chief Election Commissioner. On 420 Indian Polity. October 16, 1989, the President appointed 2 more election commissioners to cope with the increased work of the Election Commission on account of lowering of the voting age from 21 to 18 years. Thereafter, the Election Commission functioned as a multi-member body consisting of 3 election commissioners. However, the 2 posts of election commissioners were abolished in January 1990, and the Election Commission was reverted to the earlier position. Again in October 1993, the President appointed 2 more election commissioners. Since then until today, the Election Commission has been functioning as a multi-member body consisting of 3 election commissioners. The Election Commission Conditions of Service of Election Commissioners and Transaction of Business, Act, 1991 contains the following provisions. 1. The Chief Election Commissioner and the 2 other election commissioners shall have equal powers and receive equal salary, allowances and other perquisites, which are similar to those of a judge of the Supreme Court. 3.2. In case of difference of opinion amongst the Chief Election Commissioner and or 2 other election commissioners, the matter is decided by the Commission by majority. 3. They hold office for a term of 6 years or until they attain the age of 65 years, whichever is earlier. They can also resign at any time by writing to the President. 3. Anup Baranwal vs. Union of India, 2023. F. Independence. Article 324 of the Constitution has made the following provisions to safeguard and ensure the independent and impartial functioning of the Election Commission. 1. The Chief Election Commissioner is provided with the security of tenure. 2. By the 61st Constitutional Amendment Act of 1988, which came into force in 1989. 3. In 2018, the salary of a judge of the Supreme Court had been fixed at 2.50 lakh per month. Husha cannot be removed from his or office except in same manner and on the same grounds as a judge of the Supreme Court. In other words, Husha can be removed by the President on the basis of a resolution passed to that effect by both the Houses of Parliament with special majority, either on the ground of proved misbehavior or incapacity. Thus, Husha does not hold Hishu office till the pleasure of the President, though they are appointed by him or her. 2. The service conditions of the Chief Election Commissioner cannot be varied to his or disadvantage after Hishu appointment. 3. Any other election commissioner or a regional commissioner cannot be removed from office except on the recommendation of the Chief Election Commissioner. This means that the protection, security of tenure, available to the Chief Election Commissioner is not available to the other election commissioners. Though the Constitution has sought to safeguard and ensure the independence and impartiality of the Election Commission, some flaws can be noted, viz. 1. The Constitution has not prescribed the qualifications, legal, educational, administrative, or judicial, of the members of the Election Commission. 2. The Constitution has not specified the term of the members of the Election Commission. 3. The Constitution has not debarred the retiring election commissioners from any further appointment by the government. In Anup Baranwal Case 3A 2023, the Supreme Court gave the following directions to ensure the independence and neutrality of the Election Commission, free from all external political and executive interference. 1. It declared that the appointment of the Chief Election Commissioner and the other election commissioners shall be made on the recommendations of a three-member committee consisting of the following. A. The Prime Minister. B. The Leader of the Opposition in the Lok Sabha. In case there is no Leader of the Opposition in the Lok Sabha, then the Leader of the largest opposition party in terms of the numerical strength, and C. The Chief Justice of India. 2. It is desirable that the grounds of removal of the other election commissioners shall be the same as that of the Chief Election Commissioner, i.e., on the like grounds as a judge of the Supreme Court subject to the recommendation of the Chief Election Commissioner as provided under Article 324 of the Constitution. 3. The conditions of service of the other election commissioners shall not be varied to their disadvantage after appointment. According to the Supreme Court, the above directions shall be in effect until the Parliament makes a law in consonance with Article 324 of the Constitution. Powers and functions. The powers and functions of the Election Commission with regard to elections to the Parliament, state legislatures, and offices of President and Vice President can be classified into three categories, viz. 1. Administrative. 2. Advisory. 3. Quasi-judicial. In detail, these powers and functions are 1. 1b. Determine the territorial areas of the electoral constituencies throughout the country on the basis of the Delimitation Commission Act of Parliament. 2. LB. Prepare and periodically revise electoral rolls and to register all eligible voters. For the Parliament has made the Delimitation Commission Acts in 1952, 1962, 1972, and 2002. Election Commission 421. 3. To notify the dates and schedules of elections and to scrutinize nomination papers. 4. LB. Grant recognition to political parties and allot election symbols to them. 5. 1b. Act as a court for settling disputes related to granting of recognition to political parties and allotment of election symbols to them. 6. 1b. Appoint officers for inquiring into disputes relating to electoral arrangements. 7. LB. Determine the code of conduct to be observed by the parties and the candidates at the time of elections. 8. 1b. Prepare a roster for publicity of the policies of the political parties on radio and TV in times of elections. 9. LB. Advise the President on matters relating to the disqualifications of the members of Parliament. 10. LB. Advise the Governor on matters relating to the disqualifications of the members of state legislature. 11. 1b. Cancel polls in the event of rigging, booth capturing, violence, and other irregularities. 12. 1b. Request the President or the Governor for requisitioning the staff necessary for conducting elections. 13. LB. Supervise the machinery of elections throughout the country to ensure free and fair elections. 14. LB. Advise the President whether elections can be held in a state under President's rule in order to extend the period of emergency after 1 year. 15. LB. Register political parties for the purpose of elections and grant them the status of national or state parties on the basis of their poll performance. The Election Commission is assisted by Deputy Election Commissioners. They are drawn from the civil service and appointed by the Commission with tenure system. They are assisted, in turn, by the Secretaries, Joint Secretaries, Deputy Secretaries, and Under-Secretaries posted in the Secretariat of the Commission. For 22 are Indian Polity. At the state level, the Election Commission is assisted by the Chief Electoral Officer, who is appointed by the Chief Election Commissioner in consultation with the state government. Below this, at the district level, the collector acts as the district returning officer. PESA appoints a returning officer for every constituency in the district and presiding officer for every polling booth in the constituency. Vision, mission. In principles, the vision, mission, and guiding principles of the Election Commission are as follows. 1. Strategic Plan 2016 to 2025, Election Commission of India, pp. 8-9. Vision. The Election Commission of India strives to be an institution of excellence by enhancing active engagement, participation, and deepening and strengthening electoral democracy in India and globally. Mission. The Election Commission of India maintains independence, integrity, and autonomy, ensures accessibility, inclusiveness, and ethical participation of stakeholders, and adopts highest standards of professionalism for delivering free, fair, and transparent elections to strengthen the trust in electoral democracy and governance. Guiding principles. The Commission has laid down for itself guiding principles of good governance. 1. To uphold the values enshrined in the Constitution, viz., equality, equity, impartiality, independence, and rule of law and superintendence, direction, and control over the electoral governance. 2. ID conduct elections with highest standard of credibility, freeness, fairness, transparency, integrity, accountability, autonomy, and professionalism. 3. LB ensure participation of all eligible citizens in the electoral process in an inclusive voter-centric and voter-friendly environment. 4. LB engage with political parties and all stakeholders in the interest of electoral process. 5. LB promote awareness about the electoral process and electoral governance amongst stakeholders, namely voters, political parties, election functionaries, candidates, and people at large, and to enhance and strengthen confidence and trust in the electoral system of 10's country. 6. LB develop the human resource for effective and professional delivery of electoral services. 7. LB build quality infrastructure for smooth conduct of electoral process. 8. LB adopt technology for improvement in all areas of electoral process. 9. LB strive for adoption of innovative practices for achieving excellence and overall realization of the vision and mission. 10. To contribute towards the reinforcement of democratic values by maintaining and reinforcing confidence and trust of the people in the electoral system of the country. Chapter 44 Union Public Service Commission. TH Union Public Service Commission, UPSC, is the central recruiting agency in India. It is an independent constitutional body in the sense that it has been directly created by the Constitution. Articles 315 to 323 and Part 14 of the Constitution contain elaborate provisions regarding the composition, appointment, and removal of members along with the independence, power, and functions of the UPSC. Composition. The UPSC consists of a chairman and other members appointed by the President of India. The Constitution, without specifying the strength of the Commission, has left the matter to the discretion of the President, who determines its composition. Further, no qualifications are prescribed for the Commission's membership except that one half of the members of the Commission should be such persons who have held office for at least 10 years either under the Government of India or under the government of a state. The Constitution also authorizes the President to determine the conditions of service of the Chairman and other members of the Commission. In addition, the President is authorized to make provisions with respect to the number of members of the staff of the Commission and their conditions of service. The Chairman and members of the Commission hold office for a term of 6 years or until they attain the age of 65 years, whichever is earlier. However, they can relinquish their offices at any time by addressing their resignation to the President. They can also be removed before the expiry of their term by the President in the manner as provided in the Constitution. The President can appoint one of the members of the UPSC as an acting chairman in the following two circumstances. 1. Added by the 15th Amendment Act of 1963. A. When the office of the chairman falls vacant. Or B. When the chairman is unable to perform his functions due to absence or some other reason. The acting chairman functions till a person appointed as chairman enters on the duties of the office or till the chairman is able to resume his duties. Removal. The President can remove the chairman or any other member of UPSC from the office under the following circumstances. A. If HISHA is adjudged an insolvent, that is, has gone bankrupt. B. If HISHA engages, during HISHA term of office, in any paid employment outside the duties of HISHA office. Or C. If HISHA is, in the opinion of the President, unfit to continue in office by reason of infirmity of mind or body. In addition to these, the President can also remove the chairman or any other member of UPSC for misbehavior. However, in this case, the President has to refer the matter to the Supreme Court for an inquiry. If the 424 Indian Polity Supreme Court, after the inquiry, upholds the cause of removal and advises so, the President can remove the chairman or member. Under the provisions of the Constitution, the advice tendered by the Supreme Court in this regard is binding on the President. During the course of inquiry by the Supreme Court, the President can suspend the chairman or the member of UPSC. Defining the term misbehavior in this context, the Constitution states that the chairman or any other member of the UPSC is deemed to be guilty of misbehavior if HISHA A. is concerned or interested in any contract or agreement made by the Government of India or the government of a state, or B. participates in any way in the profit of such contract or agreement or in any benefit therefrom otherwise than as a member and in common with other members of an incorporated company. Independence. The Constitution has made the following provisions to safeguard and ensure the independent and impartial functioning of the UPSC. A. The chairman or a member of the UPSC can be removed from office by the President only in the manner and on the grounds mentioned in the Constitution. Therefore, they enjoy security of tenure. B. The conditions of service of the chairman or a member, though determined by the President, cannot be varied to his or disadvantage after his appointment. C. The entire expenses including the salaries, allowances, and pensions of the chairman and members and also the staff of the UPSC are charged on the Consolidated Fund of India. Thus, they are not subject to vote of Parliament. D. The chairman of the UPSC, on ceasing to hold office, is not eligible for further employment in the Government of India or a state. 2 inches 1979, the Supreme Court upheld the validity of appointment of A.R. Kidwai, a former chairman of UPSC, as the governor of Bihar. It inled that the a member of the UPSC, on ceasing to hold office, is eligible for appointment as the chairman of UPSC or a State Public Service Commission, SPSC, but not for any other employment in the Government of India or a State 3. F. The chairman or a member of UPSC is, after having completed his/her first term, not eligible for reappointment to that office, i.e., not eligible for second term. Functions. The UPSC performs the following functions. I. It conducts examinations for appointments to the all India services, central services, and public services of the centrally administered territories. 2. It assists the states, if requested by 2 or more states to do so, in framing and operating schemes of joint recruitment for any services for which candidates possessing special qualifications are required. 3. It serves all or any of the needs of a state on the request of the state governor and with the approval of the President of India. 4. It is consulted on the following matters, and it advises: A. On all matters relating to methods of recruitment to civil services and for civil posts. B. On the principles to be followed in making appointments to civil services and posts and in making promotions and transfers from one service to another, and on the suitability of candidates for such appointments, promotions, and transfers. Office of the Governor is a constitutional office and not an employment under the government. When a member of the UPSC is appointed as its chairman, he/she holds the new office for 6 years or until the age of superannuation, whichever is earlier. C. On all disciplinary matters affecting a person serving under the Government of India in a civil capacity. This includes memorials and petitions relating to such matters. D. On any claim for reimbursement of legal expenses incurred by a civil servant in defending legal proceedings instituted against him/her in respect of acts done in the execution of his/her official duties. E. On any claim toward the award of a pension in respect of injuries sustained by a civil servant while serving under the Government of India and any question as to the amount of any such award. F. On any other matter referred to it by the President, the Supreme Court has held that if the government fails to consult the UPSC in the matters mentioned above, the aggrieved public servant has no remedy in a court. In other words, the court held that any irregularity in consultation with the UPSC or acting without consultation does not invalidate the decision of the government. Thus, the provision is directory and not mandatory. Similarly, the court held that a selection by the UPSC does not confer any right to the post upon the candidate. However, the government is to act fairly and without arbitrariness or mala fides. The additional functions relating to the services of the Union can be conferred on the UPSC by the Parliament. The Parliament can also place the personnel system of any authority, corporate body, or public institution within the jurisdiction of the UPSC. Hence, the jurisdiction of the UPSC can be extended by an act made by the Parliament. The UPSC presents, annually, to the President a report on its performance. The President places this report before both the Houses of Parliament, along with a memorandum explaining the cases where the advice of the Commission was not accepted and the reasons for such non-acceptance. Union Public Service Commission. F. Limitations. The following matters are kept outside the functional jurisdiction of the UPSC. In other words, the UPSC is not consulted on the following matters. A. While making reservations of appointments or posts in favor of any backward class of citizens. B. While taking into consideration the claims of scheduled castes and scheduled tribes in making appointments to services and posts. C. With regard to the selection for a temporary or officiating appointment to a post, if A. The person appointed is not likely to hold the post for a period of more than 1 year, and B. It is necessary in the public interest to make the appointment immediately in reference to the UPSC will cause undue delay. D. With regard to the appointments to a bulk of Group C and Group D central services. E. With regard to the appointments to the posts of chairman and members of the boards, commissions, tribunals, and other similar authorities. F. With regard to the appointments to the posts of heads of diplomatic, consular, and other similar Indian missions in countries abroad, e.g. ambassadors, high commissioners, ministers, commissioners, consuls, general, representatives, agents. The President can exclude posts, services, and matters from the purview of the UPSC. The Constitution states that the President, in respect to the all India services and central services and posts, may make regulations specifying the matters in which it shall not be necessary to consult the UPSC. But all such regulations made by the President shall be laid before each House of Parliament for at least 14 days. The Parliament can amend or repeal them. Under the above provision, the President has made regulations which are called as the UPSC Exemption from Consultation Regulations for 126 R. Indian Polity. 1958. These regulations have been amended from time to time. T. Role. The Constitution visualizes the UPSC to be the watchdog of merit system in India. It is concerned with the recruitment to the All India Services and Central Services Group A and Group B and advises the government, when consulted, on promotion and disciplinary matters. It is not concerned with the classification of services, pay and service conditions, cadre management, training, and so on. These matters are handled by the Department of Personnel and Training, one of the 3 departments of the Ministry of Personnel, Public Grievances, and Pensions. 4. Therefore, the UPSC is only a central recruiting agency. For inches 1985, a new full-fledged Ministry of Personnel, Public Grievances, and Pensions was created with 3 separate departments. These are Department of Personnel and Training, Department of Administrative Reforms and Public Grievances, and Department of Pensions and Pensioners' Welfare. 5 such rules are known as the UPSC, Exemption from Consultation, Regulations. While the Department of Personnel and Training is the central personnel agency in India. The role of the UPSC is not only limited, but also recommendations made by it are only of advisory nature and hence, not binding on the government. It is up to the union government to accept or reject that advice. Further, the government can also make rules which regulate the scope of the advisory functions of the UPSC 5. Also, the emergence of Central Vigilance Commission, CVC, in 1964 affected the role of the UPSC in disciplinary matters. This is because both are consulted by the government while taking disciplinary action against a civil servant. The problem arises when the two bodies tender conflicting advice. However, the UPSC, being an independent constitutional body, has an edge over the CVC, which is created by an executive resolution of the Government of India and conferred a statutory status in 2003. Table 44.1 Articles related to the UPSC at a glance. Article No. Subject Matter. 315 Public Service Commissions for the Union and for the States. 316 Appointment and Term of Office of Members. 317 Removal and Suspension of a Member of a Public Service Commission. 318 Power to make regulations as to conditions of service of members and staff of the Commission. 319 Prohibition as to the holding of office by members of Commission on ceasing to be such members. 320 Functions of Public Service Commissions. 321 Power to extend functions of Public Service Commissions. 322 Expenses of Public Service Commissions. 323 Reports of Public Service Commissions. Chapter 45 State Public Service Commission. Parallel to the Union Public Service Commission, UPSC, at the center, there is a State Public Service Commission, SPSC, in each state. The same set of articles, i.e., 315 to 323 in Part 14, of the Constitution also deal with the composition, appointment, and removal of members, power and functions, and independence of a SPSC. Composition. A State Public Service Commission consists of a chairman and other members appointed by the governor of the state. The Constitution does not specify the strength of the commission but has left the matter to the discretion of the governor. Further, no qualifications are prescribed for the commission's membership except that 1/2 of the members of the commission should be such persons who have held office for at least 10 years either under the government of India or under the government of a state. The Constitution also authorizes the governor to determine the conditions of service of the chairman and members of the commission. In addition, the governor is authorized to make provisions with respect to the number of members of the staff of the commission and their conditions of service. The chairman and members of the commission hold office for a term of 6 years or until they attain the age of 62 years. Whichever is originally, it was 60 years. The 41st Amendment Act of 1976 raised it to 62 years. 2 added by the 15th Amendment Act of 1963. Earlier, in the case of UPSC, the age limit is 65 years. However, they can relinquish their offices at any time by addressing their resignation to the governor. The governor can appoint one of the members of the SPSC as an acting chairman in the following 2 circumstances: A. When the office of the chairman falls vacant. Or B. When the chairman is unable to perform his functions due to absence or some other reason. The acting chairman functions till the person appointed as chairman enters on the duties of the office or till the chairman is able to resume his duties. Removal. Although the chairman and members of a SPSC are appointed by the governor, they can be removed only by the president and not by the governor. The president can remove them on the same grounds and in the same manner as Husha can remove a chairman or a member of the UPSC. Thus, Husha can remove him/her under the following circumstances: A. If Husha is adjudged an insolvent, i.e., has gone bankrupt. Or B. If Hesh engages, during his/her term of office, in any paid employment outside the duties of his/her office. Or 428 Indian Polity. C. If Husha is, in the opinion of the president, unfit to continue in office by reason of infirmity of mind or body. 3. In addition to these, the president can also remove the chairman or any other member of the SPSC for misbehavior. However, in this case, the president has to refer the matter to the Supreme Court for an inquiry. If the Supreme Court, after the inquiry, upholds the cause of removal and advises so, the president can remove the chairman or a member. Under the provisions of the Constitution, the advice tendered by the Supreme Court in this regard is binding on the president. However, during the course of inquiry by the Supreme Court, the governor can suspend the concerned chairman or member, pending the final removal order of the president on receipt of the report of the Supreme Court. Further, the Constitution has also defined the term misbehavior in this context. The Constitution states that the chairman or any other member of a SPSC is deemed to be guilty of misbehavior if Husha A. is concerned or interested in any contract or agreement made by the government of India or the government of a state. or B, participates in any way in the profit of such contract or agreement or in any benefit therefrom otherwise than as a member and in common with other members of an incorporated company. T. Independence. As in the case of UPSC, the Constitution has made the following provisions to safeguard and ensure the independent and impartial functioning of a SPSC. A. The chairman or a member of a SPSC can be removed from office by the President. 3L in 1993, the Supreme Court ruled that appointment of a university professor, known to be blind, as a member of a SPSC cannot be set aside on the ground of infirmity of body or mind, only in the manner and on the grounds mentioned in the Constitution. Therefore, they enjoy the security of tenure. B. The conditions of service of the chairman or member, though determined by the governor, cannot be varied to his or disadvantage after his appointment. C. The entire expenses including the salaries, allowances, and pensions of the chairman and members, and also the staff of a SPSC are charged on the consolidated fund of the state. Thus, they are not subject to vote of the state legislature. D. The chairman of a SPSC, on ceasing to hold office, is eligible for appointment as the chairman or a member of the UPSC or as the chairman of any other SPSC, but not for any other employment under the Government of India or a state. E. A member of a SPSC, on ceasing to hold office, is eligible for appointment as the chairman or a member of the UPSC or as the chairman of that SPSC or any other SPSC, but not for any other employment under the Government of India or a state. F. The chairman or a member of a SPSC is, after having completed his or first term, not eligible for reappointment to that office, that is, not eligible for second term. F. Functions. A SPSC performs all those functions in respect of the state services as the UPSC does in relation to the central services. A. It conducts examinations for appointments to the services of the state. B. It is consulted on the following matters and it advises. I. On all matters relating to methods of recruitment to civil services and for civil posts. 2. On the principles to be followed in making appointments to Civil State Public Service Commission 429. SJJ visor vices and posts and in making promotions and transfers from one service to another and on the suitability of candidates for such appointments, promotions and transfers. 3. On all disciplinary matters affecting a person serving under the government of the state in a civil capacity including memorials or petitions relating to such matters. 4. On any claim for reimbursement of legal expenses incurred by a civil servant in defending legal proceedings instituted against him or her in respect of acts done in the execution of his official duties. V. On any claim for the award of a pension in respect of injuries sustained by a person while serving under the government of the state and any question as to the amount of any such award. 6. Any other matter referred to it by the governor. The Supreme Court has held that if the government fails to consult the SPSC in these matters, the aggrieved public servant has no remedy in a court. In other words, the court held that any irregularity in consultation with the SPSC or acting without consultation does not invalidate the decision of the government. Thus, the provision is directory and not mandatory. Similarly, the court held that a selection by the SPSC does not confer any right to the post upon the candidate. However, the government is to act fairly and without arbitrariness or malefice. The additional functions relating to the services of the state can be conferred on the SPSC by the state legislature. The state legislature can also place the personnel system of any local authority, corporate body, or public institution within the jurisdiction of the SPSC. Hence, the jurisdiction of the SPSC can be extended by an act made by the state legislature. H. The SPSC presents, annually, to the governor a report on its performance. The governor places this report before both the houses of the state legislature, along with a memorandum explaining the cases where the advice of the commission was not accepted and the reasons for such non-acceptance. R. J. F. Limitations. The following matters are kept outside the functional jurisdiction of the SPSC. In other words, the SPSC is not consulted on the following matters. A. While making reservations of appointments or posts in favor of any backward class of citizens. B. While taking into consideration the claims of scheduled castes and scheduled tribes and making appointments to services and posts. In J. The governor can exclude posts, services, and matters from the purview of the SPSC. The Constitution states that the governor, in respect to the state services and posts, may make regulations specifying the matters in which it shall not be necessary to consult the SPSC. But all such regulations made by the governor shall be laid before each house of the state legislature for at least 14 days. The state legislature can amend or repeal them. Z. T. Role. The Constitution visualizes the SPSC to be the watchdog of merit system in the state. It is concerned with the recruitment to the state services and advises the government, when consulted, on promotion and disciplinary matters. It is not concerned with the classification of services, pay and service conditions, cadre management, training, and so on. These matters are handled by the Department of Personnel or the General Administration Department. Therefore, the SPSC is only a central recruiting agency in the state, while the Department of Personnel or the General 430 Indian Polity Administration Department is the central personnel agency in the state. The role of SPSC is not only limited, but also recommendations made by it are only of advisory nature and hence not binding on the government. It is up to the state government to accept or reject that advice. Further, the government can also make rules which regulate the scope of the advisory functions of the SPSC. For such rules are known as the SPSC exemption from consultation regulations. Also, the emergence of State Vigilance Commission (SVC) affected the role of SPSC in disciplinary matters. This is because both are consulted by the government while taking disciplinary action against a civil servant. The problem arises when the two bodies tender conflicting advice. However, the SPSC, being an independent constitutional body, has an edge over the SVC. It must be noted here that the SPSC is consulted by the governor while framing rules for appointment to judicial service of the state other than the post of district judges. In this regard, the concerned state high court is also consulted. Joint State Public Service Commission. The Constitution makes a provision for the establishment of a Joint State Public Service Commission, JSPSC, for two or more states. While the UPSC and the SPSC are created directly by the Constitution, a JSPSC can be created by an act of Parliament on the request of the state legislatures concerned. Thus, a JSPSC is a statutory and not a constitutional body. The chairman and members of a JSPSC are appointed by the president. They hold office for a term of 6 years or until they attain the age of 62 years, whichever is earlier. They can be suspended or removed by the president. They can also resign from their offices at any time by submitting their resignation letters to the president. The number of members of a JSPSC and their conditions of service are determined by the president. A JSPSC presents its annual performance report to each of the concerned state governors. Each governor places the report before the state legislature. Table 45.1 Articles related to the SPSC at a glance. Article No. Subject Matter. 315 Public Service Commissions for the Union and for the states. 316 Appointment and Term of Office of Members. 317 Removal and Suspension of a Member of a Public Service Commission. 318 Power to make regulations as to conditions of service of members and staff of the Commission. 319 Prohibition as to the holding of office by members of Commission on ceasing to be such members. 320 Functions of Public Service Commissions. 321 Power to extend functions of Public Service Commissions. 322 Expenses of Public Service Commissions. 323 Reports of Public Service Commissions. Chapter 146 Finance Commission. Article 280 of the Constitution of India provides for a Finance Commission as a quasi-judicial body. It is constituted by the President of India every 5th year or at such earlier time as HSA considers necessary. Till now, 15 Finance Commissions have been constituted. The name of the commissions, the years in which they were constituted and submitted their reports, and the names of the chairman are given in IBL 46.1. T. Composition. The Finance Commission consists of a chairman and 4 other members to be appointed by the President. They hold office for such period as specified by the President in HSA order. They are eligible for reappointment. The Constitution authorizes the Parliament to determine the qualifications of members of the Commission and the manner in which they should be selected. Accordingly, the Parliament has specified the qualifications of the chairman and members of the Commission. 1. The chairman should be a person having experience in public affairs, and the 4 other members should be selected from amongst the following. 1. A judge of high court or one qualified to be appointed as one. 2. A person who has specialized knowledge of finance and accounts of the government. 3. A person who has wide experience in financial matters and administration. 4. A person who has special knowledge of economics. T. Functions. The Finance Commission is required to make recommendations to the President of India on the following matters. 1. The distribution of the net proceeds of taxes to be shared between the center and the states, and the allocation between the states of the respective shares of such proceeds. 2. The principles that should govern the grants and aid to the states by the center, i.e., out of the Consolidated Fund of India. 3. The measures needed to augment the Consolidated Fund of a state to supplement the resources of the Panchayats and the municipalities in the state on the basis of the recommendations made by the State Finance Commission. 2. 4. Any other matter referred to it by the President in the interests of sound finance. Till 1960, the Commission also suggested the grants given to the states of Assam, Bihar, Odisha, and West Bengal in lieu of assignment of any share of the net proceeds in each year of export duty on jute and jute products. These grants were to be given for a temporary period of 10 years from the commencement of the Constitution. This function was added by the 73rd and 74th Constitutional Amendment Acts of 1992, which have granted constitutional status and protection on the Panchayats in the municipalities respectively. B. The Finance Commission Act, 1951. 432 Indian Polity. The Commission submits its report to the President, lays it before both the Houses of Parliament along with an explanatory memorandum as to the action taken on its recommendations. T. Advisory role. It must be clarified here that the recommendations made by the Finance Commission are only of advisory nature and hence not binding on the government. It is up to the Union government to implement its recommendations on granting money to the states. Put it in other words. It is nowhere laid down in the Constitution that the recommendations of the Commission shall be binding upon the Government of India or that it would give rise to a legal right in favor of the beneficiary states to receive the money recommended to be offered to them by the Commission. 3. J.D. D. Basu, Introduction to the Constitution of India, Wadwan 19th edition, 2001, p. 331. As rightly observed by Dr. P.V. Rajamannor, the chairman of the Fourth Finance Commission, since the Finance Commission is a constitutional body expected to be quasi-judicial, its recommendations should not be turned down by the Government of India unless there are very compelling reasons. The Constitution of India envisages the Finance Commission as the balancing wheel of fiscal federalism in India. However, till 2014, its role in the center-state fiscal relations was undermined by the erstwhile Planning Commission, a non-constitutional and a non-statutory body. The Dr. P.V. Rajamannor also observed that there was an overlapping of functions and responsibilities between the Finance Commission and the erstwhile Planning Commission in federal fiscal transfers. For in 2015, the Planning Commission was replaced by a new body called Niti Aayog, National Institution for Transforming India. Report of the Fourth Finance Commission, New Delhi, Government of India, 1965, pp. 88-90. Table 46.1 Finance Commissions appointed so far. Finance Commission. Chairman appointed and submitted. Report in. Period of implementation of report. First K.C. Neogy 1951-1952-1952-57. Second K. Santhanam 1956-1957-1957-62. Third A.K. Chanda 1960-1961-1962-66. Fourth Dr. P.V. Rajamannor 1964-1965-1966-69. Fifth Mahavir Tyagi 1968-1969-1969-74. Sixth Brahmananda Reddy 1972-1973-1974-79. Seventh Jayam Shilat 1977-1978-1979-84. Eighth Wabi Shivan 1982-1984-1984-89. Ninth NKP Salve 1987-1989-1989-95. 10th KC Pant 1992-1994-1995-2000. 11th AM Khusro 1998-2000-2000-2005. 12th Dr. C. Rangarajan 2002-2004-2005-2010 Finance Commission 433. Finance Commissió. Chairman. N. Appointed and submitted. Report in. Period of implementation of report. 13th Dr. Vijay Kelkar 2007-2009-2010-2015 14th YV Reddy 2013-2014-2015-2020 15th N.K. Singh 2017-2019 and 20205-2020-2026. Table 46.2 Articles related to Finance Commission at a glance. Article No. Subject Matter. 280. Finance Commission 281. Recommendations of the Finance Commission, in. On December 5, 2019, the Commission submitted its first report containing recommendations for the year 2020-21. Again, on November 9, 2020, the Commission submitted its second report containing recommendations for the period 2021-22 to 2025-26. V. I. J. Chapter Y. Goods and Services. Tax Council. T. Establishment. The 101st Amendment Act of 2016 paved the way for the introduction of a new tax regime, i.e. Goods and Services Tax, GST, in the country. The smooth and efficient administration of this tax requires cooperation and coordination between the center and the states. In order to facilitate this consultation process, the amendment provided for the establishment of a Goods and Services Tax Council or the GST Council. The amendment inserted a new Article 279A in the Constitution. This article empowered the President to constitute a GST Council by an order. Accordingly, the President issued the order in 2016 and constituted the Council 1. The Secretariat of the Council is located at New Delhi. The Union Revenue Secretary too acts as the ex officio secretary to the Council. T. Vision and Mission. While discharging its functions, the Council is to be guided by the need for a harmonized structure of GST and the development of a harmonized national market for goods and services. Further, the Council has to determine the procedure in the performance of its functions. The vision and mission of the Council are as follows. Vision. ID establish the highest standards of cooperative federation in the functioning of the presidential order was issued on September 15, 2016. Department of Revenue, the Ministry of Finance, Government of India. The Council, which is the first constitutional federal body vested with powers to take all major decisions relating to GST. Mission, evolving by a process of wider consultation, a GST structure, which is information technology-driven and user-friendly. T. Composition. The Council is a joint forum of the center and the states and consists of the following members. A. The Union Finance Minister as the chairperson. B. The Union Minister of State in charge of Revenue or Finance. C. The minister in charge of finance or taxation or any other minister nominated by each state government. The members of the council from the states have to choose one amongst themselves to be the vice chairperson of the council. They can also decide his term. The Union Cabinet also decided to include the chairperson of the Central Board of Indirect Taxes and Customs, CBC, as a permanent invitee, non-voting, to all proceedings of the council. Working. The decisions of the council are taken at its meetings. 1/2 of the total number of members of the council is the quorum for conducting a meeting. Every decision of the council is to be taken by a majority of not less than 3/4 of the weighted votes. Goods and Services Tax Council 435. Of the members present and voting at the meeting. The decision is taken in accordance with the following principles. The vote of the central government shall have a weightage of 1/3 of the total votes cast in that meeting. 2. The votes of all the state governments combined shall have a weightage of 2/3 of the total votes cast in that meeting. Any act or proceedings of the council will not become invalid on the following grounds. Any vacancy or defect in the constitution of the council. Or 2. Any defect in the appointment of a person as a member of the council. Or 2*. Any procedural irregularity of the council not affecting the merits of the case. Functions. The council is required to make recommendations to the center and the states on the following matters. A. The taxes, cesses and surcharges levied by the center, the states, and the local bodies that would get merged in GST. B. The goods and services that may be subjected to GST or exempted from GST. C. Model GST laws, principles of levy, apportionment of GST levied on supplies in the course of interstate trade or commerce, and the principles that govern the place of supply. D. The threshold limit of turnover below which goods and services may be exempted from GST. E. The rates including floor rates with bands of GST. F. Any special rate or rates for a specified period to raise additional resources during any natural calamity or disaster. G. Special provision with respect to the states of Arunachal Pradesh, Assam, Jammu and Kashmir. 3. Manipur, Meghalaya, Mizoram, Nagaland, Sikkim, Tripura, Himachal Pradesh and Uttarakhand. H. Any other matter relating to GST, as the council may decide. In addition to the above, the council has the following other functions. 1. The council shall recommend the date on which the GST may be levied on petroleum crude, high-speed diesel, motor spirit, petrol, natural gas, and aviation turbine fuel. 2. When there is a dispute with respect to its recommendations or their implementation, the council shall establish a mechanism to adjudicate upon the dispute. A. Between the center and one or more states. Or B. Between the center and any state or states on one side and one or more other states on the other side. Or C. Between two or more states. 3. The council has to recommend the compensation to the states for loss of revenue arising on account of introduction of GST for a period of 5 years. Based on this recommendation, the Parliament determines the compensation. Accordingly, the Parliament enacted the law in 20174. The Jammu and Kashmir Reorganization Act, 2019, bifurcated the erstwhile state of Jammu and Kashmir into 2 separate union territories, namely, the Union Territory of Jammu and Kashmir and the Union Territory of Ladakh. The Goods and Services Tax, Compensation to States, Act, 2017. AQ National Commission, O for SCs Chapter. TE National Commission for Scheduled Castes, SCs, is a constitutional body in the sense that it is directly established by Article 338 of the Constitution. On the other hand, the other national commissions like the National Commission for Women, 1992, the National Commission for Minorities, 1993, the National Human Rights Commission, 1993, and the National Commission for Protection of Child Rights, 2007, are statutory bodies in the sense that they are established by acts of the Parliament. 7. Evolution. Originally, Article 338 of the Constitution provided for the appointment of a special officer for scheduled castes, SCs, and scheduled tribes, SIB, to investigate all matters relating to the constitutional safeguards for the SCs and ST, and to report to the President on their working. Husha was designated as the Commissioner for SCs and ST and assigned the said duty. In 1978, the government, through a resolution, set up a non-statutory multi-member commission for SCs and ST. The Office of Commissioner for SCs and STS also continued to exist. In 1987, the government, through another resolution, modified the functions of the commission and renamed it as the National Commission for SCs and STS-1. 2. The Act came into force on December 3, 1992. The Act came into force on February 19, 2004. For the National Commission for Scheduled Caste Chairperson, Vice Chairperson, and Members, Conditions of Service and Tenure, Rules, 2004. It was made as a national-level advisory body to advise the government on broad policy issues and levels of development of SCs and STS. Later, the 65th Constitutional Amendment Act of 19902 provided for the establishment of a high-level multi-member National Commission for SCs and ST, in the place of a single special officer for SCs and ST. This constitutional body replaced the Commissioner for SCs and ST. as well as the commission set up under the resolution of 1987. Again, the 89th Constitutional Amendment Act of 20033 bifurcated the combined National Commission for SCs and ST into two separate bodies, namely, National Commission for Scheduled Castes, under Article 338, and National Commission for Scheduled TIPS, under Article 338A. The separate National Commission for SCs came into existence in 2004. It consists of a chairperson, a vice chairperson, and 3 other members. They are appointed by the President by warrant under his hand and seal. Their conditions of service and tenure of office are also determined by the President. Under the rules made by the President, they hold office for a term of 3 years. They are not eligible for appointment for more than 2 terms. 7 functions. The functions of the Commission are: A. TB investigate and monitor all matters relating to the constitutional and other legal safeguards for the SCs and to evaluate their working. B. ID inquire into specific complaints with respect to the deprivation of rights and safeguards of the SCs. C. ID participate and advise on the planning process of socio-economic development of the SCs and to evaluate the progress of their development under the Union or a state. D. ID present to the President, annually and at such other times as it may deem fit, reports upon the working of those safeguards. E. ID make recommendations as to the measures that should be taken by the Union or a state for the effective implementation of those safeguards and other measures for the protection, welfare, and socio-economic development of the SCs. And F. Discharge such other functions in relation to the protection, welfare, and development and advancement of the SCs as the President may specify. T. Report. The Commission presents an annual report to the President. It can also submit a report as and when it thinks necessary. The President places all such reports before the Parliament, along with a memorandum explaining the action taken or the recommendations made by the Commission. The memorandum should also contain the reasons for the non-acceptance of any of such recommendations. The President also forwards any report of the Commission pertaining to a state government to the state governor. The governor places it before the state legislature, along with a memorandum explaining the action taken on the recommendations of the Commission. The memorandum should also: National Commission for SCs 437. Contain the reasons for the non-acceptance of any of such recommendations. The Commission is vested with the power to regulate its own procedure. The Commission, while investigating any matter or inquiring into any complaint, has all the powers of a civil court trying a suit, and in particular in respect of the following matters: A. Summoning and enforcing the attendance of any person from any part of India and examining him or on oath. B. Requiring the discovery and production of any document. C. Receiving evidence on affidavits. D. Requisitioning any public record from any court or office. E. Issuing summons for the examination of witnesses and documents. And F. Any other matter which the President may determine. The central government and the state governments are required to consult the Commission on all major policy matters affecting the SCs. The Commission is also required to discharge similar functions with regard to the Anglo-Indian community as it does with respect to the SCs. In other words, the Commission has to investigate all matters relating to the constitutional and other legal safeguards for the Anglo-Indian community and report to the President upon their working. 5 Clause 10 of Article 338 reads as follows. In this article, references to the scheduled castes shall be construed as including references to the Anglo-Indian community. Till 2018, the Commission was also required to discharge similar functions with regard to the other backward classes, OBCs. It was relieved from this responsibility by the 102nd Amendment Act of 2018. Chapter 49 National Commission. For STs. Like the National Commission for Scheduled Castes, SCs, the National Commission for Scheduled Tribes, ST, is also a constitutional body in the sense that it is directly established by Article 338A of the Constitution. Separate Commission for STS. The National Commission for SCs and STK came into being consequent upon passing of the 65th Constitutional Amendment Act of 19,901. The Commission was established under Article 338 of the Constitution with the objective of monitoring all the safeguards provided for the SCs and ST under the Constitution or other laws. The Act came into force on December 3, 1992. 2. The Ministry of Social Justice and Empowerment coordinates all activities relating to the SCs. 3. The Act came into force on February 19, 2004. For the National Commission for Scheduled Tribes Chairperson, Vice Chairperson, and Members, Conditions of Service and Tenure, Rules, 2004. Geographically and culturally, the SGS are different from the SCs, and their problems are also different from those of SCs. In 1999, a new Ministry of Tribal Affairs was created to provide a sharp focus to the welfare and development of the SGS. It was felt necessary that the Ministry of Tribal Affairs should coordinate all activities relating to the STS, as it would not be administratively feasible for the Ministry of Social Justice and Empowerment to perform this role too. Hence, in order to safeguard the interests of the SGS more effectively, it was proposed to set up a separate National Commission for SDS by bifurcating the existing Combined National Commission for SCs and STS. This was done by passing the 89th Constitutional Amendment Act of 2033. This act further amended Article 338 and inserted a new Article 338A in the Constitution. The separate National Commission for STS came into existence in 2004. It consists of a chairperson, a vice-chairperson, and 3 other members. They are appointed by the President by warrant under his hand and seal. Their conditions of service and tenure of office are also determined by the President. Under the rules formade by the President, they hold office for a term of 3 years. They are not eligible for appointment for more than 2 terms. T. Functions. The functions of the Commission are: A. TB investigate and monitor all matters relating to the constitutional and other legal safeguards for the STS and to evaluate their working. B. TB inquire into specific complaints with respect to the deprivation of rights and safeguards of the STK. C. TB participate and advise on the planning process of socio-economic development of the STs and to evaluate the progress of their development under the Union or a state. D. TB present to the President, annually and at such other times as it may deem fit, reports upon the working of those safeguards. E. ID make recommendations as to the measures that should be taken by the Union or a state for the effective implementation of those safeguards and other measures for the protection, welfare, and socioeconomic development of the SGS. And F. TB discharge such other functions in relation to the protection, welfare, and development and advancement of the STS as the President may specify. 7 other functions underscore in 2005. The President specified the following other functions of the Commission in relation to the protection, welfare, and development and advancement of the STS. 5. The National Commission for the Scheduled Tribes, specification of other functions, rules, 2005. I. Measures to be taken over conferring ownership rights in respect of minor forest produce to STS living in forest areas. Measures to be taken to safeguard rights of the tribal communities over mineral resources, water resources, etc. As per law. 3. Measures to be taken for the development of tribals and to work for more viable livelihood strategies. 4. Measures to be taken to improve the efficacy of relief and rehabilitation measures for tribal groups displaced by development projects. V. Measures to be taken to prevent alienation of tribal people from land and to effectively rehabilitate such people in whose case alienation has already taken place. 6. Measures to be taken to elicit maximum cooperation and involvement of tribal communities for protecting forests and undertaking social afforestation. 7. Measures to be taken to ensure full implementation of the provisions of Panchayats, Extension to the Scheduled Areas, Act, 1996. National Commission for STs, 439. 8. Measures to be taken to reduce and ultimately eliminate the practice of shifting cultivation by tribals that lead to their continuous disempowerment and degradation of land and the environment. 7. Report. The Commission presents an annual report to the President. It can also submit a report as and when it thinks necessary. The President places all such reports before the Parliament, along with a memorandum explaining the action taken on the recommendations made by the Commission. The memorandum should also contain the reasons for the non-acceptance of any of such recommendations. The President also forwards any report of the Commission pertaining to a state government to the state governor. The governor places it before the state legislature, along with a memorandum explaining the action taken on the recommendations of the Commission. The memorandum should also contain the reasons for the non-acceptance of any of such recommendations. 7. Powers underscore. The Commission is vested with the power to regulate its own procedure. The Commission, while investigating any matter or inquiring into any complaint, has all the powers of a civil court trying a suit, and in particular in respect of the following matters. A. Summoning and enforcing the attendance of any person from any part of India and examining him or on oath. B. Requiring the discovery and production of any document. C. Receiving evidence on affidavits. D. Requisitioning any public record from any court or office. E. Issuing summons for the examination of witnesses and documents. And F. Any other matter which the President may determine. The central government and the state governments are required to consult the Commission on all major policy matters affecting the SLK. Chapter 50. National Commission for BCs. T. Establishment. In the Mundell Case 1 Judgment, 1992, the Supreme Court directed the central government to constitute a permanent statutory body to examine the complaints of under-inclusion, over-inclusion, or non-inclusion of any class of citizens in the list of backward classes. Accordingly, the National Commission for Backward Classes, NCBC, was set up in 19932. 1. Indra Soni vs. Union of India, 1992. 2. V. The National Commission for Backward Classes Act, 1993. 3. The National Commission for Backward Classes, Repeal, Act, 2018, repealed the National Commission for Backward Classes Act, 1993. For the 102nd Amendment Act of 2018 inserted a new Article 342, enabling the President to specify the socially and educationally backward classes. Later, the 102nd Amendment Act of 2018 conferred a constitutional status on the Commission. For this purpose, the amendment inserted a new Article 338(b) in the Constitution. Hence, the Commission ceased to be a statutory body and became a constitutional body 3. Further, the scope of functions assigned to the Commission is also enlarged under the new dispensation. This was done in order to safeguard the interests of the socially and educationally backward classes more effectively. In other words, the constitutional status of the new Commission is at par with the National Commission for Scheduled Castes, NCSC, and the National Commission for Scheduled Tribes, NCST. The Commission consists of a chairperson, a vice-chairperson, and 3 other members. They are appointed by the President by warrant under his/her hand and seal. Their conditions of service and tenure of office are also determined by the President. Under the Rules 5 made by the President, they hold office for a term of 3 years. They are not eligible for appointment for more than 2 terms. The functions of the Commission are the following. A. To investigate and monitor all matters relating to the constitutional and other legal safeguards for the socially and educationally backward classes and to evaluate their work. B. Inquire into specific complaints with respect to the deprivation of rights and safeguards of the socially and educationally backward classes. C. Participate and advise on the socioeconomic development of the socially and educationally backward classes and to evaluate the progress of tier development under the Union or a state. D. Present to the President, annually and at such other times as it may deem fit, reports upon the working of those safeguards. The National Commission for Backward Classes Chairperson, Vice-Chairperson, and Members, Conditions of Service and Tenure, Rules, 2018. E. To make recommendations as to the measures that should be taken by the Union or a state for the effective implementation of those safeguards and other measures for the protection, welfare, and socioeconomic development of the socially and educationally backward classes. F. Discharge such other functions in relation to the protection, welfare, development, and advancement of the socially and educationally backward classes as the President may specify. Report. The Commission presents an annual report to the President. It can also submit a report as and when it thinks necessary. The President places all such reports before the Parliament, along with a memorandum explaining the action taken on the recommendations made by the Commission. The memorandum should also contain the reasons for the non-acceptance of any of such recommendations. The President also forwards any report of the Commission pertaining to a state government to the state government 6, and not to the state governor. The government places it before the state legislature, along with a memorandum explaining the action taken on the recommendations of the Commission. 6 Clause 7 of Article 3388. National Commission for BCs, 441. The memorandum should also contain the reasons for the non-acceptance of any of such recommendations. The Commission is vested with the power to regulate its own procedure. However, the 105th Amendment Act of 2021 exempted the state governments from this consultation with the Commission with respect to the preparation and maintenance of the list of socially and educationally backward classes for their own purposes. Chapter Special Officer for Linguistic Minorities. Constitutional Provisions. Originally, the Constitution of India did not make any provision with respect to the Special Officer for Linguistic Minorities. Later, the States Reorganization Commission, 1953-55, made a recommendation in this regard. Accordingly, the 7th Constitutional Amendment Act of 1956 inserted a new Article 350-8 in Part 17 of the Constitution. This article contains the following provisions. 1. There should be a special officer for linguistic minorities. He is to be appointed by the President of India. 2. It would be the duty of the special officer to investigate all matters relating to the safeguards provided for linguistic minorities under the Constitution. He would report to the President upon those matters at such intervals as the President may direct. The President should place all such reports before each House of Parliament and send to the governments of the states concerned. It must be noted here that the Constitution does not specify the qualifications, tenure, salaries and allowances, service conditions, and procedure for removal of the Special Officer for Linguistic Minorities. Commissioner for Linguistic Minorities. In pursuance of the provision of Article 350-8 of the Constitution, the Office of the Special Officer for Linguistic Minorities was created in 1957. HUSHA is designated as the Commissioner for Linguistic Minorities, CLM. The CLM has his/her headquarters in New Delhi too. HUSHA has 3 regional offices at Belgaum, Karnataka, Chennai, Tamil Nadu, and Kolkata, West Bengal. Each is headed by an assistant commissioner. A linguistic minority is a group of people whose mother tongue is different from that of the majority in the state or part of a state. Thus, the linguistic minorities are determined on a state-wise basis. The headquarters was established in 1957 at New Delhi. After a brief period, it was shifted to Allahabad and now, It has been shifted back to New Delhi in 2015. Annual Report 2021-22, Ministry of Minority Affairs, Government of India, pp. 40-41. The CLM is assisted at headquarters by Deputy Commissioner and an Assistant Commissioner. HUSHA maintains liaison with the state governments and union territories through nodal officers appointed by them. At the central level, the CLM falls under the Ministry of Minority Affairs. Hence, HUSHA submits the annual reports or other reports to the President through the Union Minority Affairs Minister. Role 3. The CLM interacts with the state's UTFI on all the matters pertaining to the issues concerning implementation of the constitutional and nationally agreed safeguards provided to the linguistic minorities. The CLM organization takes up all matters relating to safeguards for linguistic minorities brought to their notice by linguistic minority individuals, groups, associations, or organizations. Further, the CLM personally visits linguistic minority areas and educational institutions for an on-the-spot assessment of the status of implementation of the scheme of safeguards. In this connection, the CLM holds discussions, when required, with the chief ministers and governors of the states and the chief ministers and LT. Governors of the UTFI. She also holds discussions at the highest levels of administration viz. Chief Secretary, Principal Secretary, Education, and Principal Secretaries of the departments entrusted with the monitoring of the implementation of the scheme of safeguards for linguistic minorities. Vision and mission. The vision and mission of the CLM are mentioned here. 4. For this information is obtained from the official website of the Commissioner for Linguistic Minorities in India. 5. Vision. Streamlining and strengthening implementation machinery and mechanism for effective implementation of the constitutional safeguards for the linguistic minorities, thereby ensuring protection of the rights of speakers of the minority languages so as to provide them equal opportunities for inclusive and integrated development. Mission. LB ensure that all the states U.T.S effectively implement the constitutional safeguards and Special Officer for Linguistic Minorities Happy Face 443. The nationally agreed scheme of safeguards for the linguistic minorities for providing them equal opportunities for inclusive development. Functions and objectives in more detail. The functions and objectives of the CLM are as follows. 5. Functions. 1. To investigate all matters related to safeguards provided to the linguistic minorities. 2. LB submit to the President of India the reports on the status of implementation of the constitutional and the nationally agreed safeguards for the linguistic minorities. 3. LB monitor the implementation of safeguards through questionnaires, visits, conferences, seminars, meetings, review mechanism, etc. Objectives. 1. IB provide equal opportunities to the linguistic minorities for inclusive development and national integration. 2. LB spread awareness amongst the linguistic minorities about the safeguards available to them. 3. LB ensure effective implementation of the safeguards provided for the linguistic minorities in the Constitution and other safeguards, which are agreed to by the states U.T.S. 4. LB handle the representations for redress of grievances related to the safeguards for linguistic minorities, Chapter 52, Comptroller and Auditor General of India. Constitution of India, Article 148, provides for an independent office of the Comptroller and Auditor General of India, CAG. HUSHA is the head of the Indian Audit and Accounts Department. 1. HUSHA is the guardian of the public purse and controls the entire financial system of the country at both the levels, the center and the state. Her duty is to uphold the Constitution of India and laws of Parliament in the field of financial administration. This is the reason why Dr. B.R. Ambedkar said that the CAG shall be the most important officer under the Constitution of India too. HUSHA is one of the bulwarks of the democratic system of government in India. The others being the Supreme Court, the Election Commission and the Union Public Service Commission. The Indian Audit and Accounts Department was created during the British rule in 1753. 2. 1. As per the CAG's Duties, Powers and Conditions Constituent Assembly Debates, Volume 8, p. 405. Of Service, Act, 1971. Appointment and Term. The CAG is appointed by the President of India by a warrant under his hand and seal. The CAG, before taking over his office, makes and subscribes before the President an oath or affirmation. 1. To bear true faith and allegiance to the Constitution of India. 2. To uphold the sovereignty and integrity of India. 3. To duly and faithfully, and to the best of his ability, knowledge and judgment perform the duties of his office without fear or favor, affection or ill will. And 4. To uphold the Constitution and the laws. HUSHA holds office for a period of 6 years or up to the age of 65 years, whichever is earlier 23. HUSHA can resign any time from his office by addressing the resignation letter to the President. HUSHA can also be removed by the President on same grounds and in the same manner as a judge of the Supreme Court. In other words, Husha can be removed by the President on the basis of a resolution passed to that effect by both the Houses of Parliament with special majority, either on the ground of proved misbehavior or incapacity. F. Independence. The Constitution has made the following provisions to safeguard and ensure the independence of CAG. 1. Husha is provided with the security of tenure. Husha can be removed by the President only in accordance with the procedure mentioned in the Constitution. Thus, Husha does not hold office till the pleasure of the President, though Husha is appointed by him or her. 2. Husha is not eligible for further office, either under the Government of India or of any state, after Husha ceases to hold his office. 3. His salary and other service conditions are determined by the Parliament. Comptroller and Auditor General of India, 445. According to the Act made by the Parliament, his salary is equal to that of a judge of the Supreme Court. 3. 4. Neither his salary nor his rights in respect of leave of absence, pension, or age of retirement can be altered to his disadvantage after his appointment. 5. The conditions of service of persons serving in the Indian Audit and Accounts Department and the administrative powers of the CAG are prescribed by the President after consultation with the CAG. 6. The administrative expenses of the office of the CAG, including all salaries, allowances, and pensions of persons serving in that office, are charged upon the Consolidated Fund of India. Thus, they are not subject to the vote of Parliament. F. Duties and powers. The Constitution, Article 149, authorizes the Parliament to prescribe the duties and powers of the CAG in relation to the accounts of the Union and of the states and of any other authority or body. Accordingly, the Parliament enacted the CAG's Duties, Powers, and Conditions of Service Act, 1971. The duties and functions of the CAG as laid down by the Parliament and the Constitution are: 1. Husha audits the accounts related to all expenditure from the Consolidated Fund of India, Consolidated Fund of each state, and Consolidated Fund of each Union territory having a legislative assembly. 2. Husha audits all transactions relating to the Contingency Fund of India and the Public Account of India, as well as the Contingency Fund of each state and the Public Account of each state. 3. Husha audits all trading, manufacturing, profit and loss accounts, balance sheets, and other subsidiary accounts kept by any department of the central government and state governments. 3 inches 2018, the salary of a judge of the Supreme Court had been fixed at 2.50 lakh per month. 4. Husha audits the receipts and expenditure of all bodies and authorities substantially financed from the central or state revenues. 5. Husha audits the accounts of all bodies and authorities receiving grants and loans from the central and state government for specific purposes. 6. Husha audits all receipts of the center and states and ensures that the rules and procedures in this regard are designed to secure an effective check on the assessment, collection, and proper allocation of revenue. 7. Husha audits the accounts of all stores and stock kept in all the offices and departments of the central and state governments. 8. Husha audits the accounts of all government companies in accordance with the provisions of the Companies Act. 9. Husha audits the accounts of all corporations whose statutes provide for audit by him or her. 10. Husha audits the accounts of any other body or authority when requested by the President or Governor. For example, the audit of local bodies. 11. Husha advises the President with regard to prescription of the form in which the accounts of the center and the state shall be kept, Article 150. 12. Husha submits audit reports relating to the accounts of the center to President, who shall, in turn, place them before both the Houses of Parliament, Article 151. 13. Husha submits the audit reports relating to the accounts of a state to Governor, who shall, in turn, place them before the state legislature, Article 151. 14. Husha ascertains and certifies the net proceeds of any tax or duty, Article 279. Husha certificate is final. The net proceeds means the proceeds of a tax or a duty minus the cost of collection. 15. Husha acts as a guide, friend, and philosopher of the Public Accounts Committee of the Parliament. 446 Indian Polity. 16. Husha compiles and maintains the accounts of state governments. In 1976, Husha was relieved of his responsibilities with regard to the compilation and maintenance of accounts of the central government due to the separation of accounts from audit, that is, departmentalization of accounts. The CAG, in connection with the performance of Husha audit duties, has the following powers. I.T.B. Inspect any office or department which is subject to Husha audit. The second. 3b. Examine all transactions and question the person in charge of the office or department. 3. TB. Call for any records, papers, and documents from any audited entity. 4. It. Decide the extent and manner of audit. T. Role. The role of CAG is to uphold the Constitution of India and the laws of Parliament in the field of financial administration. The accountability of the executive, i.e., Council of Ministers, to the Parliament in the sphere of financial administration is secured through audit reports of the CAG. The CAG submits 3 audit reports to the President: Audit Report on Appropriation Accounts, 1, Audit Report on Finance Accounts, and Audit Report on Public Undertakings. The President lays these reports before both the Houses of Parliament. After this, the Public Accounts Committee examines them and reports its findings to the Parliament. 5 Vatal, P.K., Parliamentary Financial Control in India, 2nd edition. Bombay, Minerva Bookshop, 1962, p. 235. According to the above Act of 1971, the CAG has to ascertain whether money shown in the accounts as having been disbursed was legally available for and applicable to the service or the purpose to which they have been applied or charged, and whether the expenditure conforms to the authority. The appropriation accounts compare the actual expenditure with the expenditure sanctioned by the Parliament through the Appropriation Act, while the finance accounts show the annual receipts and disbursements of the Union government that governs it. In addition to this legal and regulatory audit, the CAG can also conduct the propriety audit, that is, HUSHA can look into the wisdom, faithfulness, and economy of government expenditure and comment on the wastefulness and extravagance of such expenditure. However, unlike the legal and regulatory audit, which is obligatory on the part of the CAG, the propriety audit is discretionary. Further, in 2006, the Ministry of Finance, Government of India, issued an office memorandum regarding performance audit by the CAG. The memorandum clarified that the performance audit falls within the scope of audit by the CAG. The performance audit is concerned with the audit of economy, efficiency, and effectiveness in the receipt and application of public funds. It is a comprehensive appraisal of the progress and efficiency of the execution of development programs. In this audit, an attempt is made, to assess and appraise to what extent the social and economic objectives sought to be achieved have been achieved and at what cost. 2. To examine how far the agency of department is adequately discharging its financial responsibilities, and 3. To ascertain whether the schemes are being executed and their operations conducted economically. The CAG has more freedom with regard to audit of expenditure than with regard to audit of receipts, stores, and stock. Whereas in relation to expenditure, HUSHA decides the scope of audit and frames HUSHA own audit codes and manuals. HUSHA has to proceed with the approval of the executive government in relation to rules for the conduct of the other audits. 5. The Secret Service expenditure is a limitation on the auditing role of the CAG. In this regard, the CAG cannot call for particulars of expenditure incurred by the executive agencies, but has to accept a certificate from the competent administrative authority that the expenditure has been so incurred under his or authority. The Constitution of India visualizes the CAG to be Comptroller as well as Auditor General. However, in practice, the CAG is fulfilling the role of an Auditor General only and not that of a Comptroller. In other words, the CAG has no control over the issue of money from the consolidated fund, and many departments are authorized to draw money by issuing checks without specific authority from the CAG, who is concerned only at the audit stage when the expenditure has already taken place. 6. In this respect, the CAG of India differs totally from the CAG of Britain, who has powers of both Comptroller as well as Auditor General. In other words, in Britain, the executive can draw money from the public exchequer only with the approval of the CAG. 60.d. Basu, Introduction to the Constitution of India, Wadhwa, 19th edition, 2001, p. 198. 7. The two reports are Public Administration in India, 1953, and Re-examination of India's Administrative System, 1956. TCAG and Corporations. The role of CAG in the auditing of public corporations is limited. Broadly speaking, his/her relationship with the public corporations falls into the following 3 categories. Some corporations are audited totally and directly by the CAG. 2. Some other corporations are audited by private professional auditors who are appointed by the central government in consultation with the CAG. If necessary, the CAG can conduct supplementary audit. 3. Some other corporations are totally subjected to private audit. In other words, their audit is done exclusively by private professional auditors, and the CAG does not come into the picture at all. They submit their annual reports and accounts directly to the Parliament. The role of the CAG in the auditing of government companies is also limited. They are audited by private auditors who are appointed by the government on the advice of the CAG. The CAG can also undertake supplementary audit or test audit of such companies. Comptroller and Auditor General of India 447. T. Appleby's criticism. Paul H. Appleby, an American scholar of public administration, in his 2 reports on Indian administration, was very critical of the role of CAG and attacked the significance of CAG's work. 7. He also suggested that the CAG should be relieved of the responsibility of audit. In other words, he recommended the abolition of the office of CAG. His points of criticism of Indian audit are as follows. 1. The function of the CAG in India is in a large measure an inheritance from the colonial rule. 2. The CAG is today a primary cause of widespread and paralyzing unwillingness to decide and to act. Auditing has a repressive and negative influence. 3. The Parliament has a greatly exaggerated notion of the importance of auditing to parliamentary responsibility, and so has failed to define the functions of the CAG as the Constitution contemplated it would do. 4. The CAG's function is not really a very important one. Auditors do not know and cannot be expected to know very much about good administration. Their prestige is highest with others who do not know much about administration. 5. Auditors know what is auditing, which is not administration, It is a necessary but a highly pedestrian function with a narrow perspective and a very limited usefulness. 6. A deputy secretary in the department knows more about the problems in his/her department than the CAG and his/her entire staff. T. Challenges. The Second Administrative Reforms Commission of India, 2005 to 2009, has identified the challenges before the external audit conducted 448 are Indian Polity by the CAG and explained them in the following way. 8. Second Administrative Reforms Commission, Government of India, Report on Strengthening Financial Management Systems, 2009, pp. 141 to 143. There is no doubt that external audit by the CAG has contributed a great deal in improving the financial management in the country, keeping in view the large number of inspection reports issued, audit reports presented to the Parliament and the state legislatures, and the recoveries made at the instance of audit. In its reports, audit raises many important issues relating inter alia to weak budgetary controls, deficiencies in revenue collection, wastage of public resources, inappropriate accounting, poor returns on investments, diversion of funds, system deficiencies, and numerous instances of poor management of public resources, etc. There is, however, a feeling that the impact and effectiveness of external audit could be further enhanced. Some of the factors and perceptions which are impeding the effectiveness of external audit by CAG are given below. Detailed examination offers included in the audit reports by Public Accounts Committee, PG, is barely about 15 to 20 against the total number of 1,000 to 1,500 paras included in the CAG's reports submitted to the Parliament every year. The Ministry's departments take only those audit paras seriously which come up for discussions in the PAC. 2. The Ministry's departments are supposed to submit action taken notes on the paras not discussed. Such action taken notes are largely formal rather than substantive. In the state legislatures, there is a huge pendency of audit paras to be examined by state PACs. Some of the pending paras are 10 to 20 years old. Delay in examination of matters brought out in the reports reduces their relevance. 4. Thousands of inspection reports containing a huge number of observations are lying unattended in the state and union government departments. Many of these paras have revenue implications. There is hardly any accountability for not taking timely action on audit observations. There is a feeling that the CAG's reports are sometimes not timely because there is substantial time gap between occurrence of an irregularity and its reporting by audit. It reviews programs after these have run for a few years. CAG's audit itself is post facto, and by the time the process of auditing and reporting is completed, its findings and recommendations may be too late for corrective action. Many transaction audit comments relate to earlier years and not to the year of the audit report. 6. Audit findings are based exclusively on documents and files. Many a times, the situation on the ground is quite different from what is reflected in T.E. papers. There is practically no physical verification to supplement or validate the audit findings. 7. There is a feeling that external audit reports tend to be unduly negative and their focus is on irregularities and fault-finding. Audit does not always recognize the practical constraints under which the government agencies function. Audit often does not discriminate between errors arising out of bona fide intentions and malified intentions. Government agencies are handicapped by unknown unforeseen problems, delays beyond their control, and unexpected hurdles. The auditors, on the other hand, have the benefit of hindsight. Audit as such could act as a dampener against new initiatives and risk-taking. 8. Audit reports are not always presented in a sufficiently constructive manner, as they often do not delve into the Comptroller and Auditor General of India 449 causes of the problems and how to address them. Reporting each year a large number of problems which are already known and which are not being addressed does not add value. Audit must therefore identify systemic problems. Findings are at times not focused and are in the nature of scattered observations. A macro-level view of the functioning of a department is seldom available. Audit does not give due credit for good performance. 9. The relationship between the auditor and auditee is not always harmonious. Generally, interaction is confined mainly to the lower levels. Audit is viewed as a system for policing government organizations. The view that audit is a valuable aid to management is normally missing. There is poor and inadequate response to external audit bordering sometimes on indifference on the part of government officials, which seriously reduces the effectiveness of audit. Though audit committees comprising representatives of audit and government agencies have been set up to review the departmental action taken on inspection reports recommendations, their functioning is not satisfactory. 11. There is a lack of informed media coverage of CAG's reports on union state governments. The extent of the public interface between the auditors and civil society is poor. Inspection reports are not in the public domain. 12. There is inadequate synergy coordination between external audit and internal audit. 13. External audit does not provide audit assurance on the fair presentation of financial statements of the government in accordance with stated accounting principles and policies. 14. There is rarely any audit of grants and loans to NGOs. Table 52.1 Articles related to Comptroller and Auditor General of India at a glance. Article No Subject Matter. 148. Comptroller and Auditor General of India. 149. Duties and powers of the Comptroller and Auditor General. 1. 150. Form of accounts of the Union and of the States. 151. Audit reports. I. L. Scan the QR code to access the conceptual video on discussion of CAG, AGI, CBI, and NI, their autonomy and limitations and other important topics on Edge Chapter M. Attorney General of India. T. Constitution, Article 76, has provided for the office of the Attorney General for India. 1. PESA is the highest law officer in the country. F. Appointment and term. The Attorney General, AG, is appointed by the President. PESA must be a person who is qualified to be appointed as a judge of the Supreme Court. In other words, PESA must be a citizen of India and must have been a judge of some high court for 5 years or an advocate of some high court for 10 years or an eminent jurist, in the opinion of the President. The term of office of the AG is not fixed by the Constitution. Further, the Constitution does not contain the procedure and grounds for PESA removal. PESA holds office during the pleasure of the President. This means that PESA may be removed by the President at any time. PESA may also quit office by submitting resignation to the President. Conventionally, PESA resigns when the Government Council of Ministers resigns or is replaced, as PESA is appointed on its advice. The remuneration of the AG is not fixed by the Constitution. PESA receives such remuneration as the President may determine. Article 76 of Chapter 1, the Executive, in Part 5, the Union, of the Constitution deals with the office of the Attorney General of India. T. Duties and functions. As the Chief Law Officer of the Government of India, the duties of the AG include the following. 1. TB give advice to the Government of India upon such legal matters, which are referred to him/her by the President. 2. To perform such other duties of a legal character that are assigned to him/her by the President. 3. LB discharge the functions conferred on him/her by the Constitution or any other law. The President has assigned the following duties to the AG. 2. 1. TB appear on behalf of the Government of India in all cases in the Supreme Court in which the Government of India is concerned. 2. TB represent the Government of India in any reference made by the President to the Supreme Court under Article 143 of the Constitution. 3. To appear, when required by the Government of India, in any High Court in any case in which the Government of India is concerned. F. Rights and limitations. In the performance of his official duties, the AG has the right of audience in all courts in the territory of India. Further, PESA has Notification No. F. 43-50C, January 26, 1950, Gazette of India, Extraordinary, Volume 7, pp. 33-34. Attorney General of India 451. The right to speak and to take part in the proceedings of both the Houses of Parliament or their joint sitting and any committee of the Parliament of which PESA may be named a member, but without a right to vote. PESA also enjoys all the privileges and immunities that are available to a member of Parliament. In order to avoid any complication and conflict of duty, the following limitations are placed on the AG. 1. PESA should not advise or hold a brief against the Government of India. 2. PESA should not advise or hold a brief in cases in which PESA is called upon to advise or appear for the Government of India. 3. PESA should not defend accused persons in criminal prosecutions without the permission of the Government of India. 4. PESA should not accept appointment as a director in any company or corporation without the permission of the Government of India. 5. PESA should not advise any ministry or department of Government of India or any statutory organization or any public sector undertaking unless the proposal or a reference in this regard is received through the Ministry of Law and Justice, Department of Legal Affairs 23. Inserted v. GSRE, dated February 25, 2005. 3. During the Prime Ministership of Jawaharlal Nehru, a proposal was put forward by the central government that the office of the Attorney General be merged with the office of the Law Minister. It did not materialize. However, the AG is not a full-time counsel for the government. PESA does not fall in the category of government servants. Further, she is not debarred from private legal practice. T. Solicitor General of India. In addition to the AG, there are other law officers of the Government of India. They are the Solicitor General of India and Additional Solicitor General of India. They assist the AG in the fulfillment of his official responsibilities. It should be noted here that only the office of the AG is created by the Constitution. In other words, Article 76 does not mention about the Solicitor General and Additional Solicitor General. The AG is not a member of the Central Cabinet. There is a separate law minister in the Central Cabinet to look after legal matters at the government level. * 3. Table 53.1 Articles related to Attorney General of India at a glance. Article No. Subject Matter. 76. Attorney General of India. 88. Rights of Attorney General as respects the Houses of Parliament and its committee. 105. Powers, privileges, and immunities of Attorney General. Scan the QR code to access the conceptual video on discussion of CAG, AGI, CBI, and NIA, their autonomy and limitations, and other important topics on Edge Chapter 54 Advocate General of the State. T. Constitution, Article 165, has provided for the office of the Advocate General for the states. 1. Husha is the highest law officer in the state. Thus, Husha corresponds to the Attorney General of India. Article 165 of Chapter 2, the Executive, in Part 6, the States, of the Constitution deals with the office of the Advocate General of the state. Judicial office means an office within the judicial service of the state. 3. Unlike the Supreme Court, the Constitution makes no provision for appointment of an eminent jurist as a judge of high court. Appointment and term. The Advocate General is appointed by the governor. Husha must be a person who is qualified to be appointed as a judge of a high court. In other words, Husha must be a citizen of India and must have held a judicial office 2 for 10 years or been an advocate of a high court for 10 years 3. The term of office of the Advocate General is not fixed by the Constitution. Further, the Constitution does not contain the procedure and grounds for Husha removal. Husha holds office during the pleasure of the governor. This means that Husha may be removed by the governor at any time. Husha may also quit Husha office by submitting Husha resignation to the governor. Conventionally, Husha resigns when the Government Council of Ministers resigns or is replaced, as Husha is appointed on its advice. The remuneration of the Advocate General is not fixed by the Constitution. Husha receives such remuneration as the governor may determine. Duties and rights underscore as the chief law officer of the government and the state, the duties of the Advocate General include the following. 1. To give advice to the government of the state upon such legal matters which are referred to him/her by the governor. 2. Perform such other duties of a legal character that are assigned to him/her by the governor. 3. To discharge the functions conferred on him/her by the Constitution or any other law. The Advocate General has the right to speak and to take part in the proceedings of both the houses of the state legislature or any committee of the state legislature of which he/she may be named a member, but without a right to vote. Husha also enjoys all the privileges and immunities that are available to a member of the state legislature. Table 54.1 Articles related to Advocate General of the state at a glance. Article No. Subject Matter. 165. Advocate General of the state. 177. Rights of Advocate General as respects the houses of state legislature and its committee. Table 54.2 Articles related to constitutional bodies at a glance. Article No. Constitutional bodies. 76. Attorney General of India. 148. Comptroller and Auditor General of India. 165. Advocate General of the state. 315. 324. Union Public Service Commission and State Public Service Commission. Election Commission. 338.